Well, good morning. I declare open this hearing of the Senate Legal and Constitutional Affairs Legislation Committee for the supplementary budget estimates. The Senate has referred to the committee the particulars of proposed expenditure for 2021-22 for the portfolios of Home Affairs and the Attorney-General and other related documents. These are supplementary budget estimates proceedings, and the outcomes to be heard during today's estimates are from the Attorney-General's portfolio. The committee has set Friday the 10th of December 2021 as the date by which answers to questions on notice are to be returned. The committee has also decided that written questions on notice should be provided to the Secretariat by 5 p.m. on Friday the 5th of November 2021. Under Standing Order 26, the committee must take all evidence in public session. This includes answers to questions on notice. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence to a committee. Officers and senators are familiar with the rules of the Senate governing estimates hearings. If you need assistance, the Secretariat has copies of the rules. The Senate, by resolution in 1999, endorsed the following test of relevance of questions at estimates hearings. Any questions going to the operations or financial positions of the departments and agencies which are seeking funds in the estimates are relevant questions for the purpose of estimates hearings. I remind officers that the Senate has resolved that there are no areas in connection with the expenditure of public funds where any person has a discretion to withhold details or explanations from the Parliament or its committees unless the Parliament has expressly provided otherwise. The Senate has also resolved that an officer of a Department of the Commonwealth shall not be asked to give opinions on matter of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. I particularly draw the attention of witnesses to an order of the Senate of the 13th of May 2009 specifying the process by which a claim of public interest immunity should be raised. Witnesses are specifically reminded that a statement that information or a document is confidential or consists of advice to government is not a statement which meets the requirements of the 2009 order. Instead, witnesses are required to provide some specific indication of the harm to the public interest which could result from the disclosure of the information or the document. Just a reminder, mobile phones should be switched off or turned to silent mode. Senators, departments and agencies have been provided with advice on the arrangements in place to ensure estimates hearings are conducted in a COVID-safe environment. The guidance is also available from the Secretariat. The committee appreciates the cooperation of all attendees in adhering to these arrangements. In order to comply with social distancing requirements, senators and the Secretariat may use their electronic devices to communicate with one another during the hearing. We ask witnesses forbearance to do so and apologise in advance for any discourtesy. Officers called upon for the first time to answer a question should state their full name and position for the Hansard record, and witnesses should speak clearly into the microphones. I'd like to welcome the Attorney-General, Senator the Honourable Michaelia Cash. Welcome, Attorney.
Thank you very much, Chair.
Would you like to make an opening statement?
I don't have an opening statement, but I would just like to acknowledge the appointment of Ms Catherine Jones. Absolutely welcome by the department and by the Ministerial Office as Secretary of the Attorney-General's Department.
Thank you very much, Attorney. And Ms Jones, welcome. This is your first estimates. You're going to have a wonderful day, so looking forward to it.
Thanks very much, Chair.
Misleading and deceptive conduct. Sorry.
No, not in trade or commerce, it doesn't apply. I would now like to call officers from the Administrative Appeals Tribunal. Would you like to make an opening statement before we go to questions? And Ms Leon, I can see that you are attending via video conference. Perhaps you could indicate who from the AAT is attending this morning. It's a little more tricky, of course, when people are attending remotely. If you would indicate whether you'd like to make an opening statement.
Yes, thank you, Chair. I will make a short opening statement. And just to clarify, I'm joined by Jamie Crew, our National Director of Tribunal Services here in Brisbane. And in Sydney, we have our Chief Corporate Officer, Jacqueline Fredman, our Chief Legal Officer, Chris Matthews. We also have the Senior Reviewer of the IAA, Sabet Haddad, who you can see on screen in Sydney.
Thank you.
Thank you, Chair. The Administrative Appeals Tribunal's 2020-21 annual report was tabled in Parliament last week. So I'd like to take this opportunity to outline our key outcomes for that year. Against a backdrop of fluctuating demand for reviews across our diverse caseloads, resourcing constraints and other external factors, there's strong evidence that the AAT continued to place users at the centre of our tribunal experience. We adapted the way we work to ensure cases have been progressed throughout the pandemic, including by enabling hearings, other case events and information services to be delivered without the need for people to physically visit our registries. Each year, we commission independent research to survey AAT users. Despite the impacts of the extended COVID-19 lockdowns, particularly in our larger registries, we achieved a user satisfaction result of 77% in the 2020-21 survey, exceeding our annual target by 7 percentage points. Data from the survey indicated that 81% of parties and 90% of representatives were satisfied with their dealings with our members, conference registrars and staff. Feedback about our processes was also broadly positive. Overall, the survey demonstrated that most parties and their representatives continue to receive review services that were fair, accessible, just, economical, informal, quick, proportionate, and which promoted trust and confidence in our decision making. This result is directly attributable to the efforts of our members and staff. During the reporting year, we received more than 37,000 applications, 31% fewer than the previous year. This was the first reporting year since the former tribunals were amalgamated in 2015 that we managed to finalise more applications than received, finalising 44,565 applications. More than half of these were in the Migration and Refugee Division. The AAT held in excess of 23,000 hearings, more than half of which were for migration or protection cases, and nearly 15,000 other case events, including alternative dispute resolution processes and directions hearings. We prepared more than 28,000 decisions with written reasons and delivered approximately 3,000 oral decisions. The decrease in lodgements enabled us to make modest inroads into our well-documented backlog, leaving 65,374 cases on hand at the end of the reporting year, compared with around 72,000 the year before. We are now seeing an increase in lodgements in 21-22, so it will be difficult to sustain the trend with our current member and staff resources. While we exceeded our clearance ratio of 100% in the reporting year, with finalisations outpacing lodgements, we were unable to meet our target for timeliness of completing 75% of cases within 12 months. This was mainly due to the age of the backlog in our largest practice, the Migration and Refugee Division. The target was met in some areas of our work, such as the Immigration Assessment Authority, the National Disability Insurance Scheme Division, the Small Business Taxation Division and the Social Services and Child Support Division. But the overall result for the AAT and the IAA was a combined 54%, which was 6 percentage points lower than the preceding year. As evidence of the high quality of our decision making, the proportion of appeals against AAT decisions that were allowed by the courts was again well under our 5% target at 2.3%. We remained one of the highest volume publishers of decisions amongst all courts and tribunals in Australia. We published 5,860 decisions in the reporting year, which is nearly 18% higher than our target of 5,000. Also in the 2021 financial year, we received and finalised around 1,600 requests to access documents under the Freedom of Information Act, making us one of the agencies with the highest volume of FOI requests in Australia. As in previous years, most of these were requests to access personal information associated with applications for review of government decisions in the Migration and Refugee Division. Looking ahead, the Tribunal's focus will always be on providing services to people and organisations seeking independent merits review. We are aware that our important work remains a challenge in the context of the ongoing pandemic and resourcing constraints, particularly as our largest volumes of work are undertaken in Melbourne and Sydney, where the impacts of COVID-19 have been the most disruptive. In this environment, our members and staff do all they can to progress cases and support initiatives to improve the way we work over the long term. This includes our plans to design and deliver a single case management solution to address the issues we currently experience with our outdated legacy case systems. We also welcome efforts to enhance consistency and improve flexibility across our divisions through the Courts and Tribunals Legislation Amendment Bill 2021, which was introduced in Parliament in June of this year. The AAT will continue to engage with the Attorney-General's Department and other agencies to identify further opportunities for legislative harmonisation, particularly in relation to migration and refugee caseloads, where changes will support operations in our highest volume area of work and ultimately help us achieve our statutory objective. On a final note, the Tribunal acknowledges an invitation from the Senate Legal and Constitutional Affairs References Committee to contribute to its inquiry in the performance and integrity of Australia's administrative review system, and the Tribunal is intending to make a submission. Thank you, and I invite questions from the committee.
Thank you very much, Ms Leatham. Now I'm going to start by giving the call to Senator Carr, but before I do, Ms Leatham, I just want to say on behalf of all members of our committee that we were most disappointed to have received the public interest immunity claim in the form in which it was received. As has been canvassed publicly, this was rejected unanimously by the committee. And it came within nowhere near the threshold required for a PII claim. So I do trust and hope that the AAT will take that on board very seriously, and also its obligations to answer all questions from this committee during the estimates process. I will now give the call to Senator Carr.
Thank you very much, Madam Chair. I would like to ask about some matters that go to the questions that I've put to the Tribunal concerning potential contempts of the Senate. I don't say just one, but potential multiple contempts of the Senate. And for brevity, I won't identify the questions in their full description, but by a shorter version. So I'm talking specifically here about LCC BE 20126, LCC BE 20127, LCC AE 2145, LCC BE 2163. So I'll refer to them just by their last descriptive digits. So that's question number 126, 127, number 45. I would ask Ms Latham that if you could perhaps, and I will table, Madam Chair, for the officers, so they've all got copies of the relevant documents that were placed on our website last night. If I could ask the
Thank you, Senator Carr.
secretaries to provide those documents. Now, I've also just want to indicate to Ms Jones, and welcome you to the committee. I'll be writing to you seeking further information about the role of the department in these matters. And I wanted to put my concerns to you as the Secretary concerning the Tribunal's conduct in these matters. And I've provided some advice from the Senate Clerk in terms of the procedural questions that arise here. Ms Latham, I wrote to you last week concerning providing additional materials that are required for today's proceedings. Are you able to assist me with those materials? Are you able to bring those to the proceedings today?
Senator, what we did was identify several emails which we have provided, I understand, this morning, along with a couple of other documents, including the opening statement, including the unredacted email that you had requested in your most
Thank you
recent
very much.
correspondence.
I might ask if I could get those, please. Thank you very much.
Yes, we will distribute a copy to
all news
you,
to us.
Attorney, and
No, we
Ms
don't do it
Jones.
either.
So, if I might begin, though, it's you'd be familiar, Ms Latham, is that the provisions of the Senate standing orders and various privileges requirements, I trust would be well known to you, certainly be well known to you as a result of the clerk's advice that I've tendered to you, is that there's a long-standing practice that if a person who has misled the Senate must correct the record at the earliest opportunity. Are you familiar with that provision of the Senate
Yes,
standing
Senator.
orders? And it goes to the advice that we received, the following passage from the Privileges Committee. The committees must rely on the integrity of the evidence provided to them. If evidence is deceptive or misleading, the value of the inquiry process is compromised, and that giving false or misleading evidence is therefore an act which has substantial tendency to obstruct a committee in the performance of its function. Hence, our chair, for instance, read out at the beginning of the proceedings provisions that are required of witnesses before all Senate committees, and that statement is read out to all witnesses at all Senate proceedings in the estimates process. And that's taken from the Senate Privileges Committee report 162. So you would agree, when you mislead them, that it is a very serious matter to mislead a Senate committee?
Absolutely, Senator.
So even if you didn't intend to mislead a committee, it's still a very serious thing to fail to correct the record at the earliest opportunity when you become aware that information provided to a committee is misleading. Do you also accept that?
I do accept that, Senator.
So let's go to the substance of it. Do you accept that the original responses to questions number 126 and 127 that were provided to this committee back on the I think it was just in the middle of December 2020, which purported to come from the tribunal, were in fact misleading?
Senator, as I've tried to set out in my response to the committee's letter, there was, and for the purposes of full disclosure, we've attached the various different versions in the responses. There was a conversation on the 15th of December between myself and a senior advisor where we discussed amendments to the answers. I had anticipated, as had always been the process in the past, that the suggestions would be forwarded to the AAT for settling and returning through the usual channels. I take responsibility. I was on leave at the time. I was actually in the middle of moving house. I did not attend with the same diligence as I should have to making sure that absolutely everything was clear, particularly in relation to the preparation of any revised responses. When I returned from leave, Senator, I became aware that the usual processes had not occurred, and I reviewed those answers. They were consistent with the discussion that I had had with the senior advisor. I do accept that the usual processes weren't followed, and absolutely it is the case that we had not seen and returned those responses as was usually the case. But most of the content in the tabled responses was content that had been prepared by the AAT. There was an additional sentence that was added specifically about the role of the office in the liaison. And Senator, you'll understand that the question went to the liaison between the AAT, the department and the office. And in that context, there were discussions about the finalisation of the responses. As soon as I received your letter and it became clear that there was concerns about us having misled the Senate, we, with absolute transparency in mind, sought to disclose the full chronology of what had occurred and the various different versions that had been prepared. So I can only offer my apologies for my role in the confusion and the fact that there was not an adherence to the process.
So, Stephen, I'm trying to establish whether or not you regard those answers submitted to this committee in the middle of December 2020 were misleading. And I don't...
Senator, no, I don't.
You don't?
I don't believe the answers were misleading. The answers were consistent with a conversation that we'd had. I accept that we, as subsequently discussed in Senate hearings, you did not believe we'd adequately answered those questions, and we've taken steps now to provide fuller responses to those particular questions, including submitting a revised response to question 63 most recently.
Now, I want to be clear, you are of the view they were not misleading.
There was, sorry, let me just refer specifically now to 126 and 127. Sorry, I just want to make sure I've got it in front of me. Would you be able to find that for me? In the sense, Senator, that they refer to the AAT settling the responses, I accept that that was not an accurate representation in relation to those particular questions.
Okay. So, and you would also, I presume now, given that we've got the FOI material, you'd also acknowledge that a considerable amount of material that you had put into your original drafts were removed by the Attorney-General's office.
Senator, most of the revisions that occurred were initiated by the AAT following conversations with the department.
Right.
I'm not aware that any earlier versions were provided to the Attorney-General's office.
Look, we'll get to that because we've tabled the FOI documents, which suggest to me a different interpretation would be a reasonable conclusion to draw. Do you accept that on question number 45, provided to the committee on the 26th of May, was misleading?
And Senator, I believe we have written a letter of clarification in relation to that particular question, where we have acknowledged that the revised responses issue is not accurate in relation
I see.
to that particular.
And that's the letter dated the 20th of October.
There are two letters, Senator, and yes, it's the clarification of response to 45.
But it's the same date, the 20th of October.
Yes, we dispatched them at the same time.
Yes. Do you regard that as the first available opportunity to correct the record?
On answering honestly,
26th of
Senator, we had not appreciated that it would be interpreted as misleading. The answer was given honestly in the context of many, many hundreds of questions on notice and represented the process that has been followed, with the exception of these particular two, which from my perspective was a stuffer because it didn't follow the process, but there was very much a conversation where the amendments were discussed and the approach was agreed. So it was not a case of the AAT being unaware of the responses. It was a question of the usual process not being followed, whereby we settled and resubmitted the finals.
It's not just that you clarified the record, you've provided a completely new response. That's question number 63. Completely new. For the first time, you actually answered the question, providing the information that was actually requested months after I asked it in relation to 63. Do you accept, I repeat, do you accept that the tribunal did not correct the record at the earliest opportunity as required under the Senate standing orders?
Well, Senator, as I've said, as soon as we became aware that there was a concern about misleading, it had not occurred to the tribunal before that there would be a concern about that. But as soon as we became aware that was the case, we took every step to be as transparent as possible, to set out the chronology and to provide all of the information.
So when did you become aware that it would be interpreted as misleading?
When we received the letter from the Senate committee, Senator.
That's the letter that, the documents that I sent to through the committee. Is that what you're saying? In October?
Yes, that's the case. Yes.
What, your quality control mechanisms are so poor that it requires a letter from us to draw it to your attention that it's misleading?
No, well, Senator, we believed that the answer was accurate in material respects, that the responses had been discussed and agreed with the AAT.
Nice.
The area where it is not accurate was in us revising and submitting the final responses.
I see.
And Senator, the answer was also provided in relation to a whole range of questions on notice. And as I've said, it is very much the exception in this case.
Ms. Leatham, it's got nothing to do with the volume of questions. We expect every question to be accurate. And it is not
Understood.
a reasonable explanation to say we had a lot of questions to answer. That's just not satisfactory. Now, can I ask...
The only reason I raised that... Yeah, sorry, Senator, go ahead.
Yes, well, I'd ask the department, and Ms Jones, it's not reasonable of me to ask you this as the secretary that's recently been appointed, so I'll ask Mr Anderson as the deputy secretary who was on duty at the time. But if you think it's appropriate for a more senior officer to deal with it, I'll leave that in your hands. Was the department aware that the questions that have been answered by the AAT were misleading?
Ian Anderson, Deputy Secretary, Legal Services and Families Group. Senator, no, I don't think I'd accept the premise of that question. There was, certainly the department was engaged in the process, as is laid out in the questions, by which questions are eventually tabled with committees. The department was aware that there was some toing and froing around those questions, but ultimately it's a matter for the body themselves who is answering the questions to satisfy themselves as to the content which they're providing. So I don't believe that the department thought that the questions were misleading. I wasn't particularly involved with the questions going backwards and forwards. This has been set out by the registrar in the correspondence. But I think that if the department had that view, then we would have raised that view with the tribunal.
Well, I want to examine that because if we go to the detail, following the Senate estimates in October 2020, I asked the tribunal a number of questions, you recall, that's 126, 127. In those questions, I requested details of the correspondence between the Office of the then Attorney General, Mr Porter, and the Administrative Appeals Tribunal. Specifically, I wanted to know whether the former Attorney General or the former Attorney General's office had sought to influence the way in which the tribunal had answered a series of earlier questions on notice. They actually went back for a previous year, in fact, in part, about the performance of various members of the tribunal. That was the substance of the questions. And do you agree with that characterisation?
I'd have to... I haven't been checking the details of the questions, but that sounds correct, Senator.
Sorry?
That sounds correct, but I haven't checked the details of all the questions.
So a month later, the tribunal provided identical responses to 126 and 127. Those responses did not provide me with any of the information requested. Instead, provided a very high-level summary of the process by which questions are answered and taken on notice. Now, and if I might refer you to what the clerk has said about this matter, the advice is tendered in regard to the reviewing the tribunal's responses. The AAT's responses did not provide any of the details sought and made no attempt to justify withholding that information, whether on a public interest grounds or request under the relevant Senate orders or indeed any other basis. So the tribunal's responses were, according to the Senate clerk, grossly deficient and not consistent with the relevant Senate standing orders. Would you accept that characterisation?
I certainly accept that that was the view of the clerk.
Yes. And I'm wondering, Ms Latham, would you accept that characterisation by the clerk?
I've read what the clerks had to say, Senator, yes.
Thank you. And now, on some occasions, the AAT, the final two sentences of 126, 127 said this. On some occasions, the AAT receives written questions and comments, other responses from the Attorney General's Department or the Attorney General's Office, and generally sent via the department, and or may discuss a response with an officer of the department or the office. and quote, and I want to emphasise this, the AAT is responsible for finalising responses and sends any revised responses to the department. And that's the final sentence is the critical issue here. The AAT is responsible for finalising responses and sends any revised responses to the department. And so while the AAT may be responsible for finalising responses in the ordinary course may ordinarily send revised responses to the department, the AAT did not actually finalise those questions 126 and 127. And that's the case, isn't it, Ms Latham? You did not finalise those questions.
Yes, Senator, I've clarified that was the case in relation to 126 and 127.
And in that respect, that's why these questions were misleading.
There was no intention to
Answers-
mislead, Senator,
answers,
but
not
I...
questions?
Sorry?
The answers were misleading, is that what you're saying?
The answers were,
Yeah, you said-
that is the fundamental question.
Senator Carr, you just said questions, so
That
just to
is-
correct you.
The fundamental issue here is those questions were put to you on many occasions, but your answers were fundamentally misleading in that regard.
Well, Senator, I don't accept that because the responses were provided in the context of, it was asked about a whole range of questions on notice. As I've already conceded, in relation to 126 and 127, we did not submit and finalise those final responses. Yes, I accept that was not an accurate reflection of the process in relation to those two questions.
I'm sorry, I'm having a bit of trouble following this. If it's not an accurate reflection of the process, why is it then not misleading?
Senator, I think we've accepted in our letter to you that there was a need to clarify. I've apologised for the fact that there was no intention to mislead. I accept that it was not accurate in relation to those two questions, but it does reflect accurately the vast majority of the questions that we have responded to. I'm not sure what more I can say except that I understand and we've clarified now that evidence.
But the problem is this. It's not the vast majority of cases that we expect accuracy. We expect accuracy on all occasions.
Understood, Senator.
That's not an explanation that is satisfactory, and I would defy any committee in this parliament to accept that as an adequate explanation. You set out on your letter on the 20th of October, the tribunal actually provided the department with lengthy and very different responses to questions 126 and 127. Mr Anderson, that's correct, isn't it?
Yes, Senator.
I believe that's correct.
Yes, and we
ask Mr
provided
Anderson
that-
this question, but that answer is, that part of the question is actually accurate.
I believe that's correct, Senator.
And the original responses were changed substantially and finalised by the former Attorney General's office. That is also correct, is it not?
I'm not sure about that, Senator. I'd actually pass that question to one
Well,
of my
the documents have
colleagues.
been tabled there, and that's what the FOI record shows.
Senator, as I indicated before, I
A person
wasn't...
by the name of Michelle comes to mind in these circumstances. That's what the record shows.
Senator Carr, could I just confirm, are these the documents
Yes,
that
yes,
have just
Attorney.
been provided? Thank you.
Senator Carr, this might be an appropriate point in time to just...
Well, the department might want to have a look at the documents.
Yes. So,
refresh
Senator Carr,
their memories.
I'll be running today's hearings in 10-minute blocks. Now, in your case, given the volume of material in relation to the AT, we've just done about 20 minutes. What I'd like to do is move briefly to Senator Scarr, who's got a couple of questions in relation to matters you've raised, and then I will come back to you if you're happy with that.
Of course, that's fine.
All right. So I will now give the call to Senator Scarr.
Thank you. Registrar, I've read the letter dated 20 October 2021 from you, and I've noted your comments to questions from, or answers to questions from Senator Carr, that you became aware when you returned from annual leave on 18 January 2021 that the usual process from your perspective had not been followed. Is that correct? That's when you first became aware, 18 January 2021?
That's correct, Senator.
Right. And can I say I acknowledge you've taken responsibility for that, and that's quite correct thing to do and is admirable in terms of taking responsibility. In terms of that usual process not being followed, in terms of processes such as this, isn't best practice to have a process in place such that it isn't dependent upon a key person being on leave or not being on leave? Everyone takes leave, but you need to have a process in place to make sure from a quality assurance and quality control point of view that things don't slip between the cracks. Is that a fair comment?
Absolutely, Senator. And in fact, I had anticipated that the usual process would follow, whereby there would be that opportunity for the quality control. So absolutely accept that that failed in this instance.
All right. So you've accepted that. It seems to me, though, on and from that date when you returned from annual leave on 18 January 2021, weren't you put on heightened notice that because the usual process wasn't followed in that case, you had to be particularly careful with respect to answering any questions that dealt with those matters because the usual process had not been followed? Is that a fair comment, that you really should have been put on heightened notice?
With the benefit of hindsight, Senator, yes. I have to say that it wasn't perhaps as significant and in the context of all of the questions on notice that we had responded to. I completely accept now that there's a particular issue now in relation to these questions and should have been much more mindful about the responses in relation to that. So again, I can only apologise and acknowledge that that should have been, I should have been on heightened alert.
Right. So it's really, you accept it's not good enough to say that there were a great number of questions that were asked, and Senator Carr has every right, as every senator has, to ask questions, and we have every right
Absolutely.
to expect. And we have every right to expect accurate answers to each question. So you accept the proposition that it's really not satisfactory to say the whole range of questions, you're simply using a form of language that you're using on other questions for these questions, and on this occasion, because of the particular issue that had occurred, the answer was not correct. You accept that's a breakdown in good practice?
I absolutely accept that, Senator.
Okay. Did you give any thought after 18 January 2021, as this matter progressed, as to how you could ensure that this breakdown in process was brought to the attention of this committee at an appropriate time, at the earliest possible time?
What we had done was have conversations with the department to make sure that the process was adhered to at all times in the future.
Miss Lathleen, I'm going to interrupt you here. There was a very specific question about your obligations to this committee.
Yes.
Could you please address
Yes.
the senator's question?
Okay. Senator, as I've tried to indicate, if I had anticipated or appreciated the significance of the fact that the answer might be misleading in respect of those two questions, I would have taken immediate steps to address it. I can only say, with the benefit of hindsight now, it's very apparent that we should have paid more attention to correcting the record. But as I said, we didn't appreciate the context until we received that letter. I've tried to be as absolutely transparent about the process, the chronology, and what led up to those answers. But again, I can only apologise that we should have taken that to the committee at an earlier point.
Okay. Chair, I've got some questions in relation to an article that appeared in the Brisbane Times on 25 October 2021, and I'm happy to table that article. Registrar, do you have a copy of that article? You're in Brisbane. This is the Brisbane Times, very esteemed publication. I'm sure you read it every day like I do. It's an article dated 25 October 2021 at 11:05 a.m. Government tribunal paid some members in years they did no work.
Yes, I am familiar with that one, Senator.
Okay.
So you're happy to take questions without having the article in front of
No,
you?
she's got it.
Oh, you've got the article?
Yep. Okay.
Okay, thank you.
I've formally tabled a copy of the article.
Thank you, Senator.
Now, Registrar, I'm going to walk through this because I think it's important to get some of these points on the record. In particular,
Yes.
because some people were referred to in this article and they don't have the benefit that we have of actually putting information formally on the Hansard record. So that's the purpose of me engaging in this in this process. So I'm going to refer firstly to Dr. Nicoletti, and I'm quoting from the article here for the purposes of Hansard. Dr. Nicoletti said she had not received any payment in the past 2 financial years. She was appointed to the tribunal in 2006, but with the growing demands of running her legal practice, sought not to be reappointed in 2017. However, the AAT's president persuaded her to stay on, she said, because the tribunal didn't have other specialists in pharmaceutical patents. Since then, very few pharmaceutical cases have come up, and Dr. Nicoletti doesn't intend to seek reappointment when her term ends in 2022. She noted tribunal work could often be time-consuming because the AAT required members to take on cases outside their area of expertise. Historically, I've done a lot of social security cases and also tax law cases, customs cases, where you are required to get across another area of law in order to be able to make a determination, she said. End quote from the article. Registrar, reading that article and seeing that the AAT currently has the services of a specialist in something as obscure as pharmaceutical patents, it troubles me that we're now in a situation that because Dr. Nicoletti says she's busy in her practice and she's been allocated cases across social security, tax law, customs cases, that we could lose the benefit, the AAT could lose the benefit of Dr. Nicoletti's expertise. Does that go to the process of allocation of cases? Is there an issue with allocation of cases if the AAT could lose the benefit of someone who's a specialist in a specific area of law with respect to something as obscure as pharmaceutical patents, and she is potentially, well, she says she's not going to seek reappointment because she's been allocated cases outside her area of practice? Is there an issue with there? Do you identify an issue there in terms of process of allocation of cases?
Senator, we do have a number of very specialised members, and the reality is that we may sometimes only get 1 or 2, sometimes no cases in a particular year, depending on the type of review it is. There is obviously real benefit in having some of those specialised members available to particularly participate on a panel in relation to hearings in those areas. I can't comment on the specific allocations to Dr. Nicoletti, but it certainly is the case that having them as part-time members can be valuable because they can continue to participate in other employment, providing it doesn't conflict with their duties on the tribunal. And so it's not unusual for us to have very specialised members available to do work from time to time rather than regularly undertaking reviews.
Well, you say you can't comment on the particular case allocations to Dr. Nicoletti. I put it to you, because Dr. Nicoletti is a specialist with respect to pharmaceutical patents, shouldn't you be aware that she's being allocated cases outside of her particular specialty, and as a result of that, she's actually potentially not seeking reappointment because she is being allocated cases outside of her particular area of specialty? Isn't that something you should be aware of as registrar?
Well, Senator, I'm not involved in the allocations. There are division heads who assist the President in the running of the business of the division, including constitutions or the allocations of work to particular members. So I would need to take on notice if there are particular questions about the allocations in that division. I would be happy to get that information, but as registrar, I'm not involved in the allocation of matters to members.
Okay, I'll move on to...
Ms. Leslie, can I just by way of clarification, your role is the administrative head of the AAT, is that correct? I assist the President with the administrative affairs of the tribunal. The President is the head of the tribunal and he's assisted by a number of deputy presidents who are division heads, and they are responsible for the review function or the running of the review functions, including the members in the tribunal. So just to clarify, while you're not specifically responsible for case allocation, isn't it of concern to you as the administrative head assisting the President if there is improper case allocation occurring at the AAT?
Absolutely, it would be of concern. I'm not aware that there's been any improper allocation of cases. Generally speaking, what happens is each of the division heads will identify the particular members that are eligible to sit on cases.
Yes, Ms Lethlean,
I mean-
you say you're not aware, but we've just got a very prominent article which details one member's concerns about improper case allocation. So how can you say you're not aware?
Well, my understanding is Dr Nicoletti hasn't actually undertaken any work since the 17-18 year, so I'm not sure what she's referring to when she talks about previous allocations that she's undertaken.
Well, she said the
I'd
word
need to-
historically, as Senator Scarr has referred to. Historically, I have done a lot of social security cases and also tax law cases, which are outside her area of expertise. This is reported in the newspaper. And Ms Lethlean, you say you're not aware of any issues with case allocation. That just doesn't stack up.
My understanding is that she hasn't done any Centrelink work at all since 16-17. So there would have been a process whereby members doing work in those particular areas would be inducted and assigned to do work. So we don't get members to do work unless they've been inducted and trained in particular areas. So I would need to make further inquiries to find out what work she did undertake. But my understanding is that she was doing specialised work, and I would need to make inquiries about her comments around Centrelink cases, but it would be going back many years, I understand, Senator.
Okay. Chair, with your indulgence, I'd like to move to a second person who's referred to in this article.
I'm just conscious of we've just exceeded your 10-minute block. Would you? You're quite happy for Senator Scarr to? Yes. All right, Senator Scarr, if you finish this line of questions, thank you.
All right, I'm going to refer to another quote from the article, Registrar. Quote, although Mr Tragard, that's Tragardh, is named in the documents the AAT gave Parliament, he said he was never sworn in as a member, having declined the appointment due to ill health. End quote. Registrar, how do you explain the fact that the AAT, in terms of answers to questions on notice, has referred to someone as being a member of the AAT when they never actually became a member of the AAT?
And also, I might add, sorry, Ms Lethlean, under circumstances where there was a very negative reflection on Mr Tragard, which is a reputational issue for this particular person. So I too am very, very concerned to read this fact in this newspaper report.
Yes. Senator, I can report that he was appointed, but my understanding is he didn't ever get sworn in as a member, and he wasn't inducted, and he's never received any payment or undertaken work for the tribunal. The explanation I can offer is that when we were preparing the material, he's obviously in our database, having been appointed as a member, and so has been captured through the collection of that data and that information. But I can confirm that he wasn't sworn in and he hasn't undertaken work or been paid.
Well, again, Registrar, doesn't that go to quality assurance and quality control? In terms of this committee having confidence in terms of the answers which are given to questions on notice, you've referred to this gentleman who was never sworn in due to ill health, and you've referred to this gentleman in terms of your answers to questions on notice. Do you appreciate how that undermines confidence of this committee in terms of the quality of the answers to questions on notice?
Well, Senator, the questions actually just required us to run a whole lot of data. He was a member. He didn't resign until the 5th of April. And so that meant he was captured when we did the searches for the information. I accept what you're saying, and we did our very best in the time available to be able to answer the questions accurately. But I will say we did qualify the answers by the fact that we hadn't had an opportunity to properly verify all the information in the time available.
How does he become a member if he was never sworn in?
The appointment is still valid. So once you are appointed, we receive the instruments of appointment, and that effectively brings them in, if you like, to our system. But they cannot be allocated work until they're sworn in and or inducted, and that didn't occur in relation to this member.
I'm sorry, Ms Lethlean, bringing someone into the system is a very different proposition to swearing in a member. And just
Absolutely.
Just remember what's happened here. You have presented our committee with factual information that this is a member in a manner which really reflects on his reputation. This is a member who did no work. I mean, this is a barrister who declined the appointment. And you have reflected, as the AAT has reflected on him. So what is going on with your systems? I mean, this
Well,
is
Senator,
excuse me. This is a very, very serious oversight, a massive administrative oversight by the AAT. Surely.
Well, Senator, my understanding is the answer only indicated that he had undertaken no work for the tribunal.
Look, you're just being
I don't
sorry.
believe
With
it's-
respect, I'd say you were just being argumentative here, Ms. Lethlean. Can you not accept that if a member is not sworn in, not capable of hearing cases, he declined the appointment, that the AAT, this is a shocking administrative oversight by the AAT. Do you agree with that?
I apologise, Senator. We'll have to obviously review our processes to make sure that for any member, it's an unusual situation, but I understand what you're saying. We will make sure that we attend to that and there is no capturing of any members unless they have been sworn in and that they take up their membership, if you like. I accept that.
So, Registrar, why is it that I have to find out about this as a member of this committee from an article in the Brisbane Times as opposed to answers that this committee has put on questions on notice? Is there anything else I'm going to find in the media that I'm not going to find in the answers to questions on notice?
I suspect there is.
Senator, as I said, I apologise, but the answer simply indicated that he was a member. Sorry, he was effectively a member, as in he had a valid instrument of appointment between the 23rd of November 2018 and the 5th of April 2021 when he formally resigned. So, notwithstanding, I've accepted that he wasn't sworn in and wasn't doing work. That is the reason why it was captured in the information that was provided.
Ms. Lethlean, I would ask you to seriously reconsider your answer then. You've just given evidence to our committee that he was effectively a member. Now, yes, he was appointed. So that is, I put to you, Ms. Lethlean, that is not accurate. He was not effectively a member if he was not sworn in to
Did nothing.
to hear cases as a member of the tribunal. Being appointed.
Well, let me
is a different matter.
That. Sorry. Yes, I accept that, Senator. I'm sorry. I should have said he had an instrument of appointment, but I fully accept what you say. We need to ensure that if somebody doesn't get sworn in and take up their appointment, that they are not recorded on our system.
Just one final question, Chair, and thank you for
I think
for
Mr.
your
Anderson wants
indulgence.
to. Mr. Anderson, do you want to add to that answer?
I did, just to point out that under the AAT Act, members are appointed by the Governor-General. So it would be possible for a member to be appointed by the Governor-General but not to be subsequently sworn in. So under the legislation, they are in fact a member, even if by virtue of not subsequently being sworn in and inducted, they're not able to carry out the duties of a member.
Well, Mr. Anderson, can I ask you, that's a very technical interpretation, and I trust your legal judgment, having seen you appear before this committee. Having said that, in that situation, don't you think it's even more important that when you provide an answer to a question on notice, you make sure you provide the full context with respect to a particular individual, so that all the information, including all of the context in relation to that peculiar situation, is conveyed to this committee? Isn't it important to do that?
I absolutely agree, Senator, that witnesses have a duty to provide evidence that's as clear as possible to the committee, so there's no question of that evidence being misunderstood.
And Mr. Anderson, particularly under circumstances where the AAT has reflected very poorly on Mr. Traggard, basically saying, here we are, we've got a member who's done no work. Now, if there is a technical appointment, that's a very, very different matter to be sworn in and be ready and willing to work. So I would put to you that the AAT, in its responses, has been totally deficient.
I don't think it's appropriate for me to comment on the AAT's responses. I haven't seen that particular one. I don't think that's one of the ones that's been put in front of us. I just wanted to make clear from listening to the questions.
Thank you. Yes, I
that
understand.
It
Thank
is
you.
possible
Thank
to
you.
be a member but not to be able to operate as a
Yes,
member.
thank you very much.
Registrar, my final question, and I started these questions saying that I'm raising these issues because I wanted to make sure that the people referred to this in this news article had the opportunity to have the full circumstances of their situation on the record, right? So that's my intention in raising this matter. I do not know Mr Traggard. I've never met the individual, but I was mortified when I read this article. So can I finally ask you this? Has anyone from the AAT reached out to Mr Traggard and apologised that he's had to have his name in the media and has had to clarify to the media his position because of the way his involvement with the AAT had been represented in terms of the answers to questions on notice? Has the AAT reached out to Mr Traggard and say, Mr Traggard, we apologise for this confusion, we've learned from this situation, we take responsibility for it and we'll make sure this doesn't happen to anyone else again? Has anyone done that, Registrar?
I don't believe so, Senator. I take your point. Can I say that we did notify all of the members who were the subject of the questions on notice to let them know that the material was being provided. We did also take care to provide some contextual information to explain reasons why there might be a number of members who didn't undertake any work. And so it was intended that it would actually explain why there were a number of members who, through no fault of theirs, may not have undertaken any work in particular. Can I say as well that I accept what you're saying about reaching out to the members. We do try whenever there is any media attention to make contact with each of the members in that instance. So while I can't say with certainty that it's occurred in relation to this particular matter, I will undertake that we will do that.
I think that would be appropriate.
Ms Lethlean, can I also ask that in relation to any other part-time members, under circumstances where the AAT has improperly reflected on them by suggesting that they've done no work when in fact they may not have been available or they may not have been called upon, could you also please review all of these reflections on part-time members? And it may well be necessary to make the committee aware of other instances where you have not provided us with all relevant information. And it may also be necessary, apart from apologising to Mr Traggard, because there's a gross impact on his reputation, can I also please ask that you do so in relation to the way in which you've reflected on all part-time members and report back to the committee on that as well. On that note, I'm now going to give the call back to Senator Carr.
Thank you. Time is pressing, so I would like to just indicate that I am particularly concerned and remain concerned about the contrast between what has been said to this committee through the AAT and your response, Madam Registrar, and the FOI documents, which to me show that there is a substantial gap between the explanations given and the actual activities that are undertaken. And I'm particularly, well, I also believe that the department needs to examine what's occurred here. Mr Anderson, I would have thought it would be appropriate when you saw those FOI registrars that there were matters that required further inquiry. Did you undertake any inquiry into that matter?
I didn't personally, Senator,
No,
but Mr Gifford.
I would speak of the department.
So Mr Gifford can say more about these matters.
We have Mr Gifford.
Mr Gifford.
Morning, Senator Carr. Cameron Gifford, Chief Operating Officer for the Attorney General's Department. So yes, if I can maybe start by explaining the usual process and then the process that applied to these particular questions on notice 126 and
So, Mr.
127.
Mr Gifford, when you discovered that these questions were not accurate, were misleading, what action did you take?
So Senator Carr, as I say, if I could start by describing the general process and then what's happened with 126 and 127, because
I'm not interested in a long discussion on the general process. I'd like an answer to the specific question I've asked you. When did you discover these questions were not accurate? and were misleading, and what action did you take?
Senator, I would not agree with your premise that they're misleading or inaccurate. In answering your question, please let me just describe the general process and then the departure that occurred in relation to 126 and 127, because that will answer your question about what inquiries we have made internally about what had happened for these particular questions on notice. So as a general premise, we received questions on notice drafted by the agencies. They were received in our Senate estimates team, who do an initial check to ensure that it accords to the usual process. They're within the general templates, that the answers are relevant to the question, and we provide them on to the Attorney General's Office for review. In some instances, the Attorney General's Office has comments, questions or queries, and they will usually come back through my Senate Estimates team, or if not the Senate Estimates team, the relevant policy team, and there may be discussions with an agency about the nature of the response that's to be provided. Ms Leatham has mentioned in her response to your letter and to the correspondence from the Clerk of the Senate, in this particular instance, the final step whereby we would normally provide the final version of a response before it is tabled to an agency for their confirmation did not occur. It did not occur in this instance because we were relying upon notes made within our parliamentary document management system, recorded from a senior advisor of the former Attorney's Office, that the substance of those two queries had been agreed by the Registrar of the AAT. And on that we relied and then organised for the tabling of those two documents. As I think Ms Leatham's evidence points to, it was not until she returned from leave that she became aware that the usual process whereby we would give her, the AAT, the opportunity to review the final document before tabling did not occur. But also I understand Ms Leatham's evidence is that on reviewing those two final versions of the documents that were tabled, it accorded with her conversation with the relevant senior advisor, and she was comfortable that that was the evidence of the AAT.
However, the letter that's provided to this committee on the 20th of October 2021 indicates that that's not an adequate response.
Certainly, Senator, we would accept that we have had an oversight in terms of the final step for that process for those two questions on notice. For us, we have found this quite an exercise to confirm the usual processes. In this instance, haste was the enemy of good process. For us, the two questions on notice were part of 156 questions on notice that we were tabling on that particular day. We made an error by relying on the note within our parliamentary document management system without confirming that with the AAT, and we have taken this as an opportunity to make sure that we reconfirm those processes within our relevant team.
So it remains the fact that the information provided to this committee was wrong, inaccurate, I say misleading.
You do say that it is misleading, Senator. Again, I would say that the evidence of the AAT is that they had reviewed the evidence as it was tabled.
Okay.
It conforms with the conversation they had.
Well, we'll pursue this in another forum because obviously there's not sufficient time here today. But I'd ask the current Attorney General, because clearly this is not your direct responsibility, and I acknowledge that. It was Mr Porter. And he's in the FOI documents, the person is identified that was dealing with this. I'd like either you or your Assistant Attorney General, I'd ask, are you prepared to investigate this matter? Or do I have to just rely on the Senate privileges processes?
Well, Senator Carr, that is obviously a decision for yourself.
Yes.
I will review the evidence that has now been given today.
Can I turn then to matters that the report that the annual report was tabled earlier in the week. There have been, and the Registrar referred to this in her opening remarks, you're saying to us there that you've received over 54,000 applications and finalised 51,600 and 72,000 applications on hand at the 30th of June 2020. So the tribunal has received more applications than it's managed to finalise. That still remains the case, doesn't it?
Senator, for the last financial year, we actually were able to exceed the clearance ratio of 100%. So it was the first occasion since amalgamation where we managed to finalise more applications than we receive.
However, we look at this in specific terms. We look at the Migration Refugee Division, who experienced a 50% drop in applications. That's correct, isn't it?
So there was a decline in applications in that division, more particularly in the migration rather than the refugee area.
Yeah. It finalised, you had 52 finalisations, 2021, but it finalised about 45,000 applications. So it fell short of your own targets in that regard?
Yes, I believe that we had expected to finalise more matters. We were impacted to some extent by the pandemic and the ability not to conduct in-person hearings that we would otherwise be able to.
If we go to the Veteran Appeals Division, there's 48% of applications being finalised within 12 months of lodgement. That's correct, isn't it?
Yes, that's correct, Senator.
So if a veteran's denied a veteran's entitlement by the government and wants to appeal the decision, he or she will have to wait more than 12 months to get a decision made. Is that correct?
Senator, the pathway for Veterans Appeals matters has, for a long time, been a type of application review that often takes several conferences. There's often further evidence that needs to be gathered during the course of that. So the timeframes in relation to the finalisation of veterans matters are not because of the unavailability of members, for example. We try and progress those as quickly as possible, but it's often the case that the parties are still in the process of preparing their hearing, and there may be several conferences or directions hearings held before the substantive hearing is conducted. And
Sorry, go on. I apologise to interrupt.
I was also, sorry, I was just going to say too, Senator, there's also a significant number of those that end up being resolved through agreement between the agency and the applicant. And so there's an opportunity through our process for alternative dispute resolution to occur as well.
So if we take another area, we've got disabilities, the medium waiting time there, what is 19 weeks? Is that correct?
Senator, I might just invite the National Director Tribunal Services to look at the caseload statistics in more detail if that's you're interested.
Jamie Crew, National Director, Tribunal Services. Senator, in 2021, the median time to finalise in the National Disability Insurance Scheme was 23 weeks. That's up from 1920 at 18 weeks.
I see. Why is that?
There is a significant increase in workload in that division, Senator. The workload in that division from 1920 to 2021 increased 21%.
So workload case problem, is it?
Yes, Senator. It's an increase in workload.
All right. And so if we go to age pensions, what have we got, 2 months? Is that the case? 2 month delay?
Just 1 moment, Senator. For age pension, Senator, I just don't seem to be able to put my hand on that number.
Well,
We'll have somebody find that for you,
find that.
Senator, and
I'll
we'll.
come back to that, Senator, if that's okay.
so we go through a whole series of others. The Migration Refugee Division, the wait now is 2 years. A year in the Freedom of Information Division. Small Business Taxation Division, we have to, half a year for the matter to be resolved. That's correct, isn't it?
Migration and Refugee Division, 108 weeks
Yeah.
to 30 September this year and 99 weeks at 2021.
So tens of thousands of Australians, the waiting times have actually not decreased. That's the situation, isn't it?
Different times in different divisions, Senator.
But it's equally, what I say is accurate though, isn't it? For hundreds of thousands of Australians, waiting times have actually increased.
Senator, with the exception of the Migration and Refugee Division, which absolutely has a significant backlog, and there are delays that we are working our very best to avoid, most of the other work that we undertake in the tribunal is dealt with as it comes in effectively. So it will be allocated to either a conference registrar or an early case assessment registrar, and it will then proceed on a pathway to resolution.
Right.
So there isn't, it is the case, however, that there are some caseloads that do take significantly longer to proceed to a substantive hearing and finalisation. But I just wanted to be clear, it's not necessarily waiting times, it's the length of time it takes for
Sure.
the matters to
I
complete.
understand that. But you see, with the question of performance is important. So we've got
Absolutely.
Member Keith Kendall has what your records indicate, they paid $66,799 from the date of his appointment on the 25th of February 2019 through to the 30th of June 2019, so over 4 months, and he did not finalise one single case. That's correct, isn't it?
Senator, we've prepared some information about the various different members that you were interested in discussing. So I'll
Yes.
just ask Mr Crew to provide what he can.
So, Senator, Mr Kendall was appointed on the 25th of February 2019 and was inducted on the 25th of March 2019. During that period, Mr Kendall did not finalise any work.
That's right. So if we put it in context, the average full-time member finalised 187 cases and in that period, 18-19. That's about 15 per month. Now, according to the Tribunal's response on notice, that's number 78, Mr Kendall's benchmark over there had 41 case days and he completed no cases. We've confirmed that. I'm just wondering,
That's correct.
so what was he paid the money for?
So he would have started induction, Senator, and he would have been allocated cases towards the end of the financial year.
Yeah.
And it is likely that matters would have finalised in the next financial year, that he'd been handed towards the end of that financial year.
All right, what about Peter Ranson? Paid $68,452 on the day of the appointment, 25th of February 19 through to 30th of June 2019. Again, the 4-month period. Did not finalise a single case.
So, Senator, Member Ranson again was appointed on the 25th of February 2019 and was inducted on the 25th of March 2019. Member Ranson is an accountant who co-sits with a number of other members, and there are some matters where he sat, but as a co-sitter in the system doesn't get allocated those cases. So again, same rationale that he would have started cases and been sitting on cases at the end of the financial year that didn't finalise that financial year, but also the fact that he used his specialist expertise to co-sit on a number of cases.
I see. So let's look at another one, Mr Lambie, Mr James Lambie. That's George Brandis's former Chief of Staff, isn't it? I've got the right.
Senator,
I've got the right person.
I'm not sure, Senator, that question.
I believe it is.
I believe so.
Thank you. So he met 65% of the benchmark in 2018-19, 45% of benchmark in 2019, 2021, despite being paid $320,000 for the year. That's correct, isn't it?
Which year, Senator, sorry?
For the year, do you want me to repeat those figures? 40. So he
Thank you.
45% of benchmarks in 2020, 2021 was paid $320,000. Is that correct?
My understanding the remuneration for 2021 is $329,356.
Sorry, I've undersold him. My apologies. Well, we'll fix that. So, did the President of the Tribunal ever raise concerns about Mr Lambie's performance with Mr Lambie or with the Attorney-General?
I'm not aware, Senator.
Would you take that on notice, please, if you're not aware?
Yes, we can take that on notice.
Yes. And Mr Ransom, was there any questions raised about his performance?
No, in fact, Mr Ransom's benchmarks, he works across a number of divisions. So he doesn't just work in the Migration and Refugee Division.
Right.
And in fact, in 2021 exceeded his benchmarks for the MRD, but also did work across the General Division and Social Security's, the CSD Division.
So he was applauded, was he, for increasing his workload?
My understanding, his numbers say that he's been meeting his benchmarks.
Righto. So what about Mr Ian Berry? 74% of benchmarks in 2018-19. 42% of his benchmarks in 2021. He was being paid $221,000 per year. Is that correct?
$221,472, Senator. That's correct.
So his performance didn't improve, did it? It went backwards.
He certainly finalised less matters, Senator.
Yes, that's right. So why? Well, I mean, I'll just make sure I got the right person here. This Mr Berry is a former member of the Queensland Parliament, LNP member of the Queensland Parliament. He's the one, I'm not from Queensland, he's Lord Lamington, isn't he? Senator Scarr, isn't he?
Well,
he was referred to as Lord Lamington.
He was in fact president of the Queensland Law Society.
Oh, right. He's probably well qualified then. He maybe he's well qualified, but his performance went backwards. And I was just wondering, did the President of the Tribunal raise any concerns about Mr Berry's performance?
I'm unaware, Senator. We'll take that on notice.
Thank you. What about the
Senator Carr, can I just perhaps, if you could just give me a little bit of leeway to just interject at this point. You're raising very important questions about performance of members, no question at all. But I just wanted to seek, by way of clarification, the benchmarking issues in relation to performance, because what is concerning to me is whether the benchmarking captures whether a member is dealing with a particularly complex case, which may take a lot more time, and that is not being reflected in the number of cases finalised. So, as I say, Senator Carr, have no issue with obviously holding all members to account for performance, but
very good.
I do want to just ask the registrar.
Well, perhaps you should take up a block later on and you could go for your life on that. But I'd just like to finish this series of questions if I could.
All right, if I could just quickly, I agree with you, we can do that, but just quickly clarify, Registrar, does the benchmarking capture the complexity of cases? So if a case was to run for 30 or 60 days, is that factored into your benchmarking?
The benchmarking is based upon an indicative timeframe, if you like, Senator, for particular types of cases. So it does try and address complex or more complex matters, but of course you're absolutely right that there can be cases that are different or unique or particularly complex. in which case the benchmarking may need to be adjusted to be able to address that.
Okay, so but the fact of the matter is the benchmarking does not reflect the actual complexity of cases overseen by a member in a particular financial year. That's correct? You're just using a deeming. You're using a deeming basis for complexity of cases. You're not actually capturing the actual complexity of cases overseen by that member in a particular year.
If I could clarify, Senator, the benchmarking only applies to the Migration and Refugee Division, and that's been a system which has been developed by the division head in consultation with her senior members and members.
Sorry, and I do want to go back to Senator Carr. Could I just ask you to answer my question? So your benchmarking does not actually capture the actual cases and the complexity of actual cases.
It has different categories depending on the complexity, but those are bandwidths, so they're not going to capture every variation, if you like. They are indicative timeframes.
So they don't capture the actual cases heard by the member.
I think she's
The
answered that
benchmark,
question.
Senator, is a planning tool.
Yeah.
The benchmark
Yeah, no, I
is a
understand
planning
that. I
tool
just
for
want a yes or
allocation
no,
of
please.
cases.
Well, you won't get a yes or no because the answer doesn't require a yes or no.
Well,
It's a
Senator
different
Carr,
question.
if you could just, I just want to clarify. So it doesn't capture the actual cases, is that correct?
They divide the benchmarks into different categories of cases depending on the caseload. So, for example, a student visa matter will be assigned a particular benchmark value, whereas a complex protection matter will be assigned a different benchmark value. And then depending on what the caseload the particular member undertakes, the benchmark will be made up of those various different components.
Oh, look, I'll return to this more later, but I will hand over to Senator Carr. Thanks,
Thank
Senator
you.
Carr.
I just would like to deal with another matter. That's a campaign director, Mr. Porter's. I'm wondering if you could tell me if Mr. Francis, Mr. Joseph Francis, who's a former member of the West Australian Parliament, met 65% of his benchmarks in 2021. He took home 249,000, is that correct?
255,384.
Oh dear, look, I keep underestimating these fellas. I do apologise. So we'll have to read this more carefully. I know. So he managed to finalise 2 cases. They must have been incredibly complex. 2 cases. That's in 4 months. That's correct.
In 1819, Senator.
Yeah. That's right. 2 cases?
That's correct.
Yeah.
Yes.
So he sat across a number of divisions that included social services and child support in that division, older Australians and various others. They had, this is the one that's actually where they're waiting some months. I see they've received a basic, this is where people are receiving a pension of, what, $882 a fortnight. And Mr. Porter's campaign manager is getting $10,000 a fortnight. That's also correct, isn't it?
Senator Carr, could I ask you just to refer to members in an appropriate way, please, not in the way you have done so.
Well, but Mr.
Well, I should.
All right.
Please be
Mr. Joseph Francis.
Thank you. Please be respectful to the members, not to refer to them in that sort of slightly denigrating way.
So we got the former Liberal MP for Macarthur, Mr. Russell Matheson, paid $249,000, met 56% of his benchmark. That's correct. That's 2021. That's correct.
So 2021, Senator, 253,885 is the payment. 56 of the benchmark is correct.
Mm-hmm. And so,
Senator, could I just clarify in relation to Member Francis? He finalised 4 matters, but 2 were substantive matters.
I see. Okay. Well, we want to make sure we get that right. And did the President raise any concerns about performance in regard to either of those gentlemen?
I'm unaware. You take that on notice.
Okay. And then there's the question of the Deputy President, John Pascoe. one application finalised. He was appointed February 2019. He's on, what, $500,000 per year? That's correct, isn't it?
So 2021, 495,454. Deputy President Pascoe was appointed on the 25th of February 2019 and was inducted 25 March 2019.
Is it correct? One case?
So one case finalised in 18-19, again starting at the end of the financial year, Senator.
Any issues raised about performance there by the President?
Again, Senator, he increased the number of cases finalised the following years, so I'm unaware if there are any conversations, given it was that first year, towards the end of the financial year.
So I can go through Mr Shane Evans.
Just Senator Carr, just in relation to Mr John Pascoe, I am concerned about the reflection on members under circumstances where the reporting in a particular financial year reflects only a very limited period of time. So Mr Pascoe was sworn in March, inducted in March of that year, in March of 2019, and apart from his case responsibilities, there were also other responsibilities, I understand, as Deputy President. Is that correct?
There are usually, Senator, I'm unaware of what exactly it was at that time, but there are usually other responsibilities. There were a number of matters that were being managed by Deputy President Pascoe, given that there were a number of directions hearings undertaken. So it's not just...
So the case, just to be very clear, the case finalisation does not reflect the hard-working nature of any particular member, does not reflect their workload, does not reflect other duties that they might be taking on and other contributions that they might be making.
Finalisations is just one indicator.
Is just one indicator, okay. Because that's what is concerning. I mean, Senator Carr, and it's a bit free-flowing, I realise at the moment, but Mr Pascoe is a very esteemed former family court judge. So, and all of the members come to the AAT with a great reputation and in a whole variety of different fields. And when we're looking at workload and performance, it does concern me that the way in which the AAT is reporting on members' performance does not in fact reflect the contribution that they are making as members. And the finalisation of cases is only one indicator. So I just want to really make that point very, very clearly.
Thank you very much.
That there should not be any reflection on any member, because a finalisation of a case does not reflect the extent of work by any particular member. It's only one part of their work.
Look,
Thanks,
Senator, you're
Carr.
absolutely right. We had tried to provide that context in our answers to show that there are a whole range of indicia and that finalisations in and of themselves don't count a range of other work that members do undertake.
Or that one finalisation doesn't equal one finalisation.
Okay, well, I'm not quite sure about that, but we'll return to that soon.
so we'll obviously need to deal with this a lot more detail in further inquiries. It's just that, and the fact that there are so many of these Liberal appointments, Liberal Party personnel, is not in itself a disqualification. It's just that I am interested in their performance and whether or not there is appropriate accountability on these questions. Now, can I turn to Mr John Griffiths? Is he still a member of the Administrative Appeals Tribunal?
As I understand it, Senator John Griffin.
Sorry,
Griffin.
Griffin. Yes, my apologies. Griffin.
Yes.
Is he a member?
Yes, he is, Senator.
Is he a lobbyist at Barton Deakin?
Senator, we became aware that John Griffin was listed on the Register of Lobbyists following a media inquiry that was directed to the Tribunal on the 11th of October of this year.
And where was that media inquiry from?
I believe, Senator, that it was, I'll just get the article handed to me if I could.
Senator Carr will need to go.
I'm
Senator Scarr, sure.
yeah, sure. Sorry, did one have on the same issue? Yeah, sure.
Yeah. Just if you want to just wrap up this.
Yeah, I just want to finish this section if I
Okay.
could on Mr. Griffin, because it goes to...
So just, Senator Carr, you'll just finish up this little block of questions and then
Yeah.
we'll move to Senator Scarr.
Yeah, sorry, so this is newspaper,
Yes, it was in the Australian Financial Review, I believe, Senator, on the
Righto.
11th of October.
okay, 11th of October, AFR, righto. Now, I understand that Mr. Griffin was appointed by Mr. Porter about 2 years ago.
I believe that's the case, yes.
And Barton Deacon's website boasts that he's one of the most experienced government relations and political strategy advisors, and he continues to assist Liberal and National parties on state and federal election campaigns as a senior political strategist and campaign advisor. Now, if he's been on the lobbyist register, presumably from that length of time, Minister, I'd ask of you, do you think there is a question here about, well, has he ever lobbied your office? Can you tell me that?
Not to my knowledge, Senator Carr, no.
And is it the case that, I just ask you, are you concerned that there's becomes a problem with lobbyists being asked to make decisions in regard to reviewing government decisions, particularly when they professionally are required to lobby the government about government decisions?
Well, decisions in relation to the allocation of work has already been articulated by the registrar are a matter for the AAT.
Well, it's just that in the case of Mr. Griffin, he told the Guardian newspaper that prior to his appointment at the AAT, he formally declared in writing to the AAT team at the Attorney General's Department, Mr. Anderson, you'll be able to confirm this presumably, or is it Mr. Guildford, that my employment status with Barton Deakin, a declaration that included that he and the firm were listed on the lobbyist register. So if he was appointed in February 2019, I'd ask the department, what did the department do, or when did you become aware of Mr. Griffin was a lobbyist?
Senator, Mr. Griffin declared that he was registered on the Register of Lobbyists at the time that his appointment was being considered.
Did you advise the Attorney General prior to his appointment?
That information was provided to the then Attorney General.
Thank you. And did you raise any concerns about the potential conflict of interest as part of that advice?
Senator, I don't want to go into the appointment process being a cabinet in conference
Yes.
process, but I'll just say that Mr. Griffin did declare that he was a registered lobbyist, and that information was considered as part of the appointment process.
Yes, I understand that. But the appointment process surely would cover the issue of conflict of interest. And given that we've already dealt with this in regard to the matter of Mr. Tony Barry, who was also, the tribunal didn't know that he was on the lobbyist register until it was, I think it was raised here. You presumably knew at the time of the cabinet meeting that he was a lobbyist.
So I've said, Senator, that Mr. Griffin declared his interest. The purpose of a private interest declaration is to declare matters that might give rise to a possible perception of a conflict of interest, and to talk about any measures that the individual would take should there be an issue of a conflict of interest.
Sure.
Of course, if you're appointed to the AAT, you then have a statutory obligation under, I think it's Section 14 of the AAT Act, to declare any conflicts of interest in relation to proceedings that you're potentially going to be conducting or involved in.
I see. Now, could I ask the tribunal, was that provision of the Act followed?
I'm sorry, Senator, could you just restate the question that you would like the tribunal to answer?
Mr Anderson's just pointed out, under the AAT Act, members are required to declare conflicts of interest. As in regard to Mr Griffin, or Mr Barry for that matter, has that provision been complied with?
So it is the case, Senator, that in the case of Mr Barry and more recently in the case of Mr Griffin, when the President became aware of their inclusion on the lobbyist register, he wrote to both of those members indicating that he believed there was potentially a difficulty with section 11.2. In the case of Mr Barry, he is no longer a member of the tribunal. We're awaiting a response from Mr Griffin in relation to that particular provision.
Okay, so can I ask, when did the President become aware that Mr Griffin was on the lobbyist register, and when did he write to Mr Griffin?
So the President became aware when the media inquiry was directed to us on the 11th of October, and he wrote to Member Griffin on the 21st of October.
Just can you please explain to me how, if Mr Griffin's appointed in 2019, the President and declared by the department to the Minister,
declared to the department by Mr Griffin, which was conveyed to the then Attorney General.
To the Attorney General, that the AAT was not aware until a media inquiry on the 11th of October, nearly 2 years later, that Mr Griffin was on the lobbyist register. How does that occur? How does that come about?
So, Senator, perhaps I should say from the department's perspective, when a private interest declaration is submitted, that's submitted for the purpose of the appointment process, and so under the Privacy Act we wouldn't be able to disclose that to the AAT, which is for a different purpose. We've now changed our processes, so we now seek the consent of a person when they lodge a private interest declaration at the time of being considered for a potential appointment.
When did you change your processes?
I'd have to take on notice the specific date. It's relatively recent, I believe. I think it's this calendar year, Senator.
Okay, but you can see the problem.
I understand.
We've already previously raised, in the case of Mr Barry, this difficulty of a publicly available register of lobbyists, which we could identify and any member of the public can presumably identify, knows where to find it. But the AAT doesn't seem to know where to find it. And in this case, where the Cabinet process clearly identifies a conflict of interest and the AAT doesn't seem to know about it, and only becomes aware of it as a result of a media inquiry 2 years later.
Well, Senator, I should say the Cabinet process involves identification of potential conflicts of interest or perception.
Yes, we understand that.
Your wording was to say it identified a conflict.
All right, a potential conflict of interest. My point is, you are saying you didn't tell the AAT because you thought there was a privacy issue.
Because we'd collected that information for the specific purpose of the appointment process.
And the Attorney, and you're, Madam Minister, you're not aware of this matter until presumably I've raised it.
That is correct, Senator Carr.
I'll make that presumption.
Thank you.
But the question arises, why does it take a media inquiry for this to become a matter for the AAT to inquire into? The probity arrangement's so poor that a public register is not even pursued by the agency.
Well, Senator Carr, I believe that Mr Anderson has clarified that the department has now changed its processes to seek the consent from all potential new appointees for the information provided in the public interest declaration to now be provided to the AAT if the individual is ultimately appointed to the AAT. And prior to that, as Mr Anderson articulated, it was up to individual members to declare any potential conflict of interest to the AAT. But Mr Anderson's evidence is that the department has now changed its processes.
See, the tribunal told The Guardian, which is an article published on the 13th of October, not the Financial Review, it was The Guardian, is that correct? Have we got, so there are 2 media inquiries, not one?
Sorry, no, you're correct. It's Paul Karp in The Guardian, Senator.
Not the AFR?
I'm looking at The Guardian on the 13th of October, Paul
Right.
Karp.
Yep, okay. So we're talking about the same thing here. You indicated, the tribunal indicated that an annual disclosure process for all members was to be introduced. Did that come about as a result of that inquiry?
Senator, that work was underway. The President had requested that occur as a result of the last incident with Tony Barry, and that process will be put in place this financial year and repeated every financial year for all members.
So Ms Leslie, just to confirm that you haven't been requiring members to make their declarations of any potential conflict of interest on an annual basis, because I do note that it is a matter for the President, in his opinion, under Section 11 of the Administrative Appeals Tribunal Act, whether a part-time member engaging in paid employment is, in the President's opinion, engaging in work which conflicts or may conflict with the proper performance of his or her duties. So doesn't the buck stop with you to collect this information firstly, to make sure that the President is appraised of any potential conflict, and then it's a matter for the President to, in his opinion, exercise his view in accordance with Section 11 of the Act?
Senator, we agree that there is a pressing need for that process to be introduced. Previously, upon induction, members were all informed of their ongoing obligation to disclose any conflict or potential conflict. Part-time members, you'll appreciate, have a whole range of different forms of employment, and they're not required, like full-time members, to get approval from the President. But it's clear as a result of these experiences that we need to take further steps, and so the President has directed that that form be introduced, and that will be asked, every member will be asked to complete that every year in the future.
So it's been pretty ad hoc up until now. So in other words, there hasn't been a proper process where part-time members are routinely asked about their conflicts of interest or potential conflicts of interest. It sounds a bit of a mess in terms of how this has been administered.
Senator, there has only been these couple of instances where we're aware of a problem, but we accept entirely we need to do more,
Ms.
to be
Leslie,
proactive about making sure.
I'm asking about your processes, because you're not able to identify problems unless you have proper processes in place. And it appears, and as Senator Carr has highlighted, it appears that you have had inadequate processes to identify potential conflicts of interest.
We accept that, Senator. We've also asked the department to make changes to the process to ensure we get the information upon appointment, as well as introducing the additional annual disclosure.
But please don't put all the onus on the department under circumstances where there is an AAT Act. I mean, I understand your point there, but there is an ongoing obligation under Section 11 of the AAT Act in relation to outside employment.
We accept that, Senator.
Thank you.
And we will do what we can.
Thank you very much. Senator Carr,
But Senator Watt just wanted to follow up two
I've got
questions.
two follow-up questions out of
I'm
Senator
very
Carr's.
conscious that we've
We've
had a big slot with,
Yes, I know.
with you, Senator Carr.
yes.
So before we go to Senator Watt, I would like to go to Senator Scarr, and then we could go to...
I won't be too long, sorry.
All right, so we'll go to Senator Scarr, and then we'll go to Senator Watt, and then back to you, Senator Carr, if we can, before our 11 o'clock break. Senator Scarr.
Yep. Registrar, do you understand the significance, do you appreciate the significance of what's occurring here today in terms of individual members of the AAT having their productivity, their work ethic questioned through this process? Do you understand the significance of this in terms of the integrity of the AAT and the reputation of those individual AAT members?
Absolutely, Senator. And if I could say, having accepted the Senate committee's decision about the PII claim, part of the basis upon us having raised that was concerns about some of this information being able to perhaps not give a complete picture about the members' performance or issues. And so that was a concern. I understand the significance of it, yes.
Registrar, I put it to you, Senator Carr was quite entitled to ask the questions that he asked. The question from my perspective is whether or not these benchmark progress percentages actually reflect what is actually happening in terms of the workloads, the professionalism and the contribution made by each of the members. Senator Carr is quite entitled to ask the questions and quite entitled to expect an answer. The question then shifts to whether or not the benchmark progress percentages that are listed and which have been referred to by Senator Carr reflect the reality of the contribution being made by each AAT member. Do you believe that the percentages which are included in the answers to questions on notice actually reflect that contribution or not?
Senator, I would take the committee to the answers that we provided where we gave a lot of information about what the benchmarks are, which is a planning tool and isn't necessarily indicative of performance. They are, if you like, quantitative measures that help us plan our workload and allocate work. But there are many other factors that go into determining whether or not a member is effective.
Well, look,
and we have outlined those in our questions on notice response.
I understand, Registrar, and I'm sorry, we have limited time and I want to make sure Senator Watt has an opportunity. I put it to you, this matter's going to the Legal and Constitutional Affairs References Committee, and I put you on notice that I will be fiercely interrogating these benchmark progress percentages with a view to making sure each member of the AAT and their reputation is appropriately protected through that process, because I have grave concerns that some of these members are now the subject of speculation which is not warranted. It might be warranted with respect to others, I don't know, but I have grave concerns about this process. I put you on notice in relation to that. In relation to the complexity of cases, is it fair to say that there's a spectrum in terms of complexity? At one end of the spectrum might be a simple case in relation to whether or not the AAT even has discretion, even has jurisdiction. So a threshold issue where the matter can be easily disposed of. That's at one end of the spectrum. Is that a fair comment?
That is absolutely the case, Senator. We will have matters that are relatively straightforward and some that are very complex.
Okay. At the other end of the spectrum, Registrar, could be a case which has been dealt with by the AAT on one occasion. It's then gone to the federal court. It's then been remitted back to the AAT after being dealt with by the federal court, and therefore there's a great need that case is dealt with by a senior member of the AAT, and it's dealt with in a meticulous fashion to make sure the AAT gets it right after it's been remitted back to the AAT. Do you accept that would be an example of a case on the other end of the spectrum?
That would be an example, Senator.
Do you think these benchmark progress percentages actually reflect, in particular, the complexity of the cases on that other end of the spectrum, where a great measure of meticulous analysis is required after a matter is referred back from the federal court?
Again, Senator, the benchmarks only pertain to the Migration and Refugee Division, not to the whole tribunal.
So let's just talk about the Migration Division.
Yep. And it is the case that those benchmarks are based on an analysis of historical caseload data. But of course, they can't accommodate absolutely every case. There are variations within that.
To what extent does the process depend upon the member actually seeking recognition of that complexity, as opposed to the process itself recognising that complexity? So to what extent is the onus on the member to argue their case with respect to complexity in order to get the benchmark progress percentage up? To what extent does it depend on them actually agitating for a higher benchmark progress percentage?
So, Senator, I'll give you my understanding of the process, which again is managed by the division head of the Migration and Refugee Division, but they will set a caseload strategy each year, which reflects benchmarks for the caseload they deal with. There is then an opportunity if a member considers that the work that they've been allocated is not aligned with the benchmark, or there are other circumstances that might impact on that they can then ask the division head or their senior member for some adjustment to the benchmark.
So, Registrar, if someone's quite a humble member of the AAT, perhaps they couldn't be bothered with agitating for greater recognition of the complexity of the cases they're dealing with, they'd rather just focus on getting on with the job, it could well be that their benchmark progress percentage doesn't accurately reflect the work they're undertaking. Is that correct?
That may be possible depending on whether they'd approached for an adjustment or not, Senator.
Well, maybe it is possible. It could occur. Isn't that correct?
It certainly could occur by the sound of it. Yeah.
Okay. I'd like to put on notice this question. I would like to know the number of cases which have been remitted from the federal court back to the AAT, and which AAT members have actually dealt with cases which have been remitted back from the federal court. So the purpose of the question, I'll make it very clear so the context can be put around the answer when it's provided, and I'm expecting context to be provided. The purpose of my question is to identify accurately work performed by members of the AAT with respect to the most complex cases. So we can see where a matter has been dealt with by the AAT, it's gone up to the federal court, sent back to the AAT, and a process of selection has been made with respect to which member of the AAT should be dealing with that more complicated case. And one of the reasons I'm asking for this, Registrar, is because in your opening statement you refer to, correctly, and I congratulate you for referring to it, that the proportion of appeals against AAT decisions is at 2.3% under the 5% benchmark. And it seems to me members of the AAT who are dealing with that most complex category of cases have a key role in terms of assisting the AAT to make that benchmark. Do you understand the context of the question in which I put on notice for you?
I do, but Senator, may I clarify, are you only interested in the Migration and Refugee Division or all remitted matters across the AAT?
Well, I'm actually interested in all the matters across the AAT. I think the same principle applies. If a matter is remitted from the federal court, you need to make sure you've got a senior member of the AAT who's going to deal with it meticulously, so it's dealt with correctly after it's remitted back to the federal court. Does that make sense, Registrar?
Yes. There will be matters remitted from the Federal Circuit Court in respect of Migration and Refugee Division, as well as the Federal Court for other matters. That's fine. Well. Wanted to be clear.
If we could include both, and if we can include the context. And just on a final note, I apologise for my passion in relation to this matter. I'm very keen to make sure the members of the AAT have their reputations protected, and that they're giving a fair hearing through this process. And that's where I'm coming from, Registrar. Thank you.
Senator Scarr, thank you so much. We'll now go to Senator Watt.
Thanks, Chair. I just really want to begin by clarifying a couple of things and following up a couple of things, particularly from Senator Carr's questioning. Registrar, there were some questions earlier about Mr Ian Berry, the member of the tribunal. Have there been any complaints made about Mr Berry during his time as a member of the tribunal?
Complaints against members are a matter for the President, so I'd have to take that on notice, Senator Watt.
Are you aware of any yourself?
I am aware of a complaint that was made to the President, yes.
And what was the general nature of that complaint?
My understanding it was a complaint that was not related to his role as a tribunal member.
So it related to his alleged behaviour outside of work, did it?
Senator, I really don't have the details. I'm aware in broad terms of a complaint being made to the President, but I don't want to misspeak here. So I'd be very happy to take on notice.
Right.
Yep.
Okay. Do you know whether that complaint has been resolved?
My understanding is that there has been correspondence with the President, but again, I'm not sure of the status of whether it would be resolved or not. I'd have to take that on notice.
Okay, if you could please. Do you know whether any action has been taken against Mr Berry as a result of that complaint?
I'm not aware of any, Senator, but again, I don't want to conclusively offer. I really would have to check with the President.
Okay, if you could take that on notice as well, please. Then just going back to Mr Trigard, who we know is a former Victorian Liberal candidate. Minister, can you remind me, he was appointed before your time, so which minister appointed him?
I would need to take that on notice. If you can point me to the year.
It's November 2018, so that would be Mr Porter?
I defer to Mr Anderson. I believe it would be former Attorney General Porter.
Right.
Mr Porter was the Attorney General at that
Yes.
time.
Okay, so he was an appointee of Mr Porter, obviously endorsed by Cabinet, and he was appointed to specifically help the tribunal manage its large caseload of migration and refugee matters. But what we've established today is that he, and has been established previously, is that he's literally never shown up to work.
Oh, I'm sorry,
Well, he hasn't done
Senator
any
Watt.
work.
That is not so. Senator Scarr.
So,
Senator Watt, if I could just hold you there, that's a misrepresentation of the evidence that we've heard today. I would ask you to. Well, I'm going to make it very, Senator Watt, I'm going to make it very clear that that's a misrepresentation of the evidence. Mr Trigard did not take up the appointment in that he was not sworn in and he declined the appointment, and we've heard extensive evidence in relation to that. So please don't mischaracterise this. That's a very unfair thing to say.
did Mr Trigard actually want to be appointed in the first place? When he was appointed?
Yeah, I mean, who are you directing
Well,
that
it's probably
to?
best to direct it to the Minister, given it's really about the
I would need to take
appointment
that on
process of the
notice,
former
but
Minister.
Chair, my understanding is based on the evidence today that he was never sworn in as a member of the tribunal, and that was certainly the evidence that was given by the registrar. I believe the evidence was also given that he ultimately declined the appointment due to ill health.
That's right.
I might say, and Senator Watt, with all due respect, you may just wish to clarify what you've just said. Given we are talking about the reputations of people, given the reporting on the 26th of October 2021, and I do see that he was obviously given the opportunity to provide a response to the media inquiry, I think it might be appropriate for Mr Trigard to be given the opportunity to review the evidence of Hansard and actually himself formally respond to the committee, because it would appear that his reputation is being brought into question in terms of the questions that are being put. And if he never was actually sworn in as a member, if he did ultimately decline the appointment based on ill health, I do believe he does need to be given the opportunity to defend his reputation.
I have no objection to that.
Thank you,
Thanks,
Senator
Attorney.
Watt.
Senator Watt, I'm not sure whether you were here when this matter was being canvassed, but we did canvass
It
this
was
in a lot of
canvassed in
detail.
detail,
Yeah, that's
Senator.
my
Yeah.
last question in
Yeah.
relation to Mr Trigard. The evidence we've had this morning about Mr Griffin, who we know was a lobbyist at the time of his appointment, and the evidence today is that Mr Porter was informed that Mr Griffin was a lobbyist, but appointed him anyway. There's no dispute about that.
Mr Griffin declared that he was on the register of lobbyists before he was appointed.
Yep. So, Minister, why did Mr Porter, as the former Attorney-General, and the Cabinet, of which you were a member, knowingly appoint a lobbyist to the AAT?
Again, Senator Watt, and I think the evidence has also been canvassed in detail. My understanding is that under subsection 11.2 of the AAT Act, part-time members are not precluded from undertaking paid employment outside of the AAT.
Sure, but you don't think there's anything wrong with a
unless-
lobbyist being appointed?
Unless, in the President's opinion, and this certainly was the evidence that was provided, it conflicts or may conflict with their duties. So ultimately, it is for the President to determine, and in particular we've heard the evidence today as to how the AAT allocates the work. Under subsection 11.2 of the AAT Act, it is the President's opinion that is relevant. I think also, though, Chair, we did hear evidence in relation to it is up to an individual member to declare any potential conflicts of interest to the AAT. But certainly, and the evidence of Mr Anderson was, the department does recognise the importance of the AAT having a full understanding of a potential member's possible conflict of interest. And as such, the department itself has changed its processes, but we also heard evidence from the registrar that the AAT itself is also in the process of introducing an annual disclosure process to ensure that all potential or perceived conflicts of members are identified and managed appropriately.
And was that new?
Senator Watt, I am going to just hold you there because it is just after 11. We are due to take a 15-minute break. So,
And we'll come back to the AAT, Chair.
yes,
That's fine.
I
Chair,
just
may
wanted
I,
to.
Chair, may I just make a suggestion? I
Yes.
think Senator Carr is finished questioning the AAT.
Oh, no, I've got...
No?
this is-
Okay.
well, I've got one issue. If you could extend us, give us 10 minutes, I could finish the AAT proceedings.
That's an option. I've got about 5 minutes.
You've got about 5
so-
minutes.
Perhaps we take the break with all due respect to the departmental officials and...
My sense is that we could run through till about 11:45, perhaps up to 12 on the AAT.
Oh, okay.
So I'm very
Yes,
happy
well,
to.
I don't
That's
think
fine.
we need that
It was-
length of time.
It was only if we were the only ones with questions, I was going to suggest.
No,
it
I've
was
also
going,
got,
but,
I've
yeah.
got some questions as
All
well.
right.
Yeah.
Okay.
All right, well,
Thank you, Chair.
we will suspend for morning tea and resume just after 11:15. Thank you. The committee is now in session and we're continuing with the Administrative Appeals Tribunal. And Ms Lisleen, I've got a number of questions for you in relation to a couple of matters. Firstly, you've given evidence that you've consulted with part-time members as to answers to questions on notice in terms of their performance and other related matters. Can you just describe to me that consultation again?
To is before we provided our responses to the questions on notice on, I believe it was the 8th of October, which was the deadline set by the committee for responding to those. We emailed each of the members who were included in any of the responses to the questions on notice, just to inform them of the material that was going to be submitted to the committee and to indicate that in light of the timeframes, if there were any errors or things that needed clarification, that they were invited to let us know and we would look to make those corrections if necessary. And that was simply because the timeframes didn't permit us more time to be able to consult more broadly with the members.
So what day did you email members in relation to... So this is in relation to the response to the committee on the 8th of October when you provided 14 responses to questions asked by Senator Carr?
If you wouldn't mind just giving me a moment to check that, Senator, but I believe it was probably either on the day that we had to provide it or potentially the day before. So very close in time to us needing to furnish the responses.
So did you consult with members at all prior to that time?
Senator, we had only just collated the material to be able to provide that. There had been earlier in the year when we had begun the process of collecting information, there had been some earlier engagement in relation to some questions on notice. I would need, if you want the specific details about to whom and the dates, I could certainly take that on notice. But in relation to the questions that we responded to on the 8th of October, I regret that there was not sufficient time for us to consult with the members.
So
We notified
do you
them.
have the conviction that when you provided those answers that they were accurate and there was no issue with the accuracy as to the answers given to this committee?
You might, if you read the information, or sorry, the preface to the data, we actually explicitly indicate, Senator, that we hadn't had the opportunity to properly validate or verify that data. So it was a qualification, if you like, in relation to the provision of that information. I'll just ask if somebody has a copy.
So where is the note to the committee that you didn't have an opportunity to verify or properly check what you
I'll
were submitting.
just try and, I'll just find the answer to the question on notice.
That was put to us.
Oh, Chris Matthews? Could I perhaps invite our Chief Legal Officer, Chris Matthews, may have the response at hand to be able to just take the committee to that section of the answer?
Chris Matthews, Chief Legal Officer. Chair, by way of example, if you look at the response to LCC AE21,
Mr Mackey, I'm sorry, I'm having a lot of difficulty. You're cutting out. Having a lot of difficulty hearing you.
apologies, Chair. Is that any better?
Well, it's a bit better. So, look, I'll just be very brief on this. Whereabouts in the information to the committee did you indicate that you did not have confidence necessarily in the accuracy of the answers?
No, she didn't say that.
So,
Ms Lethlean,
Chair, if you look at...
you were concerned that there may be some areas where it was not accurate, is that right?
She didn't say that.
I'm just checking exactly. Ms Lethlean, could I just return to you? In your response to questions on notice on the 8th of October, you've indicated that you only consulted with members on that day or the day before. Did you have a confidence that the answers you provided the committee were accurate?
Senator, we were confident that the material had been extracted from our systems, but as is always the case with data, it's always best to be able to go through a process of validation and cross-checking. I'm just trying to get my hands on the particular question on notice responses, but my recollection is that we actually prefaced the information on the basis that we had not had time to do that.
Where?
Well, we've got a copy of it there.
Yeah, so I'm just wanting to understand, so in the prefacing of the information, you've said to me on the 29th of September, this will involve compiling and reviewing a significant amount of complex information. We will use our best endeavours to meet the deadline, and I will write again if it appears that our responses cannot be provided. So that was the preface.
Senator,
There was
Senator, in the
advice.
actual responses.
Yes, there was further...
In the actual...
Madam Chair, I recall from the answer...
Yes.
We get the context here. This is in regard to us, the committee unanimously rejected the public interest claim.
Yes.
And I asked for the material to be responded to by a date, the 8th was the memory, and the agency responded that they had provided the date and that they had written to members, they had contacted members of the tribunal to advise them of this information that they had provided, and they had opportunities for them to comment on it. That's my recollection.
I've got the correspondence from the 8th of October. I can't see any reference to that, so I've just asked the
That's the
Secretary...
answer. It was in the answer of my memory.
I've just asked the Secretariat to...
Could perhaps, Chair, the registrar, I can see the registrar find it for you. Would that assist?
Yeah, could you just point to me, Registrar, where you've indicated that in relation to...
Yes, if you, for example, Senator, if you look at our response to number 80.
Got a copy of 80? Mm-hmm. Have a look.
And if you look at the bottom of page 2 and on to page 3, you'll see that we've said in the time available to prepare this revised response, it has not been possible to thoroughly review all of the data nor fully validate it for accuracy.
Thank you. So since that time, since the 8th of October, have you done further work to validate the accuracy of those answers?
We have given members the opportunity to come to us if they have any concerns about the data. I personally have I've had some queries from members and I've had some further information submitted. So we will, but at this stage there's nothing to indicate the information was inaccurate. It's more around providing more context around some of those responses.
So some members have indicated to you that they have concerns about the answers to questions on notice provided on the 8th of October. Can I draw your attention to an email that you sent to members on the 8th of October in relation to questions on notice. Are you familiar or do you recall that email to members?
Yes, I do, Senator.
Are you able to provide the committee with a copy of that email?
I don't have one here, but I'm sure we could provide a copy to you. It would not take long to do that, Senator.
All right, thank you very much. If you could provide a copy of that email to the committee, and then I will return to some questions in relation to that, because what I'm concerned about is that members were not given an appropriate amount of time to respond, because this email was on the morning of the 8th of October and you submitted the questions on notice on the 8th of October. So there was essentially no time. And now we've heard that some members have raised concerns about the responses, and yet again, we have not been made aware of this. We've not been
Senator,
made aware that... Sorry, Registrar.
Sorry, Senator. If I could clarify, I haven't been made aware by any members of any errors in the information. There have been concerns raised by some members about the provision of the information, and I've sought to explain that we were required to provide the information because of the decision to decline the PII claim.
Yes, so there was some issues in relation to context. Some further information was provided. Now, are you sitting on that information? Is there any reason why we haven't been furnished with that further information?
The only further information that I've been provided was members who were interested in providing. So, for example, the answers may have asked for a specific period of time for work that they've undertaken. I have one member who's given me a more complete record of the work that they have undertaken over an extended period of time. I have indicated that if they wish to make their own submission to the committee, that they're willing to do so. But, Senator, there's nothing in that information that alters the accuracy of the questions on notice responses that we've provided to date.
And so has that, have you conveyed that particular offer to all members, that they may wish to make their own submission to the committee?
My recollection, Senator, is that's in the email that was distributed to all members, but once I can get a copy of that, we can confirm that that is the case.
All right. Look, I just wanted to go back to some evidence that you've previously given this committee in relation to benchmarks and performance, because clearly those benchmarks reflect poorly on a number of members, but I am concerned about the benchmarking process, because as you have previously made very clear, the fact that approximately half of the members, and I'm quoting Hansard from a previous estimates, I think it was last year, the fact that approximately half of the members aren't meeting that benchmark would suggest that perhaps this is something that needs to be adjusted from time to time. So I think the suggestion that it is somehow indicative of the quality or the performance of the member would be a misrepresentation or a simplification of what the benchmarks are designed and used for. So given the benchmarks, on your own admission, they may well be a misrepresentation of any particular member's work or contribution as a member of the tribunal. Isn't it important that further information is provided by the AET in relation to context?
Senator, we did seek to provide all of that contextual information again in the preface to our response to the questions on notice, where we indicated that the benchmarks were only one of multiple indicia about the performance of members. And we also sought to explain that benchmarks are more directed at being a planning tool to be able to work out what sort of finalisations we might be able to make as an aggregate and as an agency, and to help in the planning of the allocation of that work. So it is absolutely the case that the benchmarks are only one criteria that would be looked at in terms of the performance of members.
Okay, so we're about to receive this email, but isn't it the case that you advised members in the time available to prepare this response, that's a response to questions on notice on the 8th of October, it has not been possible to thoroughly review the data nor validate it for accuracy, and the data provided in relation to finalisations does not provide a full and accurate representation of a member's workload and output. Is that what you said to members?
That is what I said to members, yes.
And then you've gone on to say, should you identify any errors or issues that require correction, please email me those details and we will be able to consider and submit to the committee at a later date.
Yes, that's correct.
So you've told me that some members have emailed you, and yet we've received, in relation to wanting to provide further information to your responses to the committee on the 8th of October, and yet we have not received any further information. You undertook to members that you would furnish that information to the committee.
Yes, Senator. I've only received one email from one member with some additional information. I have explained or discussed with that member whether they would prefer to submit it themselves or whether they would like the AAT to submit it.
Well,
can I just be clear, there hasn't been any errors that have been identified to me at this point in time that would require a correction, but I'm very happy to furnish the information in relation to the member that has provided.
well,
further
why
information.
Ms Lethleen, the point is I'm making, why haven't you done so? You've got an ongoing obligation to this committee to make sure that we have full and accurate information in relation to your questions, to our questions to you. So you're sitting on information provided by a member under circumstances when you committed that you would provide this information to the committee, not the members.
Senator, I accept what you say. There was nothing in the email from the member that was indicated there was anything incorrect. And in fact, all they were wishing to do was to provide further information that went outside of the terms of the questions that had been asked in the context of giving a fuller picture of their performance.
Well, we would appreciate a fuller picture. That's the whole point. We don't want a
Understood,
distorted
Senator.
or misrepresented picture of any member's work performance. So you have undertaken to members in this email on the morning of the 8th of October that you would provide us with further information so we could make an appropriate judgment on these matters, and yet you failed to give that information to the committee. I mean, I would put to you that that's just not good enough.
Senator, there was nothing in the information provided to me that went to the question on notice, but I'm very happy and I'm fully prepared to discuss with the member providing that to the committee immediately.
Well, I'm looking at your
And-
email,
and-
and that was the commitment that you made, and you've
and
already
it's a
indicated
commitment
that there was further information provided to in relation to one member's workload, and I would suggest to you that you have not furnished the committee with all relevant information in relation to those questions on notice. Again, you have not done so in a timely way. You're sitting on information, and I would say, as chair of this committee, that that is not satisfactory.
Senator, if I could just clarify too, the member had provided the information to me, not on the basis that we would necessarily give it to the committee, but to give a more complete picture for my information and briefing today.
That's not your undertaking. No, Ms Lethleen, I'm sorry to interrupt, but that is not your undertaking that you gave to members in this email. Should you identify any errors or issues that require correction, please email those details and we will be able to consider and submit to the committee at a later date.
Yes, Senator, but there haven't been no errors or corrections that are required. It was more information that was being provided by the member.
No, you didn't hear me what I've just read to you. I said, should you identify any errors or issues that require correction? So,
Yes, but, again,
I would
sorry,
ask if you could
The member
please...
did not believe they needed, the member didn't believe they needed correction. The member was asking to provide more fuller information outside of the parameters of the questions that had been asked. But I would like to go back and have an opportunity to ask that member if they are comfortable with me just providing that material in full to the committee, or if they would prefer to make their own submission.
Well, I think what's important in relation to every member, particularly where there's been adverse reflections, that every member is given an appropriate opportunity to provide further information, either in his or her own name or through you as the registrar. But I am concerned about the adverse reflections made on members under circumstances when not all of the relevant information in relation to a member's workload or performance has been provided to this committee. So can you undertake to...
Senator, yes.
Could you undertake to please convey
on
that to these members and provide them with a proper opportunity and proper process, not emailing them on the morning of the day that you submit these questions, which I would put to you is not fair or appropriate and does not safeguard the reputations of your members.
And Senator, it was most unfortunate that we didn't have the time to do that. Under normal circumstances, we would consult fully, but we will undertake to make that process available to all members.
Thank you, Registrar. I'm now just going to quickly go to Senator Scarr before I hand over to
Registrar,
Senator King.
Registrar, just going back to that time issue, and I reflected on this as a member of this committee when we were dealing with this matter and the need for you to provide the information. Isn't it correct to say that if the AAT had done some better research in relation to public interest immunity, you would have been put on notice earlier that you were very unlikely to be successful in terms of your claim of public interest immunity, and therefore you would have had more time? Is that a fair comment or not?
Senator, I will say that the public interest immunity claim was raised in good faith for the very reason that there were concerns that the information that had been sought wouldn't give a complete picture about the member performance. I have to say we did seek advice from both procedural advice from the Australian Government Solicitor, from the Attorney General's Department, and through them the Department of Prime Minister and Cabinet. The difficulty being that these sort of questions don't have precedent, and so it wasn't clear whether or not the Browns would actually accommodate. But we were certainly given advice that there were arguable grounds to be able to raise the public interest immunity claim.
Well, I was. Go on, Registrar. Sorry to interrupt.
That's okay. The reason that we had expressed the concerns about the harms were for some of the reasons now that are being articulated today about pieces of information that do not give a complete picture about the performance or workload of a member, perhaps being misinterpreted or reported in the media in ways that reflects perhaps unfairly on members. So that was one of the grounds upon which we expressed concern about that.
So thank you, Registrar. I understand that, but if the advice you received was that there was an arguable case, wouldn't the prudent thing to do, would it not have been prudent to have run a parallel process where you prepared the information on the basis that the public interest immunity claim may well have been rejected, put the members on notice that you were claiming public interest immunity on the basis of what you thought was an arguable case, in good faith, I'll accept that, but run a parallel process so that members had sufficient time to consider the information with respect to them, given their names are in the media now, etc., and you had more time to validate the information, etc., in the event that the public interest immunity claim was not accepted, which it wasn't accepted unanimously by this committee. Wouldn't it have made sense to have run that parallel process?
Yes, Senator, and I can tell you that there was significant work that was being done in parallel to be able to anticipate in the event that we were not able, that our public interest immunity claim wasn't accepted. It's perhaps difficult to articulate, but with 3 case management systems, there was a huge amount of data that needed to be extracted and collated here. So we didn't sit on our hands while we were waiting for the committee to consider it. But there was very significant work that needed to be done to get those responses tabled by the due date on the 8th of October. But I do accept what you're saying. It would have been far better and preferable to be able to have sufficient time to consult properly with the members in relation to that material.
Okay, thank you.
Thank you very much, Senator Scarr. Senator Carr.
Yes, a couple of things. For the advice of officers, it clearly require additional information to be provided to them. I'll table the documentation here, the clerk's advice and the committee correspondence in regard to the public interest immunity claim. I am staggered that the registrar says that she sought advice from 3 departments, and there was an arguable case for this public interest immunity claim. The advice that we had was that this has been an unprecedented claim being made by the AAT in regard to adverse impact on the operations of the tribunal, disclosure of personal information. It's just an unprecedented proposition that was being advanced. And it was most unlikely that the Senate would ever accept such a proposition. And in that context, given that these questions were asked back in April, why the sudden rush to actually have the material presented, I think, falls a little flat. But having said that, it is a point being made. There was 35 members of this particular division in which information was sought. One person has said they want further context provided. That is correct, isn't it, Registrar? One person wants further context?
That's correct.
No, I'm not surprised people are embarrassed by these statistics. Not surprised in the slightest. But, you know, it's within your capacity to provide further context, and you're entitled to do that. No one's arguing the toss about that. Now, to make clear about this, though, you're suggesting that members of the tribunal have been advised that they can write to this committee directly, make submissions directly to this committee. Is that what you're saying?
May I just check the email does include that? My recollection is sorry, I'm just checking with my support staff here.
So we're just waiting to have that email provided
Okay,
to
but I
the
just want to be clear about this.
So we can have that table, please.
Because is it the did I understand you correctly, Registrar? Did you make that submission to this committee?
Sorry, Senator, what was the question you were asking?
Have you advised members of the tribunal that they can make a direct submission to this committee in regard to these statistics that you've provided?
I just, before I answer that question, want to have a copy of the email in front of me to be certain that, in fact,
That's all right.
it did say that.
It's not a trick question. I just wanted... Is that what you've said to the committee? That's all. It's an unusual process, that's
yes,
all.
Sorry, if I could read to you. It says, if you have any concerns about the possibility of adverse comments being made about you in Parliament after the information is provided to the committee, you should be aware that there's a process for making a reply should you wish to do so. This is discussed in section 5.7 of the government guidelines for official witnesses before parliamentary committees and related matters.
So you are advising members of the tribunal that they can write to this committee directly?
Yes, Senator.
Right. So I take it in regard to the References Committee inquiry, you're also advising them they can make submissions directly?
I have not done that, but there'd be no reason, Senator, why members
I just wanted to be
couldn't
clear,
make their
that's
own
all you're saying. Thank you. And I've tabled the document so you can actually establish what the clerk has said and what we've said to you in terms of our rejection of your public interest immunity claim.
So this is the 14th of July.
This is the 14th of July correspondence.
And that is already on our website.
These are public documents. I'm not leaking from the committee or anything. It's just so, but you should have access directly to them.
No, Senator Carr. I would never think that you would do that in a million years.
Well, I probably would announce it in advance if I was. But the point being that there has been a very strenuous effort here to get information from the committee, from the agency, which we're entitled to get. And there's been a very stringent and strident proposition put back to us that you didn't want to provide it. Now you have provided it, and we're now going to have a discussion about what that means, which is normal process. Now I'd like to just follow up on the question of whether or not there are any other members of the tribunal, Mr Anderson, that you're aware of that are in fact lobbyists.
Senator, there's one member who may be a part-time member who may be on the Tasmanian Register of Lobbyists. We're pursuing some details on that. That's not a publicly searchable register, and it's certainly not maintained by the Commonwealth. So there's one member, as I say, a part-time member who may be on the Tasmanian Register of Lobbyists.
But that's the only one that you're aware of?
That's the only one that, in addition to...
It's not confirmed yet?
In addition to, we've discussed Mr Griffin.
That's true. Now, the two that we've drawn attention to to the tribunal were the mechanism by which you discovered that they were lobbyist, and that prior to your recent changes in ministry practice came about as a result of this committee's work. That's correct, isn't it? The department didn't advise the AAT that they were lobbyists, did they?
No, I don't believe we did,
No.
Senator.
Now, can I turn to another issue? And because we are obviously extending through to 12 o'clock or so,
We will.
try to do that.
Yes,
Good.
we'll need to extend through
Yeah.
till 12.
So the Freedom of Information Act does apply to the Administrative Appeals Tribunal, does it not, Madam Registrar?
Yes, it does, Senator.
Now, I just want to be clear about this, that the FOI Act requires the federal ministers and agencies to maintain a public record of information relating to its operations under the FOI Act, required to update it every 10 days of a person being granted access to information. That's also correct, isn't it?
Yes, it is, Senator.
A couple of months ago, I was, as I often do, as you know, in my spare time, I just wander through your registrar, and a bit of a humorous note here that this is what we do. I lodged a question notice on the 13th of August regarding the operations of the tribunal, and it's there discovered that you were in breach of the FOI Act. That's correct, isn't it?
Yes, Senator, we were.
I'm just wondering, again, we have an example whereby, I'm just wondering, how is it that it requires a senator to point out that you've been in breach of an act almost 2 years in this case? How is it that it requires that type of process to be undertaken before you discover breaches of this type?
Senator, thank you for your question. And if I might invite our Chief Legal Officer, Chris Matthews, has some more detailed information about the freedom of information issues.
Yes, Senator, on receiving the question on notice, it became clear that there were, at that day, 12 requests for access to documents, in relation to which we
I do
hadn't
apologise.
included.
Can we just make sure that no footage has been taken
Oh.
of the table?
Yes,
Because obviously
excuse
people
me
have
to the
notes on
cameraman.
table. Just to ensure that no footage is actually taken of any computer. Thank you. Thank you.
So you're just taking a photograph.
Thank
of
you. So, I'm
places.
sorry, I just had to raise it because there's a clear line of sight.
And you know, I promise I'm not rolling is a very firm commitment from any cameraman, so I do believe you.
Yeah, no, thank you very much. Thank you.
Get your shot quickly if I was you.
Senator Henderson's previous experience.
You won't, I'm sorry, you can't be behind any of the witnesses at the
Move
table.
forward, move
You need
forward.
to move forward, yeah,
They've got the tape in the wrong spot.
yeah.
Yeah, that's right.
So we can't have any papers or any other information.
Thank you. Thank you.
Sorry?
So we're
Senator Carr?
explaining how it is that you were in breach of the law for at least 2 years. I think that's what the question revealed, didn't it?
So, Senator, it revealed the number of requests since the 2018-19 year in relation to which we hadn't included information on the disclosure log within the 10 working days after giving access to those documents. And in total, there were 21 requests across that period. And as at the date you asked your question, there were 12 requests in which, in relation to which we hadn't included information on the disclosure log. And that was remedied.
And how long has that been going on for?
So in your question, Senator, you'd asked from the 2018-19
Yes,
year.
I understand that. I've asked you that. You've acknowledged that in regard to the question that I asked. But surely that's not the extent of the breach of the law.
Senator, we haven't looked further back at that, beyond that period as yet.
I see. So, Minister, what do you say to the proposition you've just heard about the agency breaking the law?
Well, I'd certainly give the agency further opportunity to respond, but obviously you raised some serious issues, Senator Carr, and I'm sure the agency will provide full and detailed particulars of the issues that you have raised.
So for 2 years, this is in 2 years in regard to this occasion. What about the department? Could I ask Mr Anderson, how long have you been aware that they've been in breach of the law?
So, I first of all note that I don't administer, my part of the department doesn't administer the FOI Act, but just
Okay.
Secretary.
So who does? Who administers? We've got the right person here that can help me. If you can't help me, who can help me?
Senator, we will have people here later in the day, excuse me, in relation to the FOI Act.
All right. But it's a simple proposition, though.
Well, what I would say is, I mean, we're responsible for the administration of the FOI Act. That
Yes.
doesn't extend to us monitoring how individual agencies maintain their disclosure logs. That is a matter for the agency.
Okay. So it's not your problem.
We provide, in terms of general administration, and of course the Office of the Information Commissioner plays a role in providing education and advice about the appropriate implementation of FOI Act provisions, but it is not the responsibility of the department to monitor disclosure logs of agencies, whether they're in our portfolio or more broadly.
Well, are you concerned that there's been a breach of the law for an agency within your portfolio?
Obviously, it's a matter for the AAT to provide further information about the specifics of what have happened. As the department responsible for the FOI Act, we're obviously concerned to ensure that it is appropriately followed and the obligations under the Act are appropriately followed. But I think the Office of the Information Commissioner in particular has responsibilities to ensure understanding of those obligations.
All right. Well, look, once again, just going through the log, what have we got here? Notice number 4001. It's on the 2nd of September. The Tribunal sent its response to my question to the Attorney-General's Department. So that's the 2nd of September. And I'll table that, if I might, Madam Chair. Now, the response set out to the Attorney-General's Department on the 2nd is different to the response that was ultimately provided to the Senate. Now, in response to the Tribunal, it set out to the Department, the Tribunal said it, and it said on page 167, the Administrative Appeals Tribunal does not administer the FOI Act. It is not a matter for the AAT to determine whether or not its own actions conform to the requirements 11C of that Act. Now, that part of the Tribunal's response was not provided to me. So who's responsible within the department? And I presume it's within the department? Was it the department that did it, or was it the Attorney-General's office? For removing that part of the answer?
In terms of the department's involvement, Senator, I have to take that on notice to the extent that we had any visibility of that.
Sorry, you don't know?
No, I do not know.
So is there someone here that can tell me?
They may not be in the room, unfortunately, Senator
Would you
Carr,
like
as you know, because
to...
Are you able to table that document?
We have,
So-
we just...
Oh, you just have tabled it? I don't
Yep.
think we have a copy.
I just want to know, because, you see, it strikes me that if the Tribunal claims that it doesn't administer the FOI Act, and it's not for the Tribunal to determine whether or not it's in compliance of the Act, it's quite clearly an outrageous proposition, given what you've just said, that you believe they are responsible for whether or not they administer their own behaviour under the Act.
Just to advise that that document is being photocopied now.
Thank you
and
very
it will
much.
be with you very shortly.
Thank you.
So can I ask, is it the case that the Attorney-General's Department does administer the FOI Act?
That's correct, Senator.
It is correct. Is it your view that other Commonwealth agencies are not responsible for ensuring that they comply with the FOI Act?
I think as a general principle, the Act as drafted, if it applies to that agency, then that agency has a role in ensuring its own compliance.
So what do you say to the proposition then that the tribunal is not, because it's not administering the Act, it's not a matter for the tribunal to say whether or not it's complying with the Act?
Senator, without having discussed this with the agency, perhaps it's a matter that there's an issue in terms of their understanding of the obligations of complying with the Act. Perhaps there's some more we can do to assist them in understanding the requirements of the Act.
It's a bit more than just a bit of understanding though, isn't it? It goes a bit stronger than that. If an agency within your portfolio says it doesn't know whether or not it's responsible for its compliance with the law.
Senator Carr, perhaps compliance of the Freedom of Information Act itself and including the disclosure log obligations, which I think your questions have been going to. The questions might also be more properly put to the Office of the Australian Information Commissioner because they actually are responsible for the compliance of the Act.
Okay, all right. Well, then tell me this.
And they'll be on later on
We'll do
this
that.
afternoon.
We'll do that. Minister, I'll do that. But you see, I'm having trouble. I'm not a lawyer, you see. I have trouble with this sort of thing, you know. I have enormous trouble understanding how it is that an agency can break the law, right? It gets pointed out by, you know, a person such as myself. They have to try to fix it. They say, well, it's not their problem. It gets tidied up through the FOI process, we find out, because someone's doctoring up the answers. And no one seems to think that that's a big deal here, you know? The Attorney General's Department shrugs its shoulders.
Well,
Now,
Senator
as I
Carr,
say,
that's a very unfair characterisation.
unfair but accurate.
It is very unfair and it is not an accurate reflection.
I have taken a very hard line when evidence is misrepresented, whether it's by a witness, by a minister, by a senator.
Excuse me.
That's not an accurate representation
all right,
of...
well, can I ask the
Sorry,
tribunal?
Senator Carr, just if I can ask you to pause for a moment. If I could just remind all senators of... No, excuse me, Senator Patrick, I'm just giving a ruling. Just to remind all senators of the importance of representing accurately evidence given to this committee.
Right.
Thanks, Senator Carr.
And Chair, as I've stated, compliance with the FOI Act is actually the purview of the Office of the Australian Information Commissioner. They will be on later at 2 p.m. today, and the questions will be more appropriately put to them.
So when you say administer the law, they're not actually responsible for enforcement. Is that what the proposition you mean?
Well, compliance with the FOI Act is regulated by the Office of the Australian Information Commissioner. But perhaps, Senator Carr, the AAT could take you through whatever processes they have put in place to ensure that going forward, their log is properly updated in response to the questions that you have put.
So, well, yes, and specifically though, I'd ask the tribunal, is it still your attitude that what is your attitude towards your legal obligations under the FOI Act?
Senator, it's absolutely the case that we must comply with the FOI Act. And we don't dabble with that proposition at all. I think the sentence that was included did kind of reference that the compliance with the FOI Act is a matter for the Australian Information Office of the Australian Information.
I see.
And so we would
Chair,
take away from
don't
that.
know, Senator Carr, I could not understand that answer.
Yeah.
Is there any way that the officer
Apologies,
could again...
I was a bit distracted for a moment.
repeat the answer to
Sorry,
the
look,
question?
we have got some major... I think it's... is it the AAT in Melbourne? You're based in Melbourne?
Sydney.
In Sydney, apologies. We are having some difficulties with the connection from the Sydney remote video conferencing facility. Could you please just repeat your answer? And I'm wondering whether broadcasting might give some advice, whether it's worth disconnecting and reconnecting so we might get a better connection. just have one more go and see
Senator,
how we
I
go.
could assist. I believe Mr Matthews was saying that there's absolutely no question that the AAT accepts that it is responsible for complying with the FOI Act. The sentence that was referred to by Senator Carr was intended only to recognise the role of the Australian Information Commissioner as the regulator in monitoring for non-compliance, but there isn't it was certainly not intended to suggest that we don't accept fully our responsibility for complying with it. And in fact, we have taken steps to make sure that we absolutely ensure that our compliance with the disclosure log is up to date and monitored very regularly. I've also urgently requested an internal audit of our FOI function to ensure that our compliance can be as absolutely best practice as possible. It is the case, as I mentioned in our opening statement, that we deal with more than 1,600 applications, FOI applications every year. That doesn't excuse our lack of compliance with the disclosure log requirements on this occasion, but we've taken steps to ensure that that's addressed, and the audit will hopefully make some further recommendations to improve our compliance in that regard.
So this clause here that says it's not a matter for the AAT to determine whether or not its own actions conform with the requirements of 11C of the Act. What do you say to that proposition?
Could you just point...
That's in the table answer I've given, right? That was. What do you say to that proposition?
I think Mr Matthews explained that that was simply noting that we don't determine the breaches. The Office of the Information Commissioner is responsible as the regulator for determining the breaches, but there's no question that we are responsible for compliance as an agency. So that is what I'd say.
Okay. And what's your explanation for why you were in breach of the law?
Is Mr Matthews back on the line?
Not yet, Chair.
Senator, it was,
Oh, yes.
it was the fact that our processes for the routine consideration of decision-making and then adding information to the disclosure log were just not implemented in a consistent manner.
All right. Look, just finally, because I'm finishing my questions, I trust. There were some matters in regard to matters Senator Watt had raised in regard to questions of study leave, whether or not any members of the tribunal were studying law, and it still hasn't ended. That's question number 3273, and I suppose you'll say it's outside of the Senate estimates process, but nonetheless a question on notice 3273 in regard to the study leave for law. What's happened with that answer?
Senator, I believe that we had responded that the AAT does not fund or support study leave for members. We weren't, there may be members who of their own volition are undertaking legal studies, but that's not information unless we're responsible for organising or paying for it, which we don't, then we wouldn't have access to that information.
Right. So you just don't know if there are any members of the AAT studying, senior members, deputy presidents who are studying law?
No, we wouldn't hold that information,
Right, okay.
Senator.
Is the
because it's not part
department
of it.
financing any study leave for AAT members?
I don't believe so, Senator. That wouldn't be our role.
So you've got, you can't assist me with where I should go to find this information? As far away as possible would be your first answer, I know, but let's take it beyond that, right?
So, Senator, not at all.
It was outside the purview of estimates in your...
Yes, that's right. So, but is it, who's in the department, in the AG's department, who finances your study leave for public servants?
So the department has a policy about study leave for officers, and there are approval processes that are gone with them, but they don't apply to statutory office holders such as members
Okay,
outside the
so
department.
that's not, you would not normally pick up study leave for any of the agencies?
We would not pick up study leave for agencies.
Right.
No.
So are you able to assist me with how are agency members offered study leave?
It's a matter for each agency, Senator. I mean, because it's about the use of the agency's resources,
fair
it's
enough.
typically a matter for that agency to have a policy about it. And
Yeah, all right. That's fair enough. And so I can ask the registrar: is the AAT offer any study leave at all for any of its members?
We only have study assistance available for staff. We explicitly exclude members from the study leave assistance program.
Okay, so I just want to be clear about this. As far as you're just not aware whether or not senior members or deputy presidents are currently studying law.
No,
All right,
I'm not aware.
Thank you very much. Given the time, we'll see the questions.
Thank you very much, Senator Carr. Now give the call to Senator Patrick.
Yes, thank you very much. Just got some questions in relation to FOIs and the handling of them. And this is not so much, this is not so much FOIs on the AAT, but FOI matters that are brought to the AAT. It appears that the numbers of FOIs are increasing, up from this year, last financial year, 124 applications on hand, up from 104 the year before. I just want to comment as to resourcing in relation to these general law division matters.
Senator, yes, it is the case that there has been a slight increase in those matters, but my understanding is that there are sufficient members available to be able to progress those in a timely manner. So while it is an increase in the scheme of the tribunal's workload, it's a relatively modest increase.
Okay. And can you provide me, perhaps on notice, some details as to sort of the shortest FOI matter? I guess perhaps someone has withdrawn from a matter. Let's just stick to matters where a decision is made by the tribunal as opposed to some consent exiting process. What the range is in terms of time it takes to deal with those matters, those sorts of matters.
So, Senator, I'm sure we could give you a range from quickest to longest, if that's what you're looking for, over a particular financial period.
Yeah, if you could just do that over the last couple of financial years, I'd be grateful for that. And perhaps if you could give an indication for the matters that have where a decision has been made by the tribunal, again, let's exclude consent decisions, but where, in effect, a decision is either varied, set aside or affirmed, just which of those categories they fit into.
So matters that have been determined following a hearing, what the outcome was?
Yeah, whether it's it just in broad categories of either affirmed, varied or set aside.
Yes, Senator.
Okay, and now just in relation to the National Cabinet decision of Justice White, and I'm not going to go into the mechanics or details of the decision itself, but in a couple of committees now, the executive has asserted that the decision of the tribunal is, in a sense, not binding on the executive. Now, I'm not suggesting they haven't complied with the decision of Justice White. What's your understanding as to how AAT decisions should be considered by government as opposed to, say, a judicial decision?
I might invite our Chief Legal Officer, Chris Matthews, to provide a response to that, Senator.
Senator, obviously AAT decisions aren't binding in the way that court decisions are in terms of the application of law. The tribunal doesn't have its own enforcement powers in relation to its decisions. It is a matter for agencies to implement the particular decision that's been made and then to consider the relevance of an AAT decision for administration.
Okay, so
I think would be the fair response.
Okay, so in the context of, let's just stick within the context of other FOI matters. One would presume that if the AAT makes a ruling, that it would have some persuasive or binding influence on decision makers, i.e. the Information Commissioner and original decision makers within departments. Is that a fair thing to say?
I think it's a difficult thing for the AAT to actually say as a kind of general proposition how its decisions are to be treated in that sense, because it is then a matter for administrative decision-making agencies to determine their own course.
I just go back to a decision by the founding president of the AAT. I think it was Lawler and the automotive. It was a licensing decision, and I think is it Justice Brennan that was the founding member of the AAT, founding president. Yeah, so
The founding president, yes.
I was under the impression that AAT decisions, that the AAT can in fact deal with matters of law in its decision making. So it would consider the facts and would consider, the law as it applies to those facts, and if indeed the law is uncertain, may well make a determination, as to what the law is if there's an absence of judicial precedence. Is that a fair assessment of what the range or what it is that the tribunal can do?
So in making a decision, the tribunal must take into account the facts and apply the law, but it doesn't make binding rulings on the application of the law because it's not a Chapter 3 court. So it's that making binding decisions in relation to how the law is to be interpreted is the exclusive domain of the court.
Okay, so I understand that. What I'm trying to get to is that in the process of making a decision, in the absence of a precedent, and Justice White's decision is a good example. There were no decisions about National Cabinet and its status as a committee of the Federal Cabinet. In effect, he had to determine that as a matter of law in order to then be able to apply that to the documents that were being sought, which were the minutes of National Cabinet. So it's fair to say the tribunal will, if necessary, make a finding of what the law is, even if it doesn't have judicial precedence.
That's correct, Senator.
Okay, and do we distinguish in any way between a judicial member sitting on the AAT versus, say, a deputy president that is just a lawyer?
My understanding, Senator, is that when the federal or family judges are sitting as members of the AAT, they are sitting as administrative decision makers in that context.
Okay, but one would expect the weight of that decision, of their decisions, to perhaps be more closely considered by people that make decisions underneath them, and perhaps in terms of informing government.
So, Senator, yeah, there is no doctrine of precedent in relation to AAT decisions, but certainly a decision made by a more senior tribunal member could be seen to be persuasive.
Yeah, has more weight would be perhaps a reasonable term.
Yes.
Yeah. Okay. Okay. Thank you. That's all I have, Chair. Thank you.
Thank you very much, Senator Patrick. Senator Scarr.
Thank you, Chair, and I must say I found that last round of questions extremely interesting. I think Senator Patrick is going to be lecturing in administrative law soon at one of our most esteemed universities.
I have to get a law degree first.
Oh, you already have one, don't you?
I'm a bush lawyer.
Bush lawyer, PhD. Registrar, can I finish this round of questions from me in relation to how the Administrative Appeals Tribunal has responded to the COVID-19 pandemic, and whether or not there are any learnings in terms of how the AAT has operated from the COVID-19 pandemic. And I, just to provide a bit of context, speaking to members of the profession, there's a bit of a theme that's developed over the last year and a half or so in terms of matters being dealt with by video conference or in a far more efficient way than perhaps happened in the past. For example, call-over proceedings, etc., where lawyers used to always trundle up to the chambers and there'd be a room full of lawyers all charging out at $500 an hour waiting for their matter to be called. Instead of doing that, do it by video conference and then promote efficiency in terms of the legal processes. So I'm interested to hear if there are any learnings from your perspective in relation to the operation of AAT, which we can take forward post-pandemic to improve efficiency.
Thank you, Senator. I think it's absolutely the case that the experience with the pandemic, which saw the AAT, along with many courts and tribunals, shift its emphasis to remote hearings, primarily using videos, will have a lasting impact. We were really pleased to see the increase in the satisfaction rating in our last user survey. And if you look at the anecdotal comments from some of those respondents, it's clear that a lot of the applicants appreciate the convenience associated with being able to appear by video rather than having to attend a registry. So we will be considering, even as we emerge from the pandemic, about the opportunities to look at particular caseloads where we may offer video hearings on an ongoing basis. I think particularly for rural and remote applicants, it's been a particularly good development from their perspective. It's also the case that the technology is rapidly improving. So we've been using Microsoft Teams for our video hearings, and there are already a number of enhancements that are going to be delivered that will only make that experience better for applicants and parties in the future. We also, I guess, are looking at the opportunities around how we can have a more flexible approach to delivering services more generally. So a lot of the things that were previously dealt with in person, we'll be looking for opportunities to offer those through digital service. We now have online lodgements in all divisions. We now have a portal where people can upload documents, for example. So I think it has probably expedited some of the digital developments that the AAT had already hoped to be able to move towards. The only thing I'd add too is that we've also have a Build Back Better approach. So we've been looking at the COVID-19 response and some of the learnings that have come not just from the AAT but from other agencies, so that we can think about, as we move out of the pandemic, what are some of the things that we can retain and keep into the future. So that is definitely being considered actively by our tribunal leadership group at the moment.
Okay, so I must compliment you on that phrase, Build Back Better, the Triple B approach. So I commend whoever came up with that. I'm interested to know, what's the process then in terms of capturing those learnings? I note that you issued special practice directions in terms of your response to the COVID-19 pandemic. I'm impressed that you have that view that the AAT should build back better, but how do we make sure that isn't lost in the rush after the pandemic to get things back to normal? Have you got a timetable or a process? And if so, what expectation should we have as a committee in terms of seeing that progress, seeing you actually build on the foundations as you build back better?
Yes. I might invite Jacqueline Fredman, who is on our COVID working group, who might be able to provide a bit more detail about that.
Certainly. Thank you, Registrar. Jacqueline Fredman, Chief Corporate Officer. For the committee's for interest was actually former President Bill Clinton, who I believe came up to Build Back Better. It was something that...
That's a disappointment, but anyway, go on.
Sorry to disappoint you. That is the case when we started looking at how we might move beyond the pandemic, and we began doing some research and so forth. Last year, I started reading disaster recovery literature, and this phrase came up time and again. That seems to be where it had come from, but I was happy to latch onto it as I think it resonates with people. We actually set up a project in August last year, which was the Build Back Better project, to examine the ways we responded to the pandemic, because we wanted to capture what had worked well with what we wanted to retain into the future, but also as a literature review, we spoke to lots of other agencies, not to tribunals, but other agencies, public and private sector, to share learnings and learn from them as well. So we presented a paper to the Tribunal Leadership Group earlier this year. I think it was February this year, and we had a number of meetings with Division Head and President to capture what the group recommended to that retain. We also developed working from home policies to take us into the future, so we could evolve into a hybrid way of working, because that's something that clearly, having surveyed our members and staff, people really appreciate the ability to have flexible work, whilst recognising that working from home was imposed on people. People did foresee into the future that it would be something that many people wanted to retain, part of a choice of working partly from home, partly from the office. Another aspect we looked at was the way we responded to safeguard people's psychological health. We had already, I think, tribunal reasonably comprehensive ways of looking after people's mental fitness, but we did ramp up those measures considerably when the pandemic hit. So from about March, April, we brought into a number of measures. We had Calm app, that reach out service, which is trained psychologists able to speak to people, we trained our managers to be able to deal with managing people really effectively, because for many people in the organisation, they were used to managing their members or their staff in the same physical location, so it was quite disconcerting to suddenly not having that physical proximity. It's a very different way of leading people and managing people. So there's a number of agreed outcomes that came from the meetings of the Tribunal Leadership Group. I think it's fair to say they've probably rolled into business as usual for the corporate areas. So, for example, in my branch, the human resources area, the business support area, we're looking at how we can use our property footprint more effectively. Where we have people who may want to work in a hybrid way, we might look over time at how we redesign our workspace, and that's something that a number of agencies are looking at as well, to be able to use effectively and smartly. So there's a number of measures, but certainly an ongoing conversation and dialogue. There's recently a future of work that came out that Home Affairs and the ATO had sponsored, that has a number of really useful observations and insights that be applied across the APS. So it's something that we're looking at continuously.
I imagine when you're looking at different methods of work, there's that balance, isn't there, to be achieved between the benefits that flow from members and staff working in the same physical proximity, promoting collegiality and the ability to reach out to members and staff who maybe need the benefit of that in a collegiate fashion, as opposed to everyone working remotely and you don't really know where people are up to. So is it fair to say it's a question of reaching the right balance?
That balance was the word that sprang to mind as you were asking that question. That's very much the case. We have not specified a particular division between working from home and working in the office. I know some agencies have taken that step, but we have been in our policies that it would be very unusual that somebody would be working more frequently at home than they would in the office. So it's really about striking that balance between affording flexibility to people, but also appreciating that in-person interactions are extremely important to maintain.
Okay, thank you very much. I really do commend the AAT on those initiatives. Thank you very much.
Thanks, Senator Scarr. Look, I've just got a couple of questions before we go to lunch. Just wanting to refer back to the email of the 8th of October, which has now been tabled, and thank you for providing that to the committee. I just want to confirm that in relation to the responses to questions on notice 78, 80, 81, 82, 83 and 62, as stipulated in the email to members of the 8th of October, that the attachments to this email reflect what was submitted to the committee, so there were no changes?
That's correct, Senator.
Thanks, Ms. Lethlean. You've indicated in the email, and we did obviously speak about this earlier, but just wanting to reiterate this issue. In the time available to prepare this response, it has not been possible to thoroughly review the data nor validate it for accuracy, and the data provided in relation to finalisations does not provide a full and accurate representation of a member's workload and output. Have you, in the 3 or so weeks since this time, have you validated the responses for accuracy?
Oh, well, Senator, that process was referring to the fact that we hadn't been able to check with the members as to whether or not they had any discrepancies with the data. As I've indicated, nobody has been able to show any error or correction that needs to be made, but there has been some further contextual information provided by one member. So as I've already said, I'll pass that on to you. But in terms of the validation of the data, it is sound as far as we understand. I'll just ask Mr Matthews to clarify that his team who assisted with this matter hasn't been made aware of any other problems.
Ms Leslie, just as that's a separate issue.
Yeah.
So just before we go to Mr Matthews, that's a separate issue in relation to consulting with members, but in relation to your own obligations to validate the accuracy of the data, has any work been done since these questions were furnished on the 8th of October? What work has been done to validate the accuracy of this information, given you were not able to confirm to the committee on the 8th of October that this information was necessarily correct?
Well, we have a reporting team who do regularly run reports. My understanding is there's no information we've been made aware of at this time that would require correction to the answers that we have provided to the committee. I will go back to our reporting team and ask if there's anything further that has been revealed since we furnished those answers that would require any clarification or correction for the committee.
Have you conducted any work to validate the accuracy of these answers since the 8th of October?
I would need to check with the reporting team what, if any, activities taken in relation to the information that's been provided.
Well, given you've alerted the committee in relation to concerns about the accuracy, what processes are in place to ensure that the AAT is proactively ensuring that information given to our committee is accurate?
Yes, Senator. We do regularly ensure that our reporting is, sometimes there are data entry delays, which might mean that the information that we run a report might change at a particular point in time. I can assure you that we do regularly ensure that the validity of the information that we hold is as accurate as it can be at any point in time. And I will undertake to make sure that we rerun any of the reports that provided the source information for the information that we furnished to the committee. And if there's any departure from that information, we will table a further response to clarify that.
Okay, so under circumstances where you're not certain as to the accuracy of answers given to this committee, what is the process that you follow to ensure to ensure that such answers are accurate?
Senator, we've got 3 different case management systems from which we retrieve the data for this information. Obviously, the database is dependent upon information being input into that by various different members and staff. And so it really is just a case of we're confident about the information being provided at a point in time. There may be some times when we rerun reports, there might be slight discrepancies because of data entry issues. And so we do rerun reports and sometimes need to make adjustments to particular data if there has been a change.
So you're not confident in this email to members because you've said it's not possible to validate it for accuracy. So since the 8th of October, what work has been undertaken by the AAT to validate the accuracy of the questions provided to this committee?
The validation involves, Senator, firstly, inviting members, if their records or their understanding of their workload differs in any way from the material that has been provided there, that opportunity has been given. And I'm not aware that anybody to date has raised any concerns about errors. Otherwise, we are confident that the material now, the data that's been provided is accurate, subject to that qualification I gave about data entry from time to time.
Well, I'm sorry
adjustment.
to harp on this, but you've made it very clear that you could not validate the accuracy of these questions. So now you're saying that you're confident that they're accurate. So therefore, what work has been undertaken since the 8th of October which has given you this confidence, which wasn't there on the 8th of October?
But only one of the 35 contacted.
You know, Senator Carr, if you could just allow me to...
We've been over
Ms.
this
Lethlean.
4 or 5 times.
Senator Carr, could you...
Senator, yeah, the use of the word validate was more an opportunity to make sure that the member didn't have any different information or material or data that conflicted with the material that we had provided. So it was in that sense that I indicated we hadn't had a chance to check with them that our records matched their records, and that is why I left open the opportunity for them to come back if they had any concerns about that.
Ms Lethlean, just another issue. The committee has previously raised concerns about pay rates which are inconsistent concerning part-time members. Some members are sessional members and they get paid on a per case basis. Some get paid on a daily rate basis. This has given rise to some, as I say, inconsistencies and possible unfairness in the way in which part-time members are remunerated. What action have you taken in this regard to address this quite important issue?
Thank you, Senator. And yes, you're absolutely right. There have been a number of legacy arrangements that have been in place for the administering of part-time member payments, depending on which division the member undertakes that work. The Tribunal Leadership Group identified back in late 2019 that it was important that we have a consistent approach to part-time member remuneration. There has now been work undertaken to move all of the part-time members, irrespective of which division they're in, into a single timesheet arrangement for payments. That process is being tested as we speak. So there's been a pilot that's been rolled out with a range of members, part-time members who work across various different divisions. As soon as we're waiting on clarification at the moment from the Remuneration Tribunal determination about a couple of provisions in the determination, particularly around cancellation fees and how they might apply. And then we'll be proposing to roll out that single pay system for all part-time members. And I anticipate that will happen before the end of the financial year, Senator, so that we will retire all of the legacy arrangements and all part-time members will be remunerated in accordance with the same arrangements.
So this issue was first identified back at the end of 2019, is that right?
Yes.
That this was...
Yes, Senator. Yep. It was. Unfortunately, with COVID, we were not able to advance the system as rapidly as we wanted to, but we are now in a position to be able to roll that out before the end of the financial year. It is actually, the current arrangements are integrated with our case management systems, so there is extensive systems work behind the scenes to make sure that we're in a position to pay people the correct amounts. You'll appreciate when it comes to people's payments, we don't want to move until we're confident that the system is absolutely ready.
Can I just finish by asking, we've heard lots about remuneration from different members being paid different rates of pay. Can I just ask, and I'm sure this is on the public record, what's the remuneration for you as the registrar? I would have to actually get that provided to me, but from memory, Senator, it's about the total remuneration package is around $415,000 per year. And including superannuation?
Yes, it's a total remuneration package, Senator.
And is that over...
Somebody's just handing it to me.
And is that, what term of appointment does that involve?
So, Senator, I was initially appointed for a 5-year term, which is the maximum that applies under the AAT Act. And then in April of 2019, I had an extension of a 2-year appointment at that time. So the appointment ends in April of 2022.
And it's 415,000 as a fixed rate per year, including superannuation.
415,680 total remuneration package inclusive of super, yes.
All right, thank you very much. Well, that brings to an end the committee's examination of the Administrative Appeals Tribunal. I want to thank all members of the tribunal, including, of course, the Registrar, for your time this morning and for your evidence. We have run a little bit over, so we will try to catch up during the afternoon. We will now take a lunch break for 1 hour and return at 1:35. Thank you very much. So all are attending remotely by video conference. That's correct?
Yes, thank you, Chair. Sarah Norton. I'm appearing from Sydney.
Good afternoon and welcome. Would you like to make an opening statement?
No, thank you, Chair.
We will now move to questions from senators. Senator Carr.
Thank you very much. I would like to pursue a couple of matters that I have raised on previous occasions concerning the Bernard Keeley issue and witness K. Now, I understand that it's confirmed that the Commonwealth's prosecution in this matter has now cost $3,670,379.91. That's correct, isn't it?
Not the prosecution with respect, Senator.
Yeah.
Our costs are quite different to that. Our external costs are 501,600 and, sorry, I withdraw that. Our internal costs are 501,607 and our external costs are 110,304.
Thank you. It's, would you say that the Commonwealth DPP would consider that you've had sufficient resources to investigate and proceed with all the prosecution briefs that come before you, that is in a timely manner?
Sorry, could you just repeat the question, Senator?
Well, does the Commonwealth DPP consider that you have sufficient resources to investigate and proceed with all prosecution briefs that come before you in a timely manner, as well as having sufficient contingency set aside for any major matters that may come before you requiring substantial additional resources?
Well, in terms of investigation, we don't investigate, so our role is to prosecute. In terms of sufficient resources, in the short term, we have sufficient resources. We have some of our funding measures which end at certain times, so there's a little bit of uncertainty there. They do normally get renewed, but we do feel we have sufficient resourset in the short term, yes, to do our work in a timely.
So it invariably means though that you have to set some priorities. Wouldn't that be a fair description?
In terms, well, we have a target for all our brief assessment matters of 90 days. So we do try and progress our matters as much as we can and not prioritise in that sense. We try to give all our matters priority.
They're all equal priority, are they? Is that what you're suggesting?
Well, of course, some urgent matters have, I mean, because we are operating through the state and territory courts in the main and to a small extent the federal court, we clearly have court deadlines that we have to work towards. And we clearly have issues such as our terrorism matters, etc., which may have particular urgency at particular times.
Yeah.
But we do try and conduct our duties in a fair and equal manner. Yes, Senator.
See, I've been particularly concerned about the cases of Bernard Colliery and the witness K matter. It's some time, and I noticed that this month the ACT Court of Appeal overturned a ruling in that matter. I just wonder, is it correct that the Commonwealth has intervened at several stages to argue for greater secrecy in the prosecution of witness K and Colliery?
Well, it's very important, Senator, with respect to define our terms of what the Commonwealth means in this context. We've got the Commonwealth DPP, which is clearly my office. Then there's the attorney, the Commonwealth attorney, and the Commonwealth attorney has certainly intervened in relation to the issues of what is appropriate to keep out of the public. So there are various aspects clearly in matters involving national security which do require an assessment as to what is and isn't appropriate, is not appropriate.
So is it that many commentators suggested that the interventions, though, have in fact originated from the Attorney General's office. So is that assessment correct?
Well, that's the role that they take in relation to matters under the National Security Information, Criminal and Civil Proceedings Act of 2004. Yes, it's a role that is regularly performed in matters which concern matters such as national security. It's certainly not unique to the Colliery witness K matter. And can I also footnote witness K has concluded. And
yes, I understand that. I understand. I'm just I've just noticed in the press reporting that the court cited the importance of open justice in preventing political prosecutions. This is in the Colliery case, allowing scrutiny of prosecutors and giving the public the ability to assess the accused's conduct. Do you think that's a fair description of the court's ruling?
That is part of the court's ruling, as I understand it, yes. Well, it's a part of the summary. I don't believe that the full ruling is in public yet.
Right.
So that's right. It is our view, though, Senator, if I can say that the prosecution of Mr Colliery, so far as is possible, should be in as much of the public eye as is possible.
Sure. So you would agree with the principle of open justice? Well, not an absolute requirement, it's vitally in principle in our justice system, and beyond that, it's actually essential to our concepts of democracy.
It's a terribly important concept, and there's of course a balance in all matters involving matters such as terrorism, national security, matters of that ilk. There is a balance to be struck, and it's where that balance falls. Yeah.
The previous estimates, I've raised some issues in regard to the prosecution policy of the Commonwealth DPP, which provides a two-stage test which must be satisfied for a prosecution to commence. The first is there's sufficient evidence to prosecute the case, and the prosecution has to be in the public interest. You recall that discussion at the last faculty evidence back in May.
Yes, I wasn't personally present, but my colleague, Mr Bruckard, was, yes, and I have heard that evidence, yes.
So we could notice that in regard to witness K, which court decision to actually spared witness K a prison sentence. It was a 3-month suspended sentence and a 12 months good behaviour order. The ACT court took into account that he was unlawfully revealing confidential information about Australia's action in East Timor. And witness K was motivated by a desire for justice rather than for any personal gain. And that similar matters were canvassed in regard to Keneally. It's in defending himself against the charges. It's understanding that Keneally's not the primary offender, and he's only been charged in relation to his actions representing witness K as his lawyer. That's correct, isn't it?
It's hard to summarise it in perhaps as few words as those, and I suppose it's proper to say that his involvement came about during the course of him being a lawyer in relation to witness K.
Well, remember, we did canvass this whole issue about what is the nature of public interest in terms of your responsibility, and you made it clear that the public interest, while it must have been considered in this matter, that you also, I think the office conceded that it did not consider the broader public interest in regard to prosecution or what damage it was doing to Australia's relations with East Timor. Would that be correct?
Well, yes, and can I also reiterate, and I've said this at a previous estimates as well, that the prosecution policy also contains clause 2.13. A decision whether or not to prosecute must clearly not be influenced by the race, religion, sex, national origin or political associations, activities or beliefs of the alleged offender or any other person involved. B, personal feelings concerning the alleged offender or the victim, or C, possible political advantage, disadvantage or embarrassment to the government or any political group or party, or D, the possible effect of the decision on the personal or professional circumstances of those responsible for the prosecution decision. That's part of the prosecution policy too, Senator.
Yes, I agree. And I'm just wondering, and you did confirm also, though, that it's possible for the Director of Public Prosecution to discontinue a prosecution if it's no longer in the public interest to proceed. In fact, you're obliged to do so, isn't it? That's also correct?
Absolutely.
Yeah.
Yes, that is correct.
So I'm just wondering if we could just go through that. Well, I asked back in May, would you take on notice whether the Attorney-General, whose consent was required to commence these prosecutions, could also withdraw her consent in the prosecution of Mr Cleary, and at which point it would cease. Now, I don't recall, did we get an answer on that?
The attorney, I understand, provided an answer, but yes.
It was an answer, was it?
Senator Sarah Chidgey, Deputy Secretary,
Yeah.
Integrity and International Group. Yes, we did provide an answer.
All
to
right.
that
Well,
question.
I'll get the our assistants here to dig that out for me. So I just want to be clear about how this works. Then, I'm just wondering how it remains in the public interest, given these following propositions. I'll put these to you, and you tell me. There's been a lack of progress in the prosecution, with no trial date apparently set, despite the prosecution having commenced almost 3 years ago now, and there's been, dozens of hearings. There's been an enormous and continuing expenditure of limited Commonwealth resources on this matter, which are in excess of, nearly $5 million with various costs involved. That is, that these prosecutions, in fact, go to matters that were concerning events that occurred 17 years ago, relate to allegations that implicate senior members of the Howard Liberal government in wrongdoing, and noting that, having pleaded guilty, the primary offender in these matters, witness K, was given a 3-month suspended sentence, which is already concluded, and a 12-month good behaviour bond, which the ACT court acknowledged when he unlawfully revealed confidential information about Australia's actions in East Timor. Witness K was, and it was stated, was motivated by a desire for justice rather than any personal gain, and noting that there's been no suggestion that Mr Cleary, who is a respected lawyer and formerly Deputy Chief Minister and Attorney General in the Australian Capital Territory, and who will turn, 74 this year, he doesn't pose any threat to to the country. I was just wondering, given that the court found in relation to witness K there was no suggestion Mr Cleary was motivated by personal gain in any of these actions, could you just tell me how is it that there's a continued public interest in the prosecution of Mr Cleary given those circumstances?
Well, first of all, with respect, I can't confirm some of those circumstances you've put, but I do accept that there is delay in this matter. Part of that delay is because of the particular nature of the matter involving national security matters and also the pandemic. So that is some of the delay in the last few years. The matter of public interest is a complex It is a matter where a whole lot of matters are balanced by our office. We continue to review matters, whether or not they're in the public interest, and we have determined on the material known to us and the seriousness of the alleged conduct that it remains in the public interest to proceed. Further than that, given the matter is before the court, Senator, it's not appropriate further for me to comment.
Senator Carr, we will need to
I'll
move
just
to other
finish. Well,
senators. Could you just perhaps wrap up with this
sure,
last question?
I'd ask the Attorney-General, given those circumstances and given, say, some of the other actions that the government's taken in regard to court action on robo-debt and various other things, there's remarkable double standard here, surely. I'm just wondering, how do you see it? Is there a continuing public interest served by ongoing prosecution in this matter?
Well, Senator Carr, as the Commonwealth Director of Public Prosecutions has stated, the matter is currently still before the court, so we do need to be very careful in what we say. But you would be aware, because you have prosecuted this at a number of estimates, and obviously you've made statements in the Senate as well. But the CDPP considered the briefs of evidence and, as you are aware, made an independent decision that a prosecution was appropriate, having regard to the prosecution policy of the Commonwealth. In relation to your further question, I would refer back to the evidence that has just been given by Ms McNaughton in her capacity as the Commonwealth Director of Public Prosecutions.
Thanks, Attorney. We will now need to move to other senators, and I give the call to Senator McKim, who is attending by way of teleconference. Senator McKim.
Good afternoon to the witnesses. Ms McNaughton, I wanted to explore a similar issue to Senator Carr, and noting that you've confirmed to Senator Carr that there is the capacity for the DPP to make a decision to discontinue a prosecution if it is in the public interest that occur. Can I ask you to confirm, please, that in your consideration of that matter, you are considering all 24 of the criteria that are listed in regards to public interest in the prosecution policy?
Well, in relation to that, there's non-exhaustive matters, first of all, Senator McKim. So there's matters in addition to that which will always be taken into account. And I don't know whether they all apply. So we consider those matters which we believe are relevant.
All right. And could you please, and I'm happy for you to do this on notice so you can think about it and have some time to consider it, but could you please provide the committee with a list of which of those matters you do believe relevant in your consideration of whether it is in the public interest to continue with Mr Caleri's prosecution? And could you also please provide the committee on notice with any other considerations that you have applied that are not listed in those that non-exhaustive list?
Well, Senator McKim, as we are all aware, this matter is a matter which is before the courts. For me to start discussing various matters which go to my decision whether or not to institute a prosecution, when the matter is before the courts as to whether or not the matter is made out, is with respect a matter where I would claim public interest immunity.
All right. Well, I look forward to you providing a detailed claim for public interest immunity in writing so that can be considered by this committee and potentially ultimately the Senate, because I, on the face of it, can't see how you justifying that it is in the public interest to continue this prosecution could possibly compromise in any way the procedures before the court. So I do look forward to you providing that public interest immunity claim in writing. Could I ask, and look, I may get the same response, but I wanted to put to you the comments from the ACT Chief Justice when when a ruling was made to overturn a decision of the trial judge that some of the relevant material in Mr Caleri's trial should remain classified. And the Chief Justice of the ACT said there was a very real risk of damage to public confidence in the administration of justice if the evidence could not be publicly disclosed. Is public confidence in the administration of justice a consideration in assessing the public interest in this matter?
Of course it is, yes, Senator.
So
It's
that
one
is
of the many matters. There's a balance of matters that, as I say, there's a balance of a whole range of matters, non-exhaustive matters, which need to be considered. At the end of the day, it's a judgment call by those in my office making the decision, and we balance a whole range of matters, including the seriousness of the offence and the need for deterrence, as well as other matters. And there's a whole range of matters, Senator.
No, I do appreciate there's a whole range of matters. I'm aware that there is a list of 24 in the prosecution policy, and that is a non-exhaustive list, and I accept that you will need to make judgment calls. What I'm trying to find out on behalf of the committee, and so far unsuccessfully, is which specific issues you considered and how you could possibly come to the view that it is in the public interest to continue with Mr Caleri's prosecution. That's what I'm trying to find out, but you have made a public interest immunity claim, which means that I can't explore that any further in today's hearing. But as I said, I look forward to reviewing that claim that you will make. Can I ask then, in relation to specific matters, is the sentence allocated to witness K in an associated matter relevant to consideration of the public interest?
In relation to, is the sentence in relation to witness K relevant to our assessment of the public interest in continuing our prosecution against Mr Caleri? Is that your question?
Correct.
That's one of the factors which we would be proper to factor into the very many factors, yes.
All right, thank you. And could I ask the Attorney-General, please, does the Attorney-General, separate to the DPP, review the public interest in continuing with the prosecution of Mr Caleri on an ongoing basis?
Senator McKim, as I've stated, the Commonwealth Director of Public Prosecutions, they've considered the briefs of evidence and they have made an independent decision that a prosecution was appropriate, as the CDPP has stated, in accordance with the prosecution policy of the Commonwealth.
Yeah, that wasn't my question, Attorney. My question was, do you, independently of the DPP, also consider whether it is in the public interest to continue with Mr Caleri's prosecution?
Well, the Commonwealth's position is clear, and I have advised the Senate committee previously of the Commonwealth's position. The Attorney-General's power to discontinue a prosecution is reserved for very unusual and exceptional circumstances. And in fact, Senator McKim, there has not been an intervention by any Attorney-General since the establishment of the Commonwealth Director of Prosecutions, either under Section 71(1), I believe it is, of the Judiciary Act 1903, or under the powers provided to the Attorney-General by Section 8 of the Director of Public Prosecutions Act 1983. Again, I believe I did advise the committee of this last time. Such an intervention would therefore be extraordinary and would necessarily, by its nature, represent political intervention in a process which, as I have articulated, has conventionally been one that is independent. And as go back to what I stated, both in response to Senator Carr and now yourself, the CDPP themselves, they considered the brief of evidence and they made an independent decision taking into account everything that the CDPP herself has now referred to, that they would prosecute the matter.
All right, well, I've asked you twice now, and twice you've just answered a completely different question, so I'm going to take that as a
Chair, I
no.
directly answered that
Can I
question.
ask you...
Senator McKim, I would just ask that you not reflect on the attorney in that way. The attorney has answered the question as she sees fit. So...
well, she most emphatically hasn't answered the question, but anyway, can I ask then, attorney, is it the position of the government that the bugging of the Timor-Leste cabinet in 2004 did occur, or is it the position of the government that it did not occur?
Well, Senator McKim, as I have already stated, the matter is before the court, so we do need to be very careful with what we have said. Secondly, this was an independent decision after the CDPP had considered the briefs of evidence, an independent decision made by the CDPP that prosecution was appropriate, having regard to the prosecution policy of the Commonwealth.
Attorney, is it the position of the government that the Australian government bugged the Timor-Leste cabinet deliberations in 2004, or is it the position of the government that it did not bug the Timor-Leste cabinet deliberations in 2004?
Again, Chair, this is a matter that is currently live before the courts. I do not propose to comment any further than what I have already stated.
Oh, well, I'm going to take that as a claim for public interest immunity. So once again, Attorney, I look forward to
Senator
you
McKim,
substantiating that
while I
claim
have
in
great
writing.
Senator McKim, while I have great deference to senators, it's not a matter for you to make that determination or impose that on the attorney. So I'll take that as a gratuitous comment. We've got 1 minute left before I need to go to other senators.
Well, we can talk about that later, Chair, but the attorney is refusing to answer a legitimate question, or
Chair,
at least a
that
question.
is a complete mischaracterisation of my answer.
That needs to be taken as a claim for public interest immunity, but we can discuss that in a private committee meeting. I'm very comfortable with that. And
Well,
on
that's
that
not an
basis,
accurate
I-
characterisation of the minister's response. Minister, do you want to add anything further to that?
No, I've provided
okay.
an answer to the question.
Senator McKim, do you have one last question?
No, Chair, I don't, because
Okay.
the Minister's refusing to answer my questions.
Thanks very much, Senator McKim. I will now give the call to Senator Van, but just before I go to Senator Van, I just wanted to ask Ms McNaughton, could you just remind the committee and those who are listening and for the purposes of Hansard, what this prosecution is about?
In relation to Mr Kaleri?
That's right.
Yes. He has been charged with offences relating to communicating ASIS information contrary to the Intelligence Services Act.
Thanks very much, Ms McNaughton. Senator Van.
Thank you, Chair. Ms McNaughton, does the CDPP make prosecution decisions independent of government?
Yes.
And in the matter of Mr Kaleri, did the CDPP make the decision to prosecute?
Yes.
Thank you.
Subject to seeking the consent as we're required to do under the legislation from the attorney as a final step.
Thank you. How many matters did the CDPP prosecute in financial year 2020-21?
2021. I don't know that I've got those precise numbers
You can
with
take
me,
it
I'm
up.
afraid.
Please take that one on notice if that assists.
Yes. Yes.
What are the different legal practice areas that the CDPP brings to a prosecution?
I'm sorry, I don't quite understand your question, Senator. I mean, I can indicate that my office is divided into a number of different practice groups and that they're broadly under different crime types. Is that what you're getting?
Yes.
Right, so we've got organised crime, counter-terrorism, we've got revenue benefit fraud, we've got commercial financial corruption, got human exploitation, border protection and international import-export. And we've also got international thinking. So IASA stands for International Agencies and Special, anyway, our sort of other matters, or sort of our miscellaneous matters.
Got it. And organised crime and counter-terrorism is a key priority of the government and for the safety of our community. How many referrals were made to the CDPP in 2020, 2021?
I have to take that on notice. And that's not only, so organised crime and counter-terrorism, so they're two different crime types that we deal with together because they've got certain similar aspects to them.
Okay. How many matters does the CDPP currently have on hand?
Again, I could, if unless one of my team can provide that to me quickly, I'd have to take that on notice. I'm sorry.
That's fine. And if you'd also take on notice how that, have both the referrals and matters currently on foot, how they compare to the previous financial year for me, please.
Yes, and are you interested in the complexity? Because we have noticed a change in complexity of the matters over a period of time. So numbers, as reflecting, I think, a previous conversation today, numbers aren't necessarily reflective of the full picture.
And is that something you wanted to comment on now, or something that you take on notice?
We'll take on notice, but just saying that if we give numbers are not necessarily reflective of actual workload, because the complexity is changing.
Okay. Thank you kindly. Thank you, Chair.
Thank you.
Thank you very much, Senator Van. Just checking whether any other senators are seeking the call. No? In that case, we might thank officers from the Commonwealth Director of Public Prosecutions.
Okay, thank you.
Ms McNaughton, thank you very much for your time and for your evidence today.
Thank you, Chair. Thanks.
I'd now like to call officers from the Australian Commission for Law Enforcement Integrity.
So Murray will do this.
Ms Hinchcliffe, good afternoon.
Good afternoon, Chair.
Do you have an opening statement?
Sorry, Chair, I do not have an opening statement.
Thank you. No. Apologies. I understood you had an opening statement.
No.
I'm sorry, I misheard.
No, Chair, I do not have an opening statement.
Apologies, I was waiting. Thank you so much. We will now go to questions from senators. Senator Watt.
Sorry, I might be misunderstanding something here. Ms Hinchcliffe, I can see you're the Integrity Commissioner. I thought we were doing ACLI.
Yes, that's right.
You're handling ACLI as well? Okay, great. It's a while since
Senator,
I've asked. It's a while since I've asked ACLI
Senator,
questions.
I'm the Integrity Commissioner, and the agency that I head is ACLI.
There you go. The last time I was asking ACLI questions, there was someone very different to you sitting in the chair. So forgive me for missing that. I've been there, done that. Okay. Thanks then, Ms Hinchcliffe. I noticed in this year's budget that an amount of $10 million had been transferred from the CIC, which I think stands for Commonwealth Integrity Commission, contingency reserve provision to ACLI for the purpose of funding ACLI's expanded jurisdiction for 1 year, commencing 1 January 2021, pending the establishment of the Integrity Commission. Is that correct?
Senator, we received additional funding in 21-22 of $12.9 million in relation to our expanded jurisdiction. You're correct that that's through an estimates variation from the Commonwealth Integrity Commission budget measure, and that additional funding has been in effect rolled into our base, so it's in the forward years for us, on the basis that when the CIC is established, we will become the law enforcement or the law enforcement division of the CIC.
Okay.
So our funding will move to the CIC.
Right, so that's effectively a bit of a temporary transfer, is it?
Well, it's going out into the forward estimates through the budget papers, but yes, when the CIC is established, we will be rolled into the CIC and our funding will be as well.
Okay, so ACLI, for the moment at least, has absorbed funding that was initially set aside for the Integrity Commission.
Yeah, that's my understanding of how the movement of money's happened, and it's occurred for our expanded jurisdiction. So we had 4 new agencies come within our jurisdiction on the 1st of January this year, and that funding is to resource us for that expansion of our functions.
Okay, and is it also correct that since the 1st of January this year, amendments to the Law Enforcement Integrity Commissioner regulations of 2017 have expanded ACLI's jurisdiction to now cover the law enforcement functions of the Australian Tax Office, the Australian Prudential Regulation Authority, the ACCC and ASIC?
That's exactly right. So that was the jurisdiction expansion that I was just speaking about, and that's what that additional funding relates to.
Okay. And is this the extent of the planned expansion of ACLI's jurisdiction, or is it to be further expanded?
No, my understanding is that's then the expansion of ACLI, and that, as I said, we will then form the law enforcement function or division of the CIC.
Okay. Is it your understanding that this expansion is being carried out consistent with the government's proposed model for a Commonwealth Integrity Commission that was contained in the consultation draft legislation released last year? Is that your understanding?
Senator, as I just said, my understanding is that we will become that law enforcement division. That's using that language that's in the exposures draft of the CIC, noting that at the moment that's an exposures draft.
Okay, so that's the ultimate objective, is that ACLI would be effectively absorbed into the Integrity Commission as its law enforcement division?
Yes, that's my understanding, Senator.
Okay. And how advanced are you now in expanding the jurisdiction that you were granted?
Senator, so we have now brought on the 4 new agencies. They all came into our jurisdiction on the 1st of January. The expansion was announced in the October budget last year, and the additional funding was given to us at that point. So we had, in effect, 2.5 months to bring those new agencies into our jurisdiction. Along with the funding, we were also provided additional ASL, and we have gone through extensive recruitment to bring those additional staff onto into ACLI. We're not quite finished that yet, but we've made significant progress, and I'm happy to provide you with some numbers of that recruitment if that's of use.
Maybe if you just can table those. Yeah.
Of course. I can provide it on notice if that's useful.
Sure. So in summary, what would you say are the major steps that you've taken to give effect to this expansion of jurisdiction?
So there's a number of steps that we've taken. Firstly, we've worked very closely with the new agencies to understand their business, to understand the corruption risks and vulnerabilities that occur in relation to their work, to understand the way that their structures are set up. We've also spent a lot of time working with them for them to understand ACLI, but also understand their requirements under the LEAK Act, the Law Enforcement Integrity Commissioner Act. So agency heads who come within my jurisdiction have a number of mandatory requirements under that Act. Also for them to understand the way that our assessment processes work when they notify us of matters, for them to understand our expectations of investigations when we refer them back to agencies to investigate, or when we have joint investigations with them, and also their obligations in relation to reporting back to me when they conduct their own investigations. So that's part of the work in terms of bringing them on board into our jurisdiction. And then there was a significant piece of work that we've done in relation to our own organisational structure to be able to deal with what in effect has turned out to be a doubling of our size. So we went from being an agency that had a headcount of 50 people at the 30th of June 2020 to an agency that has an ASL of 110. So we're doing significant recruitment to be able to bring us up to our ASL levels. From the 25th of October to the 29th of November, we'll have 14 new commencements. We've got 13 offers at the moment that have been made, and onboarding is in progress. So by the end of this year, we should be close to having 100 staff. For an agency of our size, there's no redundancy to do that kind of work, and it's been a significant piece of work for us. I'm incredibly proud of the work that the agency's done to do this.
Okey-doke. So in essence then, there's obviously the whole debate still going on about a Commonwealth Integrity Commission, what form it would have, legislation, what the legislation would provide, etc. But in the meantime, your agency has obtained funding that was originally to be for the Integrity Commission. It's picked up responsibilities that would otherwise go to the Integrity Commission. Isn't this, Minister, this is probably best to put to you, doesn't this show that the government is just moving ahead with its own weak version of an Integrity Commission when any reasonable commentator has described the model that you've proposed as a toothless tiger and all sorts of other epithets?
I disagree with the proposition that you've put, Senator Watt, and I think the Integrity Commissioner has highlighted that the government has taken substantial steps towards the establishment of the Commonwealth Integrity Commission. And in fact, Chair, with indulgence, I will reiterate the steps that the government has taken in relation to the establishment of the Commonwealth Integrity Commission.
It's 1,000 days since it was promised.
Senator Watt, with all due respect, you asked me a question and I am going to now provide you with the answer. Given what you stated in your preamble to the question, which, as I said, I fundamentally disagree with. As the Integrity Commissioner has outlined, in the first instance, Chair, the government had committed, it was $147.4 million in funding to the Commonwealth Integrity Commission. That included $106.7 million in new funding to the Commonwealth Integrity Commission in the 2019-20 budget. It was also in addition to the existing funding that already existed for ACLE, which was $40.7 million over the forward estimates as at the 2019-20 budget, and that would then be transferred to the Commonwealth Integrity Commission upon its establishment. And as we've just heard the Integrity Commissioner take you through, Senator Watt, in terms of the steps that are going towards the establishment of the Commonwealth Integrity Commission, and in particular the law enforcement function, ACLE does now have an expanded jurisdiction, and that was stage one of the implementation of the Commonwealth Integrity Commission. And as the Integrity Commissioner has stated, on the 1st of January of this year, ACLE was expanded to include, and I think you articulated this as well, Senator Watt, the Australian Competition and Consumer Commission, the Australian Prudential Regulation Authority, the Australian Securities and Investments Commission, and the Australian Taxation Office. We'd also provided ACLE with $54.3 million to support its expanded jurisdiction until the Commonwealth Integrity Commission formally commences. And the evidence that the Integrity Commissioner also gave in terms of the increasing size now of ACLE, they had ASL of approximately 50 people, and what we're now seeing is almost a doubling, in fact it's more than a doubling in size of the agency to ASL now of approximately 110 ASL.
Chair, this is an extremely long answer.
Well, no, Senator, what you made in your preamble, you said that the government was not taking any steps towards establishing a Commonwealth Integrity Commission.
My question was a
And
lot
I'm
shorter than the answer.
Clearly setting out all of the work that we have done in relation to
We have had 1,000
moving
days.
towards the establishment of a Commonwealth
We've had
Integrity
1,000 days. I would
Commission.
hope something's
We've
been done.
also had,
Senator
Chair,
Watt.
as you know,
Senator
exposure
Watt.
draft legislation.
I've done a lot of things in 1,000
was
days.
released. There was substantial feedback provided, and the department has been analysing that feedback, but in particular, the experience of state and territory anti-corruption bodies. And around Australia, Senator Watt, I mean, you'd be aware, you've got one in Queensland that's different to, say, the one in Victoria or the one in New South Wales. And so when you look at the experience of state and territory bodies and the different procedures and processes that they have in relation to each one, it shows how important it is to get the model right. So I am currently considering the feedback provided in relation to both the state and territory anti-corruption bodies, but also the extensive feedback that was provided during the extensive national consultation on the exposure draft legislation.
You and I
Senator
both...
Watt, just pause for one moment. We have gone well over time, but I'm going to give you a bit of grace, and could you just perhaps ask one more question in this block?
Yeah, we'll no doubt have a further discussion tonight when we get to the department about these issues, but you and I both know that the feedback the government received from its consultation on its proposed model was, on the whole, scathing of what was being proposed. You haven't even introduced legislation into the parliament, having promised that we would have a commission in place during this term of government. And in the meantime, the government is going ahead shifting resources to ACLI, giving it a bit of an expanded jurisdiction because it knows it has no intention of actually putting together a proper integrity commission. That is just a fact, isn't it?
I fundamentally disagree with what you've stated, Senator Watt. I've just outlined the government's position in relation to the establishment of a Commonwealth Integrity Commission.
I mean, you're setting up
Senator
a
Watt,
weaker model.
We will need to share the call around, and I'm now going to move to Senator Scarr. I give the call to Senator Scarr.
Thank you, Chair, and welcome, Commissioner. I have to try and be objective as I ask these questions, but I do feel a bit proprietorial as Chair of the Joint Parliamentary Committee with oversight of ACLI, and I'm just so impressed at the job that you've done and your team has done in terms of preparing for the introduction of the Commonwealth Integrity Commission. I want to ask you about the expansion of the jurisdiction first, in terms of including the law enforcement officers of ASIC, APRA, ATO and the ACCC, I think. What's your assessment of how those agencies themselves are adapting to the expansion of ACLI's jurisdiction to include law enforcement functions within those agencies? How are they responding to the increase in ACLI's jurisdiction?
Thanks, Senator. The feedback that I get from the agency heads of those agencies is that they welcome the oversight of ACLI. They want to work closely with us. They understand the partnership model that is created under the LEAK Act, and we've had very good engagement from them. It is a different regime in relation to what they've necessarily had before. There are, as I said, a number of mandatory obligations on agencies under the LEAK Act, but my sense so far, noting that the jurisdiction started in January and we're only in October, is that the agencies have been particularly engaged and supportive of our jurisdiction.
Excellent.
Senator Scarr, my apologies. I just wanted to ask any witnesses who have come on, and I think Ms Fewings from the Federal Court, just if you could turn your camera off so you're not sort of remotely appearing at the table. Thank you. That would be appreciated. And you're saying, oh dear, I don't know how to turn my camera off. I'll let you work that out.
I was wondering when Ms Fewings had joined ACLI.
Oh, well done.
The Commissioner did refer to extensive recruitment.
One of the tricky issues with remote attendance is we just like to have those who are appearing from Ackley at the table, remote table at the moment. Thanks very much, Senator Scarr.
Thank you, Chair. You made mention, Commissioner, of the expansion of your numbers from 50 to 110 and the other preparatory work you've been doing. And that preparatory work is on the basis that the Commonwealth Integrity Commission is going to be established and Ackley will form one of the two divisions of the Commonwealth Integrity Commission. That's right, isn't it?
That's right, Senator. And we're being quite forward-leaning in relation to this. So we are doing a lot of work internally at the moment, which is about making our processes fit for a expanded Ackley, but wherever possible, thinking ahead into the coming year of an implementation of a CIC and making sure that whatever we do now is going to be fit for purpose for, again, another expanded agency.
Right.
So whatever we can put in place now that will help with the implementation of the CIC, we are doing.
Excellent. So the work you're doing now, just to be clear, is on the basis, the operating assumption, until something else happens, you're not aware of anything, is that the CIC is coming, the Commonwealth Integrity Commission is coming, and you're doing work in preparation for Ackley to form one of the two divisions of the Commonwealth Integrity Commission. Is that correct?
That's exactly right, Senator. And you can see that through our corporate documents. Our corporate plan mentions the work that we are doing to get ready for the implementation of the CIC. Our annual report this year mentions the work that we're doing to get ready for the implementation of the CIC. We're doing whatever we can now to make sure that not only can we go through this expansion that we need to go for Ackley, but whatever we can put in place that is going to support an even bigger agency, we're making sure that we do that now.
Excellent. And one of the things I've been impressed, Commissioner, is the rigour with which you and your team have taken to looking at standard operating procedures, the processes to triage referrals, etc. Is that all work that's going to assist in terms of the establishment of the Commonwealth Integrity Commission, making sure it's got systems and processes in place which are appropriate to enable it to do its job as efficiently as possible?
Yeah, absolutely, Senator, and that's what I'm talking about as well in terms of making sure that whatever we put in place now is going to be fit for purpose for a larger organisation. That's particularly true in our corporate side. A lot of the work that we're doing there to ensure that all of our corporate governance is fit for purpose for not only this expanded Ackley, but a much bigger CIC. In the operational side, we also think in those terms. It may be, and it will depend on what the CIC looks like, at the end of the day, that there will be some differences between the two divisions, and so you'll need to have some differences in process. But wherever we can possibly pick up something that Ackley has done and be able to use it on for both divisions, it seems to me that is a much more efficient way of doing it.
Excellent. There's just one other area I want to touch on, and that is the area of public hearings. Now, during your time as Commissioner, have you seen the need to hold a public hearing? And in relation to any decisions you have made in that regard, what are the factors you consider as to whether or not a public hearing should be held or whether or not it should not be held?
Sure, Senator. Under the Leak Act, I have the power to hold private or public hearings, and the way that I read those provisions in Part 9 is that first I need to make a decision whether or not a hearing is required, noting that hearings are a coercive power where someone must appear before me and they must answer truthfully, and the rules about self-incrimination are done away with. But the quid pro quo of that, of course, is that any incriminating evidence that they might give cannot then be used against them, except in relation to false or misleading statements that they might make. So it's a coercive power, and I take that very seriously. So the first part of that test is a hearing required to obtain the information that we need? There is absolutely times where a hearing is required, where we've tried a number of other investigative steps, and the last remaining step is that we require a hearing, or where a person has been very clear to us that they won't provide us the information unless use a coercive power because they want the protections that are required under that. So hearings are absolutely an important part of our toolkit, and we use them. So first I decide whether a hearing is required, and then the LECAC sets out a public interest consideration that I must have in relation to whether or not the hearing is held in public or in private. And I go through that consideration for every hearing decision that I make.
So in your time as Commissioner, you haven't seen the need to actually hold a public hearing as opposed to a private hearing?
In my time as Commissioner, I've only held private hearings, that's right.
Right. And in terms of prior to your coming on as Commissioner, has
I'm
ACLEI...
unaware that ACLEI has ever held a public hearing.
So ACLEI has never, even though it has the power to hold a public hearing, it's never seen fit, or the Commissioner, whoever, yourself and your predecessors, have never seen the need to actually hold a public hearing in order to discharge your obligations. Is that correct?
Senator, my understanding is public hearings have never been held. That's
Okay.
correct.
Thank you very much.
Thank you very much, Senator Scarr. Just a couple of questions from me, Commissioner. Could you just in summary explain the breadth of your corruption prevention responsibilities?
Thank you, Senator. The longer that I'm in the job, the more I think that really the bang for your buck is in the corruption prevention space. So we absolutely must do the individual investigations, and those investigations help us to see individual matters. But it is that corruption prevention piece to be able to talk to agencies about where the corruption vulnerabilities lie in their agencies, to be able to provide them with support in relation to those vulnerabilities, to be able to provide best practice information, and also, again, to be forward-leaning into the rest of the APS. So not just to focus on our law enforcement agencies, but to be sharing information across the APS about corruption vulnerabilities that we see and the ways in which to deal with them. So we have a very small corruption prevention team, and the expansion is enabling us to make that slightly bigger. They run a number of different activities. One of the activities that is highly valued by agencies is the corruption prevention community of practice that we run, where we bring together staff from across each of the agencies that are in our jurisdiction to talk about a number of corruption vulnerabilities that we see and to talk about best practice across the jurisdiction so that people can go back to their agencies and to be working proactively on corruption prevention within their agency. My corruption prevention team at the moment is working on the ABSEC conference. Now I'm going to get the acronym wrong. This is the Anti-Corruption Australian-wide conference that is held every 2 years. Next year it will be held in November 2022. ACLEI and New South Wales ICAC and LEC in New South Wales will be co-hosting that, and my corruption prevention team are running that. The corruption prevention team provide comments and identify corruption vulnerabilities on each of the reports that we write in relation to investigations that are completed. And they also produce a vulnerabilities report each year, though we've had feedback from agencies that they would like to have that more as a real-time product. So we're looking at trying to move from a yearly report to a quarterly report.
Commissioner, can you give me some examples of how you are working with agencies to prevent corruption before it arises? Just a practical example of the sort of information that you are conveying to alert officers and members of the public service that there may be a corruption risk.
Absolutely. So we have a number of fact sheets on our website that talk about the corruption vulnerabilities that we see, and that's always interesting for people to go and look at. But what has some real power is when we can provide products for agencies where people talk about real-life examples of experiencing corruption and how that occurred. And at the moment, we're working on a video with one of our agencies, which we will use through our agencies, which involves someone that we investigated and prosecuted, providing a discussion about how they were groomed and what that then led to and what impact that's had on their life, and a very clear message of if you think that it's too late to speak up, it is not too late. You are never in too deep to say to someone, I think I'm in trouble.
So this is about identifying concerning behaviour in the workplace, making sure that people know that if something looks not quite right, that they should be very alert to possible corruption, and encouraging people to take proactive steps before things happen that shouldn't happen.
Exactly. And people understanding their responsibilities and understanding that message that it is never too late. If you have done something wrong, it is never too late to speak up and then try to fix it.
So I realise obviously there's been a lot of debate about the introduction of a CIC, but the fact of the matter is that ACLEI represents a very strong commitment by the Commonwealth to combat corruption.
Senator, we have a clear mandate in the LEAK Act in relation to the law enforcement agencies, and we're carrying out our role.
Can you give me a little bit of an overview of the sorts of activities that you've undertaken in terms of actually combating and prosecuting corruption?
So, Senator, we have four key activities that we undertake. We assess the notifications and referrals that come to us to determine whether or not they're a corruption issue and then to decide how to deal with them. We conduct our own investigations. We send matters back to agencies for them to conduct investigations, and we support agencies in their conduct of investigations, and then we also have our corruption prevention role. In relation to the prosecutions and the reports that we put out, at the moment we have 4 defendants before the courts in relation to a range of matters that are across the country. I might say, in fact, all of the prosecutions that we have at the moment are in a different state or territory. And we provide, as I said, reports to the Attorney-General in relation to the completed investigations that we undertake. So far this financial year, we've provided 5 reports to the Attorney-General. 2 of those we have already published. We go through a secondary procedural fairness step before we publish any report. We have 2 reports that we are in the process of that step with, and 1 that we will just about start.
Well, Commissioner, thank you so much. That brings to a close my questions and questions from senators. We really appreciate your evidence and your time today.
Thank you, Attorney.
Thank you.
Thank you.
It's now my pleasure to call officers representing the Federal Court and the Federal Circuit and Family Court of Australia. All of whom are attending remotely by way of video conference. Good afternoon to officers from the Federal Circuit and Family Court and to the Federal Court. Would anyone like to make an opening statement? Just also a reminder that when you introduce yourself for the first time, and also when you are speaking, if you could just identify your name because of the slight complications of attending remotely.
Good afternoon, Chair. Good afternoon, Senators. It's David Pringle here, CEO and Principal Registrar of the Federal Circuit and Family Court of Australia. I do have a short opening statement of around 5 minutes that I'm happy to give to the Senate, and I should just clarify I'm here with my fellow witnesses today as well. That's Virginia Wilson, Deputy Principal Registrar, Anne-Marie Rice, Senior Judicial Registrar and Executive Director of Dispute Resolution, Lisa O'Neill, Senior Judicial Registrar and Family Violence Specialist, and Janet Carmichael, Executive Director of Children's Service.
Thanks, Mr Pringle. Off you go.
Thank you. I should clarify that I address you from an administrative and operational perspective on behalf of our courts. While we remain focused on risk, responsiveness and modernisation, the period since we last appeared before you in May has been a truly momentous time for our courts. On 1 September, the amalgamation of Family Court and the Federal Circuit Court took place, creating a new structure, the Federal Circuit and Family Court of Australia, otherwise known as the FCFCOA. To our understanding, we are now the largest court in the country with around 120,000 filings per annum and over 100 judges. We have an exceptional team of judges, judicial registrars, court child experts and staff, servicing litigants across 43 locations, many in regional Australia, and covering a wide variety of important areas of law, including family law, migration, workplace, bankruptcy and consumer law. This reform of the courts took effect in a relatively short 6-month period, thanks to the hard work of our judges and staff and the leadership and vision of Chief Justice Alstergren. In that time, the entirety of both courts' family law rules were finalised into one harmonised set of rules, the first time in 20 years that this has occurred. These rules were extensively consulted on and have been widely supported. We also revamped our entire set of practice directions with new central practice directions for each of our family, migration and general federal areas of law. Every form for filing was rebuilt, and our 2 old websites were discontinued and replaced with one modern website with easier to navigate pages and new tools such as informative videos. Much of these changes were only possible due to the dedication and skill of the federal court entity staff who provide many of our technical and corporate resources. It must be noted that the court undertook these reforms whilst calling over some 7,000 family law cases for special case management hearings and maintaining a 96% clearance rate, notwithstanding the impact of COVID-19, which required us to repeatedly adapt to changing restrictions and lockdowns in different locations, so as to ensure access to justice for all Australians. In the same period, made possible by the funding from government provided in the May budget, the FCFCOA expanded its judicial registrar cohort, including those in the senior group, by approximately 1/3, with a similar growth in our court child experts. 2 Deputy Chief Judges have been appointed to Division 2 to help manage family law and general federal law respectively. There have also been the appointment of 19 family law or general federal law judges over the last 6 months, including new judicial positions. And in fact, since March, that's 24 judges. These judicial and registrar resources have covered many areas, including cities such as Sydney, Hobart and Adelaide, and regional locations such as Newcastle, Lismore and North Queensland, and have underpinned the court's transformation, providing the specialised skills necessary to support these significant reforms, the centrepiece of which is the Chief Justice's new family law case management pathway. Under that new pathway, the heavy workload of judges is being alleviated to allow judges more time to focus on trials and judgments and to list their hearings sooner. Already, less than 8 weeks into the reforms, average docket numbers have reduced considerably. This has been achieved by our skilled body of family law registrars taking on new categories of work, including busy duty lists and many interim defended hearings, as well as through a significant growth in safe court-based dispute resolution, minimising costly and stressful litigation. Additional court child experts, Indigenous liaison officers and support staff are also providing critical support for the new case management pathway. With these resources, other important initiatives have also been implemented. This includes the expansion of the COVID-19 list, which allows for an initial electronic hearing before a judicial registrar within days of an application being filed, and the creation of a new national contravention list to deal with non-compliance with family law parenting arrangements and other court orders. Previously, contravention applications took many months to be heard, and they can now receive an initial electronic hearing soon after 14 days in all locations. We have also continued the incredibly successful pilot projects in family law, the Lighthouse Project, and the Small Property Claims PPP 500 project. In general federal law and migration, we will now commence a thorough review of our rules and practice directions. Recent judicial and registrar resourcing will also assist to tackle the growing backlog in migration cases. Briefly, I should address two very important other areas, the first relating to ensuring a safe and respectful workplace environment with the courts. In June last year, the Chief Justice appointed a number of judges, registrars, senior staff and a former judge, the Honourable Jennifer Coate AO, to a Judicial Conduct Committee. That committee's mandate was to review the court's judicial complaints procedures, policies and educational strategies. I'm pleased to confirm that additional training has been undertaken and 2 new complaints and workplace conduct policies were released on 9 June this year, which are victim-focused and adopt a no wrong door approach with regard to making complaints of inappropriate behaviour about any person. These policies also set out the process for making any complaint about a judge and reflect the court's zero tolerance policy approach to inappropriate behaviour to ensure a safe and supportive working environment for all. Finally, and notwithstanding all these successes, it must be remembered that there remain significant challenges for the FCFCOA, including in the area of family violence. The Lighthouse Project demonstrates that more than 60% of our parenting disputes screen as high risk. Data from over 12,000 electronic notices of risk filed in parenting disputes shows that nearly 80% of our matters involve at least one major risk factor, including child abuse, family violence, mental health issues, alcoholism or other substance abuse. And nearly 1/2 of such matters have 4 or more of those risk factors in them. Now, with the bedrock of a new and more effective case management system in place, the immediate challenge for the FCFCOA is to ensure that these complex cases receive careful and nuanced case management, tailored to fit the needs of each case, regardless of where those cases arise, in our cities or our regions, and importantly, for our Aboriginal and Torres Strait Islander peoples. Naturally, in order to support vulnerable people and deal with complex risk scenarios, additional resources will be required, including for the expansion of the Lighthouse and PPP 500 projects. And we welcome ongoing discussions with government in that regard. This is indeed an exciting and momentous time for the FCFCOA, one filled with not only steely determination to meet the challenges that lie ahead, but great hope and optimism arising from the ongoing and effective transformation of our policies and case management practices in all areas of law. Thank you, Senators.
Mr Pringle, thank you so much. It is indeed an extremely exciting and momentous time for the newly merged court. I do want to also check if the federal court has an opening statement. Ms Lagos, Mrs Fewings, I know you're there, starring.
Senator,
Yes.
I'm from the National Native Title Tribunal, but my colleague Sia Lagos, the Registrar of the Federal Court, is having communications difficulties, I think.
Is it? Do you know whether Ms Lagos does have an opening statement?
Mr Treadwell will.
Miss Lagos.
Scott Treadwell, General Counsel with the Federal Court of Australia. Sia Lagos, unfortunately, is having some issues getting into the meeting through WebEx. which we're trying to resolve at the moment.
All right, thank you. Well, look, we'll move to questions from senators. If you could, if you do have an opening statement, perhaps we could table it, or you could pass that through to the Secretariat. But we'll move to questions from senators now.
Thank you.
Thank you so much. And I give the call to Senator Grogan.
We are running somewhat behind, so I've just got a few questions. The Family Court Annual Report and the Federal Court Annual Report from 2021, I will note that this is the last time that these two courts will provide their reports separately and express some sorrow for that. Just quickly on the highlights that you have in the Family Court's Annual Report, which does include 83% of judgments being delivered within 3 months, 22,331 applications being filed, and an increase of 412 Twitter followers. I'm wondering if that's a little bit of humour thrown in, or was the small increase in that number of people following the Family Court's Twitter account actually a significant highlight of the year?
Senator, thank you for your question. It's not an attempt
Mr.
to
Pringle,
humour.
just so we can identify Mr. Pringle, thank you.
I'm sorry. We do take the use of social media very seriously, the obligations the court has in communicating with litigants in the profession. So no, the reference to the Twitter followers was to show that we are engaging in an electronic method on multiple levels with the profession and court users.
And do you find Twitter as a useful channel for that engagement?
Indeed, it can be. In fact, it can be an effective way of getting out a link to various other more detailed information that might have been posted on the website or media statements and the like.
Thank you. I didn't see any reference to the Family Court in the Family Court's Annual Report to the Morrison government's announcement on the 8th of October 2020 regarding the Family Court facilities in Launceston. I didn't see it in the Federal Circuit Court Annual Report either. Christian Porter announced $5.4 million for a new court facility over a year ago. Can you take us through what's happened since then?
Yes, I might ask my colleague Virginia Wilson to assist in a moment, but certainly there's been progress made. A new court building needed to be identified, and then of course a leasing arrangement negotiated. So that process has been underway, but I can...
Sorry, can I just interrupt you? You cut out there for me a little bit. Did you say you've identified a building already, or you still have not identified a new building?
Yes, that's my understanding. Bear with me a moment and I'll ask Ms Wilson to just confirm, please.
Ms Wilson, did you hear that question?
Yeah, sorry, there was... Virginia Wilson, Deputy Principal Registrar at Federal Circuit and Family Court of Australia. Like Mr Pringle, there was a cutout for a little bit there. So sorry, could you, if you wouldn't mind, Senator, if you could just repeat that?
Yes, of course. I'm wanting to know if the announcement of the $4.5 million of funding for a new court facility in Launceston, what has actually happened since then? So the announcement was over a year ago, I believe it was the 8th of October 2020.
Yes, Senator, there has been quite a lot of progress here. With being a Federal Circuit Court and Family Court of Australia, we're working with the Federal Court entity, and they've responsibility for provision of corporate services, including the property responsibility. Now we're up to the stage we're up to with Launceston. Premises have been identified. There is work at the moment in relation to plans in relation to those premises.
Okay, so you've identified, that sounds not great. You've identified a premises, and at what stage are you? How long do you think it's going to be before you land that?
Senators, David Pringle here. I might ask Sia Lagos, who I note has joined us, who heads the Federal Court of Australia entity as well as the Federal Court CEO, to refer to those matters as they deal with building and those sorts of property matters.
And Ms Lagos, welcome.
Thank you, David, and thank you, Senator. Thank you. My apologies for my technical issues. Can I advise, Senator, that there has been extremely good progress in the time that we've been undertaking this task, and we're expecting those building works to be completed in the early part of next year. Having undertaken securing the premises and engaging the various, going through probity and procurement processes, so we're hoping that the building works will be finalised early next year.
Okay. So,
Ms Lagos, apologies, Senator Grogan. At the conclusion of Senator Grogan's questions, if you have an opening statement, we might need to move to that. Can you just indicate whether you do have an opening statement?
No, thank you, Chair. No,
Right.
I tried to say, despite my technical difficulties, there's no opening statement.
Thank you very much. Thanks for that clarification. Senator Grogan.
I just a level of concern really. For years we've seen people express concern about the facility in Launceston. It's small, there's only one waiting room, there's a shared entrance, shared exit, shared lift, and from your own highlights, there's a significant amount of traffic goes through your facilities across the country. And in Mr Pringle's opening statement, he also referred to the very high level of at-risk cases, family violence cases, etc. And all of those people going through such a tiny facility. There have been issues there, quite a number of issues there over the last few years, and just very concerned at the length of time this is actually taking. Can you be more specific in terms of when we're likely to see a genuine change in the facility in Launceston and a new facility being open?
If I could take that element of the question on notice and provide you with more specificity in terms of the actual concrete next steps, but I can give you assurance that this is a priority project. Those concerns that you've articulated have been well and truly addressed in the planning for what is going to be the reconfigured premises, and it is an absolute priority in terms of what is needed to be done, and we're anticipating that early next year those works will be completed and the building operating in the manner that it needs to, with all of those safety and security measures in place. But I can be more specific in terms of precisely where we are in the actual detailed steps of the process, and take that on notice.
Yes, that would be great if you could take that on notice, because we do believe this should be an absolute matter of urgency for yourselves and also for the Morrison government, given the issues we've seen. I'll place the rest of my questions on notice. Thank you, Chair.
Thank you very much, Senator Grogan. Senator Scarr.
Thank you, Chair. Ms Lagos, just in relation to the Launceston premises, it just seems to me from that timeline that actually very good progress has been made and is being made in relation to establishing the new premises. So from your perspective, everything's going according to plan and as quickly as it reasonably can. Is that correct?
Absolutely so, Senator. It has been prioritised, having regard to the concerns that were applicable to the building as it was operating. It has been absolutely prioritised. Funding is secured, has been earmarked, and the process is well underway. And as I can only state, I'll be very precise in the response to the questions on notice in terms of precisely where we are, but I can assure you that our Head of Corporate Services has prioritised this piece of work.
Excellent. Thank you very much. Excellent. Thank you. Mr Pringle, I've got a few questions for you, and I'll introduce them by taking my hat off to the attorney in relation, she's now looking at me, in relation to the flood of judicial appointments we've seen since you became attorney, and if I can congratulate you for the great work you've done in that regard. It's terribly important, and I really do congratulate you on that. Mr Pringle, can I ask you how many new appointments have there been in Division 1 and then Division 2, and if you can outline the differences between the two divisions?
Senator, thank you for your question. Could you clarify?
Yeah, so if you can give us how many judges have been appointed to Division 1 since the establishment of the Federal Circuit and Family Court of Australia, how many have been appointed to Division 2 and the total of the number of judges in Division 1 and Division 2 now? Does that make sense?
It does, thank you, Senator. I can clarify that the present number of judges that have been appointed to Division 1 is 34, including the Chief Justice and the Deputy Chief Justice. And the total number of judges that have been appointed to Division 2 are 70, which does not include the Chief Justice or the Deputy Chief Judge. So the present number in total of possible appointments is 35 in the Division 1 and 75 in Division 2.
35 and 75, so that's a total of 110. Is it correct to say that you now have more judges than any point in time in the history of the court?
To be 100% certain, I would have to check that and put it on notice, but my understanding is that's correct, Senator.
Okay, and then in terms of gender diversity, have you got the breakdown in terms of male, female judges in terms of each of the two divisions?
Bear with me, I will check that for you. I'm sorry, Senator, I don't have the gender breakdown for you, but I can indicate that in the recent number of appointments there has been a high proportion of female appointees.
So in terms of recent appointments, do you have the proportion to give us a feel in terms of gender diversity?
I would have to count those out for you. If you don't mind, I do have support staff here with me. We could perhaps do that in the background and come back to that one shortly. Or
that's okay. No, it's just if someone could do that in the background and just tell me when you have the answer, that'd be useful, just so we get it on Hansard. I'm really interested in some of the, and you referred to them in your opening statement, quote, incredibly successful pilot projects in family law, end quote. And you refer to, in particular, the Lighthouse project and the Small Property Claims project. In relation to the Lighthouse project, at what stage in the progressing a project such as this, where it's a pilot project and you're assessing the success of the project, does it transition to become something which becomes more of a fixture of the court? I'm wondering if you can give any indication as to your thinking or the court's thinking in that regard.
Yes, certainly, Senator. In regard to the Lighthouse project, which really is groundbreaking, not just nationally but internationally in terms of what it seeks to achieve, we believe that we've seen enough of the project roll out and the implementation be conducted successfully to suggest that it's a very successful project, that it has all of the elements that would suggest it will succeed with the rollout to other registries. It's presently in 3 registries only, and we believe that in the very near term we would be in a position to be able to expand that to all registries right across, plummet into the operations of the court. Ultimately, what it allows the court to do is to drill deeply down into assessment and triage of family violence and other key risk factors, and then to allow us to pick an appropriate case management pathway to deal with those cases. So we believe we have seen enough in terms of the operation already, even though it continues to improve as it goes. But also there's been an interim draft report provided by the independent evaluators, which is very supportive of the project itself and the way it's been implemented.
Excellent. And in relation to the Small Property Claims project, and just by way of introduction, I suspect everyone on this committee would like to see people going through an issue which requires a property claim to be settled, to have that settled as efficiently as possible with a minimum amount of fees being paid to lawyers and the maximum amount distributed to the relevant parties. Can you give us an indication as to how that project's going on a pilot basis? And again, what do you see the pathway in terms of it becoming potentially a more permanent fixture or as part of the court?
Yes, Senator, the PPP 500, which deals with property pools or asset disputes of $500,000 or less. So you can imagine how quickly that level of assets could be dissipated or impacted by litigation. That has been perhaps our most successful pilot ever run. It runs in 4 registries across the court. It is showing at this stage through registrar-led case management and dispute resolution that 75% of those matters are dealt with only 1 or 2 court hearings usually, and then off to dispute resolution without the need for any involvement by a judge, saving a lot of judicial resources in the process and allowing those judicial resources to then be targeted towards other cases. So the speed, the cost effectiveness of it, and the fact that many of them, in fact, most of those matters resolve now through dispute resolution, which allows the parties to actually have a contributing hand to their future outcomes, means that it's going exceptionally well. And we again believe that that can be rolled out to all registries across the country very, very effectively.
Excellent. And you touched upon judicial resources being used efficiently. And I think, Mr Pringle, last time you appeared before this committee, I referred to the fact that I'm a big fan of registrars, and feel free to take that personally, and all registrars on this video call should take that personally. Can you please explain from your perspective how the appointment of additional registrars has actually boosted the efficiency of the court and also helped assist in freeing up judicial resources for the more complicated cases? Not that the registrars wouldn't have the capability to undertake complex casework themselves.
Can we just first establish there was an increase in registrar?
So Senator Patrick's also just interjected to us to confirm there has been an increase in the number of registrars. So if you could address that as well as part of your answer to the question. Thank you.
Thank you, Senator, or Senators, I should say. Just dealing with Senator Patrick's question first, there most certainly has been an increase in the number of registrars. Again, the funding has helped to facilitate that. It's grown by approximately 1/3 since the funding was provided, and that has enabled our registrars at a number of different tiers. So from our senior judicial registrars, sessional registrars and deputy registrars, all to take on new categories of work. Now, in short, that's in 3 core areas. They can take on the front-end triage work, first return hearings that are really very busy and take up a large amount historically of judicial resources. They've already moved since 1 September into that space. They can deal with a lot of interim defendant hearings, that is our senior judicial registrars, again, most of which were being done previously by judges. They can take a very significant proportion of that. And then finally, they can do dispute resolution together with our court child experts to help resolve cases earlier. The net effect of all of that is that judge time can be saved at the front end and in all of the interlocutory fights that happen during proceedings, so that they can list their hearings earlier and deal with their judgments as soon as they possibly can. And secondly, pardon me, there's a bit of feedback there. And secondly, they can also deal with dispute resolution, which when you settle cases early on in a proceeding or earlier on in a proceeding, what it does is save a huge amount of resources downstream that would otherwise impact our judges and others within the court. So it's good for the court resources, but it's also much, much better for the litigants who, of course, will spend a lot less money and be affected from a stress and anxiety point of view much less.
So it's fair to say it's almost like a virtuous circle, isn't it? The reducing the waiting times, the pressure on the judicial resources, the stress on the litigants. It's a virtuous circle in terms of the positive impact of this reform. Is that a fair comment?
Yeah, absolutely. It has a sort of a growing impact. At the moment, we have a very large amount of legacy caseload from the old system, which we've got to work through. But once we get through that, more significantly, you'll see the full efficiencies of this new system. Already, though, it's having an impact. I did mention in my opening statement that docket numbers are reducing. They've reduced quite significantly from something like 330 on average prior to these changes on 1 September to now around 265, and we're less than 2 months into the new arrangements. So we'll continue to watch the data because it's quite early, but they're very good early indicators.
So I'll just finish on this point. Just that reduction in docket numbers, which you referred to in your opening statement, you said less than 8 weeks into the reforms, average docket numbers have reduced considerably. The numbers you just gave then, as I took them down, were a reduction in average docket numbers from 330 to 265. So that's approximately a 20% decrease in docket numbers for each judge. Is that correct?
Across the board, if you average it out, obviously there'll be different numbers within different types of dockets, but that's right, Senator. And of course, the additional judges that have been appointed would assist with that as well.
Okay, all right. If I can just congratulate everyone who's been involved in terms of bedding down the new court, including coming up with one set of court rules, which I think is an astoundingly positive achievement, given all the stakeholders had to be consulted in that regard. And I'll go back to the chair. Thank you.
Thank you very much.
Thank you. And Senator, Chair, can I just note I do have an answer for the Senator's question in regard to gender split. My staff have been very helpful
thanks
in the
very much,
meantime.
Mr Pringle.
Thank you.
Go
I
ahead,
understand
please.
that in regard to the most recent rounds of appointments, in Division 1 there were 2 female and 3 male, and in Division 2 there were 5 females and 1 male.
Excellent. Thank you.
Thank you so much.
You're welcome.
I will now give the call to Senator Patrick.
Yeah, thank you very much. Just to clarify, you said 34 Division 1 justices.
No, I think the figure was 35.
Well, he said 35 as well. So is there 34 placed but 35 positions?
Actually, Mr Smirtle, on that point, could I maybe ask if you're able to clarify the number of Division 1 and Division 2 judges? I think the evidence, I'm sorry, I heard 35 in Division 1, 75 in Division 2. Can you confirm that that's correct?
I can clarify the difference between those numbers, Chair, if it helps.
Right, thank you. Can you give confirmed figures, Mr Pringle?
Yes, so because of recent appointments that require now, they only just happened not that long ago, some of them need to be refilled. The higher figures were the total possible judicial numbers, and the lower figures were the actual numbers that we have at the moment. So 34 is the current number of judges in Division 1 for a maximum of 35. 70 is the current number of appointments in Division 2 for a maximum of 75.
Thank you very much.
Now,
Senator Patrick.
That's where I was trying to get to as well. So,
yes, thank you.
So I just want to go back. It's not clear to me, since the passage of the bill in February 21, so February this year, how many appointments have been made to Division 1 and how many have been made to Division 2?
Senator, I've got that information in front of me. I believe in Division 1.
Senator Patrick, just to
I think
help
Dr.
Mr
Smirtle
Pringle.
may have some information that may assist
Thank
the
you.
committee to make it a
Just
bit
for
easier.
what period of time are you wanting those appointments?
Well, since the passage of the legislation, which was February this year.
Thank you. Mr Smirtle, are you able to provide some accurate figures?
Okay. Alban Smirtle, Assistant Secretary, Legal System Branch. In relation to Division, well, if we're looking at it from the commencement of the legislation, which was the 1st of September, there have been 5 appointments made to Division 1, and in relation to Division 2, there have been 8 appointments. That includes also that there have been 2 Deputy Chief Judge positions created as a result of the bringing together of the 2 courts. So that's 2 Deputy Chief Judge positions and also 6 additional new appointments made.
So, Mr Smirtle, the Law Society at the time of the merger put out a press release saying the merger would collapse the family court into a generalist, chronically under-resourced and overburdened FCC. Has that occurred?
Senator, I think this is sort of ground that's been well trodden over the passage of the reforms. I think the evidence that Mr Pringle has provided shows that the court is going very well, and that the ability of allowing a single point of entry, single set of rules, common case management, practice and procedure is all working very efficiently. Obviously, it's less than 2 months in, but with the additional funding that the government has put in, 60.8 million for the new over 4 years for case management reform, which has also allowed the development of a central assessment team, which is able to assist in terms of fast-tracking the single point of entry and also the appeals process that has been put in place as well. So whilst it's very early days yet, I think that the evidence that Mr Pringle has already provided shows that the reforms are going very well.
Thank you. Mr
And
Pringle.
so, Senator Patrick, you actually weren't here for the opening statement, which actually set out the different KPIs, how... we might get you a copy of the opening statement.
I was here for the opening statement.
You were surprisingly quiet, obviously.
I was just referencing what the Law Council had said during the debate, during the debates in the bill, and I think the evidence is that what they predicted
has not occurred.
Has not occurred.
Correct.
That's essentially what I was going with. And I wonder, Mr Pringle, I mean, when your interaction with members of the Law Society, have they now sort of stepped back from their concerns, or are they still concerned?
Generally, Senator, I think there was a lot of almost a crescendo of interaction with different parts of the profession, including the Law Council, in the lead up to the 1 September changes. It certainly is the case that that level of expressed concern has calmed down or died down since then. There's been the odd comment here or there, but what we're getting is a lot of feedback from members of the profession who are seeing the new case management model that really are speaking very highly of it. So I think you're right in that generalised comment. I can't give you any raw data on it, but certainly anecdotally, there seems to be less by way of concern expressed and a lot more by way of supportive comments on some of the new features and the timing and speed of the new case management system.
Yeah, thank you. Our rules of evidence allow you to say that, so that's good. Can you just confirm the common rules have been settled?
Yep. Indeed, they are not just settled but in force.
Thank you. I was going back to the Assistant Minister's second reading speech, summary speech. I just want to check a few things. She said, as part of the implementation of these bills, the government will provide, and this is to Adelaide, a further Division 1 judge. Has that occurred?
Yes, it has indeed occurred, and the registrar resources have also occurred.
Well, so I'm just going to go through the list. 2 additional Division 2 judges to the Adelaide Registry?
Yes, that's happened.
And an additional judicial registrar to support the Adelaide Registry. Has that occurred?
Indeed, not just one, but more than that.
Okay, this might be slightly outside the courts, but related. The Minister also announced the reformation of the Law Council, Family Law Council. Has that occurred? Has that occurred?
Senator, that's not a matter for the courts, it's a matter for
No, I understand that.
So that's very well advanced. We've been going through a consultation process with the Law Council and others as to who might be appropriate members. Normally there's about 8 to 10 members of the Family Law Council, so that's very well advanced.
All right, and that's all I really had. Thank you. I realised that was out of scope, but it was in the same part in her speech, so I thought I'd just kill it off there. Thank you. Thank you very much, Chair.
Oh, thank you very much, Senator Patrick. Look, I've just got a couple of questions, Mr Pringle, in relation to the new court. This is a momentous, wonderful celebration for this nation. And as someone who chaired an inquiry into family violence law reform back in 2017, and some of our recommendations have now been adopted as part of the new court, this is so wonderful to see, and I just want to put on record again my deep concern about some of the unwarranted claims made by the likes of the Law Council of Australia in relation to the new court, which of course does away with 2 sets of rules, 2 sets of entry points, a whole lot of other complexities, including, of course, and it's disappointing, Mr Pringle, that we haven't heard any voices of praise in relation to one of the very important initiatives of the court, and that is the 14-day contravention list. Now, I mean, when we talk about access to justice, Mr Pringle, access to justice means getting access to justice in a timely way. And this is a wonderful step forward for the new court. Could you tell me about the contravention list and how that is now working and what difference that this will make to families?
Thank you, Senator. Yes, the contravention list is something that really builds on the very effective model that was first tested in the COVID-19 list. That is to say, it is a registrar-led, but of course supported by judges as well, electronic and national system that allows for anybody across the country to be able to bring their applications in a speedy manner before the courts. Now, the contravention list was in various different registries from time to hearing matters in different ways around the country. It's now one consistent national electronic methodology. As you mentioned, the 14-day time period is a vast change on what was previously many months before these matters were able to get on before the court previously. The effect of it is that we will allow parties to address their concerns about non-compliance with court orders, including parenting arrangements that may not be being complied with, in a speedy fashion. It means that we will help also to change the culture of non-compliance that has been a problem with the system in the past. Again, it's relatively early days, but what we're finding is that the overwhelming majority of these matters are resolving fairly quickly once they get a court hearing, and only a handful of percent of matters really need to move towards a judge because parties, once they appear before a registrar, start sorting their issues out very quickly.
In relation to the contravention you're talking about, Mr Pringle, in relation to the contravention of court orders? Well,
indeed, in relation to the contravention of court orders, but also what it means is the most serious matters, the ones that might consider some form of imprisonment or other step to be considered, those sorts of more serious matters can now make their way swiftly to a judge as well. So it's graded differently. The resources are applied in a different way, but importantly, it means anybody from any part of the country can also get there. That includes more remote regions around the country.
Well, that is wonderful because there's so many families have experienced when you have court orders and they're not complied with, and people say, well, what's the point of these orders? So the fact that there is now this instant access to justice is a huge step forward, and as I say, pretty disappointing that we haven't heard from the likes of the Law Council to celebrate these momentous improvements in family law and access to family law justice in this country. Just want to do a couple of other things I want to touch on briefly. The Family Violence Cross-Examination Scheme, this was first an initiative obviously to ban the cross-examination by perpetrators of their victims in the family courts. That was first recommended by the inquiry that I chaired back in 2017. Could you please update the committee on the progress of that scheme?
Yes, I'd be happy to. I may also just flag that I'll also pass this question on to one of our experts in the field, but certainly it's been utilised by the court, ensuring that where there are serious issues of family violence and the like, the funding kicks in to allow for a safer way for those proceedings to be able to be undertaken. The detail of the application of it, is that the area that you wanted to inquire?
Just a quick update on how the scheme is going. Who's the relevant expert on the scheme?
I might pass to Deputy Principal Registrar Virginia Wilson on that.
Ms.
Thank
Wilson,
you.
thank you.
Thank you, Senator. In terms of, so we can speak in terms of how it's going from the court's perspective. I mean, as you would be aware, the department and government has undertaken a review of the scheme. And I know the court officers have been involved and been interviewed as part of that review. I think it's a matter for the department, but I think that might have been the point where there's been a report on it. But certainly we participated in that. Judges, registrars, those involved in relation to that, which was a useful exercise. I think in part that review and the terms of reference, I think, were precise, looking at how it was operating, funding requirements, and then, how effectively it was operating in terms of access and in relation to meeting its objectives, which I think in terms of, and I can't specifically speak for what the judges would have said who were interviewed in relation to that, but certainly my understanding from the point of view of the court as to how it's meeting objective is that it is. And I think what you hear the main concern has been in relation to the funding for it and the, the continuation of funding so that people litigants in terms of being able to utilise it, and that stems into protection. The parties being cross-examination continue to have those.
Sorry, Ms Wilson, we're starting to have some troubles with the audio. So thank you so much. I might just move to one other quick issue. I know Senator Thorpe's got some questions. Mr Pringle, just very briefly, the Select Family Law Committee chaired by Mr Andrews made some very important recommendations, including in relation to capping the fees of lawyers in property cases. One of the biggest access to justice issues in the family courts is the cost of legal representation. In many cases, lawyers are gouging their clients. There are some very, very good family lawyers around this country, but there are also some that don't always act in the best interests of their clients. What's the court's attitude in relation to this particular recommendation insofar as managing legal costs?
Thank you for the question, Senator. I might address it firstly in a broad sense, given that, of course, the concept policy issue of capping or not capping is ostensibly one for government. But in terms of the concern that the courts have in relation to the fees that clients are charged, and of course how expensive litigation can get, particularly with the various emotional issues that arise in family law areas, the court has taken a fairly strong stance in relation to that. If one looks at the Central Practice Direction, which was recently issued by the Chief Justice in support of the new court arrangements, the beginning of that practice direction sets out a number of core principles, many of which are geared towards parties and their lawyers having obligations to run their cases as efficiently and cost effectively as possible, and there being the possibility of costs orders being made if a party doesn't do so or a lawyer doesn't do so. In addition, the new legislation that came in with the operation on 1 September has within it an overarching purpose, and that overarching purpose now imposes a statutory obligation on not just parties but their legal representatives to ensure again that proceedings are run as cost effectively and efficiently as possible, and anybody who doesn't, of course, would fall foul of those statutory provisions. What that means then is that the court now has a number of tools at its disposal to look at if there are suggestions or allegations that parties have been acting inappropriately and running up the costs all the time and delays in litigation. So there are a number of tools that we can now utilise within the courts, and I don't think there would be a judge in the court who isn't concerned to ensure that cases are resolved or finalised in the most effective manner possible. The same for registrars. But in terms of the broader policy issue, that specific issue that you raised, Madam Chair, I would have to say that that's a matter for government, and you may wish to raise it either with the department or others.
Well, it is to some degree, but I will say that judges have at their discretion, as some judges of the Family Court have done, to take a very strong stand in relation to costs matters, including referring lawyers who do not act in the best interest of their clients to their professional conduct bodies for on the basis of alleged professional misconduct. So the court has a very strong role to play in relation to managing costs, because this is a fundamental premise of access to justice for families and people who do need to use the family courts. On that note, thanks Mr Pringle. I will end my questions there and give the call to Senator Thorpe. Oh, Senator Thorpe,
Thank you,
I've just
Chair.
been told doesn't have any questions. No? Any other senators have any questions? That being the case, Senator Thorpe.
Chair, beg your pardon.
Yes.
I just want to check that my questions are relating to OPCAT.
No, we haven't called. No, we're still with the Federal Court and the Federal Circuit and Family Court of Australia, Senator Thorpe. We are running a bit
My apologies.
behind. So we will come back to you. Thank you. So I do want to thank officers from the Federal Court and the Federal Circuit and Family Court of Australia. Thank you so much for your time and for your evidence today. It's a bit more challenging when everyone is attending remotely. We do very much appreciate it. And Mrs. Fewings, if you want to stay on and play a starring role in the rest of the proceedings, you're welcome to. Thank you so much, everyone.
Thank you,
we
Chair.
are most
Thank you,
grateful.
Senator.
Thank you, Chair.
Thank you.
Thank you.
It's now my pleasure to call officers from the Office of the Australian Information Commissioner.
Are we going to take a break, Chair?
Oh, apologies. Yes, we will take a break.
Just for the
yes, thanks very much, Attorney. We will take a, sorry, I did miss that. I was getting ahead of myself. We will take a 15-minute break and return, we'll suspend now and return at 10 to 4. Thank you. The committee is now in session and I call officers from the Office of the Australian Information Commissioner. Ms Falk, welcome. Would you like to make an opening statement before we go to questions?
Well, thank you, Chair. I do have a brief opening statement. As senators may be aware, our annual report from the Office of the Australian Information Commissioner was tabled last week, and it provides a detailed view of the work that we're doing to uphold privacy and information access rights and to strengthen online privacy protections. Against the background of the pandemic, our regulatory approach, Chair, is focused on meeting community expectations for proactive release of government-held information and also for strong privacy protections in areas of higher risk. We advised and continue to advise on areas that are critical to the pandemic response and recovery, from privacy protections in relation to vaccinations to how agencies can meet their FOI obligations in a timely manner. We also finalised a number of investigations into significant privacy matters, and we're bringing to a close a joint investigation with the UK Information Commissioner into a facial recognition app. We also recently issued determinations on Uber and 7-Eleven, outcomes that accord with our regulatory focus on high privacy impact technologies and the online environment. Other regulatory priorities for the OIC include overseeing compliance with personal information security obligations through the Notifiable Data Breaches Scheme and the Consumer Data Right. Turning to FOI, in our FOI work, we are continuing to encourage proactive publication and administrative access to government-held information without the need for an FOI request. And I'm pleased to say that the introduction of administrative access schemes by a number of agencies, such as the National Disability Insurance Agency and the Department of Veterans Affairs, has in fact reduced the number of FOI requests received by government agencies for personal information. Along with the agency FOI statistics, our annual report also highlights Information Commissioner reviews, where demand for our services does continue to grow. Last financial year, we received over 1,200 applications, up 15% from the previous year, and up 140% since 2015-16. In turn, we've increased our finalisation rates year on year by 23% last financial year and up 124% since 2015-16. And as you would know, we'll be welcoming an FOI Commissioner, an SES Band 1 FOI Assistant Commissioner and support staff as announced in this year's budget. And this will go some way to assist us in addressing the increasing volume of work. Returning to privacy, one of our key roles is to influence the handling of personal information through our advisory and monitoring functions. And last financial year, we made 21 submissions and made comments on 50 bills, including a substantial contribution to the review of the Privacy Act. Yesterday, the government released a discussion paper for consultation as part of this review, along with draft legislation providing for the development of an online privacy code and proposed penalties for breaches of privacy, which are in closer alignment with competition and consumer remedies. These reforms will help to ensure Australia has a privacy framework that's fit for the digital age, that promotes innovation and economic success while preventing harm to individuals. These are very much live issues which need to be addressed, and we look forward to playing a constructive role in the industry-led development of the Online Privacy Code and in the review of the Privacy Act to ensure protections that are fit for purpose into the next decade. Thank you, Chair. That concludes my opening statement.
Thank you very much, Ms Falk. We'll now go to questions from senators. Senator Watt, are you seeking the call?
Chair, I am. Thanks, Ms Falk and your colleagues. I just want to begin with a report that appeared in the Sydney Morning Herald on the 21st of October, headlined, George Christensen says AFP letter falsely accuses him of serious crime, and it makes reference to an application, an FOI application that I believe is being handled by your agency at the moment. Are you familiar with that report?
I'm aware of the report, yes, Senator.
Thanks.
So, Ms Falk, you don't need a copy of that report in order to answer this question?
Chair, I'm happy to hear what the question is and then advise accordingly. I recall an article in general terms.
Thank you.
Thanks, Ms Falk. So, according to this report, the Nine Newspapers Network has sought a copy of a letter from the Australian Federal Police to then Home Affairs Minister Peter Dutton in relation to a police probe into Mr Christensen's frequent travel to the Philippines. And again, according to this report, Mr Christensen has objected to the release of the letter on the basis that it falsely accuses him of a serious crime. Is that correct?
So, Senator, you'll appreciate that it is a current matter before my office. It is a matter in which I'm yet to finalise my Information Commissioner review decision. So I feel limited in what it's appropriate for me to say in this forum without the consent of the parties.
Well, are you able to confirm then, I mean, for the matter to come before you and your agency, it obviously has passed through a few steps. People don't immediately bring a matter to the Information Commissioner. So are you able to confirm that the Nine Newspapers Network did attempt to FOI this letter from the Federal Police to Minister Dutton initially? That was the original FOI request?
Senator, I'd need to check the facts and circumstances, but it would inevitably follow that for a matter to be before my office, there must have been an application made by a party to the relevant agency.
Yep.
A decision either made or deemed, and then accordingly an application made to my office.
Yeah, so presumably for it to have got to your office, an FOI request was made, was rejected, the internal appeal mechanisms were used, didn't resolve it, and then it comes to you. You're essentially the Court of Appeal in these sorts of processes.
So, Senator, there's an internal review process where applicants can ask for an agency to review their initial decision. Alternatively, a matter may come directly to my office. without going through internal review. But again, I can't comment on the particular facts and circumstances. There are matters that come to my office, for example, where no decision has been made, but rather there's been failure to make a decision within the statutory timeframe, which renders it deemed and then triggers a right for review to my office.
Okay. And have you and your officers seen this letter that has been sought under FOI, Ms Falk?
Senator, the matter is under active consideration by the office, and it is practice for us to review any of the documents at issue.
Okay, because again, according to this letter, this report, what the letter says is that the AFP advised Minister Dutton that it was closing the case into Mr Christensen, its investigation, but warned that he remained an ongoing risk of being compromised, according to sources who have seen the letter. Are you able to shed any light on that?
No, Senator, and it would be inappropriate for me to do so at this stage of the proceedings.
Okay, no, I thought that would be your response, so I won't push that any further, that aspect of this. So according to this article, the matter has been under extensive review by the Information Commissioner, who brought in, quote, the spy watchdog, the Inspector General of Intelligence and Security, to determine if there is a risk to national security. Have you, without getting you to sort of say what has been said about that, have you had to consult the Inspector General of Intelligence and Security on this matter?
Senator, I'd need to take the matter on notice, but there are a number of cases where we would consult the Inspector General of Intelligence and Security. Indeed, it is a requirement under the Act that I do so, where exemptions are claimed by the agency or minister that raise issues of national security.
Okay, because again, what this report says is that initially the AFP objected to releasing the letter that it sent to Mr Dutton on the grounds it could be an, quote, unreasonable disclosure of personal information about Mr Christensen. Was that the original basis for refusing to release the letter?
I'm unable to comment, Senator.
Because you don't know, or because it's under active consideration?
On both bases.
Right, well, is there anyone else who's here who might know the answer to that?
No, Senator, I don't believe so.
Okay. Well, let me put it this way. Have the grounds that the AFP claimed to block the release of this letter changed along the way?
I'd have to take that on notice, Senator.
Not sure the answer?
Senator, no, I'm unaware of the answer to the question, but I can say that in Information Commissioner reviews, we would look at the original decision, we would seek submissions from parties, and it is open to those, to a respondent agency or minister to change the basis upon which it seeks to claim that a document is exempt, and that would be considered by my office. So that is not an unfamiliar practice.
I mean, in what way could the release of a letter concerning a police investigation into a politician compromise national security? How is that possible?
Senator, I do consider that it risks going into the facts and circumstances of an active matter upon which I'm yet to deliberate and make a final decision, and it would be inappropriate for me to answer the question.
Have you or your officers ever previously had to consult national security agencies regarding requests to release documents concerning politicians?
There are none that come to mind, Senator. My only qualification is to draw on the evidence that I gave previously around the need to consult the Inspector General of Intelligence and Security in accordance with the legislation.
I can well imagine that there would be some circumstances about particular documents, especially those about defence matters, that might invoke national security concerns, but I would have thought it's pretty unusual for that to be raised in the context of a politician. So, but anyway, the point is that none that you can recall?
That's correct.
Thanks. This article also says that Mr Christensen has made 2 secret submissions to the information watchdog in a bid to prevent the AFP's letter from being made public. Are you able to confirm that?
Senator, I'm not able to confirm that.
So without going to the specifics, is it reasonable to assume that Mr Christensen has requested that this document not be released?
Senator, that conclusion should not be drawn from my evidence.
This has been going on quite some time. Again, according to this report, the newspapers involved have been seeking to access this letter from the AFP to Minister Dutton about George Christensen for nearly 2 years. Is there a reason it's taking this long to finalise this matter?
Senator, the office, as I said in my opening statement, has had a significant increase in the number of applications for IC reviews that we've received. We have undertaken a number of improvements in our processes such that we have increased our finalisation rate. It is the case, however, that some cases are taking longer as a result of that, and the more complicated cases, including those that may raise national security or require consultation with third parties such as the IGES, are those that we would expect to take longer to resolve.
And when do you anticipate?
1 more minute,
when do you anticipate that you'll be able to make a decision about whether to provide access to this document?
Senator, I need to take that on notice.
You don't know if it's going to be soon?
Senator, I'd need to check the status of the case in order to be able to give you an accurate answer.
Okay. And my last question here, you mentioned, well, has Mr Christensen himself been given access to this document that he is seeking to block the release of?
I'm not aware of the answer to that question, Senator.
Is it usual practice to allow parties to this type of matter to have access to the documents involved?
Not usual practice, Senator, no.
But you don't know whether it's happened this time?
That's correct.
Okay, could you
Thanks,
take
Senator
that on
Watt.
notice though?
I'll take it on notice.
Thanks. Thank you.
Thank you very much, Senator Watt. I will now give the call to Senator Waters, who is attending remotely via telephone. Senator Waters.
Thank you very much, Chair. I'll just check you can hear me okay.
Yes, we might need a bit more volume, but no, you're coming through loud and clear.
Thank you. I'll be as loud as I can. Thanks, Ms Falk. My first question is whether an FOI Commissioner has been appointed yet.
Thank you, Senator Waters, for the question. Government has not yet appointed an FOI Commissioner to the ongoing role. However, the Attorney General has appointed my colleague, Ms Elizabeth Hampton, who is joining us today, as the Acting Freedom of Information Commissioner from the 13th of August this year for a period of 3 months or until a permanent appointment is made.
Okay. Do we have a time
Senator
frame?
Waters. Sorry, Senator Waters. The appointment of the FOI Commissioner, we're actually currently going through the recruitment process or the merit-based selection process. So whilst the appointment process is ongoing, as the Ms Falks has stated, I have appointed an interim FOI Commissioner.
Thank you both. Thanks, Minister. What is the date for the appointment of the permanent FOI Commissioner?
Well, the selection process is ongoing at this point in time, and that's why we have appointed the interim FOI Commissioner, so that this important work could commence, because it is a commitment that we made, as Senator Patrick knows. And as such, when the appointment process is finalised, we will make the announcement.
Okay.
I'm thinking of applying. I'm a referee. Could be departments.
I might continue because I think I've only got 10 minutes. I'm sure Senator Patrick
Sorry,
will get
Senator
a good
Waters.
time.
Senator Patrick was making a comment.
You have the call, Senator Waters.
Thank you, Chair. Ms Falk, yours in your report says that ongoing resourcing issues means that a gap between income FOI work and finalisation work remain, will the budget allocation for an FOI commissioner completely address existing resources gap, or do you expect that there may still be a requirement for more resourcing to close that gap?
Thank you. So the appointment of an FOI commissioner together with an SES Band 1 assistant commissioner for the area of FOI, plus some support staff, will be a welcome addition that will help to address the ongoing workload. However, as I pointed out in my opening statement, the increases that we are receiving are quite exponential, being a 140% increase over the last 5 years. And at the same time, we have increased our finalisation of those matters by about 124%, but a gap does remain. So what we're doing at present is looking at workflows and systems in light of having another FOI commissioner on board, and then also considering whether additional resources may be needed for case officers. So that's a matter that's under active consideration, and once I have formed some conclusions in relation to that, I'll raise these issues with government.
Okay, thanks very much. Have the key performance indicators for the office changed for the additional funding and the appointment of the interim and soon permanent commissioner?
I'm sorry, Senator Waters, you're breaking up a little bit. Would you mind repeating the question?
Yes, my apologies for my terrible internet at my house. I'm afraid I can't fix it. Have your key performance indicators changed as a result of either the additional funding or the new interim to be permanent FOI commissioner?
Thank you. They have not changed. Our key performance indicator for Information Commissioner reviews, which is the area we're currently talking about, is that we seek to resolve 80% of matters within 12 months. The last couple of years, we've achieved about a 72 or 73% compliance with that KPI. So what we would be looking to do is to meet the KPI of 80% with the additional resource. Thank you.
Okay, thank you. Now, your annual report shows that complaints about the government's handling of FOI requests rose almost 40% last year, and that refusal rates and delays have also worsened. Have you analysed any particular trends in what data is being withheld?
Thank you, Senator. The statistics that are provided by agencies give us a snapshot of a number of factors. It tells us the number of requests that agencies are receiving, and then the numbers that they are granting in full or in part, and also the refusal rate. It also gives us some information on timeliness. It doesn't give us that next layer of information which your question might be going to.
Yes, okay, thank you.
Which is the information itself that's at issue.
Okay, thanks, Ms Falk. Will the new FOI commissioner, whether it's the interim person or permanent person, have a role in improving departmental compliance?
Thank you for that question. One of the roles of both the Information Commissioner but the FOI Commissioner is to undertake education, also monitoring, and ensure that agencies are enabled to comply with statutory timeframes. So we have been doing work in relation to this on two fronts. One is that you mentioned complaints that are made to the OAIC. Delay and timeliness is the key area of complaint, and I have undertaken a number of investigations where I've made recommendations that seek to address the cause of those delays, and they're published on our website. The second is that we have analysed the agency statistics and we have corresponded with agencies where we see there's a need for improvement in their timeliness and asked for them to consider the causes and to put in place a rectification plan. So I consider that this kind of work is already in train and that it will be built upon by the FOI Commissioner.
Thanks, Ms Falk. Could you let me know which of those agencies you've written to seeking improvement in their response statistics?
Yes, Senator, I can take that on notice.
Okay, thank you. Your report notes that the Prime Minister's Office is one of the agencies with the worst track record, with more than half of FOI requests not being decided within the timeframes. Has your office undertaken any targeted training with the PMO, spoken with the officers responsible about why they're falling so far behind?
No, we've not undertaken targeted training with the PMO, but what we have done is, as part of our International Access to Information Day, which occurred on the 28th of September this year, is that we released a suite of resources, including an FOI Essentials Toolkit, to assist decision makers to make timely and good FOI decisions. And that's available to all agencies and also to ministers.
And have you checked to see whether agencies have used that new resource?
So anecdotally, and also from our website statistics, we know that the resources are being downloaded and used. We also run sessions with our Information Contact Officer network twice a year, which we did a month or so ago, where we ensure that these resources are brought to their attention, and my staff receive feedback around the implementation of those resources. So I'm confident that they're well known across the APS.
Thanks, Ms Falk. You told a recent Senate
Just
inquiry...
one more minute, Senator Waters.
Thanks, Chair. You told the Senate inquiry into the COAG bill that you were not consulted on the bill and that you didn't believe changes in Cabinet to National Cabinet was justified. Have you had discussions with the PMO on that issue since the Senate inquiry?
Senator, would you mind repeating just the last part of your question?
Yes. Have you had discussions with the PMO on that issue since the Senate inquiry? It's not me shuffling papers, so I'm sorry, I can hear the noise too, but it's not me.
I'll just repeat what I understood the question to be. It was whether I've had discussions with the Prime Minister's Office subsequent to the committee hearing on the COAG bill.
Yes.
No, I have not, Senator.
Okay, and final question, have you had any discussions with your state or territory counterparts about any amendments that might need to be made to their FOI laws to be consistent with an amended National FOI Act?
Not since the hearing, Senator, and I would say that I've not had such discussions in those terms, so I've not been advised by my counterparts of any proposals in relation to state and territory laws. My interactions with my state and territory counterparts was that in relation to the bill itself, and my submission that I provided to the committee.
Thanks very much, Ms Falk. Thank you, Chair.
Thank you very much, Senator Waters. Senator Patrick.
Thank you very much. So some of my questions have been answered in the proceedings. I might just firstly declare that I am litigating against the Commissioner in the Federal Court. So I think I'd just lay that on the table. It's friendly litigation, I think. But if you are uncomfortable, Commissioner, in anything I ask or you think it's unusual or might be related to the court case, then please just indicate that and I'll respect that. I just want to go to some of the numbers that you provided this committee. There's an answer LCC BE20 tax 71 that where you sort of dealt with an estimate of the number of matters you thought you could resolve versus the number of matters that you predicted would arrive. In that answer, you basically said that you were in a position to be able to deal with about 829 reviews per annum. Do you recall that? I don't want to...
Yes, Senator, I do.
Okay, and you also indicated a growing number of cases. It's very interesting. You predicted 1226 reviews for last financial year, and you were out by 2, so you did very well. But the number was rising. I just wonder how the Information Commissioner appointment will affect that 829 estimate that you made.
So to take the question to be around the proposed appointment of an FOI Commissioner?
Yeah, well, I'm just looking at the numbers you predicted, that 829 reviews per annum. What difference do you think the appointment of an Information Commissioner will make to that number? FOI Commissioner, I apologise.
Thank you. So as you've pointed out, Senator, our estimation around the numbers of matters that we could deal with turned out, in fact, to be a slight underestimation. So we have, in fact, resolved higher numbers. Last financial year, we resolved 1,018. And that's for a number of reasons, including, and not the least of which is the dedication of my team and their commitment to continual innovation and efficiency. I think it's too early to give you a sound answer in terms of the impact that will make. Where we are at present is we have Ms Hampton, who's acting as the FOI Commissioner, and Ms Hampton is focusing her attention on some of the very complex matters that we have on hand. And what I envisage will happen is, as we are able to resolve some of those complex matters and some of our older matters, that will enhance our efficiencies moving forward. I think, though, that it does need to be said that we have nearly 1,400 matters on hand, and a significant proportion of the caseload is over 12 months old. So I think it will take some time to come out with an even report.
Yeah, so you did indicate in a question on notice provided in the Senate that the numbers had, in terms of matters finalised over 12 months, that number was rising, or has been rising for some time. So 4 years ago it was 97 matters, then 177 matters in 2018-19, then 237, 281 last financial year, where the matter has been more than a year, and already this year 54. I'm not sure how you. So that's so that indicates that if I'm right, that question on notice you provided to the Senate, those numbers finalised over 12 months, that doesn't indicate how many are outstanding, is that right?
That's correct, Senator. It does not.
So how many are outstanding for more than 12 months? So you've answered how long it's taken, or how many have been dealt with that are over 12 months old. As it currently stands, how many matters do you have before you, FOI matters, that are more than 12 months old?
So the figure that I have, Senator, before me, which will be valid as at 30th of September, is that 667 matters are over 12 months old.
Wow. Can you provide on notice how that's changed over the last 3 or 4 years?
Yes, Senator. I can tell you that it's up 10% from last financial year.
Yeah.
But if I may, I would also like to point out that we have increased the number of cases that we have resolved within 120 days.
Mm-hmm.
So that is up from 48% the previous financial year to 57% at the conclusion of this financial year.
Yeah, look, you know, I actually like the work that you do. I have no issue with it, but still, you know, there's 667 applicants who've been waiting more than a year. How many more than 2 years? We know of at least one that Senator Watts was referring to before.
So of those 667 matters that are over 12 months, 261 of them are over 2 years.
And what's the longest one that you have outstanding?
Senator, I might just refer to my colleague Ms Hampton to see if she has that figure to hand. Otherwise, I can take it on notice for you.
Thank you.
Thanks, Commissioner. Elizabeth Hampton, Acting Freedom of Information Commissioner. As at the end of the financial year, Senator Patrick, the oldest matter we had on hand was dated the 27th of March 2017.
So it's 4 years. Just over 4 years. Is that a matter that's after personal information or policy government style information?
I can't tell you with any specificity the particular request for that application, Senator. What I can tell you, though, is that there has been a significant review of all of our oldest matters, and all of those matters that are on foot from around about this period have been substantially progressed and are moving to
So what's the
completion.
problem with this particular matter, without going to the details of the matter itself? In general terms, why has it taken 4 years?
It's generally the case, Senator, that with those matters that are still on hand after such a period of time, there are complexities around either the nature of the materials sought, the number and complexity of the exemptions that have been claimed by the agency in the matter, and the complexity of the submissions on both sides.
See, there's many matters would go to the federal court that wouldn't last that long, and in some sense you sit not as the final merit review. There's another opportunity thereafter. You might have someone that sits and waits for 4 years, gets an adverse decision, so you might get a favourable decision from you, so you might grant access, and then the government appeals it, and that adds another year or two to the, by that time half a decade's gone by. When you're seeking access to information, it just seems to me incredible that you can get a matter that takes longer than almost any other court case in what is a merit review, where there is another avenue of review that follows. I mean, one might think you might be able to get to a point where you resolve the matter to a reasonable level, and then there might then be a further fight in the AAT, but often that's narrowed down to a particular point.
And that's the nature of the review process in many cases, Senator, that the nature of our internal process is such that in receiving submissions from both parties, there's often a reduction in the scope or the number of the exemptions claimed, and a refinement of the scope of the materials at issue sometimes. More materials are released during the process as well. So the refinement of the matter is often part of the process of reaching a conclusion in an IC review.
But you would accept that having another next stage of review can also be a refinement. I just feel for people. I've been in the situation where I've had a matter that's you've had for 2 years, you've granted me access, and then you end up with the government appealing. And a year later, 3 years later, you still don't have the information. So I just wonder whether or not you think about that in the context of the way in which you make decisions, that in fact there is another step after your own process.
Yes, of course, Senator.
Okay. I've got one more very short line of questioning and this goes to the decision
Senator Patrick, we are over time, so I am going to have to share the
We can come back to me, that's fine. Yeah, that's fine.
Senator Grogan?
Thank you.
Senator Grogan, thank you.
I might just follow on from Senator Waters regarding the annual report and the Office of the Prime Minister having fewer than 50% of FOI requests within the statutory timeframes. Can you tell me, does that constitute a breach of the FOI Act?
Thank you, Senator. So the FOI Act has within it statutory processing times. Ordinarily, a FOI request should be processed within 30 days, but that time may be extended by agreement with the applicant, or in other cases, through making an application to my office and granting an extension of time. Those circumstances might be, for example, where a case is particularly complex or voluminous. If those extension of time provisions haven't been invoked and the matter's not decided within 30 days, then there's non-compliance with the statutory timeframes. The consequence of that is that the agency or the minister is deemed to have refused access to the documents, and the applicant then has a right to request review from my office.
So you say that the Prime Minister's office has decided fewer than 50% of the FOI requests within the timeframes, but there's no further detail in terms of whether that might be 40%, 30%, 20%. Do you have any more detailed figures on that?
Yes, Senator, I will have a further breakdown that I can provide. So the Prime Minister's office in 2021 received 61 applications, and of those, 14 were processed within the statutory time frame, which is 38.9%.
That's pretty low. That is very low. I have one example of a letter sent to the Prime Minister's office, and it related to documents concerning Mr Angus Taylor's use of a forged document in a juvenile and unsuccessful attempt to embarrass the Lord Mayor of Sydney. I can table that letter if you like.
Senator Henderson, Senator, with all due respect, Senator Grogan, that is your characterisation of what occurred. Minister Taylor is not here to provide a response to that. So if we could just be clear, that's your characterisation of what occurred.
Indeed.
And also, look, just Senator Grogan, just to remind all senators that it is not appropriate and a breach of the standing orders to reflect on other members or senators.
So the letter in question was sent to the applicant 140 days after it was received, which again seems like a lengthy period of time, and it refers to quite a lot of the usual standard text about it being too onerous to undertake the request. The request is actually quite limited in terms of only specifying 4 or 5 days that are in question. But this, as a, is that the typical approach that we are seeing? Of at 38.9%, it would indicate that it might be, of this sort of contemptuous approach to FOI?
Senator, the statistics indicate that the Prime Minister's office has not complied with the statutory timeframes on a number of occasions. In relation to any minister or agency where that is the case, we would be advising them, as we do with all of our FOI decision makers, to ensure, first of all, that they're looking at whether they can proactively release information that's in the interests of the citizens without the need for an FOI request. Secondly, if there is a matter that's going to take longer than 30 days, that they're consulting early in the piece with the applicant and seeking an agreement. And if unsuccessful and they consider it's a complex or voluminous matter, that they are seeking an extension of time in accordance with the statute from my office. So we do encourage those processes to be used. in terms of ensuring the statutory processing timeframes are complied with. And the objects of the FOI Act are to promote public access to information promptly and at the lowest reasonable cost.
So does the Prime Minister's office respond promptly to your requests? So the notion of 30 days and then seeking an extension, are you getting that sort of engagement from the Prime Minister's office? And in addition to that, the content, so again, as I say, the letter I have here refers to one event that happened on one day and the capture was a 5-day period, which does seem to be quite narrow.
So, Senator, I can't comment on the specific facts and circumstances. In terms of the cooperation of the Prime Minister's office, my staff have not raised any issues in that regard with me, so my assumption is that they're cooperative in the absence of such advice. I should also point out that there is perhaps more limited information available to the office around the conduct of ministers' offices in relation to FOI than government agencies, and that's because the statute does not allow individuals to make complaints about delay, for example, in relation to ministers, only in relation to agencies.
Okay. We might actually put a few, with these further statistics, we might put a few more questions on notice for you relating to the specifics on that. Thank you very much.
Thank you, Senator.
Thank you very much, Senator Grogan. Senator Patrick, you've got about a few more minutes, I understand.
Just one issue.
Thank you.
It's to the Information Commissioner, and I might ask the Attorney something afterwards as well. In other committee meetings, we've been talking with the PM&C in relation to Justice White's decision in the AAT about National Cabinet, and it appears as though they've sort of said that obviously all FOI matters with PM&C go on the facts of the matter and the circumstances, and that's not in question. But there seemed to be some reluctance that claims of Section 34 for National Cabinet documents may not be, or may still be advanced. I'm wondering if you're considering putting any guidelines, anything into your FOI guidelines in relation to Justice White's decision.
Thank you, Senator. Yes, we have got that matter under active consideration. We'll look to update relevant parts of the guidelines. We usually do that on a schedule, and we'd anticipate doing that in this quarter.
Are you contacting other agencies that may be, for example, requested to provide, for example, NCCC documents that were prepared by in the industry department that went to National Cabinet? Is there any guidance been issued by your office in relation to that? Because it seems to me that if the issue of National Cabinet is raised, PM&C are of the view that that matter then must be referred to the Cabinet Office because it touches on what they say is Cabinet still.
So, Senator, in the FOI guidelines, there is reference to FOI decision makers referring to the Cabinet Handbook if they're dealing with information that could invoke Cabinet exemption, and also conferring with Prime Minister and Cabinet in that regard. And that is a long-standing practice. It's often the case that Prime Minister and Cabinet provide evidence to decision makers and indeed to my office around whether a document ultimately proceeded to Cabinet or if it's a document of Cabinet and the relevant minute, etc. So that practice is a long-standing one. In terms of specific guidance, as I said, we haven't issued specific guidance. I anticipate that when we update the relevant parts of the guidance, we'll make reference to Justice White's decision.
Okay. And finally, just flicking this up to the Attorney, In questions related to this FOI matter with PM&C, they have put on evidence that they are still of the view that the National Cabinet, and this might not necessarily for the purpose of FOI, but National Cabinet is a committee of the Cabinet. That is, Ms Foster put that on evidence as that is the view of the department, basically saying that, you know, Justice White was making a decision as a Deputy President of the AAT. Now, I just wanted to read just from his decision. He makes it really clear because his first task was not to look at my documents and try and untangle them, the documents I requested. His first task was, in fact, to make a determination, was it a cabinet? He said, having addressed several matters, and this is on about page 60 of his judgment, paragraph 210, having addressed several matters bearing on the question of whether the National Cabinet is a committee of the Cabinet, I have then sought to consider their collective effects. In my view, taken together, they point persuasively against the National Cabinet being a committee of the Cabinet within the meaning of the statutory expression. Now, I find it quite incredible that someone who's a justice of the Federal Court, and I accept as acting as the Deputy President, has made such a determination, yet somehow PM&C have decided to ignore that outside the context of perhaps FOI. And in our simple bush lawyer talk, because I'm not a lawyer, in some sense, he's not writing he's not having an ace in that he's in the High Court. He's not even perhaps a judge of the Federal Court being a jack. He might be a 10, the 10 card, but there would be no one in PM&C that would hold a higher card than that in terms of making an assessment about National Cabinet. It just seems to me that the position adopted by the Federal Cabinet is actually quite disrespectful to one of our judicial officers. I just wonder if you've got a comment in relation to that.
Thank you for the question and the comment, Senator Patrick, and I know you and I have personally discussed this. Just in terms of your discussion yesterday in Prime Minister and Cabinet, and I believe you asked questions of both Ms Foster and Mr Reid, and certainly in relation to the responses given by Mr Reid, I do have the Hansard here. And you'd be aware he stated the decision of Justice White has been drawn to the attention of all decision makers, just following up from what Ms Falk was saying. And he actually reiterates that for you on a number of occasions. Just in relation to the particular case, though, you're referring to, which is, of course, your case, and I think we spoke about this earlier this morning in relation to the decisions of the Administrative Appeals Tribunal, and you'd be aware the Tribunal is a merits review body and as such does not make binding decisions in the same way as a court. But further to that, and I don't obviously want to move into the purview of something that is more properly the purview of PM&C and the questions that were asked yesterday. But you would be aware that since its establishment on the 13th of March 2020, all members of the National Cabinet, that is the Prime Minister, the First Ministers, First Ministers and Premiers, they have participated on the clear understanding that meetings are conducted in accordance with the long-standing Cabinet conventions, or should I say according to long-standing Cabinet conventions, and in particular the most important convention being that confidentiality applies to papers and deliberations. You'd also be aware that following the decision of Justice White on the 17th of September 2021, the Prime Minister and all Premiers and Chief Ministers released a joint statement affirming the importance of confidentiality to relationships between the Commonwealth and the states and the territories. And I understand yesterday you did pursue the different grounds that were put forward by Prime Minister and Cabinet in the actual case itself. But our position as a government has always been clear. National Cabinet information is Cabinet information and should be accorded the appropriate confidentiality.
But this is a statutory definition for which you must have regard to a judicial officer's consideration above, say, a policy officer or a premier or, in fact, a Prime Minister. If we recognise what each of the three tiers of government, the legislature, the judiciary and the executive are responsible for, it just disturbs me in a country where rule of law is important that you would say, well, you know what, the premiers and the Prime Minister are simply going to ignore the ruling of a federal court justice on the statutory meaning of a cabinet.
Yep. Look, we'll respectfully agree to disagree because, as I said, members of the National Cabinet have always participated in these meetings on the clear understanding
flawed
that
understanding
cabinet
maybe.
confidentiality
Might be a flawed
applies.
understanding,
And we'll
Attorney.
agree to disagree in relation to that.
Senator Patrick, we are going to have
All right.
to wrap up.
All right, no, we will agree to disagree, Attorney. Thank you.
Thank you, Senator Patrick.
Thank you very much, Senator Patrick. That concludes the committee's examination of the Office of the Australian Information Commissioner. Thank you so much for your time and
Thank
for
you very
your
much.
evidence this afternoon. I now call officers from the Office of the Commonwealth Ombudsman, and while everyone is coming to the table, remotely or otherwise, I just wanted to indicate we are obviously running behind, so from a time management point of view, I had some earlier discussions with Senator Carr, and after having further discussions, we don't have any issue in letting go the Australian Law Reform Commission.
I'm very pleased to hear that.
And also,
What about the Financial
and
Security
also
Authority?
the Australian Financial Security Authority.
Yes.
So,
That's it.
there being no other objections, could I just thank the ALRC and the Australian Financial Security Authority, but and I'm sorry that we're not letting you know earlier, but we really appreciate you being on standby, but we won't need to proceed with any questions. Thank you very much. Good afternoon. Welcoming officers from the Commonwealth Ombudsman. Would you like to make an opening statement before we go to questions?
Thank you, Chair. I don't have an opening statement today.
Thanks, Ms McKay. Now we move to questions from senators. Senator Grogan.
Thank you. Following on from the May estimates, we discussed complaints received by a number of MPs about the way Comcare had dealt with their claims. Now, you've responded on notice that having considered the issues raised by Labor in those hearings, that you've decided to commence an investigation which will consider the policies and procedural framework, and we're very grateful for that. Thank you. But I just have a few very short questions. Understanding that this is a private investigation, is there any means by which members of the public can make a submission to this inquiry? I imagine there'd be people who would want to.
Thank you for the question. We're conducting this matter as an own motion investigation rather than an inquiry. So it's not generally a matter that we would receive submissions in relation to.
Right, okay. And is there anything you can tell us about what you've found out to date?
I can, Senator, yes, thank you. So, yes, this was a matter that was raised, as you say, at May estimates, and we commenced an investigation into Comcare's policies and procedural framework for the administration of the independent medical examinations. And I can indicate that the investigation is currently underway, and Comcare has been open and receptive in discussions with our office and our requests for information to further the investigation. And at this stage, we're aiming to be in a position to finalise the report early next year in 2022. But our preliminary view is that Comcare has several reasonable procedures in place, but there are opportunities to improve its approach in administering independent medical examinations, in particular in relation to three things. An overarching policy to guide requests for independent medical examinations, procedural guidance about the relevant considerations for decision makers requesting an examination, and thirdly, how administrative issues related to complaints about medical practitioners are identified and addressed. And we've spoken to Comcare about the preliminary views. We haven't done a draft report quite yet, but we have spoken to them about the views that we have. And they're open to building on their existing frameworks and implementing those changes and improvements. So I think we're having a really good dialogue with them, and hopefully at the end there will be some real improvements to the way that they conduct this business.
Great. Will there be a public report?
We have an option under the Act, or the Ombudsman has an option under the Act to publicise a report or make public a report. And that will be a decision for the Ombudsman at that time. It may be me, it may be the new Ombudsman. So I won't guess.
It would be very beneficial, I think, to have a public report, given there have been so many challenges.
Noted.
Have there been any further complaints in the meantime to the Ombudsman regarding Comcare?
I'm not sure I have that detail to hand, but I might ask my colleague, Ms Taylor, who's on screen. She looks after our complaints management branch. She might have some detail about those type of complaints. Ms Taylor.
Ms Taylor, you can hear us loud and clear?
Can you hear us?
Yes.
Yes, okay. Thank you. Julia Taylor, Senior Assistant Ombudsman, Complaints Management and Education Branch. Unfortunately, I think we'll have to take that question on notice at this time. I would have to go back and have a look at our data and check whether or not we've received further complaints in regard to the own motion and where that data was up to at that time.
Thank you. If you could get back to us, that'd be great.
Yeah.
That's all. Thanks.
Oh, thank you very much, Senator Grogan. I'm just received a message. I believe Senator Thorpe is seeking the call. Senator Thorpe, or it may be in relation to Senator Thorpe. I can see you coming through loud and clear.
Thank you.
You're seeking the call in relation to the Ombudsman?
Yes.
You have the call.
Thank you, Chair, and thank you to the Ombudsman for presenting today. My questions are around the OPCAT, and my first one is around the full implementation of OPCAT being due, I think, around January 2022. Can you tell me, please, if you are on track to deliver at this time or that time frame?
Yes, thank you for the question. And yes, the implementation date for OPCAT is the 20th of January 2022. And we have been nominated as the National Preventative Mechanism, as well as the National Preventative Mechanism Coordinator for the Commonwealth. And I understand that there have also been MPMs, or what we call them in short, nominated in Western Australia and the Northern Territory as well. Full implementation of OPCAT will require nomination of NPMs for every jurisdiction, and I understand that AGD is in discussions with all of the jurisdictions about nominating their NPMs in time for that implementation date. But as we're the National Preventative Mechanism, we're not responsible for the implementation across all of those NPMs. We're responsible for the Commonwealth and the coordination of all the other NPMs as part of OPCAT. Oh, I think you're on mute, Senator Thorpe.
The Vice Chair of the UN Subcommittee on Prevention of Torture, UNSPT, recently presented at a webinar where she stated that the UNSPT has recently communicated with the permanent mission in Geneva, expressing its concerns that an overarching legislative framework for the OPCAT has not been enacted in this country. Can the Attorney-General confirm whether she has received the communication from the UNSPT, please?
Thank you very much, Senator Thorpe. I just wanted to convey to you that we have the Assistant Minister Stoker, who has now joined us at the table. So welcome, Assistant Minister.
Thank you very much, Senator Henderson, Madam Chair. I'll take that on notice.
Great. You may need to take this one as well. The Attorney General's Department has repeatedly stated that legislation or an intergovernmental agreement is not required to meet the obligations of the OPCAT. Does the Attorney General maintain this position?
I'll take that on notice too, Senator Thorpe.
Thank you.
Ta.
Senator Thorpe, oh, sorry. You have the
I've
call.
still got a couple more.
Okay, thank you, sorry.
This is also for the Attorney General. Ms Mohammed stated that an offer of assistance has been made by the UNSPT to the Commonwealth in regards to its OPCAT responsibilities. Does the Attorney General intend to take up the UNSPT's offer?
Look, I'd have to take it on notice simply because we need to check that the factual premise on which that's based is correct, and then we'll get back to you.
Sure. Thank you, Minister. My next question is to the Commonwealth Ombudsman. The UN Committee on the Rights of Persons with Disabilities made a recommendation to Australia in 2019 to ensure that organisations of persons with disabilities can effectively engage in the establishment and work of the National Preventative Mechanism, NPM. Does the Commonwealth Ombudsman's OPCAT Advisory Board membership include someone with a disability or current experience on a disability representative organisation? If not, why not?
Thank you for the question. And yes, the OPCAT advisory group that was established by the former Ombudsman does not currently have a representative who represents the interests of people with a disability. It has a number of members. It used to have Mr. Edward Santo, who was the Australian Human Rights Commissioner until he recently moved on. Professor Neil Morgan, who is an Inspector of Custodial Services. Professor Bronwyn Naylor, who's the co-founder of the Australian OPCAT Network. Mr. Paris Aristotle, who's the CEO of Foundation House. And Mr. Noel Clements, who's from the Australian Red Cross. And Mr. Brendan Thomas, who is the CEO of New South Wales Legal Aid, but also our First Peoples representative. The membership of the OAG is a... Sorry.
That's great. And
the membership of OAG...
I'm not bringing
Sorry, Senator Thorpe, I just would like Ms McKay to be given the opportunity to complete her answer.
Thank you.
Okay, my apologies.
That's okay.
The membership of OAG is a matter for the Ombudsman, and we can, or the Ombudsman can make a decision to add members to the OAG as necessary. So that may come in the future, a representative of persons with disability. We don't have one at the present time, and we're not at this point in time looking at imminently inspecting places that for people with disability. We're concentrating on immigration detention, holding cells for the Australian Defence Force, and police holding cells.
Well, the UN Committee on the Rights of Persons with Disabilities made a recommendation to Australia in 2019. I must say that's a little bit disappointing, and you might have the token blackfella on there, and all respect to all the committee members, but can you give me an idea, particularly to people living with disability and that obviously their voice hasn't been, well, it's obviously been overlooked for a couple of years now. Can you please tell community what is in place to have real representation?
What I would also add to that answer is OAG, or the OPCAT Advisory Group, isn't the only way that we engage with civil society in terms of our OPCAT responsibilities. We have a number of engagements with civil society, and actually I have my colleague Ms Fontatoff on the line, who is responsible for my assurance branch, who looks after our OPCAT responsibilities, and I'll see if she has anything to add in terms of our engagement with civil society that could assist you.
Thank you.
Thank you, Rebecca Vodatoff, Senior Assistant Ombudsman of Assurance Branch. As the Acting Ombudsman mentioned, our OPCAT Advisory Group membership does include, or did until very recently, Mr Ed Santow from the Australian Human Rights Commission. While he's not the Disability Commissioner himself in that capacity, that is an organisation that does have access to that expertise and that subject matter within it. Also, as Ms McKay mentioned, we do engage with civil society organisations outside of the OPCAT Advisory Group itself. That involves regular meetings with officers from my branch as well, with a range of organisations that represent a range of sectors and parts of the community. I would need to take on notice what engagement there has been in that context with disability groups.
Thank you. That would be great. I think that, you know, it's 2021 and grassroots community people, blackfellas, people with disability, people of colour. I don't need to give you the cultural awareness and the, you know, accessibility to what we need to change about this government. But if we're just an add-on, like blackfellas are used to being, but, you know, particularly people living with disability, if it's just an add-on, then I know what that feels like. So if you don't mind making it, taking it on notice and doing something about it. I have another question. Will the Commonwealth Ombudsman convene meetings with state and territory governments for the purpose of implementing OPCAT?
Senator Thorpe, we are going to need to wrap up, so we will need to make this your last question.
Chair, Sarah Chidgey, Deputy Secretary, Integrity and International Group, Attorney General's Department. That's a part of the role the department has been playing in implementation of OPCAT, and we have had a range of meetings with states and territories. It's also been discussed previously at the Council of Attorneys General, but the department most recently had meetings through September with states and territories about implementation.
Thank you very much, Ms Chidgey. Senator Thorpe, we will need to leave your allocated time now. Thank you so much.
I have a number of questions that I'll put on notice as well, please, Chair.
Thank you so much.
Thank you.
That's now concluded the committee's examination of the Commonwealth Ombudsman. Ms McKay, thank you to you and your officers for attending today. We are very grateful for your time and for your evidence.
Well done. Thank you very much.
I now call officers from the National Archives of Australia. Mr Fricker, welcome.
Thank you.
Do you have an opening statement?
I do, Chair, if I may.
Yes, thank you.
Thank you, Chair. Just to bring the committee up to date with some operational developments at the National Archives. First, I should formally introduce David Fricker, Director General of the National Archives. Chair, on the 1st of July 2021, the government announced funding of $67.7 million across 4 years for the National Archives of Australia to provide a funding boost for its critical functions as the custodian of Australia's memory through the preservation of Commonwealth records. Now, with this funding, the National Archives is implementing its Defend the Past, Protect the Future program of work. which is underpinned by improved digital service delivery and stronger technical infrastructure. This will equip the National Archives to meet the evolving needs and expectations of the community and the government in the digital age. This comprehensive program of work will enable digital preservation of 270,000 of the most at-risk collection items. It will provide digital storage, preservation and access to more of the National Archival collection through an upscaled, cyber-secure, trusted digital archive, through increased resources to proactively digitise records for easier, faster access by all Australians, through a specialised fit-for-purpose digitisation hub and consolidation of the nationally dispersed collection into facilities with superior preservation and digitisation capability. The funding also provides additional capability to work with government agencies to identify archival value records to be transferred into the collection and to accelerate public access to declassified government records. This Defend the Past, Protect the Future program will further the Australian government's digital transformation agenda and its reform agenda for the Australian public service, Delivering for Australia. This is a transformational investment for the National Archives. It will enable important next steps to realise the vision set out in our Strategy 2030 paper to become a world-leading archive, empowered and resourced to ensure that authentic government information is created, is secured, preserved and accessible to the government and the community. Another major achievement over this year is the completion and launch of the National Archives' whole of government information policy entitled Building Trust in the Public Record, which provides guidance to all government agencies in records management. The policy supports continued improvement in government information and data management capability to meet current and emerging information challenges and to support broader government priorities such as digital transformation and data use and data sharing. Our national digitisation and preservation strategies have been refreshed to identify priority digitisation projects for both at-risk and high-demand collections. The current focus areas for us include magnetic tape records, our photographic collection, and high-demand series, particularly World War II service records. Also in 2021, the National Archives progressed significant capital works projects to accommodate current and future operational needs. The completion of our film preservation laboratory in Chester Hill, New South Wales, and refurbishment of our digitisation centre at the Canberra Preservation Facility were major capital works projects this year. Over this period, despite the limitations placed on every Australian by the COVID-19 pandemic, the National Archives has found ways to provide services and engage with its clients and the community. Understandably, face-to-face engagement decreased this year. However, online visitation across all our media platforms increased by more than 515%. And throughout the year, we had extraordinary spikes in media attention. The National Archives Members Program was launched in November 2020 to provide new opportunities for Australians to experience their National Archives and join the Archives community. The program now has membership of 930, and I was delighted when Her Excellency Mrs Linda Hurley agreed to become the inaugural NAA Members Patron. This year also we've received unprecedented contributions from the public to support our activities, approximately $1.1 million to date, from 912 individual donations. I'll pass the form to you, Senator. Most notably, actually, if I do reflect on those donations, most notably we received a $1 million contribution from Ms Barbara White from Sydney. And this outstanding donation will be used for the preservation and ongoing access of the photographs contained within the World War II service records to preserve the faces of those individuals that served Australia. Our gratitude for these donations cannot be overstated. This show of public support affirms the value and importance of the National Archives' role to preserve the nation's historical record. The National Archives of Australia is the only Commonwealth Government entity legislated with a task to ensure that the essential evidence of government activity is secured, preserved and made accessible. This unique aspect of the National Archives defines its principal role to carry Australia's memory from one generation to the next. The National Archival Collection includes hundreds of millions of records. In physical form, we have papers, photographs, films and audio recordings that occupy some 360 shelf kilometres. In digital form, we've accumulated over 5 petabytes of documents, images and audiovisual content. And for the most part, these records are not souvenirs, they're not edited opinions. They're the evidence of what has taken place, an essential resource for a nation that wants to understand its past and shape its future. Senator, my term of appointment with the National Archives ends this year at the end of December, and if you will allow me, I would like to take this opportunity to publicly express my thanks to the Archives executive team and all the staff that I've worked with. And also I would like to acknowledge the sustained support of the National Archives Advisory Council, noting in particular that Senator Carr, with the committee today, is a current member of that Advisory Council. And the engagement and support of Senator Stoker, our Assistant Minister, since her appointment to the position this year. Thank you very much, Assistant Minister. Pleasure. And finally, through you, Chair, I'd also like to take this opportunity to thank this committee for the attention that it has given to the National Archives. After all, the National Archives is an accountability agency, and I've always regarded it as a valued duty and a privilege, in fact, to participate in this process in this place, providing accountability to the Australian Parliament.
How can we ask hard questions after that?
That's right, so leave me alone.
Mr. Fricker,
thank you very much, Chair.
Thank you for a really celebratory opening statement, and I think all Australians celebrated with obviously the announcement of this funding boost, and which will support so many essential services and such great work that you have planned for the future. So congratulations to you and all your hard work in doing what you do, because we all know that the National Archives is an incredibly important institution for our country.
Thank you, Chair.
Madam Chair, before you go to questions,
yes,
may I make
Assistant
a small
Minister.
contribution?
Yes.
I wanted to put on the record the extraordinary thanks of the Australian Government for the work of Mr. Fricker. His enthusiasm and knowledge and passion for this field is in a league of its own, and I have very much benefited from his expertise and diligence in this role. He's taken an important agency from, in many ways, being in the back of Australians' consciousness, much closer to the front, and he has helped to steer the institution onto a path that will set it up for being significant for the long term, and for that I really want to say thank you.
Thank you. Thank you, Senator.
Yeah, I was actually just about to ask if you wanted to make a comment. Thanks, Assistant Minister. And Senator Carr, you've been very instrumental in advocating for this institution.
Thank
so
you.
please, over to you.
It's been a real pleasure to be able to do so. The National Archives is a great national treasure of enormous value to the people of this country. We've had a particularly tough year, given how long it's taken to get progress on the Tune Review. I just want to place on the record my thanks to you as the Director and your unswerving engagement with members of the Council. We can be a difficult lot, not known for our shyness, but I think it's a commitment that was shared, despite the extraordinary breadth of experience on that council, largely a conservative group, I might add, from my observation. Very conservative given the length of time this government's been in office. Well, I think, that's a statement of fact. It's a very broadly based conservative group of people, with a few exceptions like myself. but a shared commitment to the archives and a deep, deep concern for what was happening in the archives. But I just want to emphasise my thanks to you, Director General, and the way in which you have acted as an advocate for this national treasure. And given what Senator Stoke has just said, my disappointment that you weren't reappointed.
Well, may I say that after 10 years of loyal service in a role...
That's not an excuse. 10 years is not an excuse not to reappoint.
It's not. I don't think
Senator
it's
Carr, I feel like you're descending into the period of questions now. But,
No, I don't.
But 10 years
I don't think
is-
it's necessary to debate.
I think it's important to recognise the important contribution here, and that his contribution of some 10 years pretty much outlasts everybody who has ever led this institution, and that is an endorsement.
Well,
Thank you, Assistant Minister.
I've been here considerably longer than 10 years.
Yes.
And as in many other senators, that's not grounds for termination.
Senator Carr.
Well, Mr. Fricker, again, thank you for your wonderful contribution. There's all-round praise for your work and the work of the National Archives as a incredibly important Australian institution, and we are all celebrating the $67 or so million of additional funding that you have now at your disposal to do incredible work to preserve our history, which is so important for our future. So thank you, and on that note, I will hand over to Senator Grogan.
Thank you.
I do have a couple of other questions since I've made my point. But
I might just start with just wanting to know why it took, Senator Stoker, why did it take 15 months to release the Tune review of the National Archives of Australia and 18 months for the government to respond to the findings? Given how everyone's waxed lyrical, it seems to have taken quite a long time to actually get to that point.
It's because I took 14 months to do the FOI.
Senator Patrick might give you his version of
Sorry,
mine,
you're on the
but,
wrong side of the table, Senator Patrick. So we'll
look,
just...
Senator Grogan, no reflection on you, of course, but you haven't had the benefit of conversations around this in previous estimates. But there was a period of, I think it's fair to say, lengthy reflection about the nature of the Tune review. It was released with the prompting of Senator Patrick's application for it to be released, although we had planned to release it with the government's response. It didn't ultimately delay progress in that I attended to the preparation of the government's response upon coming into the role. So from my perspective, it was dealt with quite diligently during my time.
I wonder if the delay was in any way connected to some of your commentary, which obviously you've waxed lyrical just now, but previously on the 27th of May, where you said time marches on and all resources degrade over time. And my answer is that the degradation of the records over time is part of the ageing process.
Well, Senator Grogan, it's very kind of you to quote that
it's my pleasure.
out of context. It's it's a good start for your estimates journey. The commentary that you're no doubt referring to is selective, because in the course of that discussion, that factual observation that remains true, that records degrade over time because time affects all things, including you and I, dear Senator Grogan. But what matters is what we do in response to it. And that is the essence of what the National Archives was seeking by way of support. And it is the essence of what was provided by the government to ensure that those records that were degrading were preserved in ways that would ensure they could remain accessible to Australians for the long term.
Well, it may have been out of context. I have a series of other quotes here that sort of lend to the same
Go for your life, but it's the same.
It is the same
principle. It's the same principle in that it is convenient for some to try and take statements of fact out of context and make them into something they're not. But ultimately, the proof in the pudding is in the eating, and that is that the government has provided in full the requested sum necessary to ensure preservation of these records.
I would contend that you were dragged kicking and screaming to it over an 18-month period.
You can say that if you wish, but in the limited time that I have been in the role, I would suggest I have acted quite swiftly to ensure an enormous sum of money has been provided to ensure this important institution is supported. I'm quite proud of what we have done to get this institution the recognition and support it deserves.
So on the timing issue, so at budget, there appeared to be no intention of providing the emergency funding for the archives. Then in July, I think the 2nd of July, the government announced the emergency funding. And then on the 19th of August, there was the published response after that 18-month delay. And I'm wondering what influenced that, because the general tone of all of the conversation, the previous estimates, were that you were not going to move to actually provide this funding. And I'm just really keen to understand what the influence point was in terms of the result of providing that funding and providing the response to the Tune Review.
Well, Senator Grogan, respectfully, your interpretation isn't correct. It was always the government's intention to act, but it was an intention that we wanted to implement in an holistic way, so that it wasn't just, for instance, the dumping of money into systems that weren't necessarily as well placed as they could be for the efficient use of said funds. We wanted to do it in the context of responding to the Tune Review to make sure that we were going to get the maximum impact for the long term, because we were also supporting what is in essence a transformation of this institution for the digital age. And if you take the Tune Review's recommendations as a whole, which have either been accepted in full or in principle throughout, and there's none rejected, that intention is borne out. So, I mean, you can suggest whatever narrative you like. The fact of the matter is we took a careful and deliberative process that was about making sure, as we funded this institution, we did it in a way that reflected its long-term plan rather than a short-term band-aid.
Well, I hardly think responding to the Tune Review is a short-term band-aid, given that it's quite a comprehensive review.
Well,
and laid out
respectfully,
quite
that's a different point
pathway.
to the one you just raised, Senator Grogan.
Oh, I believe I'm allowed to raise more than one point, Senator Stoker.
Well, you are, but the matter you just raised purported to draw from my answer, which was on a different point. We need to make sure that we are relating my answers to your question rather than to your next point.
Yeah, but my point is very clearly that you took 18 months to respond to a very good report, which was about protecting and transforming a very, very important organisation into the future. And I'm querying the timing, given that the tone of your response to the previous estimates did not imply in any way that there was going to be a decent result.
Senator Grogan, I haven't even been in the role for 18 months. I seized the reins.
You do not get the right to stand there and say that you're going to not take responsibility for anything that happened prior to your position.
Senator Grogan, if I could just ask you please to give the Minister the opportunity to answer her question. Your question, please.
Senator Grogan, I seized the reins as soon as I came into the role. I've had constructive engagement with Mr Fricker from the very early days of my holding the portfolio. He's been a joy to work with. We have worked together to deliver a meaningful response to the Tune Review, and we have funded it appropriately. That is a legacy that I think speaks well for Mr Fricker, and it's something of which I am proud.
We might put the rest of our questions on notice. Thank you.
Thank you, Senator Grogan.
Thank you very much, Senator. And Senator Carr, you have a
Yes.
few questions?
The question of the rewriting of the Archives Act. I asked if I could, Senator Staker, where are we at with that?
Look, the process is underway. The department and I have been working together, of course, on the advice of Mr Fricker and his team at the Archives, making sure that we take into account the suggestions that were made in the Tune Review, incorporating those, and indeed taking into account a lot of the practical feedback that comes from the National Archives of Australia's day-to-day use of that Act. So there's we've had a deep dive together, we've had conversations about what the options look like, and I've got some really good proposals before me that I expect we will be able to act upon soon.
So do you think we'll have a piece of legislation to look at soon?
I do.
Before this parliamentary term?
Yes.
Thank you. Because there'll be a requirement, I would imagine, there'll be a Senate process to be pursued here, inquiry. It won't be something that I think can be attended to very quickly.
Well,
it's not your expectation, is it, that it'd be?
I'm happy for it to be dealt with in the usual way. It's, again, an important set of criteria or settings to get right, and
important.
I'm very happy to draw on the expertise of people like you who know the institution well.
Thank you. I appreciate that you would do that. And I accept the spirit in which that's proposed.
That's quite sincere.
Yeah, I accept that too. Look, Director General, I noticed that the British Archives have released the files on the Information Research Department's activities in regard to what the CIA is described as one of the worst mass murders of the 20th century, namely the massacre of up to 800,000 Indonesians in the 1960s. Now, there are matters before the AAT at the moment. This is people that were believed to be associated with the Communist Party of Indonesia or left-wing Indonesians. Now, there's a detailed report published by the Observer and published in The Guardian recently. Now, the reason I raise this is if the British Archives and the Foreign Office in Britain is able to release this material from 1965, can you outline to the committee where we are with matters that are currently concerning Australia's involvement in the same matter?
I'm not sure, Senator, is this...
This
are you
is the
referring
matters
to
before the
particular...
AAT.
Was it the Bayuk? Is it? I'm sorry, Senator, you might have to give me some more assistance in terms
well,
of
it's
the
my
particular matter.
understanding that there's an application for the release of files from the same period, which has been stopped by the Foreign Affairs Department, sorry, by the Department of DFAT here, and the matter is being contested before the AAT. Is that? Are you familiar with that case?
I have. There are a number of matters that we have live before the AAT.
Yes, I'll go to some of that broadly. I'm going to go to that more broadly, but this particular matter is one that I'm wondering if you have any information on that before you.
You've got me guessing just a little bit, Senator, as to which particular case. There was a case before the AAT which has been resolved. In fact, the AAT set aside an exemption decision and replaced it to release the requested record in full.
When was that?
This was this is to do with the Indonesia Human Rights Report on a visit to Bayuk.
No.
No?
We might need some more detail, Senator Carr, so that Mr Fricker
I
can more...
understood this was ACES involvement in Indonesia in 1965.
Yes, Senator, as the Assistant Minister saying, I'd be very pleased, of course, to take that on
All right.
notice with some more
Well,
specific...
let me, if you'd like to take that on notice, where does that stand? And there's also the case in regard to the Australian involvement in the Allende coup, which is also before the AAT.
That's correct.
You're familiar with that one?
Yes, absolutely.
Now, where do we stand on that one?
So that matter is, as you have indicated, Senator, before the AAT. The most recent hearing was held between the 2nd and 4th of June of this year. At that hearing, we did release further details. There were a further 62 folios were released, and wholly released, and a further 324 folios were released with some exemptions as a part of that process of review before the tribunal. And the AAT is currently considering its decision on the matter.
I see. Now, the context of this is that you have a significant number of matters that put the AAT in breach of its statutory obligations in terms of its release of public records. And that's because there are objections under the Archives Act being raised by other departments of the Commonwealth. Perhaps you can outline to the committee the nature of those provisions in the current Act.
Thank you, Senator. So under the Archives Act, there's a requirement, in fact, upon my position to enter into arrangements with those responsible agencies, or the responsible minister, or person authorised by the minister, to ensure that advice is always sought prior to making decisions regarding the exemptions in the Act. So that's Section 35, to be precise, of the Act requires that of the archives. And so that is, as you would expect, conforms with the law, so we undertake that as a routine procedure. Those consultations with those responsible policy agencies may take some time to gather all of the information that we need, but that information, that advice, is then taken into consideration before I make a decision, or those delegated with my authority to make that decision do so.
I see. And there's also a provision now where those other agencies are saying they can't take any more access requests because there's no room for their storage facilities. Have I understood that correctly?
That is in fact correct, Senator. So we currently at the situation where we've exhausted the current capacity in the case of the Department of Foreign Affairs and Trade, simply through the volume of requests that are made. There's no practical limit on the number of records that can be requested. And as the requirement is there in the Act to refer those matters, we do so to the Department of Foreign Affairs and Trade.
And they say they can't handle them because they don't have storage facilities. So it's a bit of a catch-22, isn't it?
Catch-22, it's a resourcing, it is a resourcing issue.
They'd like to consider it, but they can't because they don't have room to store the files.
No, DFAT, certainly there's no pushback from any Commonwealth Government agency to perform its requirements under the Archives Act. It is, Senator, a fact that these processes can become quite protracted because of the volume of work.
And the reason I raise this is that if the British have faced up to what can be sometimes acknowledged difficult questions about events that occurred in 1965, for instance, then surely it's incumbent on us to be able to reach some accommodation in terms of revising the Act so that we can get a better fix on how these matters, these questions can be resolved. I've mentioned two, there are many others that might be held up because they would be regarded as sensitive in foreign affairs terms.
If I could make one observation on that question, Senator, we might be conflating two things. One is how much information is ultimately released to the public and how much is determined to be exempt. And on that regard, percentage-wise, in Australia we do very well. You know, we only exempt very small percentage of records. However, the other side to your question, I think, is still a very valid issue. It's one that we've welcomed. This new funding will help us to improve, is the time it can take to make those decisions. So we do release the overwhelming majority, the vast majority of records are released to the public, but I do concede, Senator, it can take some time to properly and diligently complete the process.
And I'm not casting aspersions on you in any way, but there is an issue about whether or not a statute of limitations or some other mechanism can be applied for the resolution of conflict where there is a dispute about the release of sensitive files. Now, and that's why I asked Senator Stoker whether or not these are the types of issues that are prepared to be considered when we are examining the principles of the Act and the administration of the Act, given that the National Archives has a very proud record of the public release of documents. It sometimes gets itself into trouble as a result of political decisions, the Palace letters being a case in point, where I'd argue the case, irrespective of who was in office, that would have placed the archives in that type of position, and it may end up in a procedure before a High Court, which seems to be an unnecessary expense, a credible expense to the archives, an enormous amount of difficulty for people that are genuinely concerned about these issues, and there must be a better way to resolve these types of conflicts. Now, it may well be that there are genuine national security questions where matters are held back, some files are held back indefinitely, never to be released. I acknowledge that that's a possibility. But it seems to me if the British can find a mechanism to release highly sensitive matters for the British government involving most extraordinary and, I may say, horrific circumstances, then it surely can't be on our wit and wisdom in this country to meet those sorts of standards.
Senator Carr, it might be helpful or encouraging for you to know that in the course of our formulation of the options for the amendment of the Act, we've been prepared to look at the way these things are dealt with in the UK, in the US, in other places, and see whether or not the approaches taken in those places help to resolve some of the challenges that have been seen on the Australian front. One of the matters that often gets lost in public discussion about, for instance, the DFAT capacity to deal with these matters is the enormous volume of records that is often needed to be waded through in order to satisfy just one request. And at the moment, by way of example, there's no limitation in the Act on the volume that the National Archives must descend through in order to satisfy one request. And so while some requests are short and simple, others can be enormously time-consuming to go through. So just helping people who are listening on at home understand the full spectrum of measures that are often needed to be undergone in order to tick the box for one request is an important thing in putting some light and shade on the important point that Mr Frick has made.
I accept the proposition you put before, and there's no doubt this committee will want to take an interest in this at the appropriate time. I don't, and I've made this point clear in other forums, that I don't think there should be a limit on people's ability to apply for files. It's not Professor Fernandez is a name that comes up. Researchers are entitled to apply for information. That's not the problem. The problem is the bottleneck with DFAT on this blanket proposition that says we can't deal with something because it might cause offence somewhere else in the world, and it's not consistent with the pattern that's followed in the United States. It's not consistent with the pattern followed in the United Kingdom or countries of similar type to ours.
Look, Senator Carr, what you say may be right in some circumstances, but I'd also posit the alternate example where non-Australian citizens applying from offshore have an unconfined right to request large swathes of sensitive diplomatic information without restriction on volume. And so I'd suggest the unconfined principle you have just suggested may not actually be in Australia's interest in some circumstances, and so we need to be a little bit more nuanced.
But I don't believe, Senator Stoker, that is the case. The cases that before the AAT involve Australian researchers, and the difficulties have arisen us with DFAT in regard to Australian actions internationally, some of which are up to 85 and 90 years of history.
Look, your example may be one that is correct, but so too is mine, and that reflects the complexity of the environment in which the National Archives operates. And so the process we've got to undergo as we consider the Act is to take into account the nuance that's needed to make sure that we're giving the archives the tools to properly manage all of those situations.
Chair, may I also just,
Yes.
perhaps not responding to a question, but just I do owe it to my colleagues in Department of Foreign Affairs and Trade. It's just a part of your question there, Senator Carr. There's no blanket opposition to the release. I just feel I can't leave that on record. So there is, in my experience, all Commonwealth officials have taken the Archives Act very seriously. But as I know you are aware, Senator, the Archives Act is quite specific about exemptions in reference to maintaining Australia's international relations.
Yes.
It does require investigation.
Sure, but it only takes a letter from the CIA to say we don't want to deal with this, and it sits in the files for decades, and that's not satisfactory either.
Right. No, Senator, I simply wanted to put it on record that the officers, the Department of Foreign Affairs and Trade, take the Act very seriously, and there is no blanket opposition to any part of the law.
I know. DFAT is an open book.
Thank you, Senator.
I think Mr Fricker's been quite fair in his defence
Yeah.
of
Yes,
he
the
has.
Department of Foreign
Yes,
Affairs
he
and
has.
Trade.
Always is.
And I think it's also true to say that your generalisation may be one that is somewhat flippant.
Yes.
All right, well, look, Senator
Not like
Carr,
me,
we
not
might...
like me to be flippant.
we will need to leave matters there and share the call around. And we're also rapidly approaching the dinner break as well. And now I'd like to give the call to Senator Smith.
Thank you very much, Chair. Mr Fricker, can I extend my congratulations to you and wonderful service you've done to the Commonwealth. I just want to turn back to your comments in regards to Barbara White's contribution of $1 million. And you identified that she had that was being used in terms of World War II photographic records. So does the donations policy allow someone to make a donation to the archives and then prescribe how that is to be used?
No, it doesn't. It doesn't. It's a donation is a donation, it's a gift to the archives, and then it is a condition of that donation, and particularly in terms of being a deductible gift as well, just to be clear on this, is that donation is to us. But I'm very pleased to be able to say that that donation has allowed us to now take on this, because the scale of the donation is substantial enough to allow us to apply it to a very important part of preservation of records that would otherwise perhaps been slightly beyond our reach. We have some years back been separately appropriated by the government to the amount of $10 million to digitise World War II service records.
Service records, that's right.
And so that program is continuing, but the quantum was insufficient to actually do some of the more labour-intensive photographic preservation. And many World War II records do have photographic negatives of the men and women who, put a face to the name of that service record.
I'll come to the service record exercise in a moment if time allows. In your annual report, you talk about online visitations having increased by 502%. That's not a typing error? That is a...
No, it's been quite it's quite extraordinary. Now, whether that's a factor of COVID, of people in lockdown, and we've been certainly promoting so people have a greater appetite to engage with cultural heritage through digital channels. And if I may say, I think it's been quite a lifesaver in many parts of the world where cultural institutions have gone the extra mile to make sure that cultural heritage does remain available and accessible to people. And so not only have our own programs increased the public's appetite for that sort of thing, but the general level of interest shown in these has also been greatly increased. I also believe some of the higher profile announcements that we have made and some of the programs such as the World War II digitisation, etc., have also attracted more people to connect with the documentary heritage that's held in the National Archives of Australia.
The annual report says that 7.4% of the records are digitised at the moment. Are you able to give us what is the expected, what is the objective or the goal over the next, perhaps over the forward estimates or even over the next decade?
In terms of the percentage of the overall collection, so as said in my opening remarks, we have hundreds of millions, in fact, of records. To digitise the entire collection of the National Archives would cost, I'm distant enough from my Assistant Minister, would cost many, many hundreds of millions of dollars.
Don't cause me a heart attack.
No, that's right. No, 67 million at a time, Senator. So it's, well, certainly now that I've said my farewells, it's not within my horizon to see the complete digitisation of the collection. Our digitisation efforts really are focused on those things that need to be digitised as an act of preservation, digital preservation, particularly magnetic tape records, material that's deteriorating, or other those series which are in high demand by people. So to make it more accessible to more Australians at a lower cost or free, and also if we digitise those records, they're handled less frequently, so the original material can be preserved for a much longer period of time in preservation conditions.
So if you had to identify what parts of the National Archive deserve priority digitisation, what would those 4 or 5 areas be?
So they are, and I'm happy to report...
It's like asking someone to choose between their children. That's a little cruel, Senator Smith.
That's right.
I'm sure Mr Frick is prepared.
That's right. Well, I suppose it's choosing the safety of your children. So perhaps the more infantile, helpless children get the first priority to make sure they're kept safe. So those records most at risk are the ones that are receiving that priority treatment. And they are records on media which is either deteriorating or being lost through to technological obsolescence. So the category, and I know I've discussed this before this committee in the past, much of the audiovisual heritage of the 20th century is recorded on magnetic tape. Every one of those formats is now obsolete. You know, you'd be very hard pressed to go and buy a VHS video player or a Betacam or something these days. Even the latter part of the 20th century, digital audio tape or those digital formats are also obsolete. So we need to digitise all of the holdings we have on magnetic tape to make sure they are properly preserved and carried forward for future generations. Another category in there is photographic negatives that are subject to deterioration over time because of the chemistry on those negatives. We can store them at very low temperature to stabilise them, but it's very hard to stop the deterioration of that material. So they're getting priority for digital preservation. And as I said a moment ago, Senator, if records are so popular that they're constantly being handled, that will lead to their deterioration, and so we would seek to digitise those as well.
There's a suggestion that the government's $67 million funding injection has allowed some reforms to be accelerated against the Tune review recommendations. Is that correct?
That's correct. So that funding, I think, will preserve our magnetic tape collection, for example, which is great news. It is also going to allow us to the issue that Senator Carr was just discussing. It's also given us provision to get more resources to accelerate that very process, the examination, declassification of sensitive government records, and also to work upstream, if you like, to work within the Commonwealth government, with other departments and agencies of the government, to work with those agencies to, if you like, accelerate the identification of records that need to be preserved and to have them transferred into our care. So that's an area which will benefit immensely from this funding, because it will allow us to accelerate the process through which we examine and release those records to the public.
Is digital freeze a technical archive term?
Digital freeze? It might
Disposal
be.
freeze.
Disposal
yeah,
freeze.
Is it technical archive
Yes,
term?
sorry, disposal freeze is indeed a technical term. That's correct, Senator. So we issue, routinely, we issue instruments called records authorities, which provide the permission, if you like, for the lawful destruction of government records. So this is where we would say that certain records need to be preserved in perpetuity, others can be destroyed after 10 years, after 7 years, or after they're no longer in business use. From time to time, a Royal Commission will commence or an inquiry will get underway, and therefore as a precautionary measure, we issue a disposal freeze, which simply suspends that permission to destroy records around a certain subject area. And that is to make sure that while that inquiry is underway, or an important legal matter is being investigated by the Federal Court or the High Court, it just makes sure that, as a precautionary measure, that records are not being destroyed that may be required as evidence for that particular inquiry.
And is there a threshold which is observed before you get to a disposal freeze requirement or recommendation or authority?
The threshold, it is a matter of judgment, but the threshold is if this matter is of such importance to the Commonwealth, then
or
we
to the
will,
historical record.
or indeed a historical record. But it's, well, the historical record is more about our ongoing selection policies. You know, we will always seek to preserve records of historical significance. The disposal freeze is a temporary suspension of a permission to destroy a record because of a time-limited exercise that may require that record to be adduced.
And how many disposal freezes would you issue in a year?
Well, a handful, if I can say that, a half a dozen or so. I think at the moment we have, in fact, I have it here in front of me.
Page 24 of the annual report, I think, talks specifically about one. That's right. Yep.
Yes. And we have, if I may, just quickly. Someone has gone to the trouble of preparing me a briefing note. I should use.
Just be curious, the number of disposal freezes that are in place at the moment or over the last financial year.
Yes, we have. So we have two in effect at the moment. I think we issued two. One to support the independent review into Commonwealth parliamentary workplaces, for example, and also to support the work of the National Commissioner for Defence and Veteran Suicide Prevention. So they're two examples of where we do it.
Just turning finally then to the $10 million that's saving the Second World War service records. How many records have been saved?
So overall, we have just over 1 million files. So a file could contain up to I don't know, any number of folios. We understand in the old days, I think we've all worked with files and papers. So we have just over 1 million files which fall into the World War II category. To date, we have digitised just over 400,000 out of that million. And so it's about 38% of the way through. The funding is over a 4-year period, and so we do expect to successfully complete that program. I would say, Senator, that $10 million will go so far with all of the material that would be considered to be part of the record of men and women that served in World War II. So as I mentioned, the donation we've received to allow us to pick up the photographic components of that. We're also, I'm happy to report, we're also working with the Royal Australian Air Force, who have also been able to assist us in the digitisation of some of the RAF-related records as well.
And have you been able to quantify how many records have been saved as a result of the $67.7 million contribution?
Well, to date, it's we are at the beginning, if you like, of this. But I would point first and foremost to in Quantum there's 270,000 records. Now they are in various formats, but I mentioned the audio-visual records, for example. Some just under 190,000 of that would be irreplaceable audio-visual records on magnetic tape. But in overall, the Quantum is 270,000 items that we had already identified as being particularly at risk and requiring this preservation work. This $67 million appropriation is going to allow us to digitally preserve and save those records.
Excellent, great. Thank you very much. Thank you, Chair.
Thank you very much, Senator Smith. Senator Patrick, hoping we'll run you through to 6 o'clock, which you've got 20 seconds. Do you think you can do it?
So I don't think that's going to happen, Chair. So if people don't mind running over, I'm happy, or we can come back after the break.
No, I was jesting. If you could just...
Wouldn't be more than 10 minutes. So.
No, I think we should just go over
you.
and then we can finish with the archives before we
Okay.
break for dinner. So,
Thank you.
You have the call, Senator.
Okay,
Patrick.
in your annual report on page 99, you talk about the Palace letters, talk about five other applications, which, reading between the lines, it sounds as though you may have refused access to at least part of those applications. Is that correct?
No, Senator. The other applications, so these are the applications now for the other Palace letters that we have in our collection that also fall under that High Court's ruling now to be considered as Commonwealth records for the purposes of the Act. Those applications are still underway, being considered and being processed. And we have now examined all of those documents, and we are at the final stages of concluding that process. We're just waiting for some final bits of advice just to make sure I can be satisfied that the decision will be lawful and properly considered prior to release of those records.
Okay, then it goes on to say the Advisory Council supports amendments to the Archives Act that make clear the types of records considered as Commonwealth records. One would imagine the High Court decision has provided clarity. Is the intention of, do I read into that statement, the intention of the legislation is to overturn the High Court's decision?
No, well, it's certainly not the intention of what we put into the annual report, no, Senator.
I don't think you can draw that inference.
Sorry?
I don't think you can draw that inference.
So it is in the annual report, so I'm just asking what it means when you say that you want to make clear the types of records considered Commonwealth records.
Because the High Court decision did give us, I mean, it's a High Court decision. Obviously, it's going to have major implications on the way we now go about doing our work. It changed our working definition of a Commonwealth record. So it simply is there just to reaffirm, I know it's stating the obvious, but just to reaffirm that this has had an absolute effect on the staff at the National Archives to now incorporate that High Court decision into our working definition of a Commonwealth record.
Okay, thank you, that clarifies that. I hate to do this, but I do have to declare, Chair, that I'm in litigation with Mr Fricker as well in the AAT on an FOI matter. So
just another friendly...
Yeah.
You said friendly litigation last time. You didn't use that word this time.
We just assume you're litigating against most of us.
If it's to do with access to information, you can assume I'm litigating someone. So I just wonder, this sort of relates to what Senator Carr was saying. And I don't want to prejudge what happens in the proceedings, but my matter is related to a cabinet submission that's more than 20 years old and relates to East Timor. And I'll just tell you, part of my decision making was when I get a response from the archives, because everything was redacted, I make a calculated decision that, you know what, that's likely to be wrong. And I just wonder, had you gone through perhaps more carefully examined the documents, perhaps with a bit of resistance to what DFAT might have said, we wouldn't be in litigation. And in fact, I suspect what's going to happen at a directions hearing on Thursday or just prior to any substantive hearing is you're going to walk up and say, we're going to give you part of these documents, just as happens with Professor Fernandez regularly and other people I talk to about working with the AET. And I just wonder if you just did that in the first place, maybe you wouldn't end up with with litigation.
But Senator, when you say it regularly happens, actually it's the reverse. What regularly happens is that the decisions made by the archives are upheld by the AAT. Now, the AAT is part of the machinery that we have in Australia to make sure that every decision we make is accountable and is open to scrutiny. We do, of course, we look at every outcome from every tribunal hearing we go to, and we incorporate that into our decision making.
But stepping back to Professor Fernandez's application, on the morning of the hearing, you offered a whole bunch of documents.
That's right.
Now, why is it necessary to get to a point where you're about to go before a deputy president, and suddenly you go, you know what, I'm going to release a bunch of stuff? I'm trying to be helpful.
No, I appreciate that, Senator. And again, these are two cases where, or there's one case where that did occur. But if you look at the history of matters before the AAT, that's very much in the minority. It would be, the suggestion is that we could all save ourselves time and effort by, opening the doors and the shelves of the archives and let researchers help yourselves, and we will save on legal fees and etc. That's not what the Act requires us to do. So we do apply our best judgment. We apply our best efforts to conform with the requirements of the Act, and the AAT is the appeals mechanism.
Okay. How many matters have you got before the AAT at the moment?
How many matters?
Yes.
We have 1, 2, 3, 4, 5, 6, 7, 8, 9. 9 matters.
So 9 matters before the AAT. Is that a sort of standard number?
Pretty much, Senator.
Pretty standard. And you're represented in matters before the AAT by the AGS or somebody else?
Correct, Senator.
So there is a reasonable cost involved in this. Sort of goes back to what Senator Carr was saying, that there's an apprehension. And my matter, in fact, is a DFAT matter, and he quite correctly, on evidence you provided us, there are just on matters submitted between 5 and 10 years ago that involve DFAT, you've still got 2,254 DFAT matters, substantially more than ASIO, substantially more than PM&C. So there's some element of truth to what. So it's not just anecdotal, as to what Senator Carr was saying. Can I just come back? I mean, the numbers were still massive numbers. I think your report says 24,000 or something requests that are out of time. I mean, that's just an amazing amount. Everyone's been talking about how you preserve information, but that's only part of the problem. If you preserve it and never get it released, then perhaps you should never worry about preserving it. I mean, the point is to be able to get access to it. What are we doing about things in that space?
To be fair to Mr Fricker, he doesn't have a lot of discretion on this front. The Act is quite prescriptive, and so he's not faced with an awful lot of latitude to be able to accommodate these things.
Hang on, to be fair, he's got 10,000 applications, 10,546 applications that were submitted between 5 and 10 years ago. Now, 9 of them are before the AAT. That leaves a lot that are sitting there languishing in some way, shape or form. Now, the ADJR Act allows someone to go to the federal court and say, you know what, no statutory timeframe associated with this decision. Perhaps, is there a statutory obligation for you in terms of the time it requires you are required to make a decision?
The consideration period is not quite, Senator, but there is, as you're well aware, there's a consideration period after which it is a deemed refusal.
Okay.
So it's if you like, it's deemed to have been refused, and then it becomes available.
So we've got
to appeal.
something like, 20,000 deemed refusals.
That's correct, Senator. But can I also tell the other half of the story?
Sure.
Yeah.
Because to be fair.
Yes. in a year, well, if I can quote from the year 2021 financial year, we did receive 47,000, just over 47,000 new applications for access. Each application may require, many records to be examined. In that same year, we received 47,000. We did examine 40,000 records and did complete the process within the consideration period 36,900 times. So 92% are done within the consideration period.
Yeah, but the people that come to me are not the people that you've made decisions on. It's the people where you haven't made decisions.
No, that's right.
And just be aware, I'm setting this up nicely for your predecessor because I'm going to beat up Senator Stoker for not giving you the resources. No, anyway, I'll leave it there.
Well, before you do leave it there, I think it's important to note the processes that were recommended by the Tune Review and to which we have committed and which we have resourced that are about improving the ability to go through that process of dealing with more complex applications and making sure that wait times are reduced.
Sure, okay, and in that context, I did have a question. I don't want the answer because it will take too long. But just on notice, what was
on notice?
Yeah, let's put it on notice because we are
what is
at the
the current status of the NAA's
Patrick.
efforts to implement the recommendations of the Tune Review, and can you assure the Senate that the NAA is now able to fill its statutory responsibilities in relation to the preservation of Commonwealth records? Because that was a concern. Maybe you can answer that one. Leave the other ones on notice.
Senator,
is that a yes? Or?
Yes,
I'll
Mr. Fricker.
certainly take it on notice, but I would go to the answers just provided a moment ago to Senator Smith. That in terms of our statutory requirements to preserve the records, I am satisfied that with this injection of funds over the next 4 years, our worst concerns have been mitigated. We will be able to preserve those records most at risk, which were really facing the real prospect of deterioration.
All right, thank you, Chair.
Thank you very much, Senator Patrick. And Mr. Fricker, thank you again for your time and evidence today. All the very best with your future. And again, congratulations for everything that you have done for the National Archives.
Thank you, Chair. It's very much appreciated.
Thank you so much. Senators and to all those who are here, we will now suspend for 1 hour for dinner and return just after 7:10 with the Royal Commission into Violence, Abuse, Neglect and Exploitation of People with Disability via video conference. Thank you. The committee is now in session and it's my pleasure to call officers from the Royal Commission into Violence, Abuse, Neglect and Exploitation of People with Disability. Good evening. Apologies that we are coming to you later than the program indicated, so thank you so much all for your patience. Would you like to make an opening statement before we go to questions?
Thank you, Chair. Paul Cronin, Official Secretary of the Disability Royal Commission. I won't make an opening statement, but I would just like to introduce on the video link we have Mr Andres Marcus and Ms Emma Appleton in our Sydney office, Joe Carey in Brisbane and Ms Laura Sham in our Canberra office to assist answering any of the Senator's questions.
Mr Cronin, thank you very much and thank you all for attending this evening. I am going to start by giving the call to Senator Steele-John. Senator Steele-John.
Thank you so much, Chair. Can you hear me clearly enough?
Yes, coming in very loud and clear. A very good line, so that's great.
Okay, fantastic. All right, well, the first question might just go to, I'm not sure, Chair, is it the Attorney or the Assistant Attorney General?
The Attorney is in...
Jordan, it's Michaelia.
Yes.
Hello there. All right, first one to you, Minister. Taking you back to the letter that you so kindly sent through to me during our negotiations over the Royal Commission's Amendment Protection of Information Bill, where you referenced the commencement of a review of the Act and the issue of impediments to people coming forward and sharing information with the Royal Commission, in particular to consider the effectiveness of etc., etc., etc. Just wanted to have an update from you as to how that review is going, given that we listed it as a meeting in the correspondence.
Thank you, Senator Steele, John, and I'll get the relevant departmental official to update you on that if we have someone here.
Well, I'll start off,
Thank
Senator,
you, Mr Anderson.
And if we, depending upon what level of detail we need to go to, we might need to bring someone else to the table. We've commenced work in terms of scoping and planning of that review. We've been consulting, we are consulting the Royal Commission itself. We met with legal and policy staff from the Royal Commission very recently to talk about how they might contribute to the review. And we're thinking about a broader consultation process as well. But the most important thing is, of course, we're very conscious of the time frame within which the review needs to be completed. So 22nd of February 2022, I think, is the deadline for completing that review.
Okay, fantastic. Is there pathways for other members of the interested parties to make contributions to that review? I'm thinking particularly groups that work with individuals giving evidence to the Commission, groups, etc.
There will be, Senator, but we haven't established those yet, hopefully in the near future.
All right. And can we be any more specific than the near future in terms of timelines for the opening up of those pathways? I'd just like to be able to if anybody asks me, to give them a ballpark of being able to contribute to that review.
I'll see if one of my colleagues has a more precise date that they can add, Senator.
Samantha Being, Assistant Secretary, Royal Commissions Branch. Thank you for your question, Senator. The intention is to conduct a public consultation process in the coming month. So that will open at a point in time in November and running for a period of time no less than 4 weeks. In addition to that, the approach will be to also write out to various advocates, organisations and other people and invite them to contribute to the consultation process as well.
All right. And will that involve, just that I'm clear, when you write out to organisations, will you be writing out to organisations which are currently supporting witnesses that the Commissioner's contracted to currently support witnesses to?
Absolutely, that's the intention, Senator. So we're consulting with the Disability Royal Commission, we'll be consulting DSS, and we'll also be doing our own investigations to make sure we go out as broadly as possible to invite contributions.
Okay. All right, lovely. Okay, so superb. And will there be, if it kind of commences, sorry, just to clarify, it commences and concludes within the next month? Just commences?
Commences within the next month.
Okay. Fabo, thanks very much. I will move then to a broader question that is for the Royal Commission. Obviously, for the in relation to the passage of
Senator
the Royal
Steele,
Commission's-
John, I'm sorry to interrupt. We're having some issues with the connection.
Yeah.
We're sort of missing words. So maybe you could just keep your questions quite brief, just to help us help us with the audio issues.
Yep.
Thank you.
So I'm just wondering whether the Royal Commission could illustrate or kind of give me an idea of what the implications or the impact on their work have been in relation to the passage of the Royal Commission's Amendment Protection of Information Bill. So what impacts has that had on work from the passage of that legislation?
Paul Cronin, Official Secretary, Disability Royal Commission. Thank you for the question, Senator. I'll ask Joe Kerry to answer it in a little more detail shortly, but the short answer is that we've It is only early days. The legislation passed about 6 weeks ago, so it's probably a bit early to be coming up with any final trends on how we're going, but we have seen a slight decrease in requests for private sessions and a slight increase in submissions, noting that submissions are now protected if people wish them to remain confidential. But I might ask Joe Carey, who has some more details, to pass it on to you, Senator.
And did you want to call someone else, Mr. Cronin?
Yep, Ms. Carey.
You're on mute, Ms. Carey.
So, Joanna Carey, Assistant Secretary Engagement. It is still quite early days in terms of categorically stating what the trend is, as Mr. Cronin mentioned. That's particularly the case because we do tend to get quite significant variations in numbers of submissions and registrations for private sessions on a week-to-week basis. That being said, the early trends seem to indicate no overall increase in the number of people sharing their individual experience, but as Mr. Cronin indicated, a bit of a trend in terms of how people are choosing to share their experiences. So a slight reduction in numbers of private session registrations and a largely commensurate increase in the number of submissions being made to the Royal Commission.
Thanks, Ms. Carey.
Okay. And I'm just wondering, are we able to quantify that increase in submissions at all at this point?
I don't have trend data with me, Senator, but I can certainly take that on notice if that's helpful.
Yes, if you could, that'd be wonderful. And I just wonder as well if you're able to tell us if there are individuals who have previously given their information as private during private sessions that would now like either to give that evidence as a confidential submission. Is there a process to have that private the information given under a private session converted to be a confidential submission and treated as such?
There's no process for converting the information from a private session into a submission. What we do sometimes have is people wanting to have or provide a supplementary submission following their private session, which they're now able to do confidentially through the submission process.
Okay. And is there going to be a process of kind of inviting those that gave, because I'm aware of a number of individuals who would like to do that because they understand the difference in the way that those two pieces are treated and the way in which the Commission is able to treat confidential submissions as evidence in a way than they are with private sessions. So will people that have had private sessions be invited proactively to give supplementary submissions as confidential evidence?
Yes, Mr. Cronin.
Just so you're aware that the protections that are offered to people that engage with us through the private sessions process, as well as people who make submissions, written submissions or otherwise, to the Royal Commission, those protections are now lined up courtesy of the recent legislation that passed. So in each case, that information remains confidential for up to 99 years. So whilst we always encourage people to come forward to provide information to us in whatever form they wish, there wouldn't seem to be a great deal of benefit in someone who's provided us information via a private session to then come forward with a submission. The protections essentially are the same.
Oh, yes, Mr. Cronin, sorry. I more meant for not so much protection, but from the way in which the Commission is able to utilise information given to it under a private session versus how it is able to utilise information given to it in a confidential submission. Those pieces of evidence, as I understand the Act anyway, are treated differently. And there has been, people have expressed a desire to me to make sure that they are able to give that evidence in a confidential form so that that evidence can be treated by the Commission in a different way. So that was the genesis of my question. Does that make sense?
I might pass to Ms Kerry, but my understanding, Senator, is that the information is treated exactly the same regardless of the form in which it's provided to us.
If I might just add, Senator, it's true that the level of consent people provide when they make a written submission, we ask them for consent about how they use their information, and dependent on what level of consent they choose, that dictates essentially how we might be able to utilise their information. So to the extent that people have chosen to make their information confidential, or to have us treat their information as confidential, we would continue to do so as we have been doing. It's just that the amendments allow it to continue for 99 years post-Royal Commission.
All right, thank you, Ms Carrier.
Senator Steele-John, we are over time, your block of allocated time, so we are going to have to move. Do you have many more questions?
Yeah, I do, Chair. I'm happy to move, though, to another member of the committee, but I will need another piece of time to pursue a couple of other lines. Yes.
All right. Look, to the extent we have got quite a bad line. For some reason, it's just deteriorated. So I'll go now to Senator Grogan. To the extent that you can keep your questions reasonably brief, that would help, because we are straining to hear the questions properly, and the ones that you can put on notice, that would just, I think, be helpful given the difficulties with the remote connection. Thanks so much, Senator. I now give the call to Senator Grogan.
Thank you. I'd like to just ask a few questions about MINDA, an organisation in South Australia, a large South Australian NDIS approved disability service provider. It's come to our attention that last Thursday it was reported that they were once again facing some staffing issues. And it's like the latest crisis. They've had some issues previously. In May this year, they were accused of putting clients at risk by not having sufficient staff to cover shifts. And again, in the last week, there have been some leaked reports, I believe, that indicate chronic staff shortages, and their staff are coming forward and expressing some concerns as well about the operation given the lack of staff available. I'm also of the understanding that MINDA is currently undergoing a mid-term quality audit. And I'm just wondering, has the Royal Commission received any submissions in relation to the level of care at MINDA?
Senator, what I can say is that at 6:51 p.m. last evening, Ms Cook, the member for
Hurtle Vale.
Yes, in South Australia, wrote to the Royal Commission, setting out many of the concerns that you just mentioned and many others, and have sought to bring the Royal Commission's attention to MINDA. As I said, we only received that last evening. We've passed it to our team who will look at it, and some decisions will be made by the commissioners about what may or may not be done with that particular matter.
Okay. And would you be considering holding a hearing in South Australia?
On that particular matter, or generally?
Generally.
During what I describe as perhaps a purple patch earlier this year, where we actually had 2 hearings in public, face-to-face with witnesses in the hearing room. One of those was actually in Adelaide in June, from recollection, at the Adelaide Convention Centre. It may well be that during that what the Commission has decided to do for the rest of the year is that the rest of our hearings will be held virtually, as we've been doing for the last few months. But certainly in 2022, COVID and borders permitting, we'll be looking to have hearings in person, out in the community, in regional centres and in capital cities around Australia. That hearing program is still being set by commissioners, but one of the opportunities potentially is another hearing in Adelaide, but it has not been set yet, Senator.
And can I just ask, with the submissions you receive, do you get many that are specifically targeted to a particular organisation?
The short answer to that is yes, is my recollection, but Ms Carey, who looks after our submissions receipt process and engagement, probably will have a much better idea. I'll ask Ms Carey to answer that.
Thanks, Senator. We certainly do get a range of submissions that mention organisations, mention particular providers of support. So some of those may be organisations or, for example, group homes in which people reside. Some of them will be around organisations that provide support services, government organisations. We really do get a very large range. As you can imagine, having received over 3,000 submissions to date, there's a very large amount of rich content in those submissions that really traverse the range of issues that people with disability experience in relation to violence, abuse, neglect and exploitation.
Thank you. I wonder if I could take you to the Disability Royal Commission draft report on the Morrison government's vaccine rollout for people with a disability. That report called that vaccine rollout seriously deficient and was very concerned about opening up states with the percentage being, 70 or whatever it might be, but then the sub percentage of people living with a disability being nowhere near that number. I wonder, can you tell me what sort of drove you to release a draft report at that time?
Senator, essentially the commissioners who sat on that particular hearing decided it was appropriate in the circumstances to release a draft report.
Because you felt the circumstances were immediately concerning?
If I could go to the Royal Commission's media release on the reasons for releasing it as a draft report. One was that, the first was that the hearing was conducted in May of this year. As you'd be well aware, events with COVID and vaccine rollout have all moved quickly, up to the point where it's September where we're looking to release a report. One chapter of the draft report has a chronology of updating facts between May and September. The commissioners, the commissioners were keen to give the Commonwealth an opportunity to respond to that particular chapter because there were a range of factual matters in there. So that's one reason why it was felt necessary to go back to the Commonwealth in the first instance. But secondly, the commissioners were primarily concerned about the matters that were raised in the report and the very rapidly moving situation with COVID and the vaccine rollout warranted that report to be released in draft at that time.
Now, the Health Department Secretary, Brendan Murphy, refused to respond to the findings because it hadn't been sent officially to the government. Why was the report considered a draft and why did he refuse to respond? Do you know?
I couldn't speak on behalf of Professor Murphy, but the report was in draft for the reasons I just indicated. The report has since is in the process of or has been finalised and will shortly be provided to the Governor-General and Government for tabling in final form.
So why was the draft not sent to the government?
Because that's not the process you would normally go through with a draft report. We do with the final report.
Right, but the Health Department Secretary chose not to respond to it until such time it was a draft, as it was a final report, even though the reason for your releasing it was the fact that it was extraordinarily timely and the situation was a very serious one.
Senator, I'd like to help you, but I can't speak on behalf of Professor Murphy.
Sorry, Senator Grogan as well. There will be an opportunity tomorrow. I understand Health is appearing, obviously not in this committee, but you'll be able to put those questions as well.
Yeah, excellent. So now we're in a situation where you're waiting for a formal action on that report?
The final report will very shortly be delivered to the Governor-General and to the government. And then what would normally happen, and I expect will happen in this circumstance, is government will then provide a formal response to the findings and recommendations in the final report.
Are you aware of any work that's been started on responding to those recommendations or taking any work on board based on that report? I'm just very conscious that all the states are actively opening up their borders now and actively sort of setting targets, 70, 80, 90%, and then a release. But my understanding is that the numbers of people living with a disability that are vaccinated is still way below that number.
Senator, in terms of what the states or territories or the Commonwealth might be doing in response, that really is a matter for them to respond to.
Okay, all right. Thank you very much. Thank you. I appreciate it.
Thank you, Senator.
Thank you, Senator Grogan. Senator Steele-John, back to you. Hopefully we will have a slightly better connection.
Yep, I've changed Wi-Fi connection locations. So is that better?
Not a bit of breakup, but not too bad. Let's just, as I say, maybe keep your questions short and sharp, and that will make it easier for us.
So Mr. Cronin, does the Royal Commission expect the passage of the legislation to have any implications for the Commission's resourcing requirements?
Senator, no, we don't, in the sense that if there is a significant increase in submissions, we're currently resourced to address those submissions or that increase. And as I said, to date anyway, we're not seeing a significant uptick in submissions. We're seeing a similar level of engagement of the Australian community with the Royal Commission in terms of the information they're providing to us. The mix has just slightly changed from private sessions to submissions. But it's really, as Ms Carey said, a little early to tell whether that is a true trend or not. We're keeping a very close eye on it, and we'll be reviewing it month to month just to keep an eye on what is happening.
Thank you. The other thing that's changed in recent months, or relatively recently, is the announcement of an extension to the Commission's end date. And we've also had the lockdowns in Victoria and New South Wales that have impacted on the Commission's work. So I'm just wondering if you could briefly take through the work plan to pick up for that lost time, particularly go into where you intend to go, and what the topics and hearing themes will be.
Senator, I wouldn't say too much time has been lost. In fact, I'd say the Commission's been working pretty hard over the course of the last 6 months, in particular, if you want to draw back to where the lockdowns have occurred in Sydney, Canberra and in Victoria. Our hearing program has largely continued unabated, but in a different form. Our hearings have largely been in virtual format as opposed to face-to-face hearings, with the exception of those 2 hearings I mentioned earlier, one in Western Sydney and one in South Australia. This year we've currently conducted 17 public hearings. We will conduct another 3 this year, so that'll take us up to we've conducted 14 public hearings this year. We will have conducted 20 in total by the end of this year. We, at the moment, have a program that's looking like about 14-ish public hearings for next year. We've recently updated our website that gives an indication of those hearings out until May next year. But commissioners are still reviewing and settling the topics and the number and location of hearings for the balance of 2022 and into 2023. So that's the public hearings process, and as I said, we continue to receive. We've received over 3,000 submissions. Our hotline has received over 11,000 phone calls. We've conducted over 600 private sessions. So work continues. In fact, one of the things I would say with this Royal Commission is perhaps the old way of doing things where everything was done in person. I think we've probably broken new ground in terms of use of technology to address things like private sessions engagement strategies or engagement with the community and in public hearings.
Can I ask you, thanks for that. Can I ask you about one of those two hearings that you had to cancel? One was in relation to a hearing on restrictive practices in education. Have you rescheduled those in your work plan? I'm particularly interested because we know that restrictive practices in education settings are a core space in which violence, abuse, and neglect occurs. So have you rescheduled that in the work plan?
Senator, that's, that and a number of other topics are currently with commissioners for consideration, and they'll make that call later this year or early next year.
Okay. And are you coming to WA out of any?
Senator,
well,
I think there's a problem. I don't think that's Mr. Cronin's issue.
Senator, it wouldn't be an estimates hearing if you didn't ask me that question. Yes, we absolutely intend to get to Western Australia if the borders permit us to get to Western Australia. We certainly plan on having at least one, potentially two public hearings in WA. We're looking at the back half of next year, simply because we're not confident at this stage about the first half of next year. But if we can, we will. I should add that between the last estimates and this estimates, one of our commissioners travelled to Perth and spent a week of conducting private sessions in Perth, and we continue to conduct a range of engagements, largely virtually, with a range of organisations right across Perth, WA and the community over there. So Western Australia has not been forgotten. We've just had to do business differently, but we will get there if we can.
Okay. On to outreach. I'm aware now that we've spent a while trying to fix up the legislative parameters for the Commission. That's resolved. And I'm really interested to know what work is being done around your public advertising campaign, particularly in relation to work being done to ensure that there is a high level of community awareness of the Commission. I'd love to get a bit more of a picture of how you're spending your ad budget.
Senator, we're currently contemplating whether we run a broader national campaign early next year to try and get into those parts of the Australian community that are those hard parts for us in terms of recognition for the Disability Royal Commission. And we'll have more to say, if I can say it in those terms, later this year about how that is looking for us. But we recognise we can always do more, and we will endeavour to do what we can to reach, as I said, those hard parts of the community that we need to engage with, and for them to engage with us.
And can you, for the interest of time, could you just take on, I think maybe it'd be Miss Carey, could you take on notice the number backlog in relation, or the current status of the backlog in relation to private sessions, how many have occurred, and what is the projected timeline of clearing that backlog, if you could? And then I'll just go to my last question before the chair, the real evils down the end of the phone.
Thank you.
Down the end of the screen. Thank you, Chair. I just want, so is that all right, Ms. Carey? Can you take that on notice, or Mr. Cronin?
Yeah, we'll take that on notice, Senator.
Yeah. So just a thing, in terms of employment within the Commission, we know that the Commission has set itself some ambitious targets around the employment of disabled people. Over the last 12 months, have we seen the number of disabled people increase or decrease in terms of employment within the Commission? And within that metric, has that increase or decrease come at more senior or junior levels within the Commission?
Senator, I'll ask Ms Appleton to answer that in a bit more detail in a second. But what I can say is that number, and we do keep a very close eye on it because, as you know, we are actively looking to recruit people with disability to the staff of the Royal Commission. But in my experience, that number has ranged between about 9 and 13% of the Commission's staff throughout that 12-month period. Miss Appleton will have a firmer idea. And we have a distribution of people with disability right through our senior ranks, right through to our most junior ranks on the Commission. We have at least 2 of our senior advisors who have a disability, 2 commissioners that have a disability, 1 of our SES has a disability, and that proportion ranges right down through our senior staff, right to our most junior staff. But Ms Appleton, I might just ask you to just address that in more detail if you need to.
Ms Appleton?
Miss Appleby, are you there?
Appleton?
No, it doesn't.
No, they are. They're just on mute, I think.
Right. In Sydney?
Yes.
Can you hear me now?
Yes.
Okay, sorry, apologies.
Ms Appleton, welcome.
Okay. Senator, at the moment, we have 9.7% of staff who have voluntarily identified as being people with disabilities. We generally do hover between the 9 to 13%. I don't have any trend data with me at the moment for the last 12 months, but I could take that on notice.
Would you, if that would be okay? And at the same time, I don't think you have the figure with me, but with you. But we know that in relation to employment of disabled people, having the resources there to do that is an important aspect. So are you able to give me a budgetary update for the Commission? If not, you can take that on notice as well.
Sorry, Senator, what was the actual question?
So the kind of connected question was the current budgetary position of the Commission, of the amount that you were allocated. How much money have you expended to this point / got left?
Sure. Yep. Absolutely.
Senator Steele-John, we will need to leave it there. You've put all your other questions on notice, or you can put others on notice, of course. So thank you so much. There being no other senators who are seeking the call, Mr Cronin, thank you very much to you and your officers for your time and for your evidence this evening. And again, apologies that we did keep you waiting a little.
Thank you, Chair. It's a pleasure.
Thank you.
Thank you.
I'd now like to call officers from the Royal Commission into Defence and Veteran Suicide. Dr Popple, good evening. You can hear me okay? We can't hear you. Well, you're on mute. Dr Popple? That sounds better.
Can you hear me now?
Yes. Indeed. Wonderful. Dr Popple, good evening, and apologies that we have kept you waiting. Do you have an opening statement?
No, Senator.
Thank you very much, Dr Popple. We'll now move to questions, and Senator Carr has the call.
Thank you very much. And look, I'll need to truncate these matters. I do so without meaning any disrespect, but because of the time constraints we have, I've got to ask these questions on behalf of my colleagues. And I do congratulate the Commissioner on his appointment. The matters, however, there's some matters of concern that have been raised in regard to the terms of reference and the operations of the Commission. And I'm wondering if you could assist me with some of these questions. And I'd ask, will the Royal Commission be looking into or taking evidence regarding the lack of availability of new treatments and research into new treatments in Australia, or known conditions that drive our defence personnel and veterans to suicide?
Senator, the Commission is, of course, direct their own inquiry and will, I think it's appropriate, with their terms of reference. There is a term of reference, the last of them, is any matter reasonably incidental to a matter referred to in the paragraphs above. So if the commissioners were of the view that that was sufficiently connected to the rest of their terms of reference, they could investigate that.
Okay. So it's your intention, therefore, to use that that term of reference?
No, I'm to say that that is open to the commissioners if they are of the view that
Yes,
that is
yes.
sufficiently related to their other terms of reference.
I see. So no decision's been made as yet?
No.
Thank you. Can you advise whether or not the Royal Commission will be examining the benefits of proven alternative therapies such as medical cannabis, art therapy, PTSD assistance dogs and other practices that have had a demonstrably positive effect overseas and with veterans experiencing PTSD?
Well, generally, Senator, yes, commissioners will of course be investigating generally those matters. I can't say whether they'll investigate specifically the matters you raise, but they will certainly be interested in proven solutions to the issues that they are investigating.
So it's too early to tell, but the terms of reference don't preclude that type of examination.
It's a matter for the commissioners, Senator, but I would have thought that that is generally within the terms of reference, but it's a matter for them.
Yep, okay. So we'll obviously come back to that. Look, it's been put to me that the Minister was not successful including in the terms of reference issues such as prescription medications and abuse in the ADF is that correct?
Senator, I'm not really well placed to answer questions about how the terms of reference were constructed. That might be a question for the department, but...
Well, thank you for assisting me. Can I ask one of the officers, is that the case?
Senator, it wouldn't be usual to go into the process of what went into drafting the letters patent in terms of reference, on that they're finally made by the Governor-General, and there's a Cabinet and conference process that leads into that.
So is it the fact that the terms of reference don't go to those particular questions in terms of abuse within the ADF?
I don't have the tools. I'm not sure if one of my colleagues is able to assist with that. She can come to the table, Senator.
It'd be a straightforward matter if the advice I've been given is correct.
I think, Senator Carr, I've just pulled up the terms of reference, but it is as Mr Popple, the official secretary, stated. When you look at terms of reference number J, and obviously Ms Bing is able to assist further, but it does say any matter reasonably incidental to a matter referred to in paragraphs A to I, or that the commissioners believe is reasonably relevant to their inquiry.
So it's the old any other matters that we have in our terms of reference for an inquiry. Is that what you're saying?
No, I'm not. What I'm saying is that is what the terms of reference at J state. If the commissioners believe something is relevant to their inquiry.
Okay. So it doesn't preclude. That's why I'm interested
I've
to
just
know.
read out number J, but I'll get Ms Bing
can I just be clear about that?
For you.
Can I get the officer to assist me? Would that type of inquiry be beyond the scope of the Commission?
Senator, no. As described, in addition to J, if you look at other parts of the terms of reference, so for example, B, it allows the Commission to look into the possible contribution of pre-service, service, including training and deployments, transition, separation and post-service issues, such as the following.
Yep.
And then it goes into a number of different limbs, all of which, if you read that together with clause J, enables the Royal Commission to consider it if they choose to.
Yep, fair enough. So in terms of a general note, I'd ask if the Secretary to the Commissioner could assist me here. How would you describe the level of assistance and coordination from the government and government agency with the Royal Commission? How would you describe that?
Well, it's early days, Senator, but certainly so far the Commonwealth has assisted the Royal Commission. We have presented him with a number of notices to produce, a number of notices to give. We've negotiated with the Commonwealth on those notices, as is the usual practice, and those notices have been complied with.
Right you are, thank you. So it's early days and we'll come back to all of these matters. Thank you very much. But you've had no reason for complaint about the level of assistance you've been provided?
No.
Thank you. There's been no difficulty in terms of resourcing your work?
No.
No? All right. Now,
but it's early days, Senator.
Yes. This are early inquiries as well, so we'll explore this further on other occasions. Look, it's been suggested to me as well that the chair of the Royal Commission, Commissioner Caldas, has suggested the Royal Commission was not consulted about the recent government announcements concerning the announcements by the Veteran Affairs Minister announcing the appointment of management consultants McKinsey and Company to work on improving the claims of processing system for defence personnel and veterans. Is that statement correct?
Senator, the Royal Commission has issued a statement about, amongst other things, the announcement about the McKinsey report, contract, what it might be called, the 19th of October, so last week.
Yeah.
The Commissioners noted the announcement by the Minister of the appointment of consultants McKinsey Company to take action to improve the claims system supporting veterans. The Commissioners said that the Royal Commission looks forward to learning more about the scope and the nature of the actions McKinsey & Co will be taking, and also to working with the Department to ensure the interests and well-being of bereaved families are protected. The Commission has indicated that they are mindful that both organisations, that is the Royal Commission and McKinsey, seeking to work closely with defence members and families. That being so, our processes should support those involved and avoid being duplicative, conflicting or otherwise overwhelming. So the Commissioners are concerned to make sure that the a consultation process that has been announced on McKinsey won't mean that some of our stakeholders, some of the veterans and their families that we are dealing with, aren't being dealt with twice in relation to similar matters.
Senator Carr, last question. We're just right on time. So
yeah, look, if you give me a moment, I might be able to finish this entire section. Look, it's just that. So I've read the release here, and it says here McKinsey will be releasing its plan in December. Now I'm just wondering why it is that the government would set up a Royal Commission and then put consultants into people's homes with a proposition of a report, an interim report, a plan to be released by December. Inquiry, I take it the Commission's due to have an interim report by August next year. It just seems to me remarkably, it seems a duplication at the very least. And given what the Commissioner himself has said, whether or not it makes any sense to do things in this manner.
Senator, I take it that's not a question for me because I certainly can't.
Well, all right, so okay, well that's fair enough too. That's you're not really in a position to be able to answer that. So I'd ask the department or the minister, just can you explain to me how it is that this has come about, that these consultants are appointed at the same time a Royal Commission's been appointed. The Royal Commission's required to give an interim report early next year, or halfway through this next year, but the consultants are in there interviewing people and preparing a plan for December. I'm just wondering how that works. Isn't that about preempting the work and recommendations of the Royal Commission?
Senator, respectfully, that question's better directed to the Veterans Affairs.
Yes, I thought you might say
Minister,
that, Chair.
Because
I didn't prepare this brief,
This is-
but...
Well, it is unfortunately,
but
Senator
it's the
Carr, better directed
obvious
to the
reply.
Department of Veterans
Yeah, but it does strike me as peculiar.
Yeah, Senator Carr, that's probably a good note to move over
Put
to...
that on notice then.
Yes, we will need to share the call around. Senator Van, thank you.
Thank you.
Having been involved in 4 Royal Commissions, the success of them is often tied to the comprehensiveness of their terms of reference. These terms of reference are quite detailed, aren't they?
That's correct.
That's to Mr. Dr. Popple.
Sorry, question for me, Senator?
If you'd like to, I was directing it to you, but I wasn't sure if you would take it or the department, but please.
I'm happy to take it. I think they are, yes.
Thank you. And it covers all of what a Royal Commission of this type should look at. What are the broad themes that it's looking at?
Senator, I don't think I could answer the first part of your question. It's a matter of opinion whether a Royal Commission, whether these terms of reference cover everything the Royal Commission should look at. But the broad themes are that the commissioners have been authorised into systemic issues and common themes amongst a number of specified areas that may have led to suicidal ideation. And some of those themes, some of those areas were touched on before by Ms. Bing, but they are recruitment, the relevance, if any, of the branch of the Defence Forces in which the person served, the rank.
Maybe that one might be better. I've taken on notice, Dr. Popple. What is the Royal Commission's hearing schedule? When will hearings commence?
I'm sorry, Senator, I didn't catch the last part of your question.
When will hearings commence?
Hearings will commence, Senator, on the 29th of November. The 26th of November will be the ceremonial hearing. And the following Monday, which is the 29th of November, the first hearing conducted. That one will be 2 weeks long. Both of those hearings will be public, COVID allowing, and they'll be conducted in Brisbane.
Excellent. And lastly, how much funding has been provided to the Royal Commission?
Senator, the Royal Commission has been given $108.247 million over 2 years. I can break that down if that is useful to you.
No, that won't be necessary. Thank you. I thought the number was $145.3 million over 2 years, though.
The answer I just gave you was in relation to the money that the Royal Commission has. There was also other money allocated for Royal Commission related activities,
right,
which include legal financial assistance and other support. Others might be able to answer questions about that to the Senator.
Ms. Bing, did you want to add something to that by the look on your face?
I can certainly set out very briefly for you. 145.3 million has been committed over 2 years. 108.2 million is for the establishment and running of the Royal Commission. That's the figure to which Dr. Popple referred to. 10.9 million for financial assistance for people appearing before the Royal Commission. 9.5 million for legal advice services. 14.4 million for Commonwealth legal representation and 2.3 million for management of the Royal Commission records.
Thank you. Thank you very much. Thank you, Chair.
Thank you very much, Senator Van. I'm going to hand over to Senator Steele-John in a moment, but just, Dr. Popple, one question from me. A really important issue, of course, is how will the Royal Commission ensure that no further psychological harm is done to Defence members, veterans and their families? What sort of safeguards are in place?
Thank you, Senator. Well, the Commissioners are very careful to ensure that all their activities are done in a trauma-informed way. They want to make sure that all the engagements that people have with the Royal Commission are as easy as they can be in the circumstances. To that end, we have engaged a team which is expanding. We already have some on board, counsellors well trained in dealing with people who have trauma issues. They engage with those when they engage with the Commission, whether it's 1800 number or by email or both. They will also engage with those people who are witnesses before the Royal Commission and those who may also want to take advantage of a private session with one or two of the commissioners. So we have protocols in place for how those interactions and those dealings will happen. We will offer those services to those people at various times within that process. And when the process is over, that is when they've finished giving their evidence or they've finished with their private session, we will also make sure we interact with them to make sure that they are appropriately assisted after that, and if required and if appropriate, referred to other services to assist them.
Thank you very much, Dr. Popple. I'll now give the call to Senator Steele-John.
Thanks, Chair. Dr. Popple, would you be able to provide those protocols which you just referenced in relation to the Chair's question to the committee on notice?
Yes, I can.
Thank you, Doctor. Can I ask then, in relation to this Royal Commission, will it require legislative changes to the Royal Commission Act to enable different people to give evidence who want to give evidence / share their experiences? Do you see?
Senator, are you referring to the sort of legislation that was recently enacted in relation to the Disability Royal Commission?
I am, but it's also my understanding that most Royal Commissions require some form of legislative tweak or another to enable them to function. So it's a broader question really of whether you see a need for legislative change in relation to the broad actions of the Commission. And I would indeed be interested to know whether you believe that similar amendments are needed in relation to this Commission as have just been passed for the DRC.
Senator, the short answer to your question is I don't think we have identified a need for any legislative change yet. We will be taking an interest in and maybe even participating in the review that Ms Bing spoke to you about in answer to earlier questions of my counterparts with the Disability Royal Commission. And the Commissioners have not yet decided whether or not that sort of amendment would be required for them. But the legislative change that has happened recently, about which the Commissioners are very pleased, was the making of the regulations that gave them the power to conduct private sessions. And as you're aware, that brings with it a good deal of protections around the material that is part of those private sessions. The Commissioners intend to conduct those as early as next month, and they're not otherwise, at the moment, looking for any legislative tweak for their operations.
So, Dr. Popple, the challenge that we came up against with the Disability Royal Commission, I don't want to overly link them, but the challenge was that confidential submissions given to the Commission confidentially were only confidential for the life of the Commission. Isn't it your understanding that that is also the case for confidential submissions given to this Royal Commission, unless the legislation is changed?
I think with respect, Senator, it's a bit more complicated than that because it depends on what, if anything, is done with those submissions. So, for example, if those submissions become the basis of evidence provided to the Royal Commission, they may well attract protections that witnesses and material get. But you're right, I believe there are situations where a submission might be given to the Royal Commission, does not become part of a private session, does not become part of a public hearing or a private hearing, and it is certainly the case that that submission would not come under those protections of those other mechanisms. There are other protections available, of course, under the FOI Act, for example, and the Privacy Act, but that's my understanding of it.
Yes, I mean that's the challenge I was trying to tease out with Mr. Cronin earlier, is that information given under a private session, though protected in the ways currently now offered to confidential submissions under the relevant legislation, the privacy settings are the same, However, private sessions information serves only as a narrative guide and additional information to the commissioners, whereas confidential evidence may be treated as evidence. And that's the key distinction between those two pieces of information. Is that your understanding of the difference between evidence given in submission confidentially and private sessions?
That's a little different, Senator, than what I had in mind when I just answered your question. Are you saying that the concern is that material that was provided in a submission might then be used by the Commission as evidence in circumstances where that was not wished by the person making the submission?
Oh, my understanding, Mr. Poplar, I might submit some questions on notice to add some context to this, I think, because in the interest of time, we could have quite a lengthy conversation about this particular section of the Act. My question goes to the status of information given under a private session versus the status given as a formal evidential submission. But I think what I'll do is I'll submit them on notice because you haven't answered my question, which is whether you had requested any legislation or legislative changes, and it sounds to this moment that you have not. So that ticks off my first question. So that is good. I just wanted to then go to the assurances that you are able to offer, because people give evidence to the maybe giving evidence to the Commission that is adverse evidence in relation to the Commonwealth in this space. What assurances and protections will be afforded to witnesses who give evidence that is critical of the Commonwealth?
Dr. Popple, did you hear that clearly? I know the audio is not great.
I think I did, Chair.
Thank you.
I'll attempt to answer it, and please let me know, Senator, if I missed the point. The protections, Senator, are those in the Act. I don't have the Act in front of me, so I cannot give you the provision, but there are provisions in the Royal Commissions Act which make it a defence to, broadly speaking, treat people badly on the basis of evidence they give to a Royal Commission. And the Royal Commissioners are very much aware of that, and I imagine they will remind the world of that at some stage during their ceremonial hearing. And I'm sure that at any stage it comes to their attention that anyone feels that they have been a witness and they have been subject to treatment like that as a result of having given evidence, the Royal Commissioners will be very keen to investigate that.
Okay, thank you. And look, finally, the support for witnesses to give evidence is critical in any Royal Commission, particularly critical in this context, I would argue. Can you give us an idea of the ways in which the Commission is working with veteran and serving member advocacy organisations to support people with evidence, particularly whether the Commission has been given money or whether money has been allocated to advocacy organisations to do that additional support and engagement work, and also in relation to any mental health support services that have been engaged?
Senator, I think I got most of that.
It's.
I wonder if I might take it on notice, because the answer to your questions is yes, and I can provide some more detail. I've already provided some detail about the counselling assistance we provide, but there are other mechanisms available, and Senator, if that's okay, I can provide more detail.
It is. Yeah, we're just getting every second, Senator. We're just getting every second word, so it's just a very unreliable connection. So you'll take the rest of that question on notice, just to make sure that you have the full content of the question, Dr. Popple. Thank you.
And I will submit them all on notice.
Thank you very much, Senator Steele-John. We appreciate your time. And Dr Popple, thank you so much for your appearance here this evening. That concludes the committee's examination of matters concerning the Royal Commission. We do very much appreciate your time and your evidence, and again, apologies that we have kept you waiting. Thank you. I will now call officers from the Australian Human Rights Commission, all of whom are attending from interstate, remotely by video conference. Good evening, everyone. I can see you slowly popping up on the screen. Professor Croucher, good evening. We might kick off by just asking, do you have an opening statement?
Thank you, Chair. Emeritus Professor Rosalind Croucher, President of the Australian Human Rights Commission. I'm here tonight, Chair, with Ms Kate Jenkins, the Sex Discrimination Commissioner, Ms June Oscar, AO, the Aboriginal Torres Strait Islander Social Justice Commissioner, Dr Ben Gauntlet, Disability Discrimination Commissioner, Mr Chin Tan, Race Discrimination Commissioner, and Ms Julie O'Brien, the Interim Chief Executive. And no, Chair, I do not have an opening statement, and I have ascertained from my colleagues that none of us have opening statements. We wanted to devote all of the time to you tonight.
Fantastic. Thank you so much, Professor. My apologies that we have kept you waiting so long. We do apologise that we are running behind in our program, so I'm sorry that we have kept you and interrupted your dinner, but we really appreciate all of you making the time to be available this evening. I am now going to ask senators for questions, and firstly start with Senator McAllister.
Thanks very much, Chair. And thank you, witnesses, for appearing, albeit remotely. It's very difficult, isn't it? My questions initially are to you, President Croucher. Has the Commission seen any change in the numbers of complaints about sexual harassment and sex discrimination over the past few years?
Thank you for your question. Yes, there has been a change. As to the precise, your question goes over the last few years. To that, I would need to take that specific question on notice. However, there has been recently a significant increase, up to 40% in the last year, in relation to complaints prompted in large measure by the Respect at Work report and also by the subsequent amendments to the Sex Discrimination Act. But as to the more precise detail, if your question is wider than that, I would need to take that on notice.
Do you have a quantum of the change that you've observed over the last year?
The figure that I was presented was 40%, of a 40% increase in the complaints under the Sex Discrimination Act.
Oh, that's very significant. Have you received any additional resourcing from government to address that increased workload?
Not at the moment, but we are in discussion. I have raised it with the government.
Right. And do you have an estimate of the resources that would be required to meet that demand?
I couldn't put a figure on it, but the increase in complaints has been significant in relation to sex discrimination and also in relation to the COVID complaints.
Given the resource constraints you are working under relative to the workload, how are you managing that? Is it producing a delay or any other consequence for complainants? With a significant increase of the kind we are facing, the impact will be on the time frame. The backlog will grow, and our ability to triage complaints quickly will be less effective. So yes, it will have an impact over the long term. We have alerted on our website to the impact by way of delays, but yes, it will have an impact in that way. And indeed, the satisfaction rates for our complainants and respondents may well be affected by it. When you talk about the triaging process, would you mind explaining what it is that you're referring to?
Certainly, Senator. If an inquiry comes in through our National Information Service, sometimes the information is that another agency is better placed to be able to deal with the matter, whether it's a state body or it may be the Fair Work Commission or somewhere else. So it's an ability to give a quick response, the no wrong door approach that is really important for us in terms of providing as quick a turnaround as we can. So the greater the numbers and the ability to manage that process is obviously affected.
Thanks very much, Professor Croucher. On another matter, I note that Wednesday last week the Commission commenced a community consultation inviting submissions to inform the development of a national anti-racism framework. I know that you've only just commenced the consultation, but is there anything more you can say about this project and the reasons why it is necessary?
Perhaps in relation to that question, Senator McAllister, I can defer to my colleague, Mr Tan, the Race Discrimination Commissioner, because that project sits with him.
Thank you. Mr Tan?
Thank you, Madam President, and thank you, Senator, for that question. We commenced the launch of the concept for a framework on the basis that it was an important alignment to the need that we felt in this country for a overarching national concept based on anti-racism. Can you hear me? Is that okay?
I am having a little trouble hearing the witness, Chair, but it's perhaps an inevitable consequence of the video.
All right.
I'll make the volume a bit
Mr
louder.
Tan, yes,
perhaps.
it is.
That might help.
It's very challenging, the remote connections.
Yes, it is. It is.
Maybe a bit, if broadcasting could lift the volume a little bit, that would be great.
Okay, now I'll turn up the volume and hopefully that helps.
That sounds a bit better. Yeah, thank you.
Okay, thank you. I'm going to ratchet up a little bit more.
Yes, excellent.
Oh, right.
You're used to
Okay.
turning up your stereo on a Saturday night, aren't you, Mr Tan?
Well, don't let the secret out, but yes, I do that from time to time. Thank you, Senator. The anti-racism was formed on the idea behind it was the need to align a concept of anti-racism and our understanding about how we tackle racism in this country based on a national consensus and a collective understanding about how we deal with an important issue in this country. So it was also a journey, Senator, by way of invitation to Australians to partake in a journey about dealing with racism in this country. So it is largely a document that reflects the consensus of Australians about what it is that we need to do in tackling racism in this country.
Thank you, Dr Tan. And perhaps this is back to Professor Croucher. Has the government provided you with additional funding to support the new National Anti-Racism Framework? We've lost her.
Mr Tan, did you hear that Senator McAllister's question?
Oh, it was to
Sorry,
Professor Croucher.
I also, forgive me,
Thank you.
I had myself on mute. I was going to defer that to Mr Tan.
Oh, okay, thank you.
Senator, the initial stage of the framework requires not a lot of funding, but we've had at this stage received seeding funding from the Department of Attorney General to assist in the consultation process. But much of the funding that is required will come through once the framework is in place and we roll out the campaigns and the processes relevant to the framework. So the short answer is yes, we have received some funding.
Sorry, you have received additional funding?
We have received some funding, yes,
What's the quantum of that, Mr Tan?
to the tune of $200,000.
$200,000. Thank you very much. And
you.
Professor Croucher, can you tell us a little about the other priorities for the Human Rights Commission in terms of its forward work plan?
Thank you, Senator. Each of the commissioners has a program of work that is worked out on an annual basis and also on a longer term basis. Some of the work is done through cooperation with government departments and other external partners. Each of the commissioners can speak to their own program. Mr. Tan has just referred to the racism initiatives. Ms Jenkins, of course, is at the moment in the final stages of the Commonwealth Parliamentary Workplace Review, in addition to her other portfolio work. Ms Oscar is in the second part of her Wiyani Udangani work. I'm leading the Free and Equal project in relation to discrimination law and positive framing. Each of the commissioners can speak to their areas. Dr Gauntlet has got a huge portfolio. So each of the commissioners has a particular mandate in addition to our broader statutory framing, and each can speak quite fulsomely, I can suggest, in relation to their work programs.
Thank you, Professor Croucher. I may not earn any thanks from my colleagues if I invite too much fulsome comment. I'm constant of the time frame.
Yes,
look, can I just ask, Professor Croucher, do you have any concerns about the level of resourcing that the Commission has to meet the objectives of your work plan, particularly given all of the priorities you've outlined?
The issue of our funding is a matter that we've had ongoing conversations in relation to these issues. I've raised issues in relation to funding for each of our commissioners, particularly the fact that we have two that aren't currently funded, and the rise in our complaints work. These are matters that we are in discussion about because they have had a specific impact on our budget.
Yes, of course. Which are the two that are not currently funded?
Specifically the Human Rights Commissioner and the Disability Commissioner.
Thank you very much.
Thanks very much, Senator McAllister. I will now give the call to Senator Faruqi, who is attending remotely via video conference. Senator Faruqi.
Thank you, Chair. Thank you, Chair, and good evening, everyone. Thanks for being here with us at this time of the night to answer our questions. President, if I could start off with you, and this is a question in relation to an FOI on the Commission's disclosure log relating to an application made for correspondence sent or received that included the words institutional, structural, systemic, and racism from July this year. Do you have any information on hand about that? And if you could provide me with the total processing time for the application, including any internal reviews. And I asked this question because I submitted a question on notice on this issue through Minister Stroker's office last week. So I was hoping that you might have some information for me today.
Senator, it's an important question. I can't answer that in the moment, but I'm happy to take that on notice.
Okay, that'll be great. And if you could also take on notice the total of any charges that were issued for processing the request, as I said, including internal reviews. And also, is it possible to provide me with the name of the applicant?
Whatever information I am able to provide on notice, I shall.
Thank you. President, does this sort of request ordinarily go through the Commission's legal department?
We have an FOI officer who is attached to the legal section, yes, and it's kept very separate from our other functions.
Okay, and I'm just wondering what the your staffing level of the legal section is at the moment, the legal department, where such a request would go.
I will, may I just, I'll take some advice from our Interim Chief Executive who is with me while I'm answering further questions. So I'll come back to you if I may, Senator.
Okay. And what other work does the legal department do other than, processing these sorts of requests?
Yes, I can certainly answer that. To illustrate, so a list that's not exclusive but illustrative, they have to engage in a considerable amount of work in reviewing any contracts that we're engaging in. We have quite a few contracts with external people, including government partners, and each of those contracts needs review to make sure that all aspects are appropriately covered off. Our legal team also is responsible for quite a few of our complaints that we call our human rights complaints. They are the ones that
do not sit under the discrimination laws, but sit under the aspects of our main act that refer to the international conventions and instruments that are scheduled to our act. Our legal section embarks upon that area of work. They also provide scrutiny of all of our reports for accuracy in terms of legal referencing. In addition, they manage any of the intervention matters or litigation that we may be involved in. So that may be, for example, where the Commission is a respondent through for instance, an administrative decisions judicial review or similar action. It may also be where we seek leave from the court to intervene in matters of key human rights concern. Our intervention function is one of our key functions throughout our history, and we intervene on average in about 2 to 3 matters a year. Now, I do have an answer in terms of the staffing level, Senator. There are 7 staff in the legal section. All deal with FOI matters amongst other functions.
So it's a small team given the amount of really important policy work that they do. So do you ever, President, feel, given the low level of resourcing and the importance of the policy work that the legal section does, how much time it might take from that work through a request like the one that I alluded to earlier? Is there a certain frustration about the cultural environment in which a request like this might emerge? And when I talk about the cultural environment, I mean an environment where certain people are openly hostile to the reality that racism is embedded in the structures of our society and in our institutions, and that this hostility might be impacting on the work that you and your team has to do?
Senator, without commenting on all of the aspects of your question, I should say that as a government agency, an independent government agency, we are completely amenable to FOI requests, and part of the transparency and open government is to require government agencies to be amenable to FOI requests. So whatever the motivation, that's irrelevant from our perspective. We have to consider each FOI request in good faith.
President, you spoke earlier in response to a question by Senator McAllister about the specific impacts that budgetary constraints have on the Commission. I just want to know, is the way that you are funded at the moment and the resource and financial constraints, is that financially sustainable for the Commission to continue to do their work?
The resourcing is always a challenge, Senator, and I have put it on record that we have concerns, but I've also signalled earlier in my remarks this evening that it is a matter on which we are in engagement at the moment, both with the Attorney herself and with her department. So the conversation is continuing.
And I just have a couple of questions for Commissioner Tan. That's okay?
Yes, Senator.
Thank you. Commissioner Tan, earlier there was some discussion on the anti-racism framework, and I saw on the Commission's website that you have, as of last week, called for submissions on this, which closed in December. You might remember we were discussing this in March, and you had published the concept paper, which I thought was really interesting. And in March, the Commission website stated, over the coming months, the Commission will engage with the community sector to obtain feedback on this overview. It's October now, and that's about 7 months since the paper was published. Has that community engagement happened, and how does it relate to the current submission process?
Yes, Senator, if you, the first question, the answer to the first question is yes, we have had numerous consultations. I think it's in the margin upward of 50. With community groups right across to Indigenous communities and multicultural communities. And secondly, if you look into the details of the submission, you will find that it's arranged as a paper that takes into account as a report about the things we've heard from communities, about the things that they want to see included in changes that they wish to be applied to the consultation concept paper. So it is largely in that framework of saying that it's time that we go to the public for public submission to hear from the rest of the community for what we have heard so far. But Senator, the consultation process is ongoing, so in the next few months, we will be talking to various groups as well. And perhaps it might be an opportunity to include perhaps our politicians, parliamentarians in that process to understand their thinking in that process as well.
And when is the plan to complete the framework, Commissioner?
It's projected that we're looking to receive all the submissions and then produce a conversation report on what we've heard, and then look at a revised concept paper by the end of June of next year.
Thank you. This is my last question for you before we wrap up. I'd like your thoughts on the recent announcement that Victoria will be banning the public display of Nazi symbols. Is this something that you welcome? And if so, would you like to see it rolled across the country?
I think it's an important initiative that's been taken in Victoria to reflect the concerns that have been expressed to the government. Largely, we have a very strong position take as a commission and as a community that we will in fact reject and in fact combat any symbols or any reflections that depict hate and hatred against communities. So I think it's an important and a welcome step in the conversation about what we need to do to in fact remove hatred from the community.
But would you like to see it rolled out across the country?
I think it is worthy of consideration because it is certainly something that obviously expressed a deep desire, not just within the Jewish community, but across Australian community to ensure that we reject hate where it arises.
Thank you, Commissioner Tan. Thanks, everyone.
Thank
Thanks,
you.
Chair.
Thank you very much, Senator Faruqi. We have got just 6 minutes or so before we are going to go to a tea break. I might, Senator Thorpe, are you happy to take a truncated spot and we can come back to you if you want to ask some more questions afterwards?
Sure, Chair. Absolutely.
Okay, thanks so much. I'll give the call to Senator Thorpe. Thank you.
Thank you, Chair. And thank you all for coming out tonight. I respect the work that you all do. I've been involved with some work lately and I was very impressed. So thank you. My first question is, President, was the role of the Commissioner advertised?
Sorry, I didn't hear that question in full, Senator.
So in relation to the latest Commissioner, Human Rights Commissioner, was that position advertised?
Senator, the questions in relation to the appointment, you should really refer, if I may suggest, to the attorney. I understand it wasn't advertised, but the attorney is best placed to answer questions about the process.
Thank you. Minister, would you like to follow up?
Thank you, Senator Thorpe. The government chose to appoint Lorraine Finlay as the new Human Rights Commissioner of the Australian Human Rights Commission. She is an eminently qualified person for the appointment, given her qualifications, knowledge and experience. I'll just take you through that because without a doubt she has excellent qualifications, knowledge and experience for the role. Ms Finlay has been an adjunct senior lecturer at the University of Notre Dame, Australia since 2017. She is also a lecturer at Murdoch University's School of Law since 2010. She is a senior specialist in the area of human trafficking with the Australian mission to ASEAN within the Department of Foreign Affairs and Trade. She was also a state prosecutor with the Office of the Director of Public Prosecutions for Western Australia. She has also lectured in areas including constitutional law, criminal law and legal protection of international human rights, and taught as part of Murdoch University's international human
me,
rights law program
Chair,
in Geneva. That is,
just to be
Senator Thorpe,
relevant-
for your benefit, why she was an eminent person.
Yes, Senator Thorpe.
It wasn't my question, though. With all due respect, you could roll off 5 sheets of qualifications, but it really isn't relevant to the question I have just asked. The question was it advertised? No. So in the name of accountability and transparency to the Australian people, can you please, Minister, tell the people watching, how was the appointment process conducted? Was there a short list? Or did you just hire a mate? Give us the process.
You know, Senator Thorpe, that is why I took you through Ms Finlay's
but that's not relevant.
It is because
I'm asking
she
you what the
was
process
appointed in accordance to the policies and guidelines set out in the government's merit and transparency policy, which states special circumstances where a minister may consider a full selection process is inappropriate may include the availability of an eminent person. And that is why I took you through Ms Findlay's qualifications. She was considered
So is the government
an
deciding
eminent...
who's
Sorry, Senator
eminent
Thorpe,
in
just-
this country?
Senator Thorpe, just please allow
What's
the
eminent
attorney
mean?
to... Senator Thorpe, just if I could ask you just to
I'm
pause
just
while...
trying to understand, Chair, sorry.
Yeah, I know. If I could just ask you to pause so the attorney can just finish her answer, please.
Well, as I stated,
Okay.
the appointment was made in accordance with the government's merit and transparency policy. Ms Findlay was considered an eminent person, eminently qualified for the appointment, given her qualifications, knowledge and experience, and that, Senator Thorpe, is why I took you through Ms Findlay's resume.
Okay, that's great. Thank you for that. So what are you paying her?
I would have to refer to the department for that. It would be...
Senator Andrew Walter from I'm First Assistant Secretary of the Integrity and Security Division in the Attorney General's Department. The amount that she is paid, the Commissioner is paid is determined by the Remuneration Tribunal, and I do have that number here. It's around the remuneration is around 387,000, but I'll get you that exact figure in a moment.
Thank you. I have another further questions in relation to this eminent mate. Where will this
Senator Thorpe, can I...
it's
Senator
not in
Thorpe.
WA.
Senator Thorpe, we are talking about the Commissioner, the future Commissioner, so could I just...
Well, I don't know this person. And
No, but
hasn't been
I would
agreed
ask
with
that when
this.
we have any agency appearing before us, I just would ask please to just refer to individuals respectfully, that's all.
Okay,
Thank you.
So where will the Commissioner sit? So if not in WA, will the Human Rights Commission be paying moving and accommodation costs? And how much will the entire process cost? So I understand this person is resided in WA, and if you need her to relocate, I'm sure that's going to come to a cost to the
It's
taxpayer.
incorrect.
Or
Yep.
something like that.
Yep, no, Senator Thorpe, that's actually incorrect. Ms Finlay does not reside
Okay.
in Western Australia.
So Senator
Okay.
Thorpe, I did put you on notice that we only had a small period of time, so I'm sorry that we
Yes.
are going to have to go to a
Could I
break
just
now.
get an answer to that question, please, Chair? Just in relation to, is there what are the costs in terms of the relocation of this new Commissioner?
You can refer that to the Commissioner, but Ms Finlay is not based in Western Australia.
Thank you for that. Commissioner, will there be relocation costs associated to this new Commissioner being in their role?
I'm happy to answer that question, Senator. The Human Rights Commissioner lives in Canberra. The issue of whether there is any
support for the Commissioner in that role is a matter for the Remuneration Tribunal. As to specific relocation costs, I will take that specific question on notice.
Thank you very much,
Thank
Professor.
you very much.
So thank you, Senator. We will need to just go to a break for some 15 minutes. Now, we do have a challenge. I just want to put everyone on notice that we've got a time management issue. Labor is proposing to take, and Labor senators are proposing to take another 10 minutes. I'm wondering whether Green senators could perhaps confer amongst themselves and try and keep your time to as close to 10 minutes as you can. I don't want to be too prescriptive, but I'm just conscious that I'm very keen to move to the department not long after 9 o'clock. So apologies that we are trying to race through this as quickly as we can. We will adjourn, we will suspend, and we will return in 15 minutes. Thank you.
Thank you, Chair.
So after discussing this with senators, I want to thank senators for making some accommodations. We are going to take questions from Green senators for 10 minutes, questions from Labor senators for 10 minutes, and then finish right on 9:20. Before I do, Mr Walter, you have got a very, very quick update for the committee.
Thank you, Chair. Senator Thorpe asked about the total remuneration package for the Human Rights Commissioner. I can advise the committee that that amount is $360,250.
Thank you very much, Mr Walter. I'll now give the call to Senator Steele-John.
Thanks, Chair. My question is to Mr. Gornett. Mr. Gornett, Commissioner Gornett, have you seen the Disability Royal Commission's draft report into the rollout of the government's COVID-19 vaccine strategy for disabled people? I take it.
Senator Steele-John, we're having terrible trouble with his connection. We heard the first part of the sentence, the vaccine strategy.
Have you seen the draft Disability Royal Commission's report on the rollout of the COVID-19 vaccine strategy, Commissioner Gornett?
Ben Gauntlet, Disability Discrimination Commissioner at the Australian Human Rights Commission. Nice to see you tonight, Senator. Yes, I have seen the Disability Royal Commission's draft paper on the vaccine rollout.
All right. And in relation to the conclusion that the strategy and rollout for vaccine for disabled people with disability had been an abject failure, and that the DHO's framing of the strategy and content of the rollout was found to be seriously deficient by the Commission's draft report. Do you support the findings of this report?
Senator, you are breaking up a little bit. I think the gist of what I took from your question was, do I support the findings of the Disability Royal Commission's report? I think in answering your question, it's important to take a step back and consider that whenever the disability policy system has to interrelate with the healthcare system, we have significant challenges. What the vaccine rollout required was for across Australia, where the Delta variant was, in a sense, running rampant, for people with disability to have accessible vaccinations both in hospitals, in vaccine clinics, and also in reach into homes or residential institutions. And unfortunately, there were some systemic challenges with the vaccine rollout, which meant that it was not ideal in terms of its operation. These systemic challenges which arose came from some accessibility issues with failing to understand the need for accessibility as it related to different disabilities in different locations at different times, and the need to also have both accessible procedures for when a person attended a vaccination clinic but also sought to book a vaccine. There were issues relating to the communication of where a vaccine could be obtained and helping people with, for example, cognitive and intellectual disability move through the system to get a vaccine. And there was also the issue of the information relating to providing information that was appropriate and necessary for a person or an individual who may have a pre-existing medical condition, and to understand how the vaccine would affect that particular individual. The systemic challenges which occurred, unfortunately, have meant that the vaccine rollout for people with disability has been challenging and is something that needs to improve and improve radically. We know that in the United Kingdom, when data has been obtained relating to people with disability in COVID-19, the level of deaths have been disproportionate to people who do not have disability. And for that reason, we need to be constantly vigilant to have a vaccine rollout that is fit for purpose and sustainable both now and in the future. I am, though, cognizant that it is incredibly important to differentiate between the failure of systems and that we still, though, have had many people who have worked in the healthcare system and the disability support system who have gone above and beyond to try and ensure that people remain healthy during the COVID-19 pandemic, and also that people with disability can access vaccine. So I think it is important when we look at critiquing the issue of the vaccine rollout, Senator, that we differentiate between systemic challenges and personal effort, because some of the personal effort that has been undertaken has been very, very laudable.
Undoubtedly. I'm going to move on to another area because we are so short on time.
Probably only got, Senator, because I know that Senator Cox has got some questions as well. So,
I'll just make
one
this
more,
my last question. Yeah, I'll just make this my last question.
Thank you.
The New South Wales Premier has recently indicated that the regular presence of Auslan interpreters at news conferences, which were a staple during the leadership of their predecessor, will come to an end, triggering a lot of concern from the deaf community about the potential discriminatory impacts of that. Do you think the New South Wales government decision to pull back on the use of Auslan interpreters for public announcements jeopardises the rights and safety of disabled people?
I think I need to be quite specific in how I answer your question, Senator. The issue of accessible communication is an important human rights issue, and all governments should, to the fullest extent possible, try and have, particularly during emergency announcement, an Auslan interpreter present, and also make provision for such things as easy read materials for an individual with a cognitive or an intellectual disability when they're provided with information. To the extent that the lack of an interpreter would jeopardise an individual's health, that would be a case-specific situation. But I think in the circumstances of COVID-19, it is absolutely imperative that when announcements are made, that political leaders are aware of the need to have Auslan interpreters present, that media organisations are aware of, to make sure that the Auslan interpreter is visible when they telecast the actual event or the programming, and that we understand that accessible communications takes different forms for different disabilities. We also consider, for example, people with an intellectual cognitive disability or other sensory disabilities like low vision.
Mr. Gortland, thank you.
I'll leave it there, Chair.
No, I am going to have, I do apologise, but we've got a hard marker. So I'm going to need to go to Senator Cox.
I want to leave room for Senator Cox.
Yeah, Senator Cox
Chair.
needs to have some time as well. So I will go to Senator Cox. If I could just ask all witnesses to keep your answers a bit shorter, I would be most grateful. Senator Cox.
Thank you very much, Chair, and thank you to all the witnesses appearing tonight. My question is for Commissioner Jenkins. Just wondering if you're on track to finish the review of the Parliamentary Workplace Review, if that's scheduled to finish on time.
Thank you, Senator Cox, and congratulations on your appointment. Yes, we are on track to deliver our report by the end of November.
Great. And can I just ask, what extent were you involved in the design of the Parliamentary Workplace Support Service?
That service was as a result of the work by Deputy Secretary Stephanie Foster. I was consulted in the broader work that she did, and we will consider what she has done as an input into our inquiry.
Great, thank you very much. My second questions are to Commissioner Oscar. It's in relation to the Women's Voices project, and just can you outline for us the commitments that have been made around the implementation of the recommendations of the report?
Thank you, Senator, and congratulations.
Thank
Linda. I'm happy to provide you with an update on the key issues around Wiyanyudangani, the Women's Voices report, and the project status and the milestones that we have achieved. So, Wiyanyudangani report provides a very comprehensive roadmap, I believe, with 7 overarching recommendations of systemic inequality experienced by First Nations women and girls in Australia. My focus over the past 10 months since the report's launch has been stage 2, which has included pursuing the report's implementation and working with stakeholders to prepare the foundations for First Nations gender justice and equality to take hold in Australia. Progressing the status of First Nations gender justice and equality as a cross-cutting all policy making at all levels. And the current...
Great. Can I interrupt, Chair? My question specifically was, what's the commitment of government on the recommendations, including whether there's been any funding committed in relation to its implementation?
Thank you, Senator. There has been funding provided by the NIAA office, which expires at the end of November in terms of stage 1 and stage 2 of the project. I have received in principle support from Minister Wyatt around the ongoing work, which is stage 3, to host a national summit to develop and design a national framework for action for First Nations women's gender justice and equality.
Great.
And to develop this plan. So I am awaiting confirmation on financial support to enable that process.
Yes,
stage 3.
Thank you, Commissioner Oscar. Just noting that there was a recent Kimberley Women's Forum in relation to the report. Who funded that forum?
The Kimberley Aboriginal Women's Council, mobilisation of Kimberley Aboriginal women, was a separate process funded independently of the Commission, and I am attending the official launch of this entity next week on the 4th of November.
Are you able to name the entity, Commissioner Oscar?
It's the Kimberley Aboriginal Women's Council, a newly established entity representing Kimberley Aboriginal women and their issues.
Great. Can I just ask...
Senator Cox, I'm terribly sorry. As you know, we are in time management, so we are now going to need to move to Senator McAllister. Any other questions would you please put on notice? Senator McAllister.
Great, thank you. My remaining questions are for Commissioner Jenkins. Commissioner Jenkins, are you keeping track of the implementation of your Respect at Work recommendations?
I am in a general sense, and I'm involved with a lot of the implementation, so quite specifically in relation to those.
Great. And can you tell me how many of your recommendations have been fully funded or fully implemented?
I mightn't be, and I can allow the attorney to provide that information, but if I give you an overview, I guess, and then I can, Yes, I'll give you an overview and then I'll see whether, and I'll do it as briefly as possible and see whether I need to provide you more information. So,
Look, given the time, a very brief overview would help, but can I ask you to provide on notice your tally of your implementations and the extent to which they have been implemented or fully funded?
I can, absolutely. So the short version would be, I'm chair of the Respect at Work Council. It covers a number of the recommendations, up to 24. We, as the Commission, are funded to put in place 10 recommendations. There are legislative recommendations, about 12, possibly 13. There's state and territory recommendations, and then there are 4 for the private sector. And whilst there is still some work to do in the 6 months since the government response, almost all of them have done action. And I can provide in more detail for you, Senator, the details.
That'd be terrific, Commissioner Jenkins. Can I ask you specifically about your recommendation in relation to non-disclosure agreements? In your report, you discuss the problems that arise from the use of non-disclosure agreements, and you say that NDAs, as you refer to them, have often served to intimidate and silence victims while concealing the behaviour of harassers who have been able to move within industries and continue to engage in sexual harassment without adverse consequences. Can I ask if you can just explain how it is that NDAs are used in that way? And again, I apologise to hustle you, Senator Commissioner Jenkins, but if you can do so briefly, I'd appreciate it.
Yes, it's been standard practice for a long time for settlements that involve sexual harassment to involve an element of confidentiality, and they have provided blanket confidentiality, being no one will speak of this ever again. And as you referred to, our findings were that blanket approach is not appropriate. So our recommendation was that guidance be produced to specifically identify when it would be appropriate to use that, given that sometimes parties do value non-disclosure agreements. That piece of work is currently being led out of the Attorney General's Department. So that recommendation is currently in consultation phase from the Respect at Work Task Force in the Attorney General's Department, Mr Walters' division.
Thanks, Commissioner Jenkins. Your recommendation was that there be best practice principles developed to inform the development of regulation on NDAs. Has the government requested your input on regulation, approaches to regulation of NDAs?
They've sought my input and, in fact, the input of the Respect at Work Council on the piece of work which I understand at this stage is developing guidance. I'm not clear on the immediate intention. I'd defer to the attorney, but I do recall that that recommendation was accepted and agreed to, so I expect in the longer term we will get a regulation.
Yeah, that's terrific. The government's response says that they will ask the council to develop a practice note that identifies best practice principles for the use of NDAs in workplace sexual harassment matters. The reason I'm asking you about the work on this is because that seems an incomplete response to your actual recommendation, which referred to regulation. So no request to date for input about the form of regulation of NDAs?
No, no, it's just a consultation on the work on non-disclosure agreements under that recommendation.
The best practice note. Okay, thank you very much, Chair. I'm done.
Thank you very much, Senator McAllister, and to all members of the Australian Human Rights Commission appearing this evening. We do thank you sincerely for your time. Thank you in particular, Professor Croucher. Apologies again that we were running so late. We greatly value your work and we look forward to receiving your further questions, answers to questions on notice. Thank you so much.
Thank you, Chair. Thank you, Chair.
I now call officers from the Attorney General's Department. So I think we have everyone ready at the table, and so we will, absent of any opening statement, Ms Jones, do you have any opening statement at all?
Thank you, Chair. I had contemplated making one, but in the interests of time, I won't. Just noting for myself, this is my first appearance as Secretary of the Department. We have most senior officers here available to ask questions in keeping with the guidance from the committee in terms of managing COVID arrangements. Some are appearing remotely, but the vast majority of our very senior officials are here to answer any questions.
All right, thank you very much, Ms Jones. We will firstly go to Senator McAllister.
Thanks very much, Chair. My questions relate to implementation of Respect at Work, and in particular the arrangements for working women's centres. I understand that Mr Anderson responded to questions about this issue last estimates.
Yeah, so I'm just sorry. We are in cross-portfolio corporate and general matters first. Matters to do. I think the matters that you've raised, Senator McAllister, sit in outcome number 1. Do any senators have questions in relation to cross-portfolio?
Look, I think we do. This obviously relates to, because of the nature of the recommendation, interactions with other states and territories. I do think it's appropriate for it to be considered in cross-portfolio. I'd also observe, given the delay in the committee's proceedings,
I'll just check.
To the extent that we could manage things in cross-portfolio, that will allow Labor senators to focus our effort on the things that matter most to us.
Ms Jones, can we combine cross-portfolio and outcome 1, particularly given the lateness of the hour?
We can do that.
You can do that? Yeah, that'd be great.
And we have the officers here.
We did get notice of Respect at Work, so
yeah,
that's...
All right, so let's take, we'll take questions in relation to cross-portfolio and also, not outcome 1, sorry, Legal Services and Families Group.
Great. So shall I begin, or are we waiting for Mr Anderson?
Yep.
Okay, great. Look, last estimates, Mr Anderson explained that interim funding was only provided to working women's centres, and he said this on a very short-term basis. It's really just tiding over the particular centres pending further discussions with states and territories. Minister, then you told us that the interim funding was provided to them to continue their work, but that is part of the state and territory response back to the Commonwealth that is due by the 30th of June. Have you received responses back from the states and territories?
Yep, I'll get Ms Virtue to take you through that.
Great.
Joanna Virtue, Assistant Secretary, Human Rights Branch. Thank you, Senator. I believe we did receive responses back from the states and territories by that date.
Okay, and what did they say?
Sorry, can you repeat the original question? I'm sorry, but in terms of the responses?
Yes, so essentially, I am trying to understand how the Commonwealth is proceeding with the recommendation from Commissioner Jenkins that the working women's centres be funded, not just the existing ones, but that consideration be given to establish them in the other states and territories where they don't exist at the moment. There was an exchange about this last estimates between Senator Waters, Mr Anderson and Senator Cash, and I'm trying to understand, I'm trying to get an update on that.
Yeah, thank you. Ms Virtue now understands the question.
Yes, I do, sorry, because there were other
great.
matters on which we requested their response, but this is working women's centres.
Yes.
The matter was discussed at a meeting of Attorneys General on the 9th of June 2021, and the meeting of Attorneys General tasked officials to review the scope of services provided by working women's centres and like services, and to consider the feasibility of funding for services under the National Legal Assistance Partnership. And so those discussions have been taken forward by officials and they remain ongoing.
Do you have an estimate when you expect those discussions to conclude?
I don't, Senator. It's actually this particular recommendation is led by our Industrial Relations Group, so we may need to take further detail and notice for them.
Where are they this evening?
Senator, I can assist the officials in terms of Industrial Relations Group. They're appearing tomorrow in front of the Education and Employment Committee, so they're not here
this is
tonight.
the confusing part of this committee.
But what I can say in terms of the discussions with states and territories, one of the issues is Some of the states and territories have other organisations that deliver similar services to working women's centres and had expressed the view that they wanted to continue using their existing organisations rather than establishing new working women's centres. So it's discussing with them that they are of the view that they are offering like functions but in different organisations.
Can I ask about the existing centres who were allocated, I think you'd concede, a modest amount in the May budget? When do you believe that interim funding will run out?
I would just need to check on that in terms of I'd have to take that on notice for you, Senator, in terms of the specific dates about that. They have been funded through a grants program that's funded on our industrial relations side of the organisation under the Fair Work Ombudsman's Community Engagement Grants program. So we can get some details on that. Or actually, Ms Chidgey might be able to give some detail.
Senator, the funding was 0.2 million in the 2021-22 year.
Yes, I know. My question is when it will run out.
It's for this year.
Yes, but in terms of the operations of the centres that are receiving the funding...
so the money will go to them in this year. It's a 1 year funding amount.
Yes, I know, but it was intended to stop them from closing their doors. So the question is not the year in which it's provided. The question is the point at which the funding ceases to be adequate to allow these organisations to continue to operate and provide the services that Commissioner Jenkins said were so important.
So I think, as was mentioned, Senator, the conversations with the states and territories are designed to settle the ongoing situation for those centres and determine the extent to which there are in fact other arrangements that cover those services in other jurisdictions.
So for clarity, the Commonwealth isn't committed to maintaining the operation of the existing working women's centres which are located in Queensland, South Australia and the Northern Territory?
We've given that year's worth of funding and are in consultation with states and territories.
But you would contemplate circumstances where those services closed?
I'm not contemplating anything, Senator. I think I've answered.
I'm trying to understand the negotiating position of the Commonwealth in the negotiation. Is the Commonwealth happy to accept a situation where the existing working women's centres close?
No. And Senator, that is why we provided the $200,000 in the 2021-22 budget to the working women's centres. Obviously, it was the Northern Territory, Queensland in particular, but recognising that recommendation 49 of Kate Jenkins' report itself was directed at all Australian governments, federal, states and territories. I did take recommendation 49, as I said it would, to an extraordinary meeting of Attorneys General, as Ms Virtue said on the 9th of June 2021. I put a certain proposition and members themselves gave a proposition back, and they agreed to task officials to review the scope of services provided by working women's centres. Only Queensland, the Northern Territory and South Australia, as you know, actually have them. What other states and territories wanted to have a look at was to consider the feasibility of funding of services that they have, that they would consider doing the same service but via a different funding mechanism, and whether or not we can actually look at the funding of those services, including under the National Legal Assistance Partnership. So that's where the negotiation is at the moment.
In relation to the existing centres that you've just referred to, Minister, does the Commonwealth accept it has a responsibility to at least partially fund these centres?
Well, that has been the Commonwealth's position. We do partially fund those centres.
Right. So the discussions with the states are then a question about quantum.
Broadly, yeah, broadly how you fund.
Well, in relation to the existing centres in Queensland, South Australia and the Northern Territory, is the discussion then a question about quantum, how much is provided by the Commonwealth, Or is it a question about whether
Feasibility.
you fund it at all?
It's actually the feasibility of the funding of the services, and I might get Ms Virtue to take you through, because this is one of the problems with how they are actually funded, and I think we have discussed this, though it may actually be in the industrial relations side of the portfolio. So it might be something that we can also discuss tomorrow. It's actually how the services are funded, and they're actually funded via the Fair Work
Ombudsman grants.
and they actually have to apply for it. So it's actually also the broader discussion of, is that actually the appropriate way to fund the services, with those ones actually having to apply for a grant each time?
Minister, I know that the Northern Territory Working Women's Centre wrote to you about their funding in early August, and you wrote back to them on the 30th of August. And your response referenced these discussions, but it also referenced the funding announced in the budget under the National Legal Assistance Partnership. Do you believe that an organisation that does not offer legal assistance services as defined in that partnership would be eligible to receive funding under the partnership?
That is one of the issues that's actually being discussed, because depending on how the service is offered, it may or may not fall under the National Legal Assistance Partnership, and that is actually one of the conversations that is occurring in relation to what is that feasibility.
Yes, well, is it the Commonwealth's position? What I'm trying to understand is why you made that reference to the Northern Territory Working Women's Centre in the letter, because as I understand it, they are not eligible under the Legal Assistance Partnership for assistance.
No, that's what they are
your letter
funded.
to them suggests that that is the approach that they should pursue.
It's an alternative mechanism.
But not available to this centre.
Not at this point in time.
Senator
So
McAllister,
why reference it in?
I don't have the letter in front of me. I'm so sorry, Senator McAllister.
I have a copy and I'll table it.
Would
Perhaps
you
we can
mind
come back
just
to
so
it
I
in the
can?
next
Yeah,
round of
thank you.
Senator McAllister, could we perhaps come back to this issue? I'm just very conscious that we are very tight for time, and I am going to move to 8-minute blocks of questions, just because we have many senators who want to ask questions. I'll now go to Senator Waters, and then we can come back to you, Senator McAllister. Senator Waters.
Thank you, Chair. Thanks very much. I'll go very quickly.
Thank you.
I wrote Attorney AG's department asking what powers you had to interrogate Mr Porter's blind trust to satisfy yourselves that it didn't break foreign laws. Now, the response from the Secretary said that she could issue a notice regarding production of those details if there was information indicating that foreign donors were involved, but in the absence of information, no notice would be issued. So I just find it hard to understand when an investigation might be undertaken, and what, taking former Minister Porter's word for it, there are no foreign investors.
Senator Waters, just to put you on
investigated.
Senator Waters, just to put you on notice, we are having enormous difficulty hearing your line. We're losing many words. Secretary, did you understand the gist of the question?
I did.
Thank you,
Chair.
Okay.
And noting the correspondence between myself and Senator Waters on this issue, where she raised it directly with myself and the department. Essentially, at the moment, in terms of our responsibilities under the Foreign Influence Transparency Scheme, we did, following her correspondence, look at the issues that she's raised, and on the information that's available to us, there was nothing that we were made aware of that would indicate that a foreign principal was involved in any aspect of the trust. At this point in time, we can only go by the information that's been available to us on the record, and there's no further information that we have to offer on that at the moment.
So, Secretary, there is no information on the record, that's the point. When might the department seek to actually investigate to find out if there were foreign donors, or are you just accepting Mr Porter's word for it?
Senator Sarah Chidgey, I think there were sort of two issues, both that there was no information indicating that a foreign principal was involved, but also no information indicating that any of the relevant registrable activities had been occurring as is required by that Act either. And to take action such as issuing information gathering notices, the department needs to reach a certain threshold of having information that suggests there's a matter that's relevant to the operation of the scheme before it takes those steps, and has no such information in this instance.
Okay, are you ruling out any further investigation?
If any further information became available to us that then suggested thresholds were met, we would then look at matters, as we always would, but in the absence of any such information, there's no further steps we would take.
How would it discourage foreign donations if Blind Trust is allowed to disguise their identity, and that's enough to prevent further investigation?
So, Senator, I guess there sort of might be different circumstances. So foreign donation issues are potentially a separate matter. But for the purposes of the Foreign Influence Transparency Scheme, we need to consider a number of steps. That there's a foreign principal, and there's someone else acting in accordance with an arrangement with that foreign principal to undertake certain types of activities that are registrable for the purpose of political or government influence.
Yes, but if it's a blind trust, how would you know any of those things? That's the point. Unless you investigate.
Well, there may be circumstances where there's some information available, at least on the activities that are occurring, even if the foreign principals, even if the principals involved, the identity isn't disclosed.
Sounds pretty risky to me. Okay, when the government rejected my amendments to implement positive duties in the respective work bill, said that the government was not necessarily against a positive duty, but would need to give it further consideration and assessment. Ms. Fidji or the Secretary, what work is being done to consider the positive duty recommendation?
Senator, I'm going to ask Ms. Virtue to assist in answering that question. I'm just waiting for her to be in a position to be able to do it. I think she is now.
Ms. Virtue, could you hear that question clearly?
I wouldn't mind just hearing it again, if that's all right.
So,
Yes,
Senator
what
Waters,
work is being done? What work is being done on the duty recommendation, if any?
the recommendation in relation to positive duty.
Yes, thanks for the question, Senator. So the department has provided advice to the Attorney-General on a process and timing of further consideration of legislative recommendations from the Respect at Work report that weren't part of the Respect at Work Act that passed in September. And so the government is actively considering those recommendations. In relation to the recommendation for a positive duty, there are quite a number of things that would need to be considered, including the interaction with existing duties such as the work health and safety obligations and how that will, I guess, play out in practice for employers and without causing unnecessary duplication and complexity in the system.
Yes, I understand that, but is that work being done by the department?
Yes, it is, Senator.
Okay, and are you working to any time frame on that?
Yes, we expect that consultation could commence as early as December.
Okay. Thank you. And to finish, when might that consultation finish?
In March 2022, we anticipate consultation would finish and then we would provide advice to government at that time.
Okay, thank you.
Thank you, Senator Waters. Thank you for doing such a good job at sticking to time. I appreciate it.
Yeah, I've still got 1 minute, don't I?
Yes, you do. I thought you were finishing up. I was grabbing that 1 minute. Yes, over to you.
No, I'll go, Chair, thank you. So the Women's Budget Statement promised $129 million to increase legal assistance funding. How much of that is going to women's legal services? and how much is going to legal aid?
Senator, just look, the right person is coming to the table to provide that, because there's a significant positive information to be able to provide.
So Mr Anderson has just come to the table and Mr Knott.
Thank you, Senator. Adam Knott, Acting Assistant Secretary, Legal Assistance Branch. So the $129 million that was announced by government at budget will go through the National Legal Assistance Partnership, which is a national partnership agreement with all states and territories. The negotiations of the amendments to the National Partnership Agreement are complete. The final state, which was Queensland, signed off on those last week. The allocation and distribution of the funding, excuse me, is to Legal Aid Commissions, Aboriginal and Torres Strait Islander Legal Services and Community Legal Centres. So it'll be for the states and territories to actually allocate the funding to those individual service providers. I would note that under the, excuse me, under the National Partnership Agreement variations that will come into effect at the present, there's a requirement that some of that funding be provided to community legal centres that specialise in services for women.
Thank you very much,
how
Mr
much?
Knott.
That was my question. How much of that?
So the individual allocations will be a matter for the states and territories, and that's consistent with the principles that are in the National Partnership Agreement.
Senator Waters, we are going to need to leave it there. I'm sorry. If I could ask you to, we may be able to come back to it, but otherwise we'll have to put those questions on notice. Sorry, Senator Waters, we're cross.
Just a point of clarification, Chair. The witness said some go to CLCs. What is the proportion that has to go to CLCs, please?
Senator, it's a matter for the states and territories to allocate the funding in accordance with the legal need within their jurisdiction as they see fit.
Thanks, Mr Knott. Senator Waters, thank you. We'll now go to Senator Griff.
Thank you, Chair. My questions are to the Attorney and relate to recent correspondence from her and her department. Now, Attorney, given that the term UGG, which you'd be well aware of with recent correspondence, is a uniquely generic Australian term describing sheepskin boots since the 1960s, do you consider it fair and appropriate that a US company has trademarked our word UGG, not just in the US, but in 137 other countries, thereby preventing Australian UGG boot companies from using the term UGG throughout the world?
Thank you, Senator Griff, and I acknowledge that you and I have engaged in correspondence in relation to this matter. I will ask Ms Chidgey to take you through the legal position of the government.
Sorry, Senator, I'll just be a minute. I'll see.
Senator, while Ms Chidgey is just preparing the information, I think what she'll be able to talk to is the support, the financial support that has been provided to that company in the context of the matter in the United States.
Look, I appreciate that, but that's not actually my question. My question to the Attorney was that does she consider it to be fair that, or appropriate, that a US company has trademarked the word UGG?
That is a decision for the US company under United States law, and that's why I was going to get Ms Chidgey to actually take you through. They have prosecuted in Australia. Yes, and I'm going to get Ms Chidgey to take you through the position.
Senator, and part of the reason for not intervening in the proceedings was that it could have involved the Australian government advocating for a position that's not in fact consistent with Australia's own regulation of trademarks. So the Australian legal framework it wouldn't necessarily be consistent with the decision to take a different approach in US proceedings.
It's not about intervening, it's just actually being a friend of the court. That's what that's all required at this particular point. I mean, it's interesting that, Section 41 of the Trademark Act effectively includes the doctrine of foreign equivalence, and that rather than a successful US Supreme Court appeal rendering Australian and US trademark laws inconsistent, a successful appeal would actually harmonise Australian and US laws. So it's that the inconsistent argument really doesn't cut it. Can I just in the interest of time, to just go back to the Minister, given that the US and Australian legal teams fundamentally disagree with the advice that even in the correspondence you've been relying on from IP Australia, would you agree to convene a meeting between the legal teams and IP Australia to see if this matter can be resolved in order to allow a friend of the court brief to be filed, given the deadline for filing such a brief is effectively next week? Would you agree to convene a meeting?
Well, I can take advice from the department in relation to whether or not that is appropriate. But you would also be aware, given our exchange of correspondence, that I did sign off on providing Mr Uyghur's business with legal financial assistance of approximately 200,000 Australian dollars under the Commonwealth Guidelines for Financial Legal Assistance. It is also, as you know, Senator Griff, extremely rare for the Commonwealth Government to intervene in commercial matters in foreign courts, and I have set out for you in the letters to you the reasons for that.
Minister, given that you have actually provided funds, isn't it not unusual to provide funds but not be prepared to stand up for the hundreds of Australian businesses that could be in strife if they use the generic Australian name UG?
Well, again, Senator Griff, I have set out for you in the letters the reasons for that.
With respect, Minister, that's not really the answer to my question. And I would suspect that there may be, in fact, even Senator Carr may have a view on this as well.
And if I intervene on this point, I mean, Minister, I can't quite understand why you're prepared to provide financial assistance but not provide the letter, the brief in this matter, particularly given in the past IP Australia has intervened in Australia against the same company when it's undertaken action against Australian manufacturers, and when in fact you're prepared to intervene in the Palmer case in Western Australia. It just seems to be incongruous that you're prepared to act. You're prepared to act to intervene in Palmer's case, but you're not prepared to act to defend Australian manufacturers.
Well, again, Senator Carr, as Ms Chidgey said, I did consider the request and decided not to intervene in this matter. And Mrs.
So why did you pay the money?
Ms Robertson
Senator Carr,
can
could you
take you through this process further. But as Ms Chidgey said, intervening in this matter would have required the Australian government to advocate for a position that is inconsistent with Australia's own regulation of trademarks.
That's not the position in the past.
Ms Robertson to take you through further the legal position.
Sue Robertson, First Assistant Secretary, International Division. Senator, the fact that financial assistance was provided in this matter does not automatically mean that it's appropriate for the Australian government to intervene in the foreign court proceedings. And I might just clarify that friend of the court is the same as intervening. We are using those synonymously. So they are actually separate considerations. The ability for us to provide legal assistance, I can get my colleague to elaborate on, but that is in accordance with particular guidelines. And the Australian government, as you know, provides legal financial assistance in a range of different circumstances through a range of different schemes, and each scheme has a different purpose, but all schemes are generally targeted towards helping people that would otherwise not be able to pay for their legal costs. That is a separate question to whether it is in the national interest or not to intervene in a particular foreign proceedings in which there is no not necessarily an international legal principle at stake that is in the case.
It just strikes me that the government's quite inconsistent in this approach, and I think Senator Griff has made a suggestion here that does have some merit. If you can resolve this question in regard to what has occurred with the conflicting advice from IP Australia and the actions the Australian government's taken from the 1990s in regard to intervention against Deckers when it's taken coercive action against Australian manufacturers in Australia, it would seem to me to be appropriate that this matter be reconsidered, particularly given that the government has provided the extra money and the government has intervened in other court cases, and I mentioned the Palmer matter yet again. It's quite extraordinary.
Senator Carr, is that a comment or is that a question?
I've asked the question, if you're prepared to consider a broader conference on whether or not we can resolve this issue between IP Australia and the Attorney General's Department, it strikes me as a worthwhile way to go forward.
And I believe, Chair, I said I'd take advice from the Attorney General's Department in relation to that. But Senator Griff, you'd also be aware, with all due respect, that you have written to me and I do have a letter from you that I'm still considering.
Thank you very much, Senator Griff. Unfortunately, we have reached the end of the block of your time.
Chair, if there's just 30 seconds, could you advise Attorney when you'll be providing that advice?
Well, I know you gave me a 24-hour turnaround, but in terms of the issues that were raised in the letter, and I think they were raised on behalf of former Senator Xenophon, I will respond to you in due course.
Thank you very much, Attorney. Thank you very much, Senator Griff. I now give the call to Senator McAllister.
Thanks very much, Chair. Minister, I just want to come back to that letter that you wrote to the
thank you so much,
Centre.
now that I do have it in front of me.
Yes. I'm trying to understand what the Commonwealth's position is about the National Legal Assistance Partnership. Is it correct that the Commonwealth believes that the only organisations that may be funded under that partnership are organisations which offer legal assistance services?
Now, I can get Ms Chidgey to take you through that further, but I will then respond to the letter. Now I've seen it. There were two recommendations that were referred to in the letter.
Indeed.
Senator, yes, it is the case that for the National Legal Assistance Partnership, it requires services to be about the delivery of legal assistance. I understand that letter made a reference to it because the Northern Territory had specifically asked for an update on the NLAP.
Is it the case that the Northern Territory Working Women's Centre is eligible under the National Legal Assistance Partnership as currently structured?
It depends on what the services are being offered by the Working Women's Centre, but if they're not primarily legal assistance services, they wouldn't be eligible under the current parameters of the NLAP.
No, indeed. And so why, given the funding crisis that is facing the Northern Territory Working Women's Centre, Minister, why would you have suggested that they make representations to the Northern Territory Government in relation to funding under that partnership when they're not eligible for funding under that partnership?
Well, in relation to recommendation 49, that's dealt with in the first part of the letter, and it clearly states that I took recommendation 49 to the meetings of Attorney General on the 9th of June, and as I've previously articulated, MAG tasked Commonwealth and State and Territory officials to review the scope of services provided by working women's centres and like services, and to consider the feasibility of funding for services including under the National Legal Assistance Partnership. Consultation between the Commonwealth and the States and the Territories is ongoing. If you then turn to the next paragraph, it actually refers to recommendation 53.
Absolutely.
Which
so
is
my
a
question to you
different
is why this organisation is contemplating closing its doors because of a lack of funding. Why, in response to their concerns, are you recommending that they seek funding under a partnership that they're not eligible to participate in?
I'm saying that they should make representations to the relevant state and territory government in relation to that funding.
But
It's a
it's
separate
funding provided
funding
by your
of
government, Minister. Could you
$43.9
not just
million.
change that framework to allow that funding to be available to working women's centres?
Well, that's
Is
something
that
we've
not
got
in
to
your
do in
control?
consultation with the states and territories.
Okay, so I come back to my earlier questions. When do you think those consultations are going to conclude? Because this issue has been live for many, many months. Ms Chidgey tells me she doesn't know when it's going to conclude. She also tells me that she doesn't know when the $200,000 that was provided in the last budget is going to run out for these organisations. These are organisations that were described as critically important and I think uniquely effective by the Sex Discrimination Commissioner. Why are you dragging your heels on this? Can this not be concluded?
Well, we're not. And with all due respect, I immediately took recommendation 49 of the Respect at Work report, which was referred to federal, state and territory governments. I immediately took that to the meetings of Attorneys General. The meetings of Attorneys General themselves, the state and territories Attorneys General, they were the ones who determined that it should be looked at in relation to the feasibility of funding for services, including under the National Legal Assistance Partnership. Consultation is ongoing. I do have to work with my state and territory counterparts, but I was the one who managed to get the $200,000 in the additional funding to see them through this year. And as part of the ongoing budget process next year, we would relook at what further funding needs to be provided, bearing in mind they also do receive money from the relevant state or territory governments.
So do you have a goal or a date when you are hoping to receive a report from the officers group that is working on this issue?
Well, I'd need to refer to Ms Chidgey in relation to that.
And we'll take that on notice, Senator.
I see. Mr Knott gave evidence just before, I think indicating that the $129 million that was to go to women's legal services, in fact, was not provided at all to women's legal services, but was instead provided to states and territories. Is that correct?
Senator, the $129 million for women's legal services was always intended to run through the National Legal Assistance Partnership. So that is how it's been put into effect. So that would mean then that the states and territories have that funding along with the other funding streams that the government announced at budget, and they would be tasked with allocation of the funding to service providers within their jurisdiction.
I think your evidence earlier was that there's no constraint on which service providers they give it to?
That's right. The $129 million that you're referring to can be allocated to legal aid commissions, Aboriginal legal services or community legal centres. There's a requirement in the amended NLAP that some of that funding be directed to community legal centres that specialise in providing services to women.
So when the Minister said in the press release that she issued alongside Mr Morrison, Ms Payne, Senator Ruston and Senator Hume, and when the Minister said these measures include $129 million in additional legal assistance funding to women's legal centres to help women access justice, that just wasn't correct, was it?
Senator, it's probably not for me to comment on that question.
Well, Minister, the advice that your official has just provided is that this money does not have to go to community legal services that specialise in women's services. In fact, it can go to any number of services. But your press release said this funding will be directed to women's legal centres.
Women's legal centres, and I think the misunderstanding was it wasn't to women's legal centres, capital W, capital L, capital C. It was women's legal services to women, including those experiencing or at risk of family violence.
That's not actually what your press release says, though, is it, Minister?
Well, I disagree.
It's very different, isn't it? Like there's an announcement and a press release, and then there's the actual reality. Can anyone tell me whether any legal service, any women's legal service, has received a cent under this agreement so far?
Senator, the first Commonwealth payments to the states and territories have been made to all states and territories except for two because of the timing of when they signed off on the bilateral agreements.
Can you point me to a women's legal centre that has received $1 under this agreement?
So, Senator, we haven't received information from the states and territories yet about how they have allocated
Senator
the funding.
McAllister, I'm sorry, we will have
So
to
the distribution is
finish up.
allocated for the states and the territories.
So when you said that you made a big announcement that you were giving money to women's legal services, in fact, you weren't doing that at all. You were.
No, the funding will go
giving
directly
money
to
states and
frontline legal
territories.
assistance for women to respond to the increase, but ultimately it gets provided through a funding mechanism, and that funding mechanism is what we've been referring to, and the actual distribution is then decided by the states and territories, but in accordance with the guidelines that have been provided.
Senator McAllister, thank you. I'm sorry, we do need to move to Senator Rice. Senator Rice, you have the call.
Thanks very much, Chair. Thanks everyone for being here. Look, Tony, I wanted to ask you some questions about the proposed religious discrimination bill. And beginning with, when are you proposing to introduce the bill?
Well, the position of the department, the position of the government is we would like to see it introduced before the end of the year.
Minister, we've seen media reports, and I'm tabling the media report that I was reading from last week, that the Australian Christian lobby say that they're in the final days of negotiations with the Prime Minister's office over the bill, and the ACL are claiming that they are part of a coalition of faith leaders who jointly have been negotiating very closely with the Attorney-General and with the Prime Minister's office. Is this an accurate summation of what's been happening with regards to negotiation on the bill?
I've been negotiating far and wide in relation to the bill.
So who else have you been negotiating with over the last month, for example?
I've been negotiating with stakeholders across the board. I would take on notice whether or not they want their names provided, though, with all due respect.
Okay.
Yeah, with all due respect to them, some actually don't want their name provided.
If you could
for
take
them,
on notice,
but
and
I'm more than happy to do that.
of all of the stakeholders, as much as they are willing to be
absolutely. I'll need to go to them
named.
to get their permission.
So
but
can you name some others other than those that would be part of this coalition of faith leaders?
I would prefer not to, in the event that they don't want their names publicly disclosed as having discussions with me, but I'm more than happy to take it on notice for you.
Have you been negotiating with any of the human rights organisations or LGBTIQ plus
Yes.
organisations?
Yes,
You have.
they're a very important stakeholder.
Okay. Minister, one of the most controversial parts of previous drafts of the legislation is the so-called Folau clause that would prevent employers from barring employees from expressing their religious views, named, as we know, after Rugby Australia's decision to terminate Israel Folau's contract over his homophobic social media posts. The ACL are claiming that the final draft of the bill will contain a Folau clause, yet we know that Liberal MPs, including Mr Sharma, Mr Wilson and Senator Bragg, have said publicly that the so-called Folau clause would be unacceptable to them. Can you guarantee that it won't be included?
Well, that is ultimately going to be a decision for Cabinet, and I wouldn't preempt a decision of Cabinet.
So is it accurate, the ACL saying that the final draft of the bill will contain a Folau clause?
That will be a decision for Cabinet, and I can't preempt a decision of Cabinet.
Minister, the bill that you introduce will be a very significant piece of legislation with the potential to override the rights of disabled people, women and LGBTIQA plus Australians. The first two drafts of the bill that we saw would have effectively overridden Section 17.1 of the Tasmanian Anti-Discrimination Act, which is the most comprehensive anti-discrimination legislation in the country, by providing a defence of humiliating, intimidating, insulting, ridiculing and offensive conduct which takes place in the name of religion. Will the new draft override the Tasmanian law?
Well, again, Senator Rice, I don't agree with your characterisation of that particular clause. The clause you're referring to, I believe, is the statement of belief clause. And in the second exposure draft, I don't have the bill in front of me, but the bill provided that a statement of belief made by a person does not in and of itself constitute discrimination under any Australian discrimination law, and you are correct. it also stated that nor does it contravene subsection 17(1) of the Tasmanian Anti-Discrimination Act 1998. And again, though, the final version of this bill will be a decision of Cabinet.
But you agree that that clause, as was previously drafted, would override that section 17(1) of the Tasmanian Anti-Discrimination Act?
It would have meant that a statement of belief made by a person does not in and of itself constitute discrimination, as you referred to. And as the clause was drafted, you are correct, nor does the statement of belief made by a person in and of itself contravene subsection 17(1) of the Tasmanian Anti-Discrimination Act.
So it would override it. Attorney, the largest group of complaints under section 17(1) are on the basis of disability. Are you concerned that weakening section 17 will take away protections for people with disability and others, including women and people of colour?
Again, the ultimate decision in relation to the bill is one of Cabinet, but this was merely in relation to a statement of belief.
Yes, but it would override that.
It would mean that it does not
belief,
contravene subsection 17(1) of the Tasmanian Anti-Discrimination Act.
But it would impact on people with disabilities, not just people of
it is only in relation
genders
to
and
a
sexualities.
statement of belief that is made by a person.
I'll leave it there rather than debating to and fro. Given the far-reaching impacts of this proposed legislation, will you commit to having a full and thorough Senate inquiry into the bill once it's introduced?
Oh, well, that's a decision for the Senate.
Yes, but is the government committed and
Well,
supportive?
That is a decision for the Senate.
It will be a decision for the Senate, but will the government be supporting having a Senate inquiry into
Well,
this
again,
legislation?
that is a decision for the Senate.
Will the government support that?
If the Senate determines...
helping to provide the numbers in the Senate.
If the Senate determines that there should be an inquiry, then there will be an inquiry.
But does the government, do you think that there should be an inquiry?
Again, that is a decision for the Senate.
Do you think that there should be an inquiry?
Senator Rice, Senator Rice, sorry, if I can just pause here a minute. Senator Rice, you have asked the question 4 or 5 times. The attorney has answered the question. Could you ask your next question? We've got about 1 minute to go.
Okay, 1 minute to go. I actually wanted to follow up on the questions that Senator Thorpe asked you about the appointment process for Commissioner Finlay to the AHRC. I listened to your answers to Senator Thorpe's question. Was Lorraine Finlay the only person that was approached for that position?
Yes, I understand she was.
Right. And who was involved in the process of appointing her? Was it
the Cabinet?
The Cabinet. So
that is correct.
All of the Cabinet?
It is a Cabinet decision.
So it was the Prime Minister, yourself, and all the members of Cabinet?
It is a Cabinet decision.
Was the role wasn't advertised publicly at any stage?
No, it was not.
Minister, over 80 human rights experts wrote to you in September about the appointment, criticising the appointment on the grounds that an advertised competitive process is essential to find the most qualified candidate, an open process is vital to ensure public confidence in the integrity of government, and that an open process signals to all Australians that they have an equal opportunity to apply for the highest office in the land in their field. How did you respond to their critique?
Well, again, we appointed Ms Findlay in accordance to the policies and guidelines set out in the government's merit and transparency policy.
And so that's what you told them? You didn't...
Well, that is how we appointed Ms Findlay.
Were you aware of concerns raised by LGBTIQA+ groups about Commissioner Finlay's appointment?
I was not, no.
For example, Just Equal said after appointment they were concerned about her previous attacks on existing LGBTIQA+ discrimination protections in the name of religious freedom.
No, I was not.
So you're still not aware of them?
You're raising them with me now.
So this is the first time you've heard of those concerns?
I know that there was a number of comments made in relation to Ms Findlay after her appointment, but I was satisfied and the Cabinet was satisfied that Ms Findlay was eminently qualified
So you weren't aware of potential controversy about her before the appointment on the grounds of her position on religious freedom?
I was aware that she had excellent qualifications, knowledge and experience for this role, but in particular as a senior specialist in the area of human trafficking with the Australian mission to ASEAN within the Department of Foreign Affairs and Trade.
Senator Rice, thank you so much. We now will move to Senator Watt.
Thanks, Chair. Just a few questions about legal assistance to ministers.
We'll just get the people for you.
Thanks. And just while they're arriving, this is legal assistance to ministers under the Parliamentary Business Resources Regulations 2017. You probably know the answer to these questions yourself, Minister, I suspect. I'd like to ask you about a document tabled on the 23rd of August 2021, which shows that the Attorney-General approved taxpayer-funded legal assistance for Liberal MP and Minister Michael Sukkar in relation to a defamation claim made against him on 9 August 2021. Who did Mr Sukkar allegedly defame?
Michael Johnson, Assistant Secretary, Office of Legal Services Coordination, Senator. Thank you for the question. I don't have that information. I'll have to take it on notice, but I would foreshadow that we would not ordinarily reveal information about the other party to a private legal proceeding.
Well, I mean, it's a matter of public record that someone is not suing Mr Sukkar.
So just to be clear, sorry, Senator Watt, Mr Johnson has indicated he will be taking the question on notice.
There's no one here who knows. This is a minister who is having his legal fees paid for by taxpayers.
Senator Watt, once Mr Johnson has indicated he's taking the question on notice, could I ask you to move to the next question?
Well, no, because there might, Chair, I've waited a very long time to have a chance to ask some questions.
You are absolutely at liberty to ask whatever questions, but once a
Mr
witness
Johnson is unable to answer the question, I'm entitled to ask if there's anyone else. There's a lot of other people here. I'm entitled to ask if there's anyone else who knows. Mr Anderson, do you know? Does anyone else know?
I don't know, Senator. Mr Johnson is the branch head of the relevant branch. If he doesn't know, then there won't be anyone else here who knows that specific detail.
Okay.
You are entitled to ask another question. Just to clarify, once a witness has indicated that he or she is taking the question on notice, then
that's not correct, but let's not have a procedural argument at 10 past 10.
Well, you do need to move on.
So what were the comments and how exactly... This is an important question. Ministers are only entitled to have their legal fees covered by taxpayers if it's about litigation that relates to their ministerial duties. So I'd like to know what the comments were that Mr Sukkar made, for which he is being sued for defamation, and how they relate to his ministerial duties.
In terms of the comments made, Senator, I'll take that on notice. I can say that the decision was made by the Attorney-General consistently with the rules in the regulations.
So that was based on advice from the department recommending
That's correct, yes.
Minister, you've signed off this. It was only a couple of months ago. Are you familiar with who Mr Sukkar defamed and what the comments were?
I would need to take that on notice as well.
You don't remember?
I don't recall at this point in time, no.
So you've approved taxpayer funding for one of your ministerial colleagues, but you don't have any recollection of this?
Well, Mr Johnson did give evidence that it may not be appropriate to provide that form of information, so I will take on notice what we can provide to you.
Can you please provide the departmental brief that was provided to you?
I would need to take that on notice because it may well be subject to legal... I will take that on notice for you, Senator Watt.
Why did you consider it appropriate for taxpayers to foot Mr Sukkar's legal bills?
Well, again, Mr Johnson has set out there is a process that must be gone through. And the process clearly states that legal assistance to ministers can be provided when it relates to proceedings involving their ministerial duties. This, as you would know, has been consistent across government, regardless of the political party
not necessarily for
that is in
defamation
office. The rules continue to apply. The Parliamentary Business Resources Regulations set out the requirements for legal assistance. And then subject to the advice from the department, a decision can then be made by the relevant Attorney-General at the time.
Minister Dutton recently suggested that taxpayers should fund the defamation cases of politicians, as in provide funding for politicians to sue other people for defamation. Is that proposal under consideration by you or your department?
I'm not aware of those comments by Mr Dutton. If a minister is being sued by someone, they can apply for legal assistance. That is part of the rules.
But there's no consideration being given to funding politicians
I'm
to
aware
go
of,
and sue
no.
people?
Not that I'm aware of.
Okay.
It's whether if you are being sued by someone, you can actually then apply for legal assistance.
Well, it's Minister Dutton who's suggesting this be done
I
rather
would need
than...
to see those comments.
Okay, probably just another thought bubble from Minister Dutton, I suppose. On another matter, I forgot to ask for... Senator McAllister just asked, there's something that I won't spend a lot of time on, but perhaps before we end tonight, someone might be able to table some information. There was a budget measure in this year's budget, family law system improving access and safety for children and families. $60.8 million was allocated to reform family law case management processes under that measure. What I'd like to know, and again I don't need the answers verbally, but if someone could table some information, what specific activities will be funded as part of this, how much each will cost, and can you please provide a breakdown of each amount by activity, including profiling over the forwards. I'm hoping that someone might have a brief that sets out
Are you
a bit
happy
of an
to have that on
explanation.
notice, or...?
Well, I'd rather, if it's possible to get something this evening, that would be good. I just don't want to chew up time, and nor does Senator McAllister in
Senator, if I could just
going back and forth.
mention, Senator Carr wrote to me to indicate that there were some issues that the committee would be interested in receiving information on. I responded to Senator Carr by letter just today, and that includes information that relates to that expenditure.
Okay, so that detail has been provided?
Yep.
Okay, terrific. The last thing I was going to... how much has Minister Silkar's litigation cost taxpayers so far? Sorry, Mr Johnson.
Mr Johnson.
That was a late arriving question.
I suspect the answer is we'll have to take it on notice, but I'll defer to Mr Johnston.
Thank you, Senator. I do have the answer to that. To date, it's zero.
Righto. Are you the person to ask also for an updated cost figure for the Rosato case that went to the High Court?
No, Senator.
Okay.
That is in terms of the legal costs for the Commonwealth's involvement.
Yes. Who would I be asking for that?
That will be a matter for colleagues when we're appearing for the Employment and Education Committee tomorrow.
Well, I have previously obtained this information through this department, through the Attorney General's department.
Sorry, it is this department, but
the IR section.
has responsibility.
Yeah.
So
even if it's the cost of litigation.
Yes, I'll ensure that information's available.
Okay. You might recall, or it might have been before your time, Ms Jones. There was a question on notice that was answered in around March, April, number 3241. Essentially, what I'd like to get tomorrow then is an update. That didn't take into account the High Court appeal and the costs incurred there. So if I could get an update on that, and also what that question didn't cover was the cost of legal services provided to the Commonwealth by external solicitors, who I understand were engaged in that matter.
Senator Watt, thank you. That might be an appropriate time to move now to Senator Cox.
Thank you. My question is relating to yesterday I was speaking to Commissioner Kershaw about the anti-racism and cultural diversity principles developed by the Australian-New Zealand Policing Advisory Agency. Commissioner Kershaw explained that AFP is listening to the feedback from First Nations officers and he's personally committed to implementing the principles underpinned in the agreement with Kate Jenkins. Has any funding, additional resources been provided to the AFP or other jurisdictions for the implementation of these principles?
I think that would be a matter to be directed to the Department of Home Affairs. They would be, they're the relevant portfolio department that supports the AFP.
So can I ask there's the grants to the Australian Organisations Program, which is funded through the National Justice and Policing Senior Officers Group, which is an open grant process, which has the objectives of increasing the knowledge of Australian judicial and law enforcement officers, which is in direct line to ANSPA's principles. So this falls under your department?
No,
Yes?
I think that's the Department of Home Affairs. Prior to national security and criminal justice matters being moved across to the Department of Home Affairs, the Attorney General's Department did have some responsibilities there, but I believe that's all now moved to the Department of Home Affairs.
Are there any measurements being placed around the recommendations of the Royal Commission on Aboriginal Deaths in Custody in relation to recommendation 228?
I'd need to take that on notice for you, Senator.
Happy for that. Thank you very much.
Thank you very much, Senator Cox. We'll now go back to Senator what?
Yeah, I've got one other topic.
All right.
That I was
And then we
hoping-
are going to go, we will move to Senator Van briefly and then to Senator Thorpe.
Okay. I have a very small number of questions about the Integrity Commission proposal. I'd like some indulgence, given the hour, to cover that now, if that's okay. I suspect the people who are required are here.
Secretary, is that possible to deal with that question now?
The Commonwealth Integrity Commission?
That's
yes.
right.
Yes, it is, Chair.
Okay, thank you.
Thanks. And really, it's probably mostly again to the Minister. Minister, has the government finalised its legislation to establish the Integrity Commission that it committed to establish more than 1,000 days ago?
The Commonwealth is in the process of finalising the legislation.
Okay, so you haven't yet finalised the legislation?
In the process of finalising the legislation.
More than 1,000 days ago, this was announced by the Prime Minister. Has the government radically revised its proposal to take into account the results of consultation, or will it still be what has been described as the weakest watchdog in the country?
Well, I think you and I did discuss this earlier today, but the government undertook a comprehensive public consultation process on the exposure draft legislation, as I said to you earlier today. 333 formal submissions were received. I have been considering the feedback through the consultation to further inform refinement of the exposure draft legislation before it is introduced to the Parliament.
So changes are being made to the model to take into account points made in the consultation process?
I'm taking into account the feedback that has been received, but ultimately it will be a decision for Cabinet.
When are we going to see the revised bill, Minister?
Well, that will be a decision for Cabinet.
It's been regularly promised by ministers, probably including yourself, that this Integrity Commission will be established in this term of government. Is that still going to happen?
This term of government still has some time to run, Senator Watt.
So it will be established in this term of government?
The government has always said that was what its intention was.
Are we going to see legislation this year?
That will be a decision for the Cabinet.
Isn't it true, Minister, that under your proposed model, none of the rorts and scandals involving ministers in your government, such as sports rorts, car park rorts, secret donations to Christian Porter, the list goes on and on and on and on, none of them will be able to be dealt with by the Integrity Commission that you're proposing?
Well, again, I'm currently considering the feedback in relation to the consultation process, and ultimately the Cabinet will make a decision as to what the model is.
Fair enough question.
Because
So, Senator Watt, just in relation to the reference to Mr Porter, it is disorderly to impute...
Oh, come on, you're saying it's not a secret donation to Christian Porter?
Senator Watt, I would ask you not to breach the standing orders in that respect, please.
If you want to defend your own colleagues taking secret 1 million donations, be my guest.
Senator Watt, excuse me. Please do not reflect on. Please do not reflect on the chair.
I wasn't reflecting on
you.
I was reflecting on your colleague.
Okay, good. Thank you. That's a bit better. I'm just making a ruling that it is highly disorderly to reflect any sort of improper motive on another member or senator. You have the call.
But Minister, the fact is that the model that you have proposed cannot investigate past rorts and scandals involving members of this government. It can only investigate matters that the government chooses to refer to it. That is very clear then that it will not have any power to investigate any of the rorts and scandals involving members of your government. That's correct, isn't it?
And again, Senator Watt, we have undertaken an extensive consultation process in relation to the exposure draft that was released. I have been considering the feedback, and ultimately the final model that is released will be a decision for Cabinet. But I'm happy for Ms Bogart to take you through.
With the greatest respect to
proposal
Ms
that you've put forward.
Bogart, I don't require her to elaborate on that. I mean, it is because your government does not want its own rorts and scandals investigated that we are still waiting to see legislation introduced to back in a commitment the Prime Minister made over 3 years ago.
Well, I refute what you've just said.
Do you have any appreciation for how outraged Australians are about the scandals that they have seen under your government and your failure to implement an integrity commissioner that this Prime Minister announced 3 years ago? Do you have any concept of that?
Senator Watt, you are now merely making political points at 25 past 10 at night. Again, Senator Van,
I think News Corp
this is
did
just
the other
showing how out of touch you are, because there are so many polls that show that Australians want this done. I mean, it may not be happening in
Senator Watt,
crazy
if I could
Liberal
just
Party
direct
branches
you to
in
ask a
Victoria.
question of the witnesses, please.
Can you bring Senator Van to order, please?
Senator Van, yes, I just did.
Will the proposal that you're going to bring require the support of the National Party room?
Well, it will actually require the support, I would have thought, of the Parliament.
But before you introduce it, is Mr Morrison going to seek the support of Mr Joyce and the National Party room,
Cost a fortune.
who are well
We will
known
go
for
through
their
our
support for
normal
integrity?
Coalition party processes, Senator Watt, but ultimately it's whether or not the Labor Party want to support the proposal that's been
I
brought
think the
forward.
Labor Party's position
It
on an
would be
integrity commissioner has
good if we
been
could get
pretty
consensus
clear
in
for a long
relation
time.
to the model we bring forward and pass it through the Parliament.
So if
But
Mr
ultimately,
Joyce-
that's a decision for the Labor Party.
If Mr Joyce and the National Party don't want to see an integrity commission that investigates their own rorts, this won't happen?
Senator Watt, no. Sorry,
hypotheticals.
Ministers, if I can just ask you to pause there. You've just reflected on Mr Joyce.
Yep.
That is highly disorderly. I have asked you not to do that. It is a breach of the standing orders, Standing Order 193. And
Mr Joyce proudly goes out and owns
Senator
rorting
Watt,
and pork barrelling.
Senator Watt,
He's proud of it.
disorderly. It is disorderly, highly disorderly, to be in breach of the standing orders. You have about 2 minutes.
I'm happy to cede my time to Senator Grogan so she can get started on her questions, Chair.
Well, thanks very much.
Is there a particular topic just so we can bring people forward
So
in the interest
there's
of time?
a couple of minutes of your allocated time.
Okay, well, the remaining two questions can probably be covered concerning the costs of Mr Palmer's legal challenge, that, again, taxpayers wore.
Are these questions from yourself, Senator Watt?
Actually,
or-
let's just, I'll hold off and just get exactly the questions that we want to cover asked.
Well, we can come back to you. Look, I want to hand over to Senator Van, but just Minister, just in relation to the cost of legal assistance, we heard the answer in relation to Minister Super that there's been an appropriate approval, but no money has been spent on legal assistance. In the case of former Labor Minister Joe Ludwig, who was provided with legal assistance, are you able to tell the committee what he received by way of legal assistance?
I would need to get the departmental official to come back to provide you with. It was a considerable amount. I do recall it being asked at previous estimates, but I will get Mr Johnson to read out the actual amount.
Just to clarify, Senator, are you asking the question in relation to the Brett Cattle?
That's right, the Brett
proceedings?
Cattle. Yes, that's right.
So there were three separate approvals for Mr Ludwig in relation to the Brett Cattle matter. The total amount that's been spent over the three approvals is $2,684,291.83.
Sorry, Mr Johnson, could you repeat that?
$2,684,291.83.
Wow.
Thank you very much, Mr Johnson. I will now give the call to Senator Van.
Thank you very much, Chair. I have some questions about women's safety measures, Legal Services Policy Division.
Yep, we'll just bring the people to the table.
Thank you kindly, Minister. My first question is around legal assistance funding to help vulnerable women. I understand that in the 2021-22 budget, there was announced additional funding for legal assistance funding to help vulnerable women access justice. Is that correct?
Thank you, Senator. Rebecca Mills, Acting Assistant Secretary, Family Safety Branch. That question might actually be one for Mr Knott, but I can confirm that that was part of the women's safety measures.
I'll let you have it to people at the table, whoever you would like to have at the table.
We will get Mr Knott to come back to the table. Okay.
Thank you, Senator. Sorry, could you just repeat the question?
Yes, of course. I understand that in the 21-22 budget, we announced additional funding for legal assistance funding to help vulnerable women access justice. Is that correct?
Yes, that's right. That's the 129 million that we were talking about earlier.
And has that funding been provided to the states?
Yes, to all states and territories except for 2 who will receive their first payment of that money on the 7th of next month.
Thank you. And what is the process for providing that funding?
So it goes through the National Legal Assistance Partnership. So that's as I mentioned earlier, that's a partnership agreement between all states and territories. The funding has a range of parameters attached to it. There were a number of measures actually announced at budget that have all been amended and are all flowing through the National Partnership Agreement at the same time, along with that measure.
Thank you very much. And this may stay with you or may not. Family advocacy and support services?
Depends on the nature of the question, Senator.
Again, in the budget, the most recent budget, we announced additional funding for family advocacy and support services, or FAS, as it's known.
Yes, Senator. That money also flows through the National Legal Assistance Partnership, and I think that's the 83.132 million that you're referring to.
And can you walk the committee through what that FAS does?
Yes, Senator. That might actually be a better question for one of my colleagues in the Family Safety Branch.
I could
talk about the
assist with
detail.
that, perhaps.
So, we'll save some time.
Part of that is establishing one new registry location, so that it's provided in registries of the Federal Circuit and Family Court and 25 circuit locations. It also provides funding for increased mental health and social supports. That funding for that component doesn't commence until 1 July 2022. But so it's basically an expansion both of the number of sites where FAS is provided as well as the range of wraparound services that get provided.
And are the budget announcements around children's contact services the same program and same processes?
It's a different person again.
Yep. That money is not through the National Legal Assistance Partnership, but was part of the budget announcements relating to sort of the broad legal assistance and service sort of packages.
Okay, thank you. Thank you, Chair.
Thank you very much, Senator Van. I will now give the call to Senator Thorpe.
Thank you, Chair. I'll just start straight off. I've got 8 minutes, 4 questions, so I'll cut to the chase.
Thank you, lovely.
The meeting of Attorneys General on 31 March 2021 resolved that raising the minimum age of criminal responsibility would be considered out of session. What actions have been taken since the 31st of March, please?
We'll just bring the relevant official
We
to the
could
table.
see 600 children released as soon as you make the decision, hey?
Senator Thorpe, just in relation to that, obviously, it's actually a matter for each jurisdiction individually as to whether or not to raise the minimum age. This is primarily a matter for states and territories, so it's not about one state or territory, or should I say, it's not about all the states and territories ultimately agreeing. They can actually do it individually should they wish to. Can I just also confirm for you that as at the 18th of October 2021, there are actually no young people under the age of 14 in detention, sentenced or awaiting sentence for Commonwealth offences based on the information that we do have from the CDPP. But in terms of the ultimate decision, it is actually a decision for each individual jurisdiction as to whether or not they wish, within their own jurisdiction themselves, to raise the age, the minimum age.
Thank you, Minister, and I appreciate that response. However, the expert United Nations Child Rights Committee has previously stated that 14 is the minimum age at which children should be held legally responsible. Why, as a Commonwealth, with the oversight of what goes on in this country, lead the way and show some leadership and raise the age at the Commonwealth level so that the states and territories can follow suit?
Well, again, I think as I've stated to you, it is a decision for each jurisdiction whether to raise the minimum age. And as I've also stated to you, this is primarily an issue for states and territories, as the overwhelming majority of offences involving children are state and territory, not Commonwealth offences. And as I've also indicated to you, as at the 18th of October 2021, there are no young people under the age of 14 in detention,
I heard that, Minister.
sentenced or awaiting
With all due respect,
sentence
I'm running out of
for
time.
Commonwealth offences. But you might also be
I did
aware that
hear
the
that.
Australian Capital Territory, so this is a jurisdiction themselves that has made their own decision, and they themselves have committed to raising the minimum age of criminal responsibility to 14 years of age.
Thank you, Minister. But the second part to that question, with all due respect, was why can't the Commonwealth take some leadership and just do it? Like, without passing the buck to the states and territories, why can't this federal government take leadership and stop imprisoning our babies under the age of 14? When will you, as the Attorney-General, stand up and say we will stop imprisoning babies at 10?
Well, again, Senator Thorpe, maybe because you're not here, you actually couldn't hear what I said. So I'll just, to ensure that you've got the evidence,
without
because
passing
based
the
on
buck.
what you've said, I don't think you heard what I said. There are no young people under the age of 14 in detention,
I heard
sentenced
that.
or awaiting
I heard that.
sentences for Commonwealth
not my
offences
question.
based on the
It's not my
information
question,
that we have
Minister.
from the Commonwealth.
Senator Thorpe, just please.
It's not my
Department of Public
question, though, with all due
Prosecutions.
respect. I'm not an idiot.
No, Senator
I'm
Thorpe,
not an
please,
idiot.
please come on.
So,
No, we're not going to talk.
Well-
we're not going to. Please don't.
well, I'm not
Please,
gonna
let's
be,
talk with respect. We're talking about respect.
patronised.
Can I, Senator Thorpe? Can I just make one helpful
It's gotta go both
suggestion?
ways to be-
Can I make one helpful suggestion? Because you were referring to the Commonwealth jailing babies or children.
I heard
So
that.
I think the attorney was rightly concerned that you may not have heard what she said in relation to the fact that there are no children under
So there's
14
no children.
in jail.
That's right.
So you're asking, yes, I know, I appreciate the question you're asking.
I
The- the-
understand that. I've been told 3 times in my 8 minutes.
I do apologise.
So
I thought based on what you'd said, you hadn't understood what I'd said in relation to no
I
children under
understand.
the age of 14
Yes.
actually
Yep.
being in jail at a
Yep,
Commonwealth
I get
level.
Thanks,
that.
Minister.
But my question was, Minister, when are you going to take leadership? When is this government, your government, going to stand up and say to the rest of the world, like those that have asked you, like Sweden, Norway, Chile and Canada, who have said, Australia, stop locking up babies. When are you going to stand up and say, we will no longer lock up any Australian child in this country from the age of 10?
Again, Senator Thorpe, with all due respect, I think, again, perhaps you haven't heard me. That the decisions are primarily those for the individual jurisdictions. And this is, I mean, you may not know the history to this, but I think it was in around July of last year, the then Council of Attorney Generals, it's now changed to the Meeting of Attorneys General, but the then Council of Attorney Generals, they were actually looking at it and they noted that further work needed to occur to consider adequate processes and services are in place to support children who exhibit offending behaviour. That work hadn't actually been done. That is a really important body of work that all jurisdictions need to understand. What are the adequate processes and services that you put in place to support children under the age of, say, 14 or 12, depending on the age that a particular jurisdiction decides, if they do, to raise it to, who continue to exhibit this offending behaviour. And that is the body of work that the Attorneys General was still looking at.
Thank you, Minister. I suggest you talk to the advocates who have been working in this space for a decade, and you might get some answers rather than continuing to make excuses. My next question is in relation to the Pathways to Justice report, and this is the Australian Law Reform Commission's report, Pathways to Justice, an inquiry into the rates of incarceration of Aboriginal and Torres Strait Islander peoples was tabled in Parliament by the former Attorney General in 2018 without a government response. Can you please provide a response today?
I will get either Mr Anderson or Ms Harvey to address that question. Thank you, Senator Thorpe.
There are 35 recommendations out of that report.
And apologies, Senator, but this is going to be your last question because we are over time.
Tamsin Harvey, First Assistant Secretary, Families and Legal System Division. Senator Thorpe, the Pathways to Justice report is the responsibility of the National Indigenous Australians Agency, so they would be better placed to be able to respond to questions about it. What I can say is that through the Justice Policy Partnership under Closing the Gap, that's certainly something that we would anticipate members of that partnership may wish to raise in terms of looking at particular recommendations under there.
Thank you very much,
Okay,
Ms.
so
Harvey.
NIAA.
NIAA.
Thanks very
And
much,
all
Senator
those
Thorpe.
men. Great, thank you so
I appreciate
much.
your appreciate you staying to time. I know it's not it's challenging, so thank you so much. I'll now give the call to Senator Waters.
Thanks, Chair. Just some questions about the proposed Commonwealth Integrity Commission that we've been looking for us before. I'm sure you saw a week or so the Centre for Integrity analysis of the various models of different jurisdictions and the government's proposed model. And the assessment of the government's proposed model was that it's the weakest in history. The department provided any advice to the minister in relation to that analysis?
Ms Bogart? Thank you.
Esther Bogart, Assistant Secretary, Fraud Prevention and Anti-Corruption Branch. Thank you, Senator, for the question. So it was a bit broken, but I think you were asking about the Centre for Public Integrity's assessment of the different powers of different watchdogs that have been put forward. So what I can tell you is the Commonwealth Integrity Commission exposure draft bill that has been put forward and has been part of significant national consultation over the last few months. The purpose of that commission would be to investigate serious criminal corruption in the federal public sector, and it will also play a preventative and educative role. It will have very strong powers, and it already does in the exposure draft legislation. Powers, as has been said previously by the government, greater than a Royal Commission. It includes coercive powers to compel the provision of information.
Sorry to interrupt, but the clock's ticking, and I know what the model does. My question was whether you provided advice to the Minister about the Centre for Public Integrity's analysis, saying the model is the weakest in the country. Have you advised the Minister of the findings of that report?
We have not provided specific advice to the Minister about that particular report, but we have provided some analysis of the different models that have been proposed, including the models already in existence in states and territories, and the relative strengths and limitations of different models.
Has a review of the most recent draft been undertaken in response to the Centre for Public Integrity's comparison?
Senator, not specifically, but we, as the Attorney-General said earlier, we've obviously been undertaking a very extensive consultation process and considering all of the comments and views received as part of that process and more broadly.
Yes, well, it's so expensive. It's been going on for 3 years now, and in previous versions, you've just ignored the feedback. Are you actually considering the feedback this time? Are there any changes actually being proposed to pick up on the fact that many experts described it as worse than useless?
AGS.
Are AGS?
Well, they're available, yes.
They're available.
I wrote to the committee to say that...
I'm still waiting on an answer. Are you able to address my question?
Sorry, Senator Waters, it's having a few challenges here. Could you just perhaps...
Ms Giugiano?
Yes, could you perhaps just repeat your question? Apologies.
I can just say that in response to the question about whether that feedback is being considered, yes, it is being considered in detail, and we have provided extensive advice to inform the Attorney-General's consideration.
Okay. I note that there's quite a few members of the Liberal Party who have publicly spoken about improvements that they think should be made. Mr Dave Sharma has said that he'd like to see a broader scope and the same rules for politicians and police officers. Ms Celia Hammond has said that she'd like to see public hearings in certain circumstances. Ms Allen has said she thinks the Commission should be able to initiate its own investigations. And the Assistant Minister in a few interviews has given a little bit of ground on retrospectivity. Those views communicated to the Department, they've been factored into any redraft.
Senator, we're aware of publicly reported comments and we've provided, as I said, advice on the range of views that have been received through consultation.
Have you undertaken any redrafting as a result of any of those Liberal Party backbench comments?
I think the Attorney-General had indicated earlier that ultimately decisions on the final form of the legislation will be a matter for Cabinet.
Right. Will there be further internal consultations before a bill is introduced to the Parliament, internal to the Coalition?
Well, Senator Waters, that will be a decision for the Coalition, but I've said to you that the ultimate decision is that of Cabinet.
And we've just been waiting so long for this, and you keep consulting and you keep ignoring the feedback, and like everyone just thinks you don't want to do this.
It's an opinion.
It is
Are you going to bring this bill before the Parliament?
Well, again, Senator Waters, I think I've answered that question several times today.
Well, I've been asking it for 3 years and it hasn't happened yet, so get on with it. Thanks, Chair.
Surely that's enough.
Thank you very much, Senator Waters. Now, I'm now going to give a call to Senator Patrick for about 5 minutes. Senator Patrick has questions in relation to the AGS.
Are they
Is that-
appearing online?
Is that possible to facilitate?
He's available and you will turn his camera on right at this moment.
Wonderful. Senator Patrick, you have the call.
Yeah, thank you. This is a relatively simple matter, I think.
Poor Mr Kingston's
He's waited 12 minutes to 11.
At least you made his wait worth his while.
And no opening statement, please. Yeah.
No pressure.
Well, it relates to
That is a bottle of mineral water in the background, though, isn't it, Mr Kingston? Yes, checking.
So my 5 minutes
sorry,
starts now.
it's late. We're all
Yeah. Okay.
losing our marbles a bit.
So this is just a question to the AGS because I haven't been able to get an answer out of the Prime Minister's office in relation to litigation, the matter of Patrick as Secretary, Department of Prime Minister and Cabinet 2020. So it's not the Cabinet decision. The Prime Minister, each time I ask what the cost in that matter is, which concluded last year, I get an answer that says that, let me just tell you the answer. The Australian Government Solicitor represented the Department of Prime Minister and Cabinet at the proceedings. No costs, not all costs related to this AAT matter have been assessed, approved and paid. So I just want to understand from your perspective, how much have you invoiced in relation to that particular matter?
Mr Kingston, sorry, you're on mute, I think. No.
Still on mute. And still on mute.
Is it anything at our end that we can fix through broadcasting? You've got your button on, microphone on, Mr Kingston.
Maybe you can write the answer.
Well, maybe I'll just put these verbally on notice. The reason I'm doing this is because I've tried through questions on notice to get an answer. It strikes me, I'm of concern that...
Oh, we've got you, Mr Kingston.
We just heard you.
Yes, we've just heard your paper crinkle and we have you.
Sorry, I apologise, Chair. Michael Kingston, Australian Government Solicitor. There may have just been a delay when I came off mute. Senator, I'm sorry, I know you gave the number at the beginning, but which you said it wasn't the National Cabinet matter. Which FOI matter was it?
It's a matter in relation to the Hawkeye, the Attorney General's audit that the Auditor General's audit that the attorney censored under using a section 37. And the Tallis, that's correct.
Yes.
So next year, if I win a case, I'm on a hat trick against the Prime Minister. But I've just been trying to get an understanding of the cost. I know that the cost in National Cabinet was about $170,000 to date. That's what's been invoiced. I'd like a total cost, but because the Prime Minister's been saying you're not providing invoices, that raises a concern about processes on your side. Would it be normal that you wouldn't get an invoice?
I'm not
for a
sure that
year?
the Prime Minister actually stated those words, Mr Patrick, just based on what you've just told us in evidence.
No, he said not all costs related to this AAT matter have been assessed, approved and paid.
Okay, thank you for accurately
that's in his
portraying what
answer.
the Prime Minister or the Prime Minister's office said.
Yeah.
In fact, that was PM minutes. So who actually made that statement, Mr
That's in an answer to question on notice 3215
from
in the Senate.
Prime Minister and Cabinet?
From Minister Birmingham representing the Prime Minister.
Thank you. Thank you. Mr Kingston, are you able to provide any information on this matter?
I'm not right now, but I am, Senator, very happy to take that question on notice and make inquiries about what's happened to our invoice and endeavour in consultation with PM&C to provide you with an answer.
So just to be clear, I want the total amount that you have invoiced. I'm presuming the matter must have been concluded because there's no appeal. But also I'd like to know the dates upon which you invoiced the Commonwealth on each occasion that you did.
Yes, understood, Senator.
Thank you very much.
Thanks very much, Senator Patrick. Mr. Kingston, thank you so much for your appearance.
It's a bit of an anticlimax. Staying up all night.
It's a very important question, Senator Scarr.
Mr. Kingston, all I can say is I hope you're not charging a daily rate for your 5 minutes.
Well, I'm not charging the Parliament anyway.
Oh, you're not charging the Parliament. Excellent. Well, that's one thing. Thank you so much, Mr. Kingston. I'll now give the call to Senator Carr.
Thank you. We've only got a few minutes left, and I had intended to pursue some matters in regard to Mr. Palmer and the aborted case, which I understand has now cost over $1 million. But I'll leave that to the spillover day, I think. Can I just make this observation? In terms of the exchange that occurred with Senator Watt regarding ministerial legal costs, I don't think it's being disputed that ministers who get sued for undertaking their official duties. It's not disputed that they are entitled to public support. And in fact, Minister, you personally have received considerable public support, some $300,000 I recall in regard to the AWU case. And given the nature of your work, you'd probably be one of the more active litigants, given the number of occasions in which you're sued. That'd be correct, wouldn't it, in terms of the Commonwealth?
Oh, I wouldn't know whether or not in my ministerial role I'm one of the more active litigants, but Senator Carr, as you have stated and as we have discussed tonight, current and former ministers can apply.
That's right.
For assistance from the Commonwealth for legal proceedings brought against them that arise because they hold the office of minister.
That's right. And in the AWU case, the legal expenses were around $300,000, weren't they?
I don't have that figure in front of me.
Does Mr. Johnson have the figure there?
Just a moment, Senator.
Bearing in mind, Senator Carr, you will recall that the entire case was dismissed ultimately.
It's not the issue I'm asking you about.
No, but I just want to make sure that you understand that whilst the AWU may have brought the proceedings, they were ultimately dismissed by the Federal Court. The full court of the Federal Court.
The $300,000 was about the sum?
There are 3 separate approvals, 2 approvals in respect of responding to subpoenas, and a third in terms of dealing with a particular matter before the court. The total of the 3 approvals is $434,757.
Sorry, I was going from memory, but it's... Thank you very much. So, in regard to Minister Sukkar, it's not the question about whether or not he should get Commonwealth support if he is sued. The question is whether or not Mr. Sukkar is being sued for defamation because of the work that he's doing as a minister. That's the substance of the inquiry. And Mr. Johnson, you're advising this committee that the payments have been made consistent with that principle.
I think there's a couple of points there, Senator. One piece of my evidence was that no payments have been made so far.
But the approvals?
The approval was given consistently with the regulations, which includes that requirement that was...
So there's no issue about it being outside of the guidelines?
Further than guidelines, are legally binding rules, but yes, they are. The approval was consistent with the legally binding rules.
Thank you very much. And have we got a list of all the payments that have been made to ministers since 2014? Is that readily available?
The payments that are made under approvals are tabled in Parliament annually.
But it's a readily available list, isn't it?
They are tabled, and over a financial year, they are tabled within, I think it's 3 months. The most recent one was tabled on the 2nd of September.
So is there a consolidated list that I could draw on? Would you take that on notice, please?
We can. It would be simply providing you with all of the tabled statements that already exist.
Just give me an aggregate list of...
It will be individual lists.
Yes, that's right. And the total amounts paid under that program.
Dating back until...
2014.
So it's on a financial year basis, or would that be the 1st of July 2014?
Yes, please, if you wouldn't mind. Is that all right? Thank you very much. And given that the hour, we'll leave it there and we'll...
Thank you very much, Senator Carr.
to the spillover day?
Yes, we will be having a spillover which will be scheduled shortly. This now concludes today's proceedings. I want to thank the Minister, the departmental officers for their attendance, Hansard Broadcasting, the Secretariat staff, the wonderful Secretariat staff who do an amazing job, and of course my fellow senators. I'd like to move a motion that all tabled documents are accepted. All those in favour, against, carried. Senators are reminded that written questions on notice should be provided to the Secretariat by 5 p.m. on Friday, the 5th of November 2021. Thank you all again. The hearing is adjourned.
Thank you, Chair.